I declare open this hearing of the Senate Legal and Constitutional Affairs Legislation Committee for the additional estimates. The Senate has referred to the committee the particulars of proposed expenditure for 21-22 for the portfolios of Home Affairs and the Attorney-General and other related documents. These are additional estimates proceedings, and the outcomes to be heard during today's estimates are from the Home Affairs portfolio. The committee has set Friday, the 25th of March 2022, as the date by which answers to questions on notice are to be returned. The committee has also decided that written questions on notice should be provided to the Secretariat by 5 p.m. on Friday, the 25th of February 2022. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. Officers and senators are familiar with the rules of the Senate governing estimates hearings. If you need assistance, the Secretariat has copies of the rules. The Senate, by resolution in 1999, endorsed the following test of relevance of questions at estimates hearings. Any questions going to the operations or financial positions of the departments and agencies which are seeking funds in the estimates are relevant questions for the purpose of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with the expenditure of public funds where any person has the discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has also resolved that an officer of a department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I particularly draw the attention of witnesses to an order of the Senate of the 13th of May 2009 specifying the process by which a claim of public interest immunity should be raised. Witnesses are specifically reminded that a statement that information or a document is confidential or consists of advice to government is not a statement which meets the requirements of the 2009 order. Instead, witnesses are required to provide some specific indication of the harm to the public interest which could result from the disclosure of the information or the document. Just a reminder, mobile phones should be switched off or turned to silent mode. Senators, departments and agencies have been provided with advice on the arrangements in place to ensure these hearings are conducted in a COVID-safe way. This guidance is also available from the Secretariat. The committee appreciates the cooperation of all attendees in adhering to these arrangements. In order to comply with COVID safety requirements, senators and the Secretariat may use their electronic devices to communicate with one another during the hearing. We ask witnesses' forbearance to do so and apologise in advance for any discourtesy. Officers called upon for the first time to answer a question should state their full name and position for the Hansard record, and witnesses should speak clearly into the microphones. I also would like to add that, consistent with the practice of this committee, questions which may involve a danger of prejudice to proceedings before a court will be ruled out of order. It is imperative that the decisions of courts are not prejudged either by senators or by witnesses before the committee, and this convention reflects the committee's respect for the rule of law, the presumption of innocence and the independence of judicial proceedings. This practice is consistent with the discussion of the Sub Judice Convention in Odgers, pages 259 to 266 and pages 536 to 537. I would now like to welcome the Honourable Amanda Stoker, representing the Minister for Home Affairs, Minister for Emergency Management and National Recovery and Resilience, and Minister for Immigration, Citizenship, Migrant Services and Multicultural Affairs. Minister, good morning. Would you like to make an opening statement?
Good morning. No, thank you.
I now call officers from the Department of Home Affairs, including the Australian Border Force, in relation to cross-portfolio, corporate and general matters. Mr Pezzullo, good morning. Would you like to make an opening statement before we go to questions?
Yes, thank you, Chair. Briefly, if I might. As members of this committee would be aware, I have since 23 October 2017 used estimates opening statements on occasion to keep the committee informed as to the evolution of Home Affairs as a department and as a portfolio. I will briefly do so again in this opening statement. On 20 December 2021 that is, the Department of Home Affairs marked 4 years of operation since its re-establishment in 2017. The department and the broader portfolio of Home Affairs have become indispensable elements of the government's ability to plan and prepare for and respond to the challenges with which Australia has been regularly presented in what has become a permanently disrupted world. Given the state of the world, Home Affairs is a department for the times, as the nation contends with complex, concurrent and compounding strategic challenges, such as the global pandemic, extreme weather, espionage and foreign interference, ideologically and religiously motivated violent extremism, the ongoing challenge of terrorism, disinformation, misinformation and conspiracy theories which regrettably grip the imagination of more and more, supply chain disruptions, cyber attacks, risks to critical infrastructure, and the increasing sophistication and capability of transnational serious organised criminal groups. This list is not exhaustive. In bringing the portfolio together, the heads of agencies and I have been determined to ensure that the traditions and strengths of the separate agencies within the portfolio are preserved, that their statutory independence is observed at all times, and that the professional skill and tradecraft of their workforces are valued. As a leadership team, and we meet as a portfolio board, we have sought opportunities to pool our capabilities where this makes sense, while always respecting independence. One concrete example of the benefit of having the Home Affairs construct in place during these disrupted times is the creation 2 years ago of the National Coordination Mechanism, or NCM, which is housed within Emergency Management Australia, which in turn is an operating group of the department. The NCM has quickly established itself as an indispensable tool for stabilising situations of national concern, such as disruptions to energy supplies, freight infrastructure and to essential workforces. Looking ahead, as Secretary, I am conscious of the need to ensure that the department continues to evolve in a way that is fit for purpose. The disruptions of which I spoke earlier will only intensify, and so the gains of the past 4 years will need to be built into the department's foundational structures, processes, systems and workforce arrangements. At the same time, as migration and travel settings revert steadily to a post-COVID environment, I'm also conscious that the department will need to deal with the kinds of visa and travel volumes that have not been seen for 2 years. In this context, I refer to the committee to the recently published 9th edition of the department's publication known as the Administration of the Immigration and Citizenship Program, and I've attached a link to this statement. Finally, Madam Chair, the Digital Passenger Declaration, speaking of travel volumes, or DPD capability, will be released tomorrow. The DPD is the first use case to be built on the Permissions Capability platform. It will replace the Australian Travel Declaration, or the ATD, and in subsequent releases, the paper-based incoming passenger card. While we transition from the ATD to the DPD, my apologies for all the acronyms, Madam Chair, travellers arriving in Australia before the 18th of February this week, the 18th coming up, should continue to submit an Australian Travel Declaration, or ATD. Travellers arriving in Australia on or after the 18th, which is the 18th of February, will need to submit a DPD. The DPD will be a key tool in facilitating our reopening at ever-increasing scales. Thank you, Madam Chair.
Thank you very much, Mr Bozzolo. We're now going to go to questions. In essence, we'll be operating in blocks of 10 minutes, and I'm going to start by giving the call to Senator Keneally.
Thank you very much, Chair. Thank you, Secretary, and your officials for being here today. I have some questions to ask about the processes the department uses to prepare briefs for the minister. Mr. Pizzullo, when you ask one of your officers to prepare a ministerial submission, do you have a tracking system that keeps track of that submission?
Yes.
And what does that track? For example, does it tell you when the submission has been written or when it's ready to be approved by a deputy secretary or by yourself? Does it follow the different steps in that preparation process?
It's a software system which, you'd have to excuse me, Senator, and I'll get some assistance. It's been many years since I've initiated a submission myself, but it tracks the production of a submission in a common piece of software.
Yep.
So that editing and variations can be made commonly. If you don't mind, Senator, I might just ask Ms Sharp to come and
sure.
assist if you've got any more detailed questions.
Yes, I may, and it might be useful to have her at the table. Yep. You said it's been many years since you've initiated...
In the sense of type 1.
In the sense of typing it in,
yes.
but you have actually
Oh
initiated...
yes, my word, yes.
Okay,
no, constantly. No, but by use of the term
you.
initiation, I meant the actual production of using the software in question.
Sure. Thank you. Hello, Ms Sharp. Well, I may have some questions.
So Ms Sharp is the head of our executive group.
Yes. So is the Minister's Office informed when a submission is initiated by you?
Typically, there'd be some awareness because as is the practice commonly, I think, observed across most ministerial offices of different in all different jurisdictions, there tend to be advisors who specialise in particular subject matters. So
Sure.
In the ordinary course, there'd be ongoing engagement at a level of visibility that myself or perhaps the Commissioner, for instance, wouldn't necessarily have intimate knowledge of, where...
It's not, I guess my question is, it's not an automatic
It wouldn't be,
notification?
no, it wouldn't be automatic.
Okay.
But equally, it'd be unusual for a submission to come out of a clear blue sky, unbeknownst at least to the portfolio line advisor. So the
Right.
advisor who might have some carriage within the office of the relevant subject matter might have a sense of what's coming forward. But there's no formality in the sense that the initiation of a submission has to be, if you will, authorised. And obviously the Minister and I, all of my ministers I should say, have constant dialogue on what's on their mind, what their key priorities are, what my priorities
sometimes
are.
the Minister might request a
Quite.
submission, of
Yes,
course.
quite. Yes.
Yes, I understand that. I was just trying to understand internally, does the department necessarily, or are they required to advise the Minister's Office when they've initiated a submission? And it seems like not necessarily.
Required to advise, no, but equally you don't
Okay.
want a submission just to arrive out of a clear blue sky.
Sure, understood.
It just helps handling that,
Yeah.
so the Minister can set aside some time to consider the matter. She can schedule, I should say all of my ministers, so they can schedule
Yep.
time to consider it with their advisors and others.
Great.
Yep.
So I want to ask about a specific ministerial submission that was drafted in 2018 at your request, but then seemed to be stopped by Deputy Secretary and was not escalated to the Minister's Office. And I'm referring to a report here by the Australian National Audit Office released in November last year on management of international travel restrictions. It says that that Mr. Pizzullo requested a ministerial submission to be prepared to advise the Minister for Home Affairs about the results of a stress test that examined if the Department of Home Affairs would be able to assist the Department of Health during a pandemic scenario, which included closing the borders. And that report, prepared after the stress test, I understand from the ANAO report, showed that if a pandemic lasting 9 months with border closures was to occur, the Department of Home Affairs would not be able to cope. It said that a very significant or near existential crisis would push current arrangements beyond their limits. Was the Minister aware that you had requested a ministerial submission on that stress test? Was the Minister aware in 2018? Did you advise the Minister's Office in 2018 that you had requested a ministerial submission be prepared on that stress test?
I'd have to check my own records, but I don't recall advising him that a submission was in preparation, but we will check The question of contingency planning for catastrophic or near existential crises, of which a pandemic stress was one of the ones that we did look at in and I've spoken to this committee before about the work we did in early 2018. I've got a recollection that it was certainly Mr Dutton's mind that we'd done it, but whether we reported it to him through a submission is something that, as the ANAO report clearly shows, we didn't follow through, to my displeasure.
Well, in fact, I want to ask you about that because the ANAO noted...
And I can assure you it won't happen again.
Well, the ANAO noted that the Deputy Secretary wrote on the submission that it would, quote, highlight significant concerns not being or not able to be addressed. Now, that's quite significant. The ANAO says the submission was never even provided to you, Secretary Pezzullo. Is that correct?
The findings were the fact that a ministerial submission was raised and contrary to the normally impeccable judgment shown by my deputies in nearly all cases, on this occasion their judgment failed them.
It's pretty important. It's a stress test about a pandemic.
Only from one particular view. I take your point, Senator Keneally, but from another view, I assured Mr Dutton, and history bore this out, that were an existential or catastrophic crisis to confront the nation, we would have the emergency management and national coordination arrangements in place that were fit for purpose, and 2 years later that proved to be the case. So we did our job on the substance, we didn't do our job on the paperwork.
With the greatest of respect, we've had the Ruby Princess debacle. We've had 40,000 or more stranded Australians. We have had hundreds of unaccompanied children stranded overseas, unable to come home. We've not had a national quarantine system built. We've had the Delta outbreak resulting from a failure, a breakdown in the quarantine system, the transport around the quarantine system. We've had a failure to deliver the digital passenger card. We've had the Novak Djokovic debacle at the borders. We've had empty supermarket shelves just a few weeks ago, and indeed in some cases still occurring. Are you seriously contending that we haven't experienced significant stresses that this stress test in fact predicted could happen?
No, what I'm contending is that everything that my department needed to put in place to be prepared for exactly the eventualities that you've described, we did.
I think I've just outlined that in fact in many cases, the department failed.
I can only speak for the preparations put in place by my department, and we were more than ready for the pandemic that subsequently emerged some 2 years later.
Do you think that maybe the Cabinet would have been more aware of some of the risks and some of these problems around the Ruby Princess and stranded Australians and hundreds of unaccompanied children unable to get home, and the fact that we didn't have a digital passenger card in place and the Novak Djokovic debacle that followed from that? Why wasn't this ministerial submission provided to the minister? It wasn't provided until April 2020, was it?
If I can divide the two parts of your question, the advice should have been provided to Mr Dutton in written form. I will check my own records as to whether there was not a discussion otherwise, because there are other forms of providing advice, including through routine weekly updates, but I'll just check that.
This submission didn't even make it to you.
Correct.
How impossibly could you have briefed the minister about it?
Because the outcomes of the war game or the scenario stress tests were well known to me. So
are you saying you briefed the minister about the outcomes of the stress test? So the minister did have knowledge?
I will check exactly what was briefed to him, but the fact that we're doing contingency planning for what I would describe as catastrophic crises, of which a pandemic is one,
Thank you, Chair.
Was certainly well known to the government. That's why we were able to so quickly move in the early part of 2020 to set up things like the NCM,
Chair,
as an example.
We're going to have questions about that. Chair, I have two very quick questions, and hopefully I'll get them done in the next moment.
Thanks, Senator Keneally. I'll give you a grace of 1 minute.
Thank you. The first is, will you now table that stress test? Will you release it to the public before the election?
I'll take it on notice, yes. I'm not sure that I can commit to tabling it completely in an unredacted form. There are obviously ways in which certain public interest claims can be made. I'll consult with the government and I'll try to release as much of it as I can, but I'll take that on notice.
Thank you.
I'll take the release on notice.
Secondly, I note in your opening statement you mentioned conspiracy theories and the spread of conspiracy theories. I have had a question unanswered on notice, question 3949, since 21 July 2021. And to be fair, it's to the Prime Minister's Department of Prime Minister and Cabinet, but since you mentioned conspiracy theories, I'm going to put this to you. Has the Department of Home, and I'll paraphrase my question to make it relevant to the Department of Home Affairs.
Thank you.
Given that you've mentioned conspiracy theories in your opening statement, has the Department of Home Affairs provided a briefing to the Prime Minister or the Prime Minister's office on the conspiracy theory known as QAnon?
I think strictly the answer is no. However, I'll need to take on notice whether as part of a broader piece around social cohesion and ensuring that conspiracies don't become the ideational base for extremism, that we haven't touched on QAnon in other forms.
Have you provided such a briefing to the Minister for Home Affairs?
Again, I'll take it on notice in the same spirit, whether it's the PM or whether it's the Minister for Home Affairs. We've done a lot of work on engagement with social media platforms, encouraging them to thwart disinformation and misinformation.
Yep.
Whether specifically QAnon has been picked up in that work, I'll take that on notice. In fact, the subject matter experts will be available to speak to that under the relevant program.
Thank you very much, Senator Keneally. We will need to move to other senators. I'll now give the call to Senator Van.
Good morning, Mr Pezzullo. Good to see you again. You touched on some parts of this question in your opening statement, but can you further outline what ABF/Home Affairs is doing to prepare for the reopening of the international borders this week?
Indeed, and I might ask the Chief Operating Officer, Ms Saunders, who's joined the department since we last met from the Australian Border Force, and prior to that she had a distinguished senior career in the Australian Federal Police. Our Chief Operating Officer, Ms Saunders, is also responsible for integrating our border measures work. In short, building on the various reopening tranches that were announced late last year that principally came into effect on the 1st of November, there's a further reopening that effectively applies to all vaccinated temporary visitors, and there'll be rules and thresholds around vaccination, exemption and the rest of it, which no doubt we'll get to through the course of the day. And I might just on that note hand to Ms Saunders. So border reopening, particularly, Senator, you're looking ahead to the 21st, is that right? Thank you.
Thanks, Senator. And obviously the 21st of February will be a significant milestone in reopening of the border in terms of now opening up the border to all visa holders that are vaccinated, in short. So what that means is we're opening up to a significant number of visitors to Australia, particularly the tourist industry, as well as other business sectors to arrive, and so we're well positioned to receive them. I guess the other important step in this arrangement is clarity in relation to what the standards are for those that travel to Australia and what the definition of vaccination has been. And obviously ATAGI has provided clarity in the previous week in regards to those requirements. And what that simply means is for international passengers, the definition of fully vaccinated remains as it has, and that is you've had 2 vaccinations recognised by ATAGI, and or 1 in the case of Johnson & Johnson. And it also means that you can arrive with that standards, that nothing has changed there. And of course what ATAGI has done though in that time is clarify that domestically to stay up to date you're now requiring a booster. So that's been an important clarification as well that's occurred in the previous week. But obviously ABF will talk further in regards to the preparations they have put in place to support the 21 February step. Obviously critical to that will be the establishment and implementation of the digital passenger declaration, which the Senator made reference to earlier, which will start tomorrow, which will be another important step in ensuring that we have digitised, seamless processes for passengers to draw upon when travelling to Australia.
Thank you so much, and congratulations on the new role. Can you run us through some of the technical challenges you think we might face?
Technical challenges. I don't actually foresee, in terms of technical challenges, based on our engagement with obviously industry, this is actually a very welcome step. In fact, it actually simplifies processes insofar as not requiring the various technical fixes to identify passengers that might not meet the requirements of Australia, which have been quite complex over previous months, noting that you could come to Australia if you're fully vaccinated, but if you had particular visas and or had come from countries such as Singapore, Japan, New Zealand, where we had special arrangements in place for safe travel zones. So this actually simplifies the process both for passengers and for industry and has been warmly welcomed by them.
Thank you. And what engagement has Home Affairs and the ABF had with airlines, airports, the infrastructure to do with travel?
That's been critically important throughout the entire process of reopening, Senator. So we actually meet with industry weekly to work through issues that they're identifying through the processing of passengers, preparing them for changes in health policy settings and visa requirements, and so that's been very productive. In addition to that verbal engagement, we've obviously been providing regular written updates for industry to use so that all their staff are well positioned to support the next steps.
Thank you. And how does the work of ABF Home Affairs align to the national plan to transition Australia's COVID response?
So well aligned, obviously, and this has been at the direction of government decisions. So we're still in phase 2 of the plan and rolling out what is referred to as tranche 3 of the steps within phase 2. So not the phase of phase 3 yet, but certainly working through phase 2.
Thank you. And how will the new systems that you've mentioned that we'll have in place at the border, how will they operate compared, say, to pre-pandemic?
So once again, the intent would be that it's simpler for passengers. So initially what they'll see, certainly, and we've got colleagues that can speak in more detail in regards to the digital passenger declaration. However, what it will mean is that those that have been using the ATD, it'll be a fairly seamless shift to the use of the DPD. It will collect the same information of passengers, health information and the like to inform states and territories. So that will continue as it is, but then over time the DPD will evolve to also integrate other important information, including the incoming passenger card over future months. So once again, the intent is the technology will support a more seamless process for passengers.
Thank you. And what is the volume of travellers that you're expecting from next Monday?
That's quite unpredictable, Senator, to be honest. Currently we're seeing about 10,000 passengers a day, which is certainly an increase from the 1,000 we're seeing when we'd literally closed much of the borders. But it's still quite unpredictable, noting the changeable arrangements around the globe. I mean, some countries, as you know, are still recommending against travel to Australia because of the impact of Omicron domestically. We're still pending advice from airlines as to what they propose to do in terms of increasing their commercial routes and flight numbers. So still unpredictable, but we're certainly very optimistic based on the increase in requests for visas over recent months and particularly over recent weeks to see a stark increase over the coming months.
Thank you. Thank you very much for that.
Senator, if I might,
yes, please.
If you've got any further interest in more specific data and details, under program 3.2 border management, the Commissioner and his officers might have a more granular view. So the department handles higher level strategy and policy, and we support the ABF with the deployment of the technology known as the DPD. But in terms of the day-to-day management of the primary line, the flow through airports, Commissioner Outram, I know, has got some information that you might find of interest, and that might be best dealt with under 3.2 border management.
I'll come back to it then.
Thank you, Senator, if you wish.
Thank you.
Thank you very much, Senator Van. I'm now giving the call to Senator Giacone.
Thank you very much, Chair, and good morning, Secretary. Look, I'd like to start off by asking a few questions about a contract that the department entered into with Airbnb to provide accommodation to returning government officials late last year. So I just wanted to table the first attachment, which was an AusTender and I think the Secretary might be able to provide that to you, CN 3815437.
And while that's been done, this arises under corporate management, so I might just ask Ms Saunders to come back to the table as the Chief Operating Officer responsible for our procurement activities. I'm sorry, and we're awaiting a document, are we? Okay, thank you.
My apologies, Senator. I was finding my seat when you asked the question. So if you pose the question again.
We're just awaiting the circulation of the document. AusTender, I think you said, Senator?
It was AusTender, CN 3815437.
Thank you. Thank you.
So you might have a copy there before you now,
I fear
Secretary.
I've pinched Senator Keneally's. Oh, she's offered it.
Multiple copies, Secretary.
Okay, thank you.
All right. Could you confirm for me in the committee, are you able to confirm for me in the committee that the Department of Home Affairs paid Airbnb $331,000 to rent properties where returning government officials could quarantine after travelling overseas?
I'm not sure that represented the final payout. That was certainly the contract values, as you can see clearly stated at the bottom of the contract notice. But whether that represented the actual final disbursement of monies, I would have to check. But that certainly is a stated contract value. You just got it
Does
down.
Ms Saunders know what the final contract value is then?
Yes, I do. Yes, I do, Senator. The final actual cost was for the Airbnb was $344,137. There are obviously additional costs as well associated with cleaning, health and the like as well. So the total cost for the whole provision of all services was $522,067.
What were the additional costs for?
So it included cleaning services, facilitation of transport to the location from airports, support by Sonic Health, which is payment for health medical costs associated with testing and the like during that time, as well as facilitation of basic essentials for those passengers when they were within those facilities.
So how many officials stayed in these properties under this contract?
Just a moment, Senator.
I think while Ms Saunders is looking for her in her notes, we should make clear, I think, Ms Saunders, it's a combination of both public service officials as well as, I think, staff in ministerial offices. Is that right?
That's correct.
So your reference to officials, Senator,
Well, that's right, officials.
yes. So I think
But if there are other staff or, other individuals, like you said, ministerial advisors, I'd like to know that as well too.
It was an omnibus.
But can we go with government officials? Members of the Department of Home Affairs, how many?
Okay.
There was no officials from...
Okay.
No official.
Were there any other government officials then?
Senator, what I've got here before me, so it was in support of three delegations, ministerial...
Sorry, could you just speak up a bit, Ms?
It was to support, the facilities were utilised to support 3 ministerial delegations, including their staff. The total number of passengers was 72.
So 72.
Across the three.
Across the 3. Now, I should point out, so it sounds simple in terms of I should go back a step. So the department was responsible for working with the ACT government in facilitating quarantine arrangements for returning government officials, ministers, their parties and government officials returning to the ACT. So initially, when we entered into that arrangement with the ACT, we were using particular facilities provided by the ACT government. But at a particular point when there was some Omicron risk lifted within the ACT government indicated that the Commonwealth government would have to find alternative facilities. So as a result of that, we actually engaged with ACT government about what suitable facilities might exist. So as a result of that, there were quite specific requirements from ACT government in regards to what those facilities needed to provide, and I can provide a list of those details as well if the Senator would like.
If you could.
Sure.
So essentially, about $500,000 has now been spent for accommodation to Airbnb to accommodate not just returning government officials, but also ministerial advisors. Is that correct?
That's correct.
And the ministerial advisors, which offices have they come from?
They came from Minister Payne, Minister Dutton and the Prime Minister.
And in terms of the other officials, which departments, could you be able to confirm which departments they were associated with?
I don't think I have a breakdown of any departmental officers from which departments they came, but I will confirm that and I should be able to answer that to you later this morning.
If you could, and if there are any other agencies or other associated entities, that'd be great.
Of course, going back to your earlier question in regards to the ACT health requirements, they required freestanding properties that had independent access to building, the ability to dispose of rubbish without interacting with other people, no communal or shared areas for car parking access or the clearing of rubbish, and were well ventilated with the requirements. There was close engagement with ACT government about what facilities might be available that meet those requirements, and as a result of that, we engaged with the Department of Defence to see if there was defence housing that we could draw upon. And in that instance, we identified 10 properties that we could use. We also engaged with our property contractor, JLL, in regards to properties that might be available, but they were for long term, so wouldn't be suitable for the short-term requirements that we had. And then we explored hotels and apartments, knowing they would be lower cost options, but they weren't agreed by the ACT government due to the higher COVID risk. So that was an option. The other option we obviously explored was, is it possible for officers to share some of these facilities, noting they were homes? That wasn't agreed to in all instances. And so as a result of our understanding of the demand, meeting of the ACT government requirements, the option that was agreed to by both ACT Government and the Department of Home Affairs as being the most suitable were properties that could be identified through Airbnb, and that was the rationale for that. The other point to make is the cost seems high, because if you look at it very simplistically through the lens of these people only required 2 weeks quarantine, it wasn't that simple either. So we end up having to procure the properties for 11 weeks on the basis of doing initial assessments of the properties, making sure appropriate security arrangements are in place, Wi-Fi and the like, to ensure that those officers that were staying in the accommodation could fruitfully continue their business. So we had to access it early, and then there was a requirement by ACT Government for the facilities to be available for a 4-week period post-quarantine in case that individual became positive during that time. So it then required, as I said, the arrangements to be in place from the 12th of September to the 30th of November.
I appreciate that, and I don't mean to cut you off, but we've obviously got some limited time or time constraints. But I mean, $7,500 for each of these people, considering that the ACT Government probably would have charged around $3,000 to $4,000. I mean, one on face value might have to say that, are we really getting value for money here? But I do want to go to another attachment, which hopefully the Secretariat is able to distribute to you as well, which relates to another matter to do with Airbnb. It's a question on notice number 4448. I'll just wait for that to come your way. And while that's coming, could you also take on notice from the previous attachment of AusTender, where people were returning from as well too? But if you could just take that on notice.
Senator Ciccone, one more minute.
Thank you,
Do you
Chair.
have long to go in your
I
block?
do. We're here all day, so thank you, Chair.
How much more time do you need?
I need some time.
Depends on the answers.
Yeah, well,
So another.
let's just see how we go with hopefully another.
All right, well, you've got one more minute in this block.
Yep. Could you confirm for me that an employee of the Department of Home Affairs owned a property that was rented as part of the procurement?
Senator, I can confirm that one of the properties was owned by a Home Affairs officer. I would like to clarify, though, that how that actually eventuated was Home Affairs reached out through the Airbnb platform without knowing who the owners of the properties were. One of those properties was a Home Affairs officer. The Home Affairs officer, upon receipt of a request from, it was only referred to, a government agency seeking to rent the premises, identified that perhaps it could be particularly related to this initiative that Home Affairs was now responsible for, and as a result he reached into a senior officer of the department to seek advice in regards to a conflict of interest. And on that basis, that officer said he would not take up the Home Affairs offer to lease his premises.
What's the employee's APS level?
Is a First Assistant Secretary.
It's a First Assistant Secretary.
That's correct.
And how long has that employee worked for the department?
I just want to probably take on notice the next line of questioning, because there's so few limited number of officers at that level that the officer will be quickly identified. I have caused because I've read this question on notice and my own interest was piqued. I have caused an inquiry to be made. I'm satisfied based on both contemporaneous documents as well as statements taken from the officers that the officer in question not only self-identified but said, look, it's probably better that I get taken out of the pool. So
How long was the property listed for then?
The property was listed from the 12th of September, I believe, until, and in fact the contract was until the 30th of November, I think I've got the date here, Senator, just bear with me, but as soon as we had advice from ACT Government that they were no longer requiring quarantine for fully vaccinated Australians, that property was relinquished immediately, but I will just confirm the date for you.
How were they informed of the department's decision to include the property in this rental procurement?
The advice I've had is that at that time there were actually no other properties available, and due to the tight time frame we had for the departure of the delegation, and noting the delegation had to have confirmed quarantine arrangements before they could depart, that was the only suitable property that was available at that time.
Ms Saunders, I'm sorry to interrupt you. I'm just going to ask the media just to remain within the designated areas, and also to remind media that there can be no filming on the desks, including, of course, any documents. So If you are pointing your cameras in that direction, we are entrusting you that you will only film the faces of those at the table.
Ms Saunders, what was the total cost?
Thank you. Sorry, Senator Ciccone. Last question for you, Senator Ciccone.
What was the total cost to the department for the rental of that individual property, and how many officials stayed at that property?
I'd have to take on notice the number of officials that stayed in the property, but I do have the details of the actual cost.
And if you take on notice which department those officials were from too, that'd be much
Of course.
appreciated. Yep.
The total cost paid was $15,981.
Sorry, could you just repeat that again? Sorry. Ms. Saunders.
$15,981.
Just so that I'm clear, what does that sum relate to?
That's the total cost for the rental of that particular premise for the period 12th of September to 30 November. But if I can just come back, Senator, take on notice the actual date that we relinquished the property.
Thank you.
Senator Ciccone, I just want to hold you there. We have gone over your block. I've just got a couple of questions on this matter, and then we will go back to you if you've got more questions. Can I just, as I understand it, in relation to these arrangements, they were only necessary because the ACT had terminated their home quarantine arrangements?
Well, the properties that they had identified to be utilised were now being utilised for community risks associated with Omicron, so are no longer available to the Commonwealth. So there was a combination of home quarantine in some instances, but where home quarantine isn't possible, separate premises had been identified by ACT Government within the ANU precinct, and that wasn't available to us. So as a result of that, there was a very urgent action taken by Home Affairs to identify alternative accommodation, noting that we had these ministerial delegations travelling.
And what sort of notice did Home Affairs receive in relation to needing to put these arrangements in place?
So we were advised on the 12th of July 2020, we started the responsibility of coordinating activities, and we were using premises at the ANU, and the intent was to commence those arrangements from September, potentially for a period of 6 weeks. And then on the 23rd of August 2021, we were advised by ACT Health that we'd need to identify alternative accommodation.
Sorry, just so that we're not inadvertently misleading, was that July 20 or July 21?
2021, apologies, Secretary.
No, my apologies for correcting you, but I don't want the Hansard to be inaccurate. So July 21?
That's correct, 2021.
Thank you.
And we're advised on the 23rd of August 2021. And the travel that was being undertaken by the ministerial delegations commenced in September, which was why the urgency, Senator.
Thanks very much, Ms Saunders.
If I recall, Ms Saunders, we also looked at the earlier model of both hotels and student accommodation, but they were not available, is that right?
Not deemed suitable by ACT Government. That's
so we had to go
correct.
to freestanding houses.
So there were very strict parameters as to the sort of accommodation that you needed to source, which limited your options.
That's correct, and I can repeat them again. So we engaged Department of Defence and identified 10 properties.
That's fine, you don't need to repeat that again, that's fine.
Sure, thanks,
Thank you. Senator Ciccone, you have some more questions? Thank you. Over to you.
Thank you, Chair. Anyway, I find it amazing that out of all the ACT, there was only one property that fit the bill, and it just happened to be owned by a First Assistant Secretary or someone of that ilk. It's just mind-blowing. But anyway...
sorry, Senator, just given the colourful phrase that you've used, I just want to make clear, look, I don't know what the market dynamics were. I'm a resident here in the ACT. I understand the rental market to be tight, particularly for short notice rentals. I want to make clear, because I've caused my own inquiries to be made in this regard, that the officer self-identified and said, I've come to the view that this might be related to ministerial delegations. I don't think I should be part of the program. His hierarchy, his chain of command took that on board and decided, given the paucity of short-term rental openings for that time period, that thank you for alerting us, but you're in the program. Now, I've read a report to that effect. I'm still considering that report. It was given to me last week when I reflected on the response to the question on notice. I'll further consider my position in that regard. But prima facie, on the face of the fact that the officer himself self-identified, I'm satisfied that unless something else comes to my notice, that there was proper conduct engaged in.
I mean, they've walked away with $15,000 of taxpayers.
I understand the point, Senator, but had the officer sought to disguise the fact, had the officer not drawn it to the attention of his superior, had the officer indeed not volunteered to opt out of the program, I might have a similarly jaundiced view, as I think you're inferring that you're implying that you have. But those conditions aren't apparent here to me.
All right. No, I appreciate that.
I'll read the integrity report more carefully, and if I've got a change in position, I'll advise the committee.
Could I direct you to your answer to question 5 of that Quan, 4448?
Yes.
You say that a different property was removed from the pool after an inspection found it not fit for purpose. Who conducted this inspection?
I'm not sure here.
I'll have to take that on notice, Senator. I presume it was a Home Affairs officer, but I will confirm
Did the
that.
property fail to meet the ACT health guidelines for home quarantine? And if so, which ones?
I'll take that on notice, Senator.
Could I then direct you to the answer in question 4 of that Quan? And I quote, the ACT government provided strict guidelines as to what sort of properties could be leased. Properties were sourced based on the following ACT health requirements for home quarantine, which included freestanding properties, independent access to the building, well ventilated, etc., etc. Did all 19 of the properties rented through this contract meet the ACT government's guidelines for home quarantine?
Yes, they did, Senator.
Now, I'd like to table another Quan 448. Hopefully the Secretariat will get that to you very quickly.
Is it
the same one?
448 the one that we're dealing with?
My notes. Oh, sorry, 4448. Yep, sorry. And it provides some photographs. I'm not sure if you've also got that there in front of you too. That's the third attachment of the Quan. Sorry, we'll just get that. There is another attachment. It's on its way, Secretary.
Thank you very much.
Now, this attachment provides some photographs of the Airbnb properties that were used as part of the contract. There are at least 3 townhouses or duplex-style properties which were used for quarantine under the contract. What steps did the department take to confirm at the ACT Health that these properties were appropriate despite not being freestanding properties?
Well, I understand that there was close engagement with ACT government and agreement to the properties that were identified. And in simple terms, my understanding is those properties were still deemed to meet the requirements of ACT government. And by way of example, I think duplex is slightly different to that of an apartment insofar as it still has the separation that was required by ACT government, access to facilities and the like.
So you've indicated that you were forced to use a property that belonged to an official at the department because there were no other properties that met the ACT health requirements, but it appears that there are a number of other properties that could have been used but also didn't meet the requirements. So I guess the question is, like, which one is it then? I mean, if you've got...
Sorry, Senator, what's the premise? There were other properties that didn't meet the requirements?
There were other properties that met the ACT health guidelines. So on one hand, you have a contract where you are in breach of the ACT health guidelines, and obviously we've gone to extensive questions around this particular official's property.
Has that been established?
But there were no other properties that met these guidelines.
Senator Ciccone, I don't believe the witnesses at the table have accepted the proposition that the ACT government's health requirements were not being met. Now, I'll ask...
Well, our evidence is to the contrary, that there was close engagement with ACT, and where there was a question about whether I'll call it a dual occupancy, meets the definition of freestanding. My understanding from Ms Saunders is that that was checked with ACT, who must understand both not only the zoning and property rules in the ACT, but also their application in public health, and they cleared them for entry into the program. Is that...
That's right. Senator, if I can take you to like the requirements, yes, freestanding, and I take your point, duplex has a common wall, but it still has independent access to the building, still the ability to dispose of rubbish without interacting with other people, still has no communal shared areas for car parking, still has separation in that regards. And I said I do want to reiterate that all of the properties met the ACT government requirements. The one property where there was a concern that it was not suitable, it was as a result of that decision which led to the department actively proactively engaging the officer in regards to being able to access his property. It certainly was, as the Secretary said, not initiated by the officer. In fact, the officer made it very clear that he did not wish to take up the offer, recognising the perceived conflict of interest in doing so.
Senator Ciccone, we are running to time constraints. If I could ask you to complete your questioning in the next few minutes.
Thank you, Chair.
Thank you.
So just so for, I guess, for clarity, the staff member that was in question through my earlier line of question, a superior would have had to sign off.
Yes.
Okay, so would have been signed off by what, like an SE1, SES1 type band?
Well, it would have been signed off by the area that was running the program, which was not the officer's own division. It would have been our property.
Were the two individuals
property folks, right?
worked in the same team within your department?
Say again, sorry.
Did the two individuals work in the same team within your department?
Which two individuals?
Well, the individual that owned the property and the individual that then signed off on the use of that property.
Oh, I see. I'm going to be, I just want to be circumspect here because there are a relatively few number of First Assistant Secretaries, and to answer that question directly would be a further identifier of the officer in question. I'll reflect on how best to answer it, and I'll answer that on notice. But I want to stress, Senator, that the officer in question, based on all the evidence that I've read, and I've had a report prepared for me, went out of his way to suggest this is going to be an issue in estimates and elsewhere. Best if I don't participate in the program. I think that's exemplary conduct.
If I might, Senator Cunningham, one, I would just advise you, if you're so concerned about identifying the person, not to use a gendered pronoun. Secondly,
Thank you, Senator.
are you saying, we're just trying to seek confirmation that an Assistant Secretary, SES1, signed off on a First Assistant Secretary, SES2's property being used? We're not seeking identification,
I
but
see what you're
rather
saying.
levels.
The program was being managed in a different division, probably at that level, but it might have been the First Assistant Secretary who's one level up. I'm not sure. I'll just have to take that on notice as to who is responsible for the day-to-day sign-off on the properties coming in or out of the pool.
Can I also ask, did the ACT confirm that all your properties complied with their guidelines?
That's my understanding.
It's my understanding.
Did they
Senator.
confirm it in writing?
I'll have to take that on notice.
You don't know?
No, I don't know if it's
If
in
they
writing.
did, can you please table that? And if they didn't confirm it in writing, can you please table how you can state with certainty here today that your properties did conform to their guidelines? Because you must have some basis on which you can
Yes,
make that
indeed.
claim.
Yes.
Do you have any, you said right now you anticipated this would be an issue for estimates. So do you have any basis on which you make the claim here today that your properties conform to the ACT guidelines?
Yeah, well, we had the guidelines. Obviously, ACT were very specific about those. I've outlined the guidelines to the committee. The properties adhered to those guidelines.
Well, there's a prima facie question here because they're not
where the
freestanding.
clarification was sought, direct engagement occurred with ACT Health.
Yeah, but they are not freestanding properties. So either the ACT confirmed it or they didn't.
Yeah, so we have to
ACT.
establish the mode of communication
Yes, we'll do
by
that,
which
Senator.
that...
But you're stating here today,
So,
your
sorry,
advice to this committee today is
Senator
that they
Keneally.
did confirm it.
So just to be clear, are you taking that question on
Yes.
notice? That was a bit
Well,
difficult to
I'm trying to
ascertain.
understand Ms. Saunders' answer to the committee. I'm trying to understand, is she saying she knows they confirmed it, she just can't tell us how they did it? Or is she saying she's going to go and check if
The
they
advice I've
confirmed it?
had is that the ACT government agreed to the properties we identified as meeting those requirements. What I'm saying is in terms of practicalities, the guidelines were made explicit by ACT government. We relied on those guidelines in making decisions on properties, and where there were questions or concerns, there was direct engagement with ACT Health.
And so what you're taking on notice is how that confirmation came from the ACT that these
Yes.
these properties that are not freestanding somehow conform to their guidelines that they must be freestanding.
Yes, we are taking that on notice.
Thank you.
Thanks, Senator Keneally. Senator Ciccone, we will need to finish cross-portfolio corporate and general matters. We are running over time. We are now going to move to outcome one, and I call office... Senator McKim, my apologies. It wasn't. You don't need to raise a point of order. But my apologies, I understood you wanted to raise questions in outcome 1, so that was my mission. Senator McKim, you have the call.
All right. Thanks, Chair. I appreciate that. Mr Pezzullo, I wanted to ask about the process of the department engaging with the Minister's office around decisions to release people from the offshore cohort, from APOD detention into the community. And I'll have some other questions about this cohort when we get to that output group. These are specifically in regards to how the department engages with the Minister's office. And one of your officers, Ms Jones, at the last estimates made it very clear that briefs relating to releasing folks from that cohort from immigration detention or APODs into community detention were requested by the Minister.
Yes.
That's correct, isn't it?
I recall her evidence broadly in those terms, yes. I would want to reread the Hansard.
Sure.
Which I suspect you have read more recently.
I have read it within the last 30 seconds, Mr Pezzullo, so if you could just take me, take it as read.
I'm happy to go with that.
Thank you, I do appreciate that. So what I wanted to ask was whether the Minister requested in those cases briefs from the department on a case-by-case basis, or whether the request was more made in terms of a review of all the people in that cohort.
I suspect, Senator, it's a combination. The officers who typically would handle these matters would appear under Program 2, but if the burden of your question really goes to ministerial advising, or in the same way that Senator Keneally asked earlier about submissions.
That's right.
I'll try to respond as best I can.
Thank you.
Perhaps Ms Sharp and perhaps Ms Moy could join me. So Madam Chair, as I understand the question, it really goes to overall departmental processes.
That's right,
for advising ministers. You're not asking about particular cases?
No, I'm not.
Thank you.
No.
Okay.
It's as I indicated, I will have some questions in more detail later on, but these are just in terms of the process that the department engages in
so Ms Sharp,
liaison with the Minister.
Very briefly, the process by which a submission is raised, it also goes to Senator Keneally's earlier question, how we track it in the software, and then Ms Moy, on the question about whether APOD cases are sent to the Minister, if you like, as a what's the right term here, a batch, or whether they're particular to individuals. I might refer that to Ms Moy. So Ms Sharp, just briefly on ministerial submissions generally.
Sure. Sophie Sharp, Group Manager Executive in International. So Senator, in the case that you've outlined, when a minister or her advisors request a submission, it's centrally coordinated through my team in what is called PDMS, the Parliamentary Document Management System. It is documented, tasked to the relevant line area for action, and produced by the line area and then provided to the Minister's office.
All right, thanks. And do you, are you able to inform the committee as to whether in this case, so this is specifically in regards to a request that previous evidence has been given by Ms Jones, the Minister requested advice from the department, whether that was done on a case-by-case basis, or whether the Minister said, could you review all of the people in this particular cohort?
Senator, for that exact example, I'd have to take on notice and check the system.
I appreciate it if you could do that, please. I'm not sure whether Ms Moy is.
So, Sherilyn Moy, Deputy Secretary, Immigration and Settlement Services Group. Thank you, Senator. The department regularly reviews all persons who are in detention. The power to release someone from detention or determine another place of whether it be a BVE, for example, a visa, or a community detention residence determination, is a non-compellable power of the Minister. So we refer to the Minister as part of that review process, both individuals or may include a number of individuals in one brief.
Thanks, Ms Moore. So Ms Jones's evidence to the committee during the last estimates hearings was that for this particular cohort there was a request by the Minister, and what I'm trying to establish is whether the Minister made those requests on a case-by-case basis, in other words, in relation to specific people, or whether the Minister asked the department to review all of the people in a particular cohort. So I think we've had that taken on notice. If it's possible, Mr Pizzullo, could I ask that, I'll just indicate, I'll raise this again later today in the output groups.
Can I be clear, Senator? Is it in relation to detainees in a particular site, at the Park Hotel or similar, or,
yes,
or are you asking about a cohort of detainees who have got a particular legal status?
Well, I think both, but I'm specifically interested in the cohort of people who are in Australia but who belong to the offshore cohort, if I could put it like that. I think you'd call them transitory persons. Some of them were brought in under the Medivac legislation. Others
I understand.
Have been transferred outside.
So irrespective
Medivac.
of location, that group forms a class?
That's right.
They are medical transferees, legally known as transitory persons. What we might do, because you've given us ample notice, is under 2.4 IMA offshore management. I might, not unless you've got any more questions for Ms Sharp on the tracking of submissions or the software that we use. Senator Keneally asked about that software earlier, PDMS. I think I got that right. You did. Unless you've got questions that go to the management of submissions, it might be better if it suits, through you, Chair, the committee, for Mr Ablong and Ms Moy to deal with the management of the onshore persons who have come from the IMA offshore group, irrespective of their location. I know there's been some interest in the Park Hotel, for instance, but legally we treat them as a class. And the question, Ms Moy, for you and Mr Ablong, just to cogitate prior to 2.4, is what is the process? Submissions raised by person or by group? Have I distilled the essence of your interest?
You have, Mr Pizzullo, and because you're in effect stating I've given ample knowledge, I also am interested in whether any briefs for that cohort are still resting with the Minister and haven't been actioned by the Minister yet, and also I will be going to specific locations, so if it's possible to provide a breakdown, for example,
we will do
of
as
people
much
in the Park
preparatory
Hotel.
work as is able to be done between now and 2.4.
I appreciate that, thank you.
Thank
so
you.
just another couple of quick
Just
questions.
another couple of minutes,
in corporate and overview. Look, this goes to the issue of 449 visas that were granted for people in Afghanistan. I understand they were granted by the Minister, but specifically I wanted to ask that in the provision of subsequent advice to the Minister around how to deal with people who were Afghan nationals who had been granted a 449 visa, whether the department sought any advice from the Department of Foreign Affairs and Trade during the working up of that advice to the Minister, and specifically the DFAT advice to people who held 449 visas that they should not attempt to leave Afghanistan but actually should stay in Afghanistan because it's too dangerous to travel. And of course those people then had their 449s expire, and because they followed DFAT advice, they now don't have a visa to come to Australia, and the Minister's given no assurances that those people will actually be granted a visa. So I understand that a lot of that, what I've just said, falls within the outputs, but specifically, can I ask, and I think this is a corporate matter for the department, hence asking it here, in the formation of that advice to the Minister in regards to what to do with folks who had been granted a 449 visa, which, as you would know, Mr Pizzullo, is a 3-month time-limited visa, whether the Department of Foreign Affairs was engaged with during the working up of
Well, the
that
short
advice.
answer is yes. We've had very close working relationship with DFAT, both through I'll call it the evacuation phase and subsequently. But in terms of the specifics of that engagement, I really would prefer to have my officers who can answer questions under 2.3 available.
All right, no worries. And last question, thanks, Chair. And we've dealt with this before in overview, so I just wanted to ask really quickly for an update on the New Zealand arrangement, Mr Pizzullo, specifically given the Minister confirming on the record in June last year that she was working with her counterparts in New Zealand to resettle asylum seekers who'd been medically evacuated to Australia, and specifically that she was working through the issue of whether there was, in the Minister's terminology, a backdoor way for any of the refugees to be able to go to New Zealand and then return to Australia. And the Minister said, we're working through those issues now and we'll continue to do so. So can you provide an update? Can you firstly confirm that that is ongoing?
It is, and your description of the government's position is accurate. I can confirm that both the discussions are ongoing. The relevant officers who can deal with the matter in detail would appear under 2.4, but I'm happy in very general terms to address the matter now, and then they can think about preparing themselves for your very evident line of questioning. The discussions are still ongoing. There is an issue, given the Trans-Tasman travel arrangements, whereby after a period of time, a special purpose 444 visa would become available to a person who otherwise, having arrived, let's say, hypothetically, Senator, after July 2013, where the government's policy, both sides of politics have said, will never settle here in Australia, there is a theoretical problem, or not problem, there's a theoretical outcome whereby a person could effectively settle here as a 444 long-term resident of Australia, having gone through, and I think the phrase used is through the back door, having gone.
It's not my phrase. Just
no,
to
I
be clear,
understand,
Mr.
and you were
Silva.
very clear about that. You attributed it to the minister. I understand that. So we are still working through those issues with the New Zealanders, because there's a matter of principle about then, and I've given evidence to this effect over several years. On the New Zealand side, there is a concern that there's if you like, a discount or a cost or a penalty imposed on a 444 visa holder. That they've said quite openly, we'd like you to think about that. So that discussion is still ongoing. But as to the details of where that dialogue is at, I'd prefer to deal with that under 2.4.
Okay. Thanks.
Thank you.
McKim, we will now move to outcome 1 and would call Department of Home Affairs officers in relation to outcome 1. After consultation with senators, I am going to ask if Minister Mackenzie could come to the table. Due to the minister's time constraints, we are going to move to emergency management first, to the extent that we can. And I believe Senator Watt will soon be arriving. Senator Keneally, in relation to emergency management.
Your arrival was announced.
Oh, Senator Watt, you've been so quiet. I didn't realise you were behind me.
They both left infrastructure and we've come down and sat in the back stalls.
I must say, Madam Chair,
Together.
I did notice Senator Watt kind of, slowly flanking us.
Lovely. Well,
We're not going to say creep.
Minister, good morning and welcome. And we are running a bit behind time already. So I will quickly move to give the call to Senator Watt.
Thanks, Chair. Do we have anyone from EMA here?
Yes, I'll call Joe
Thanks.
Buffoni, please.
We have
I actually haven't got too many questions
We have
in this
the
section,
Director
and
General.
Senator Grogan will have a few as well, Chair.
All right,
just
thanks,
flagging
Senator
that.
Watt.
The only questions really I had today were about aerial firefighting capacity. Mr. Buffone, Senator Grogan, I think, is going to ask a few questions about the recent events, and you'll probably want to add to that as well. But just focusing on aerial firefighting, Minister, are you aware of the aerial firefighting strategy produced by NAFC?
Yes, I am.
So you've been briefed on that?
Yes.
Great.
I had a great opportunity to call in and thank the outgoing CEO and obviously welcome the incoming.
Thanks. So when were you briefed on that, roughly? Shortly after.
I'll have to take the details on notice about the exact time or day.
Okay. But soon after you took on the portfolio, I take it? Yeah, okay. And you'd be familiar so this strategy is prepared by the National Aerial Firefighting Centre.
Sorry, NAFC, yeah.
Or NAFC?
Yep.
Which essentially coordinates aerial firefighting across the country. And you'd be aware that it made essentially a number of recommendations for what was needed in terms of aerial firefighting in Australia. Has the government prepared a response to that strategy at all?
Well, it's not something we would typically provide a formal response for, but I would like to inform the committee that we do have a national aerial firefighting capability, and I'm sure Joe can go into the details on how that's actually deployed at any given time during the fire season. But we have currently, as of the 12th of November, 148 aircraft providing 159 services. So we've got 4 large fixed-wing air tankers, 11 large rotary-wing aircraft, 67 medium and small rotary-wing helicopters, 49 fixed-wing fire bombers, including fire bosses, and 17 fixed light-wing. Of these 148 aircraft, as far as NAFC is aware, 123 are Australian-owned and registered, 12 are Australian-owned and foreign registered, 13 are foreign-owned and registered, and 6 are currently not in the country. And I would like to remind the committee that we did, as a federal government, get our very own large air tank, and that's been deployed over into Western Australia to assist with the bushfires, particularly over this recent summer.
I'll have a couple of questions about that in a tick. And I should have said...
Joe, did you have anything else to add?
Nothing more to add at the moment, thanks.
I should have said at the outset, this obviously all follows from the recommendation from the Royal Commission into the bushfires, which recommended that we have a sovereign aerial firefighting capacity, and then NAFC went away, prepared its report and strategy on what it would take to have that national sovereign aerial firefighting capacity. Just working through some of the recommendations from this strategy, I mean, let's start with large aerial tankers, which you just raised, and I acknowledge that the government has now leased a second large aerial tanker. I noticed, though, within this strategy that the recommendation of NAFC was that we as a nation buy an extra large aerial tanker, but the decision was taken to lease it instead. What was the reason to go down that path?
I'll hand over to Joe.
I'll make a reference to the Director General. We're not quite so
Informal?
we're not quite so informal within the department, Minister, but Director General.
Morning, Chair. Morning, Senators. Joe Buffoni, Director General of VMA. Thanks, Senator, for that question. Look, the decision to buy or to lease still remains quite vexed by the industry. We take advice from NAFC. What the government has done is provided the funding to secure an additional large air tanker, as has been reported, and the decision to procure or to lease rests with the National Aerial Firefighting Centre. What we have done, though, is in the grant requirements, we have, and this is the first time that we actually have stipulated that there needs to be a national large air tanker to be able to be moved around the country based on risk.
Okay, so you're comfortable with the decision to lease as opposed to buy the extra large aerial tanker?
Correct. Well, at the end of the day, it is a decision for the chiefs and the commissioners. It's not my decision, and we seek advice from them, and they are comfortable with the current arrangements, as you're seeing operating in Western Australia.
Okay. I just noticed, though, on page 21 of this strategy, it says that it sort of goes through the different options. 11-month lease, lease to buy, outright purchase. Analysis was undertaken, the analysis of commercial in confidence, but the NAFC Strategic Committee recommendation is that the second large aerial tanker be purchased outright by the Australian government. So why then, if that was their recommendation, why was the decision made to lease this aircraft rather than purchase it outright as they recommended?
Well, again, the government provided the funding. The funding was provided through the grant program on an annual basis, and then it's up to then the NAFC to determine how they're going to actually meet that requirement. I mean, obviously for the first year, Senator, you know, the funding was aligned to the budget process, so NAFC acted very, very quickly to get you know, a large air tanker in place. My understanding is they are continuing to look at options, and another requirement under the grant was that they undertake some research to understand the efficacy and also the best options for the future.
So just to go back to the beginning of your answer there, I think you said something along the lines that annual funding was provided by the government, and on the basis of that, NAFC decided to lease. Is that another way of saying that the funding provided by government was not enough to undertake an outright purchase, and that the lease was what could be afforded within the budget provided?
Look, I don't know that I would contextualise it in that way. My understanding is that we have engaged with NAFSI. The chiefs and the commissioners are very grateful for the provision of the funding, which actually provides the capability. The mode in which the capability is provided is still something that is being worked through, but the advice that we have from the chiefs and from NAFSI is that the large air tanker is a welcome addition, and that it has served its purpose in Western Australia. More than 46, I think, 51 drops, in Western Australia.
2 more minutes, Senator Watt.
In working through, I mean, you would acknowledge that one of the risks in leasing an aircraft rather than an outright purchase is that as fire seasons become longer around the world, there is a risk that aircraft can't be acquired at the time that they're needed. And I would have thought that an outright purchase would eliminate that risk.
So, Senator, the stipulations in the grant were that the aircraft be available pretty much through the early starts and late seasons to ameliorate that particular problem. Whether it be lease or procurement arrangements, we weren't specific, but the arrangements are that it must cover that period. So it's not just here in the traditional way, for the fire, for the traditional fire seasons. It will actually be here for a longer period. So early starts and late finishes are to be covered by this capability.
What's the duration of the lease?
Sorry?
What's the duration of the lease?
Oh, I haven't got those details. I'll have to take that on notice.
Yeah, if you could, please. But it's not a 12-month lease, it's for a portion of a year.
I'd have to take notice,
Okay.
Yeah, Senator.
I do have other questions, Chair, but I probably need another block.
And we're not the least.
All right, thanks very much, Senator Watt.
We grant.
Yeah.
Yes.
We do the grant.
Yeah, so just to clarify that, Senator, we do not lease the aircraft.
You provide the funding that
We provide
NAFSI
the
then
funding
leases.
through a
NAFSI
grant program. We put some guidelines and we stipulate that it must be for a large air tanker. It must cover the early starts, late finishes. It must cover, and specifically, Senator, to deal with the issue that you've raised, because, we are acutely aware of some of those changes, and that's why we've put specific arrangements in place to make sure that it will cover that risk.
I mean, as we see the variability of climate around the world, it's making sure we've got that capability onshore for those shoulder seasons, exactly to that point. And the fire chiefs are very, very grateful that we've got that extended capability.
Thank you very much, Senator Watt. I've now got a number of questions for the Minister. Minister, I just want to refer to a tweet by Mr Albanese on the 29th of December 2021 when he said Australia needs a dedicated national aerial firefighting fleet. A government I lead will deliver one. What do you say to the factual accuracy of that particular publication?
Well, I thought that was a little disappointing from the Leader of the Opposition, because as I've just outlined in response to Senator Watt and the Director-General has outlined, the government's been very forward-leaning into ensuring we do have a national capability. We've leased a large air tanker which can be deployed by our fire chief anywhere, anytime. We have quite an extensive range of firefighting capability and types available to the fire chiefs right around the country to be deployed without interference as they see fit as the experts. And I think particularly in the management of natural disasters, this is not an area we should be playing politics in and cheap political point scoring. Australians need to be confident that no matter what side of politics you're from, whether you're local, state or federal political leaders, that we're focused on keeping them safe from natural disasters.
Can I ask you about the large air tanker? Where is it currently and where has it been?
Joe will be able to go to the details, but we saw it come in late last year from the US. It stopped over, said g'day, and then flew straight to WA. I think it can dump up to 15,000 litres of retardant or water in seconds, and it's been a great support to our ground crews in WA this summer.
Yeah, thanks, Chair. The aircraft was selected for a couple of reasons. One is its capacity, 15,000 litres. The other thing is so that it can actually move around the country very, very quickly as well. It was deployed to Western Australia as agreed by the chiefs, and that's its current base. And as it's turned out, that was absolutely the right decision. When you look at the risk, the preparedness sessions that we did with states and territories that highlighted that out of all of the states, Western Australia was going to remain dry. So it's been operating there, and as I said earlier, it's done 51 drops of 15,000 litres of retardant protecting communities in Western Australia.
And could you tell me about the national naming competition?
I might hand that back to the Minister, but the Minister has, we've initiated through the Minister a naming competition for regional schools. It's being done through the Australian Institute of Disaster Resilience and also through the Department of Education. There's been significant interest from students to participate in this day, but Minister, I might hand back to you.
Yeah, thanks, Joe. Director General, I think you did really well. So I think this is about engaging young people and awareness raising in those communities that will be severely impacted by natural disasters, bushfires in particular, and to give them a chance to name our large air tanker. Now I know, and so many of their teachers have taken this on board as a first term project, and we'll be making decisions shortly once we get that feedback.
Thanks, Minister. I'm now going to go to other senators who have questions in relation to emergency management, just to manage the Minister's availability. Senator Watt, you have some more questions. Does anyone? Senator Patrick, look, I will hand to you in relation to emergency management. Senator Patrick.
Thank you very much, Chair. I just wanted to go to the warnings that were provided to National Cabinet in relation to high-risk weather. Firstly, to Mr Pezzullo, thank you very much for responding to this, or having your department respond to this FOI in accordance with law. Perhaps having read Justice White's decision, you might want to do some 101 on rule of law for Mr Gaetjens. But I do
Probably
appreciate
don't need to make the unnecessary commentary, Senator Patrick. If I could just ask you to confine
just congratulating
your
the Secretary for some good work.
If I could just ask you to confine your participation to asking questions of witnesses, please.
Sorry,
Senator Patrick.
Sorry, Senator, can I be clear, because I missed a bit of the exchange. Were you being critical, if I can just ask, of
Not
any
of you,
other...
No.
Of Home Affairs releases?
No, not of you, no.
Thank you.
I was congratulating you. I think you've done I think you did a good job.
I was using that as a swipe at someone else.
Okay, I got it. Okay.
I'm demonstrating a contrast, but your conduct is excellent in relation to that, Mr Pezzullo. Thank you.
You've had occasion to be critical of me before, so
yeah,
I'm
swings
delighted
and
that we've lifted in your eyes.
Okay. Just in relation to the brief that was provided, one of the top events on the briefing was widespread flooding,
yes.
indicating would be more likely.
Yep.
I just want to understand the process here in relation to National Cabinet receiving advice and then what flows through from that advice to the ADF, to other agencies, for example, in terms of the response. And I guess, just to be clear, I'm going to go to the response in relation to South Australia that had some severe flooding, and then the reaction times to, for example, get Air Force aircraft up to Cooper Pedy. And I know that's an Air Force question, but
understood.
I'm just trying to work out how this works.
Unless the Minister wishes to say anything initially, I might just hand straight to the Director General.
Yeah, absolutely.
Director General.
Thanks, Senator. Thanks for the question. And just to put that briefing in context, we undertook about 29 briefings across the country, very, very similar to that. Pretty much the pack that you received was public, was pretty much out in the public. So we ran a series of briefings with each state and territory first, of course, and basically that's to engage with them so that We provide the national picture, and then they provide the context from within their specific jurisdiction, because, as you know, within the Constitution, states and territories are required to undertake crisis and disaster management. We also, though, in addition, did briefings for industry. We did briefings for charities. So we went very, very wide with our briefings, very, very similar information. The other thing is within the Australian government as well, we did specific briefings. So this is going to your question around ADF and other departments. So we undertake specific briefings, and then each area starts to prepare itself and posture itself in line with the briefings that we provided. And then what happens is then, and as you would recall, that was an outlook, based on the data and information that we actually had. And when you actually look at what was realised, sadly, it was, sort of quite close to that. We had widespread flooding, we had cyclones. Unfortunately, we also had a tsunami that actually impacted, and then we had concurrent fires in WA with a significant COVID overlay. So, you start to look at that, concurrent and complex arrangements, and the consequences of those becomes quite challenging. What happens then? So that's in terms of preparedness. We also run a bit of a poll when we're running those, not with National Cabinet, because National Cabinet we didn't actually physically brief National Cabinet. It was, the brief was provided, but we run a poll around estimations of how well prepared, and across the country, all states and territories, emergency services departments felt that they were well prepared for what was coming, excluding the complexity of the COVID overlay and Omicron coming on board. So that's the posture of preparedness, and everybody was well aware there was the potential for widespread flooding, so therefore ADF would posture, and the reason I can speak on behalf, I'm not speaking on behalf of ADF, but I'm speaking about the arrangements, how we work hand in glove with ADF to make sure that they are postured. Then when we go to specifics, the specific events, then we work very closely with the specific jurisdiction, because the jurisdiction is the one that makes requests of the Australian government for support. I'll probably stop there.
Okay,
thanks.
but so I'd just like to go to this to a specific event, and that being the flooding in Northern South Australia, and obviously we saw cut-offs to Western Australia in terms of the Indian Pacific, and also the train line to WA, but also the road to the Northern Territory. Can you just tell me what EMA's involvement was in relation to that event and any response that took place, and, for example, how the Air Force ended up getting involved?
I think it was an incredibly successful operation to get 20,000 tonnes of frozen and fresh food into the stranded population at Coober Pedy in particular, and hats off to the EMA.
Is in no way a criticism, I'm just trying to understand how it worked.
So Senator, how it works, obviously initially South Australia responds. It was an incredible event, more than 200 millimetres of rain in very localised areas. Many records were broken in relation to rain, and then of course happened to land or happened to flood in a particular area that impacted on both East-West Rail, North-South Rail and the Stuart Highway.
In all of Australia. Yeah. All that water had to go onto that one end.
And as I said,
that's our luck at the moment.
As I said, records broken in terms of rain in that localised area. The response then is for South Australia to respond to initially, and they did many rescues, warnings, etc. The role of EMA and the national level is to work very closely with South Australia. So we were monitoring. I was in touch with the chief officer and the police to see whether they required any support, and at that stage they did not require support. What then happened once that obviously the initial rainfall occurred, Then, as you would recall, there was further rain that was coming within that week, and there were concerns around further flooding. What it did do, though, is it damaged the railway, and it flooded the Stuart Highway, and therefore effectively north-south supply chain and east-west supply chain was cut off for a period, and we worked very closely with South Australia and established the NCM that was focused, so the National Coordination Mechanism that was focused specifically to Cooper Pedy. We were in very, very close contact with South Australia, so they were monitoring, and we also work very closely with the supermarkets because ultimately they know their supply chain. They're the ones that actually deliver the groceries, and in particular essential groceries, and they were monitoring. In the first instance, they got supplies in through road, where they managed to get supplies in, and then it was realised that it was starting to reach a critical factor. Immediately that we got the request, in actual fact I think it was approved within 3 minutes by the Minister. We got the request for assistance in through the Minister into ADF, and then supplies started flowing very quickly thereafter. And that
what was the
continued.
time frame between those, the Minister's approval and getting an aircraft dispatched, or at least on its way to Edinburgh?
I'd have to have a look. I think it was within 24 hours, Senator, but I'd have to confirm that. It was fairly quickly.
And this will be my last question, Chair. Can you just advise me what Commonwealth resources were thrown at that particular incident?
Well, the aircraft was thrown at it. That was the primary thing. We had offered other resources, but as we said, it's up to South Australia to make those requests. Another thing that we did is with the Australian Rail Track Corporation, which owns the east-west rail line, we actually embedded ADF officers to see if they required engineering support. They did not require engineering support, so therefore there was no requirement. But pretty much we had continually engaged with our South Australia and said, what support do you require from, and this is non-financial support, so this is capabilities such as ADF or other requirements, and that's what they requested at this stage.
All right, thank you, and thank you for the job that you did.
Thank you very much, Senator Patrick. We are due to take a morning tea break, but if everyone is happy, I am going to give the call to Senator Watt, who's got a few more questions on emergency management, because the Minister also needs to leave very soon. So if I can give the call to Senator Watt, who's promised he'll be as quick as he possibly can. Over to you, Senator Watt.
I will, thanks, Chair. Just sticking with the aerial firefighting strategy, we've talked about the large aerial tanker. One of the other recommendations in the strategy is for the acquisition of additional Type 1 rotary wing helicopters, and in particular acquiring them from the Defence Forces when they become available. Have any additional Type 1 rotary wing aircraft been acquired for the national firefighting fleet since the publication of that strategy?
Senator, again, the NAFC and the Commissioners and Chief Officers make that decision. They're currently looking at the range of Type 1 helicopters that they use. Many would be aware of Elvis, or colloquially known as Elvis. There's been many, Gypsy Lady and many other types of aircraft similar to that. But they are now looking at more contemporary aircraft that meet Australian needs. So they are looking into that. The point around defence aircraft is a complicated one when you actually take them out of defence and then get them certified for civilians, and that is an ongoing discussion through NAFC. I can't give you the specifics around additional aircraft. Senator, I think the key thing is, from an Australian government perspective, with the exception of the large air tanker, we do not prescribe what aircraft that they actually either procure or lease. What we do is we provide the funding for them to actually have the appropriate fleet, and you heard the Minister actually roll out the sort of fleet. And the other thing just to put in context as well, with the grant, we have also put an additional requirement in there that they work closely with Australian industries to get Australian industries involved. Now, that's going to take some time, but that's specific to the grant requirement. So we put certain conditions around the grant, but we do not specify the type of aircraft. So that strategy really, it belongs to NAFSI and the chiefs.
Understand that. I suppose equally, this is the only place we can ask these types of questions. I understand you might not have that information at hand. Would you mind taking on notice for us whether additional Type 1 rotary wing aircraft, which is a clunky way of saying helicopters as I understand it,
big helicopters,
have been acquired since the publication of that strategy?
Yep, will do.
And also...
Just to be clear, Senator Watt, by the jurisdictions themselves?
Yeah,
and
yeah.
Okay, yep.
And I suppose also whether any funding has been provided to do so by the federal government. Has EMA had any discussions with NAFSI or Defence to facilitate the acquisition of these helicopters?
There has been some preliminary discussions. I mean, we don't get front and centre in that. Basically, we connect the relevant areas of the jurisdictions that are interested. I'd have to get some further information, but NAFSI did go out to states and territories and see which states and territories were interested in that option. And there wasn't a huge take-up, but I'd have to take that on notice,
okay,
Senator.
Thank you. The last set of questions I had is about retardant and suppressant, fire retardant and suppressant. And again, one of the recommendations in this strategy from NAFSI was that retardant and suppressants are manufactured in Australia, creating sovereign reliance, and stocks are held by states and territories and monitored centrally through the NRSC. What has happened since the publication of that strategy to manufacture retardant and suppressant in Australia?
So NAFSI were tasked with taking that specific on board and working with industry to look at the feasibility of actually producing it in Australia. That work is continuing. So there has been work on it, but that work is continuing.
Okay, but there isn't any of it being manufactured domestically at this point in time?
Not at the moment. The reality is that there's not a huge market for it at the moment because there's significant stocks still in place from Black Summer.
Yep, okay. That's it for me, Chair. I know Senator Grogan had a few questions here as well.
Thank you very much, Senator Watt. Senator Grogan, do you have questions in relation to emergency management?
Yes, I do.
All right, if you could just keep your questions as tight as possible.
Thank
you so much. Over to you, Senator Grogan.
Thank you. Thank you. The situation in Coober Pedy, I just want to clarify from what you've said, because there was some issues that it was a week before fresh produce was brought in. So can you give us the timelines on the point of time that South Australia actually sought some assistance?
Okay, I haven't got the exact date, but if I can I can articulate sort of the approach. So first of all, the supermarkets who do the supplies were continuing to undertake those supplies, and we were collectively monitoring, seeking feedback from the supermarkets whether they required any support. Then the next phase was that it was identified that Coober Pedy was having some quite significant supply issues, and that's when South Australia, under specific arrangements... Sorry, the other thing I should have added, that South Australia then made a major emergency declaration that changes the arrangements quite significantly in South Australia. So they then got trucks in overnight, and then they realised that that was still not going to meet the requirements, and that's when we got the request for ADF support and pretty much actioned that straight away. I don't have the actual...
We'll need to take the timeline on notice.
Yeah, I'll take the timeline on notice.
If you could take that timeline on notice, that would be really helpful.
If you don't have the details to hand, we'll take it on notice.
Great. I'm concerned that South Australia didn't seem to think they needed any help when there was a lot of concern on the ground from residents about how things were going. The other issue that came up during that period of time was the issue of private flight, the other aircraft not being able to land by nature of the flooding.
and that they would have been able to land helicopters. So I guess this kind of comes a little to Senator Watt's points about how many helicopters you've got, what that sort of mix of emergency management aircraft that can be deployed. Could you just take on notice to advise us what that fleet looks like across South Australia, and where, in those situations, whether other aircraft can be brought in to assist?
Can I just, for point of clarity though, just for the senators, the questions that Senator Watt had were very specific to firefighting aircraft.
Yeah.
So they are of a specific.
Yeah, and
so they are modified and not necessarily designed for the purpose that you're highlighting. Those options would be looked at, whether it be commercially or ADF, what those requirements were. But we seek advice from the South Australian Emergency Services.
No, I totally understand that and appreciate what you're saying. But if you could provide me with any further advice about what the options are there, that would be really helpful.
Yes, of course, Senator. We'll get that information to you.
Thank you. And my third question is about resilience. Obviously, a lot of the commentary around what happened in South Australia, obviously it's not a common occurrence, but we are advised, given changing weather patterns, that this is likely to be an increased scenario that we're going to have to deal with. So my point really is in terms of preparation and planning. A lot of the situation we saw in Port Augusta, particularly, was that their pumping stations were insufficient because they're not used to that sort of flooding. We also had a situation where a couple of the pumping stations did not work because the power went out, and they're totally reliant upon mains power. And there is no generator backup. In your emergency management, future-proofing, planning, is there consideration of this type of infrastructure in places like the outback in South Australia, where, while we're not seeing frequent circumstances, when they do occur, they are incredibly significant?
I just first will say the government's highly aware of the need to build resilience into our infrastructure, our sovereign capability, and a whole raft of issues, not just in response to changing climatic patterns, but indeed the global pandemic and a whole lot of a suite of issues that really in the recent years have become more and more apparent and acute. I'll hand over to Secretary Pizzullo for what he's doing in his space.
Thank you, Minister. Both the Defence Force, the Department of Defence, and ourselves in Home Affairs and Emergency Management more particularly feed into the National Resilience and Recovery Authority, which is in the Prime Minister's portfolio, the NRRA. The way we've split the responsibilities, this is a government decision that flowed from the Royal Commission that was headed up by retired Air Chief Marshal Binskin, was it would be better to have an authority that focused on long-term planning, long-term recovery planning, and obviously the, how shall I put this, Director General, the more short-term response functions are better vested in operational agencies such as Home Affairs and Defence. I can give you every confidence, though, Senator, and the Director General might give you an example. There are feedback loops, though, built in so that if we learn something about a particular crisis, if we learn about how in responding to a particular crisis there might be learnings for long-term planning, there are feedback loops, to use that term, that then loop back around to the NRRA. They then have a responsibility to build long-term resilience, recovery and reconstruction plans. If you will, we're the first responder along with Defence, and then at some point when the roadblocks come down, when the emergency is lifted, the recovery and reconstruction efforts roll in. That's what the NRRA does. But ahead of the crisis emerging, more resilient infrastructure, more disaster-proof infrastructure is a function of both the NRRA working with jurisdiction, so there might be the Department of Infrastructure, the Department of Transport. I think you refer to a power station that would relate to the Australian Energy Operator and the Department of Energy. So we would feed in our learnings, but it's very much the NRRA's role to lead on long term. Is that
and
is that a fair?
And look, I'm happy to
later
take
on tonight.
Yeah,
so
I'm happy to
if you've
take
got
those
that,
questions elsewhere.
Tonight, come and see me.
Thank you.
And I think I've got the point about feedback loops.
Absolutely,
correct,
Secretary.
Yeah. Thank you.
Thank you very much, Senator Grogan. We will now suspend for morning tea until 11:01. Minister, thank you very much. That has concluded the committee's examination of emergency management So we do appreciate that, and we will suspend and return in 15 minutes.
Thank you.
Good morning. The committee is now in session. We are continuing with the Department of Home Affairs in relation to outcome 1. And I give the call to Senator Keneally.
Thank you so much, Chair. I'd like to go back, if I could, to the stress test, because I do think it relates to both emergency management and this outcome. Secretary Pizzullo, you mentioned the minister was aware of the stress test because you believe you discussed it with him.
I recalled his awareness, but I said I was going to check.
Was he actually? Did he actually participate?
No,
in the stress test?
No, it was an exercise conducted within the public service amongst a number of agencies. I've given evidence. I'll have to recall which session of estimates that it was one of the areas that I thought the clinical side of pandemic planning, on my judgment, was not as fully developed as our clinical response plan. So when we came together as a department established in December of 17, we commissioned some early work, working with our colleagues in health, obviously, on what I would describe as the non-clinical aspects of pandemic response. It was called a stress test, but essentially it's a scenario-based exercise where officials come together in what is colloquially known as a desktop environment.
So just to clarify, that was 8 department and agencies, as I understand it?
There were a number. I'd have to refresh myself. There were certainly a half a dozen, perhaps 8, indeed.
Yeah, I think the ANAO report suggests it was Home Affairs, Health, Attorney Generals, AFP, Agriculture, Water and the Environment, Defence, Foreign Affairs and Trade, and Prime Minister and Cabinet. So
and Health? Sorry,
yeah, I said Health, yes.
And Health in that list, yeah.
And so the Minister's office and the Minister himself, like the Minister's Chief of Staff and Press Secretaries and Advisors, they weren't involved?
No.
No.
In the actual exercise itself? No.
Yes, in the actual exercise itself. We have canvassed as the...
And I should be clear, it wasn't real world, so sometimes you can do an exercise
Yeah, I understand.
that's real world, or sometimes you can review papers and do what's known as a desktop against a scenario.
So we've already canvassed that the Australian National Audit Office report says that the Deputy Secretary wrote on the submission that it would, quote, highlight significant concerns not being or not able to be addressed. Are you able to tell us, is that Deputy Secretary still at the department?
Oh, it goes back, I'd have to look at my organisational arrangements 4 years ago and just confirm.
Do you know who the Deputy Secretary is?
No. Who annotated that? No. Are they identified in the report? Because
They are not identified in the report,
the answer
hence
is
me asking you the question.
Understood. No, thank you. No, I don't recall. It was whoever was responsible for the function in February, March of 18, or thereabouts. I'll check. I'll come back to your notice.
Well, sorry, correct me if I'm wrong. The stress test was, so the stress test was in 2018.
Yes.
And the submission, this notation, was in 2018 as well on the ministerial submission.
I'd have to confirm that.
Right.
I can't recall.
So earlier you said that...
So we did, sorry, two different things at play. There was a contemporaneous conduct of the test, the exercise, and its reporting or non-reporting to Minister Dutton as the then Home Affairs Minister. I've taken on notice. I'll just check the sequence of events and whether there was any other form of briefing, for instance, through a regular weekly reporting that I give him.
So this is according to the ANAO that the Deputy Secretary, who is unidentified, and you've just said you don't recall who it is.
I'd have to check the organisational
For
arrangements.
clearing the ministerial submission, never provided the submission to the Secretary, or the Minister, Minister Dutton, because it would highlight concerns not being or not able to be addressed. And you don't recall who that Deputy Secretary is?
I don't, but more importantly, and I'm not sure how the quotation is rendered by the ANAO, I think the concern wasn't so much, gosh, this is bad news, let's withhold it. It's more along the lines of how do we solve this problem? And the solution was the modification of the National Crisis arrangements and the formation of the NCM, which was quickly activated 2 years later in March of 20.
Well, I think the ANAO finds that, in fact, it was withheld from you because it contained information.
Well, they might well be of that view,
That
and
was-
I'm not sure on what basis
that
they
essentially
call
was bad news.
Believe me, none of my deputies ever are too shy about giving me bad news.
Well,
and
you did say earlier that you were not happy about this.
No, I wasn't.
And it would not happen again. So what steps have you taken to ensure that it will not happen again?
as a matter of cultural attitude, my deputies are well aware, without always seeking permission from me, to put up submissions to ministers which are relevant to the responsibilities of ministers. In effect, we rectified the gap in advice 2 years later, in March of 2020, by not only advising on the historical work we'd done in the so-called stress test or the desktop exercise, but we acted on the internal apparatus that we thought would be fit for purpose, which is the initiation of the NCM, which was quickly agreed by government in March of 20.
Yeah, let's talk about that fast forward to 2 years later. We're
Yep.
in a pandemic.
Yep.
And on the ANAO report actually cites on 1 February 2020, in correspondence with the Prime Minister, the Home Affairs Minister and the Cabinet Secretary, you say that Australia's whole of government civil contingency planning was, quote, outdated and not fit for purpose. Do you recall writing that?
Yes,
And so how is it your contention that between the stress test
Because my
and the
advice-
arrival of a pandemic that somehow you fixed the problem?
because we had a ready-made solution based on the 2 years warning that we'd given ourselves as to what we needed to do to quickly modify the
2
national...
years warning that you hid, that was hidden from you and hidden from the minister.
The work known as the stress test was initiated by me, was reported to me, it was well known to me.
The submission wasn't reported
Well,
to
the
you.
submission-
It was hidden from you.
There is a gap in our procedures insofar as when you advise ministers, you should always do so formally by way of submission, and for that I regret that we did not provide Mr Dutton with written advice.
But it's even you. You weren't provided with the submission.
Again, I'm distinguishing...
As the ANAO found.
Senator Keneally,
I just
if you could just give
I'm
Mr Bozzillo the
distinguishing
opportunity.
between-
Sorry, Mr Bozzillo, if
Sorry,
just Senator
Chair.
Keneally could give you the opportunity just to complete your answer. Thank you.
I'm distinguishing between, and this is absolutely central to the responsibility of senior public officials to formally brief ministers on substance in writing. I absolutely get that. That was deficient in this case. It should not have occurred. As to the substance of things like, I can assure you, Senator, because I was in all the meetings, in March of 20 and February of 20, our alternative repurposed crisis arrangements did not fall on ministers from a clear blue sky. They in fact said, excellent, you've done the preparatory work, let's modify our crisis arrangements, which typically have evolved over 20 years from a counter-terrorism point of view, and let's quickly institute your recommended mechanism, which is the NCM. Good work, thank you for your contingent planning. Should we have,
Great, when
2
people
years
went
earlier...
to the stores 3 weeks ago, there was empty supermarket shelves.
Should we? That's a different, but that's the evolution of the pandemic subsequent to March of 20. I mean, we're sort of doing some time jumps here. We came together as a department. We tackled head-on the possibility of having to put in place logistical, supply chain, supermarket and other issues that might flow from a pandemic. We picked that right 2 years earlier in February of 18. Should we have written it up as a submission to the minister? Absolutely.
And so what have you done to ensure that that won't happen again?
In terms of advising,
No, in terms of your internal processes. I mean, you asked for a submission, you never got it. Did you not wonder where it was?
over the 4 years that I've been running this department in this form, I would be confident to say that that was a one-off.
One more minute, Senator Keneally.
You're confident it's a one-off?
I would be
What have
confident
you
that it's
done? You don't even know the Deputy Sec who withheld it
I'm
from you.
saying I can't recall to
You
mind
can't recall.
which one it was.
You said you were displeased, but you've taken no steps to ensure this doesn't happen
I've
again?
taken steps, so I can be blunter. Whenever there's a process failure like that, all of my deputies are briefed on my displeasure. It's mutually reinforcing.
But you don't even know which deputy it was. I'm sorry to be
It's a group
incredulous, but I find that hard to believe.
My concern and my remedy in relation to that concern is conveyed collectively.
Would you want me to read a list of your deputy secretaries out from 2018?
No,
Would
I've
that
taken on
assist
notice.
you?
I'll come back and give it to you on notice.
There's only 18 of them. I find it hard to
Senator
believe
Keneally,
that you can't recall which one it is.
once the witness has taken a
Was it
question on...
Mr Knuckles, by
Senator
any chance,
Keneally,
was
can I
it?
just
wasn't
hold
at
you
that
there
rank.
for a minute? Just to make it clear to all senators, once a question has been taken on notice,
Thank you.
You do need then to move to your next question. So, Senator Keneally,
Sorry,
do you
I
have
need
your
to
last
correct my-
do you
I-
have
I
any
need to-
last questions
I just
before
need to
your time?
correct, there are fewer
Sorry,
than-
Senator Keneally.
No, I need to correct my own statement.
All right,
I
we've got one more
apologise,
minute
Chair.
if you could just
Yeah,
quickly
there are
do that.
fewer, in fact, than 18 DEP secretaries. It wouldn't take me long to read them all out.
And I've taken on notice the identification of which deputy who made the decision.
And can you please
not-
also take on notice what action you actually took to ensure this doesn't happen again?
Well, I can tell you what the answer on notice will be, that I made it collectively clear that when I ask for a submission to be prepared, it's prepared.
But it wasn't.
Senator Keneally, we will need to leave your time here. I'm
Thank
now
you,
going to give
Chair.
the call to Senator Scarr.
Thank you, Chair. Thank you for that. Mr Pizzullo, I've got some questions in relation to cybersecurity and ransomware. Is there anyone you'd like to bring to the table for that?
Why don't you start asking your question, and Mr Ablong will take the opportunity to preambulate towards the desk.
Okay, so whilst he's perambulating...
That was a very short preambulation.
Maybe it's more than perambulating. If I can ask firstly, the government introduced a ransomware action plan to address the issue of ransomware. And I think previously this committee has asked questions in relation to matters such as the ransomware attack on the owners of the Colonial Pipeline in the United States, a critical piece of oil and gas infrastructure in the United States. There's a lot going on in the international scene at the moment, and I'm very keen to obtain an update from the department with respect to firstly, how you perceive the current threat around ransomware and cybersecurity generally, and secondly, where the department's up to in relation to introducing the ransomware action plan in particular.
I might commence in the broad and then hand to Mr Ablong, who's the relevant Deputy Secretary who covers cybersecurity, obviously working in close partnership with our colleagues at the Australian Cybersecurity Centre who are responsible for operational and technical responses. But in terms of policy, legislation and regulation, Mr Ablong is the lead deputy. On cybersecurity generally, obviously we're coming up to 2 years into the government cybersecurity strategy that was brought down in 2020. That has a number of limbs. One of the limbs relates to ransomware, but if I can just make a few comments more generally before we get to ransomware. The partnership that has evolved since both the 2016 cybersecurity strategy, but more particularly since the 2020 cybersecurity strategy, is now locked in and very much foundationally built into our procedures. We lead on policy, regulation, and where necessary legislative change, and our colleagues at the Australian Cybersecurity Centre, which is an integral part of the Australian Signals Directorate, lead on engagement with affected parties, be they business parties, advisories to the community at large, but they also undertake cyber operations as the lead technical and operational agency for the government at large. With the passing of the Security Legislation Amendment Bill last year that relates to critical infrastructure, the ASD now, through the Australian Cybersecurity Centre, has a emergency response capability known as a government assistance measure where in extremis, and obviously you'd want to have exhausted, as the legislation indeed requires, but you'd want to have exhausted all other possibilities. So in a pipeline attack, the one that you mentioned, or similar attacks, Australia now has a lawful basis for its premier signals agency. It's important, Senator, to understand that the signals intelligence part of the ASD, which we don't talk about in any particular details, but in general terms, they've got a legislated function, which I think is well known to this committee and more particularly the Parliamentary Joint Committee. They can turn that knowledge of, if you like, the actors, which they can see through signals intelligence, and I don't want to put it more pointedly than that, into defensive strategies using defensive weapons and defensive techniques. Now, typically, they were able to use those systems in support of government networks, but now with the passage of that legislation last year, and obviously as officials, it's not our place to be grateful to the Parliament, but I'll just say it anyway, we're grateful to the Parliament for providing those powers, because now in extremis ASD can come onto networks with very strict safeguards about privacy, very strict safeguards about the protection of Australian citizen data on those networks, and if you like, if I can use this term, fight in defence of those networks in extremis. Last week, Minister Andrews introduced the second key piece of legislation that is also pertinent here, the Security Legislation Amendment Critical Infrastructure Protection Bill 2022, which would also give, in a similar way, the ASD the capacity to come on in a precautionary or preventative fashion, to come onto networks under strict legal controls where relevant designations have been made, to monitor things like telemetry, to monitor things like anomalous signatures that are coming onto networks, be they banking networks, energy networks, telcos and the like. So we're working in partnership with the Australian Cyber Security Centre through our Cyber and Infrastructure Security Centre to ensure that all of the relevant designation material that we might need, should that bill be passed, of course, all the relevant designation material is available to put before the Minister for Home Affairs, who under that law would be the designating minister, and then obviously ASD would use its powers under the ISA to, if you like, defend systems both in a precautionary and preventative fashion, but also in a reactive fashion should a major incident arise. And that major incident has to be detrimental to Australia's economic well-being or to the functioning and effect of our society. So imagine if significant elements of the banking system, for instance, were taken out. So that's the general environment. It's probably, you shouldn't mark your own homework, but it's probably one of the most world-leading efforts at trying to balance the different equities in terms of legislative and regulatory frameworks, putting government capabilities onto relevant networks, but not allowing the private operators of those networks, if you will, to defray the risk back onto the Commonwealth. So it's those balances that those two particular bills, one bill now an act, the other bill before this Parliament, provide for. That's probably the headline or flagship in terms of making our cyber infrastructure more resilient, of protecting the most essential networks in the land.
Is it possible just to narrow down, if you like, the incremental benefit of the second tranche of the legislation when it comes through? So what will that give us, or what will, as a government, as a community, what will that give us that the first tranche hasn't given us? What's the incremental benefit?
So as the Minister made clear in her introductory material, so it was last week, wasn't it? Yeah. So in both the Minister's second reading speech and the explanatory memorandum, what's explained there is that the additive benefit you get from taking precautionary steps, working in partnership with the 11 critical infrastructure sectors, there are 11 that have now been designated under law under the first bill. ASD now will have a lawful capacity to both share information in a more timely fashion, to have reporting, should certain systems be designated as systems of national significance and the like, to have more timely, legally obligated reports provided to them. We are very conscious as the regulator, so we act as the regulator, ASD act as the operator. We're very conscious in not overburdening industry with additional costs, so CEOs and boards still have to make their own judgments about how to remediate some of the risks that are constantly being unearthed through intelligence sharing, through risk assessments, through the work that their own cybersecurity providers undertake. What this will provide is a standardised framework for both risk management reports to be provided, initially within companies, so the risk management reporting to the CEO then to the board, and having to provide then assurances back to government if required that risks have been mitigated to the maximum extent possible. Up until now, we haven't had common nomenclature, we haven't had common reporting cadences, we haven't had common reporting thresholds. Should the second bill pass, and obviously we're in the hands of the Parliament, what that will do is provide a standardised framework for both regulating and operating across the 11 designated sectors. Obviously there's a larger general economy which is not covered by the 11 sectors, but those 11 sectors are so fundamental to, if you like, enabling society, enabling the economy, the ability to conduct financial transfers, the ability to have assured power supplies, energy supplies, the ability to have our port and air aviation infrastructure functioning. All of those things have typically been dealt with either under pieces of legislation that are particular to that sector, or in some cases they haven't been regulated at the federal level at least. So to take an example very briefly, urban water and sewerage, very well regulated at the state and territory level, at the municipal level in some cases, with regards to things like water quality or the continuity of clean water supplies, but really no common framework for things like protecting our dams from cyber attacks, for instance.
1 more minute, Senator Scarr.
So I'm sorry, Senator, I haven't left Mr Ablong much time to speak about ransomware. Ransomware then is a particular attack methodology, but I just wanted to sketch out how the broader regulatory framework will work. But you might want to add some remarks on ransomware.
In 30 seconds, I can try and do that. Senator Mark Ablong, Deputy Secretary, Strategy and National Resilience. So just in terms of the threat, the most recent annual cyber threat report from the Australian Cybersecurity Centre showed that ransomware remains one of the most disruptive threats to Australian organisations. Last year, in the 2020-2021 year report, Cyber received almost 500 ransomware-related cybercrime reports, an increase of 15% over the last year. And in February of this year, 9th of February, a joint cybersecurity advisory report issued by Australia, the United States and the United Kingdom observed an increase in the sophistication, the impact of ransomware incidents against critical infrastructure organisations globally. So ransomware is definitely one of those things that is very much in the headlines. In terms of the ransomware action plan, you'll recall that the major parts of that related to legislative reforms that would require both additional criminal offences for those who seek to perpetrate ransomware. Those legislative reforms are being finalised as we speak and should be available to the Parliament shortly. We will progress criminal law reforms to ensure that all aspects of ransomware business model can be attacked by law enforcement, including new standalone and aggravated criminal offences in relation to undertaking a ransomware attack, extending the AFP's legal authority to investigate those that impact Australians that originate offshore, so not just those that might be undertaken by Australians, and ensuring that law enforcement can track, freeze and seize cyber criminals' ill-gotten gains through amendments to the Proceeds of Crime Act and the Criminal Act to relate to cryptocurrency. Nothing that we do here in Australia is going to solve the global problem of ransomware, other than working with partners, and Australia is part of a 31-country counter-ransomware initiative that involves a number of countries: the United States, the UK, Ukraine, Sweden, the Netherlands. The list is extensive. There are 4 main bodies of work going on, and Australia leads one of those bodies of work. We lead a body of work that's about how do we disrupt the business model of ransomware. There are other lines of effort that relate to how we better establish cyber norms in the international environment to deal with those who might provide safe havens for ransomware gangs internationally. And there are some other lines of effort that relate to how we better share information between jurisdictions that would allow us to tackle ransomware that crosses multiple jurisdictions.
If I might be permitted just to add a 20-second epilogue. Senator, I think between the two of us, we've demonstrated you've got to go on the offence, which is where the government's ransomware action plan takes you, but you've also got to play defence. That is to say, you've got to mitigate the risk as much as you can, because today the attack vector is ransomware. The criminal and state actors who use ransomware will, once they're thwarted, will then find another way in. So you've got to both defend your systems and harden your systems, as well as go on the attack against the actors. Thank you.
Okay, and the relationship with the private sector, the lines of communication with businesses that are operating critical infrastructure that might be targets of ransomware attacks, that's developed now.
It's quite mature. There's been an evolution of critical infrastructure information networks that have been basically on foot for about 20 years. They started probably in terms of terrorist attacks, and over time we've evolved them into an all-hazards network. Very deep and mature relationships, typically, Senator, with companies that have got deep IT capability, CIOs who are switched on to this problem, chief information security officers. We are thinking about how to better support the general economy across, along with our friends in ASD, because not all companies have got the depth of sophistication in terms of managing complex networks, but certainly in relation to critical infrastructure, very well developed relationships.
Okay, thank you very much.
Thank you very much,
Chair.
Senator Scarr. I now hand over to Senator Patrick.
Yes, thank you. Thank you very much, Chair. Just got some questions in relation to transport security. I asked questions of Ms Patterson last time around. Really, I'm just wondering, we appear to be transitioning out of a COVID response. There were responses in place in relation to airport security, so funding was being met by the Commonwealth. I wonder when is it intended that funding will stop? And my interest in this matter has been related to regional airports and making sure that they don't bear an unfair portion of security costs. So just really after an update in that space.
So Mr Hansford will join us. Mr Hansford manages the centre I was just speaking about, which is a cyber and infrastructure security centre. Transport security falls under his remit. Mr Hansford.
Okay. Thank you, Senator. Hamish Hansford. I'm the head of the Cyber and Infrastructure Security Centre and a group manager in the department. So a couple of issues. The first issue relates to the change in security requirements that I know that you're following, particularly in relation to regional airports. The government did commit funding in 2018-19, $50.1 million that the Department of Home Affairs administered, principally in relation to upgrading capital issues. Subsequently,
I was going to ask you to remove your mask. It's sort of an odd look.
Subsequently, the department and the Department of Infrastructure funded a joint economic analysis of regional airports undertaken by Houston Kemp, and that analysis also received primary information and data from regional airports. The departments received that information on the 7th of September last year. We're analysing the information. We did provide advice in my context to the Minister for Home Affairs on the 5th of November last year, and she considered that on the 8th of December last year. I can't speak to the Department of Infrastructure's provision of advice to their minister. So we are looking at the economic analysis. At a high level, given there's a lot of corporate material and data in that analysis, at a high level, it does say that the capital cost is a high fixed cost for running regional airports, and a lot of the capital costs were covered in the 2018-19 funding that I mentioned, and there are obviously ongoing costs of screening, which are a variable relating to labour costs within individual regional areas. You did mention the COVID-related funding, which continues to occur, principally related to the Department of Infrastructure, so I'd refer to them to talk about the detailed programs that they run, but I just make the point that regional airport screening infrastructure is covered by those funding arrangements from the Department of Infrastructure, and we are in constant contact with the Department of Infrastructure to both marry up our role in provision of security advice, including security advice about regional airports and tiering and requirements, and our regulatory and compliance role, and their role in managing Australia's airports, including regional airports, because regional funding, security is one component, but regional funding of airports has broader programs and broader support mechanisms that the Department of Infrastructure administers.
Okay, so I'm satisfied that the $50.1 million was spent on infrastructure, particularly screening equipment. However, during this transition or the decision-making process, it was identified in those studies, and I'll use Whyalla as an example, of the order of $52 per ticket for the screening costs. If you've only got few aircraft, and you have to run multiple shifts, the cost is very, very high. Now, Senator McKenzie made a statement in the chamber when I was when this regulation was subject to disallowance, saying that the department would get on and find a way to make sure that we amortise the cost so that we don't have people in the regions who are already doing it tough paying those sorts of fees for travel. It kills air travel. It's the lifeblood of these regional communities. I've asked on several occasions now where we're getting to in terms of addressing that cost, and every time I get here, there's no detail. Is someone actually working on this issue?
Definitely, and the economic modelling went to the exact issue that you identify.
No, but that's a year old. That's more than a year old. What are where's the planning that says we're going to come out of COVID, the security costs are not going to be met by the government anymore, and we need to have a model in place so we don't have people in Whyalla paying $52 and people in Sydney paying 85 cents to go through security screening. We've got to change that model, and that was accepted by the government. My understanding is Minister Dutton made an agreement with Senator McKenzie that we would not permit that to happen. Is that not the case? Is there a direction in the department that's seeking to make sure that that doesn't occur?
Right, so Mr Hansford advises that there is no direction that we have. I mean, I hear what you say, Senator. You heard certain statements made in the chamber. I can't speak to that. But do we have any current government direction that, in summary, is addressed, as raised by Senator Patrick, would, if you like, equal out the cost across airports? Or is it something that government is yet to consider formally?
Something the government's yet to consider.
Thank
though
you.
I do say that we did provide advice to at least my minister, Minister Andrews, last year on the issue. We continue to work with the Department of Infrastructure, noting that they are continuing to roll out funding programs in relation to regional airports.
So I wrote to Minister Andrews and got a response in the last couple of weeks.
Yes.
Again, that seemed to avoid this fundamental issue. We do not want people. Ultimately, what happens in the end here is the cost is borne by a local council, who either have to bear the cost through ratepayers, or alternatively, put it on a ticket price. And this is a national security issue with emphasis on the word national, and we're asking people in regions to pay that cost. And if you tell someone in Whyalla that their air ticket is going to go up $52 per flight, that is going to kill off air travel. It's going to put more people on roads. It's going to be dangerous. And I've had this discussion, and now I'm discovering that, in fact, no one's actually working on that.
I'm not sure that's what you're being told, Senator. We understand the nature of the problem. Where is the government decision process at, to the extent that you can disclose that here? It's not a decision yet taken to defray, amortise, flatten, whatever verb.
And I presume that relies on advice from infrastructure and from you guys.
Quite. So as Mr Hansford said, some economic modelling was commissioned, options presumably derived from that modelling. It's been put to our ministers, two ministers in this case. Are we in a budget process or not? Okay, we're not in the budget process. That's the evidence. So, I mean, I can't be any blunter than that.
No, I appreciate your honesty, but
we've provided the modelling.
I'll now go back to the Minister then. Minister, this was a commitment made, there was a disallowance in relation to the instrument that dealt with this, and the purpose of that disallowance was to bring attention to the problem that the regions were suffering. I remember Mr Joyce appearing at or getting involved in this. Senator McKenzie walking into the chamber and saying, we've reached an arrangement with the government whereby we will make it much, much fairer. We will not burden the regions with these high costs. Ultimately, people don't take off out of regional airports and conduct a terrorist activity in the regions. They fly to the city. And you're going to have people bearing, in the regions, bearing the cost of protecting people in the cities.
Senator Patrick, I understand the point that you're making, and look, I agree with it in substance. And I think, as you've referred to, there are plenty of statements on the public record to say that that is something the government is committed to achieving. The reason you're not getting the answers that you're looking for from this group is that it's being dealt with through the infrastructure portfolio rather than through the Department of Home Affairs. And so if you direct your questions there, you'll get a lot more joy than you're getting here.
Well, what I find, and I've done this in the past, is that I get told that the lead, that Home Affairs are the lead on this.
Well, those are my instructions.
Senator Patrick, sorry, Mr. Pizzola, we've just got 1 minute
Sure.
for your block. Do you have a final question, Senator Patrick?
Well, I'm trying to get an answer to this. I appreciate Mr. Pizzola trying to help me here.
If it's been stated to you that we're the lead, that's certainly the case. We're the regulator. We've got legal authorities to impose the transport security standards. When you impose a standard, sometimes that has a consequential impact in terms of cost. I'm not familiar, Mr. Hampton,
And the problem that our RAC committee found in relation to this, we did a hearing, an inquiry into the cost of regional airfares, was that in actual fact this hadn't been considered. Someone in the Canberra bubble had made a decision about security without doing that economic modelling, which then flowed as a result of the committee's work.
And in terms then of lead, I'm not aware that we're funded to, if you like, ameliorate or to defray costs. That really is a matter for our colleagues at infrastructure. So when you refer to who's the lead, we lead on the regulation and setting the standard based on intelligence and other factors.
Sure.
But the amelioration, is it fair to say our colleagues at infrastructure lead on that?
We're working with infrastructure. We jointly funded the economic modelling, 50-50, and we're working on the issue together, given our respective responsibilities.
Senator Patrick, we are going to move to other senators now. I'm going to give the call to Senator Ciccone, reminding everyone that outcome 1 is scheduled to finish at 12 o'clock. So if that's at all possible, we'd be most grateful. Senator Ciccone.
Thank you very much, Chair. Could I just ask Secretary, just to clarify from earlier this morning, just about one of the attachments I provided to you and the department. We've had images of the various homes in relation to the Airbnb line of questions that I put to you earlier. Are you able to just to clarify if any of the homes that I provided to you, and this is from the Department of Home Affairs, the property information, belong to that First Assistant Secretary?
I have no personal knowledge of that, but I'll see if Ms Saunders or someone else can assist me. And again, just on the basis that we're starting to get very close to personal identification, there might be some caveats on our evidence, but we'll see how Ms Saunders goes.
Thank you.
The short answer is I don't know, but we'll see.
Ms Saunders might know, but we'll see.
Well, and it might be that we are very circumspect about even... If any are, no.
I'm not asking which one.
Thank you.
Just to make that point clear, but if any of the ones in that attachment that I provided earlier belong to the First Assistant Secretary.
One of those properties belongs to the officer, yes.
Okay.
But I should also point out that we don't know who the owners are of the remaining properties. The only reason we became aware of this particular property being owned by a Home Affairs officer was because the Home Affairs officer came forward with that advice.
Okay.
Excuse me.
All right. And what was the date? Sorry, the date that officer came forward with that advice?
Secretary, I'll have to take that on notice if you don't mind. Thanks.
That's all right. I think you mean Senator.
I may
Senator.
have that.
Yeah, I'm not Secretary.
Sorry. My apologies.
I wouldn't want to do that to you.
Secretary, you don't want to demote the Senator.
My apologies, Senator. But if you give me a few minutes, I can probably answer that for you, Senator.
You've knocked him down about 10 levels.
Thank you. Look, whilst you're doing that, Mr Pizzullo, could I also just take you to a couple of questions I have to do with the National Coordination Mechanism?
Thank you.
Now, on the department's website, it describes the forum as to ensure that full capabilities of the Australian state and territory governments, and if required, the private sector, are brought to bear during a crisis, and the NCM will ensure coordination, communication and collaboration, etc., etc.
Yes.
Now, I wanted to table my first attachment that I provide to the Secretariat. It was a diagram, which is also from the department's website.
I'm advised
Just to, I guess, an attempt to...
the Director General Buffon has
Yep,
left.
that
but
first one. Thank you.
I'll see how I go with it.
Yep. Just so I can understand the participants and the functions of this body. So hopefully the Secretary will get that to you very shortly. I don't know. It's all right. I've got my own.
I'm in no rush.
Yes, well, the Chair does like to keep the time.
Now, on that diagram, firstly, the Prime Minister, for good reasons, probably sits at the top of that, but there's no specific mention...
Are we on the second page?
Yes, the second page.
Yep.
There's no specific mention of Home Affairs or the Minister for Home Affairs, but this forum is, I guess, in inverted commas, driven by Home Affairs, as I understand it.
Correct. So it's to be read...
Could I just finish? Sorry.
Oh, my apologies.
No, you're right. With
sorry,
its
I
mandate
thought you'd
coordinating
finished.
across Commonwealth, state and territory governments, would it not have been more effective for this body to sit within the Department of Prime Minister and Cabinet and leverage the PM's power?
Well, it's up to Prime Ministers, of course, to arrange their administrative structures as they see fit. When Home Affairs was established in December of 2017, what was then known as the National Crisis Arrangements, different C there, was in the Attorney General's Department. Don't ask me about the history of why it was in Attorney General's. It's a long history. Associated with emergency management, that function was transferred across. It's always understood that whether it's a terrorist incident, whether it's a natural weather event, a catastrophic incident otherwise, that the National Security Committee, which of course is chaired by the Prime Minister, would take charge, at the federal level at least, and the NCM, and you see the diagram there depicts the Prime Minister, National Cabinet at the federation level, then the NSC, obviously the Minister for Home Affairs is a member of the National Security Committee, and I attend as a permanently invited official, of course, and then the NCM sits, if you will, functionally under the NSC. The fact that we are the hosts doesn't detract from its authority. In fact, Secretary Gaetjens and I have got a very clear, as I had with Secretary Parkinson, sorry, I made the same mistake, Secretary Parkinson, when Home Affairs was first established, whatever they need to support the PM directly in terms of briefing, 24/7 advice we'll provide. But in terms of the machinery of convening meetings across all of those, sorry, it's hard for those listening to these proceedings, so I'm going to have to do like a radio visual, but the document I have in front of me is like a pie chart with many different components, if you will, of government functions, private sector functions, privately provided functions. To have a massive organisation in PM&C coordinating all of that rather than deferring the heavy lifting to us and then supporting the PM as we do through NSC. PM&C is copied into anything they want. They got full line of sight on anything they want. And I think if you were to ask them, they think it's a tremendous burden taken off them to not have to do the detailed machinery.
Could I just run through just very quickly some other line of questions, some basic facts about the NCM's role? And I understand there's a number of industry working groups.
Yes.
And I think you've even spoken about the NCM in its capacity to deal with some of the shortages that we've experienced, especially at supermarkets throughout the pandemic. Could you provide me with the names of the industry working groups that were established in the supply chains?
Yeah, we can.
You don't have that, or you take that on
Not off
notice?
the top of my head. The Director General of EMA, who was here previously, he must have misheard the guidance that was given. He thought that emergency management had been dealt with, but so he's left. But
all right, and also
we
how
can
many
get that
times
to you.
or how regularly it's met? Who are its regular participants? Who coordinates and leads these meetings? Who does it report to and how was industry engagement managed?
Senator, just to be clear, is that over the course of the pandemic or have you got a more defined time period in mind?
Oh, I'd like it if you could take it over the pandemic, so from when it's commenced.
Happy to do that.
My other question is, were any worker representatives, in particular unions, considered as stakeholders?
I've got a recollection. There was some very particular groups set up under the authority of the then Minister for Industrial Relations, Mr. Porter, that took on some of those issues early on. And where another body is filling a gap, NCM doesn't proceed. So But I know we were plugged into those discussions because I've got a very direct recollection. But as to other working groups, be they supply chains or workforce, I'd have to take on notice whether trade union representatives were
Yeah, because
involved.
I'd be interested to know if unions like the Australian Workers Union, the Transport Workers Union, the Shop Distributive and Allied Employees Association, unions that represent a lot of the workers in the supply chain, were invited or not to participate in the NCM's discussions.
Yeah, happy to take that on notice as part of the more general on notice.
You're not aware that they were or weren't?
I'm not aware, but as I said, there was a separate process which was synchronised with the NCM in the early part of the pandemic that Mr Porter ran with as the then Industrial Relations Minister with the ACTU. From memory, we were plugged into that horizontally, but I don't know that it was done under the auspices of the NCM, but I'll just check the records.
Okay. So the NCM was meant to report, so the NCM is also meant to report to the National COVID Coordination Commission, which is, I think, no longer...
No, it didn't have a direct reporting relationship. The bridging person was me because I was a member. I'm both the secretary of the department that hosts the NCM, but I was also on the commission.
That Coordination Commission, that doesn't exist anymore, is that
Correct.
right? Okay. And why?
Well, I was a member of it, but I wasn't responsible for either its initiation or its decommissioning.
Who made that decision?
I think it's best directed to the PM's portfolio. As a creature of, if you like, a prime ministerial decision supported out of the Prime Minister's department.
I guess without the NCCC, I mean, whose job is it to inform the Prime Minister about these issues in the supply chain?
Typically, there's a combination of the line minister, so if it's a fuel issue or a workplace relations issue, typically it's a combination of the line minister, but with the NCM supporting them. So, for instance, in relation to diesel exhaust fluid, Mr Buffone with the relevant department, in this case the Department of Energy, or the part of Industry, Energy, Science and Resources that had the lead, supported Minister Taylor. And it's really then specific as to the issue as to whether the Cabinet Minister takes the lead in supporting the PM and the NSC directly, attending National Cabinet and the like, or whether Mr Buffone does it.
NCM, who does it report to? Which minister?
It's for management purposes, the Minister for Home Affairs is, if you like, the portfolio minister, but it's a flexible tool that is deployable onto any portfolio that needs it. So it's a service, if you will, that deploys in support of another portfolio typically.
Senator Ciccone, we will need to move to other senators. Your time for this block has been exceeded. Senator McKim.
Thanks, Chair. Mr Pizzullo, I wanted to ask some questions about the tender that the government has out for identity matching services. Firstly, I wanted to ask, in regards to that tender, why is the department out tendering for this when the Parliamentary Joint Standing Committee on Intelligence and Security has rejected the Identity Matching Services Bill 2019 in no uncertain terms and asked for it to be completely redrafted? Why is the department proceeding with this tender?
So Mr Ablong will assist here, but there's two different issues at play here. One is the underlying system, if you will, or the underlying functionality, not all of which, some of which I do readily accept would be contingent on the passage of that legislation, but not all of that functionality relates to the passage of that bill. Mr Ablong, can you assist me with that evidence?
Okay, so Senator, as you'd be aware, the department has for a number of years run the document verification service and is in the process of working with states and territories about the face matching service. Those two capabilities collectively perform the role of identity matching services. The contract and tender which is out there is for an existing body of work that is done by the company that manages the document verification service and the underlying infrastructure. It's not about moving forward on the identity matching services beyond what we currently have approval for in terms of the identity matching services.
So it's not dependent at all on the passage of legislation?
No, it's not.
Okay, so thanks, Mr Ablong. So if I could just attempt to paraphrase your answer and then just ask you or invite you to agree with me or correct me. have you just given evidence to the committee that the tender that is out currently in regards to identity matching is not in any way related to powers that may or may not be created by any future version of the Identity Matching Services Bill or the Australian Passports Amendment Identity Matching Services Bill?
That's correct, Senator.
Okay, thanks, I appreciate that. Does the tender relate in any way to identity matching using photos of driver's licences that have been submitted to Home Affairs by some state and territory governments?
It does, Senator.
It does?
Yes.
Okay, could you just give a quick précis on what capabilities you are seeking to provide for in this tender as they relate to those driver's licence photographs?
So, Senator, the underlying infrastructure of the system that is currently operating is a system which receives requests to verify an identity from another government department or from a state or territory or from a company where they have been given either a biographical document like a birth certificate or a passport number or a driver's licence. They send those requests to us. We then send that request onto the state or territory or Commonwealth register that is the holder of that information. So if I can kind of walk you through an example, a driver's licence, if somebody in the ACT was to give their driver's licence to our system, so for instance, if they were seeking a mortgage and as one of the identity documents they provide a driver's licence, so they give that to the Commonwealth Bank. The Commonwealth Bank comes to us and says, we've got a driver's licence here.
Any bank.
Indeed.
Any bank.
Any bank. Any bank. Certainly not advertising for the Commonwealth. It's got a driver's licence number X.
Yeah.
It's for Mark Ablong.
Yeah.
And its expiry date is such and such. We send that request on through this system to the ACT driver's licence, who respond to us saying, yes, that's a legitimate driver's licence. And we then pass that information back to the requester. Now, we do about...
Sorry, can we clarify for the Senator, is it the documentary biodata or is it also the image that you're speaking of?
It is just the yes-no.
Yes.
Right? So we don't collect the images, nor do we have a database of those images. They are all kept within the state registry.
Well, could I just ask there, hasn't the department previously given evidence that some state and territory governments have actually submitted their driver's licence
images, correct,
images to the department?
Correct, but we're not allowed to use those yet until such circumstances as the IMS bill is through. Now, there have been a couple of exceptions to that. So, for instance, in the bushfire season of 1920, where residents, their houses burnt down, they had no driver's licence or anything like that, we got permission from the individual to take a photograph of them, and we provided that photograph through this system to it was the South Australian government, to their driver's licence bureau, who looked at that image and said yes, and gave us back the yes/no.
That was done with permission of the person involved?
It was done with the permission of the person.
Thanks, Mr Abraham. Could I ask just a last question on this in that case? Which states and territories have, you can give the list either way, have submitted their driver's licence photos or have not yet submitted their driver's licence photos?
To this point in time, if you'll bear with me, Senator, just get to the right page. Tasmania, Victoria and South Australia have passed their enabling legislation and uploaded data to the National Driver's Licence Facial Recognition Solution. Other jurisdictions are expected to follow with exact timings subject to each jurisdiction's technical readiness or the passage of the Identity Matching Services Bill
so
that you mentioned.
that hasn't changed since last
hasn't.
advised. So that, but do you have commitments from all of the other states and territories that they subject to those things happening, that they do intend to upload their data?
Senator, there was an intergovernmental agreement between all the states and territories in the Commonwealth that said they would do this, subject to the passage of various legislation in all the jurisdictions that related to privacy matters and the like.
All right, thanks. My only other topic for questions in this outcome is the Zero Chance campaign, which I'm just going to ask a few questions about under regional cooperation 1.5.
I think, Senator, do you mind if I just mention, whilst regional cooperation would certainly be an applicable program, the actual officers who support that program are in Operation Sovereign Borders.
Is that an ABF matter, Mr. Pizzola, or it's a department matter?
It's ABF run. We obviously support the ABF because we're the enabling service for the ABF in terms of budgetary and other support. I'd have to take some advice from colleagues, but I don't know when Admiral Jones may or may not be available, but it would be most likely under 3.4.
All right, thanks, Mr. Pizzola. What about if I just ask the one or two questions that I suspect fall under regional cooperation? If you aren't able to answer or the relevant officers are not here, I'll park them until later on. But I just wanted to ask, this has been flagged as a joint Australian-Sri Lankan government program, so I wanted to ask whether the Sri Lankan government has made any financial contribution to this.
I don't know, and whilst I'm briefed on Zero Chance in general, that's the name of the overall comms program, I really would prefer that Admiral Jones and his staff were here.
All right, thanks, Chair. I'll park the rest of my questions until later on.
Thank you very much, Senator McKim.
Thanks.
We are now going to break for lunch. We haven't finished outcome one, so if officers could remain in the building, we will continue outcome one when we return after lunch at just after 1 o'clock. Thank you very much. Well, good afternoon, everyone. The committee is in session. We are continuing with outcome one, and I give the call to Senator Ciccone.
Thank you very much, Chair. Now, I just wanted to continue on from my earlier questions regarding the National Coordination Mechanism. The AFR had reported on the 6th of January this year that Treasurer Frydenberg said that he was relying on the NCM to solve, obviously, a number of workforce and supply chain issues.
Yes.
Now, by this time, as you would have seen, Mr. Pizzulo, a number of Australians were obviously facing some acute grocery shortages and empty supermarket shelves. How regularly was the NCM, or how often did it meet through December and January with the industry groups?
To get that level of detail, I really would ask that Mr. Buffoni rejoin us. I do apologise, I hadn't realised that you still had an interest in this. We can certainly take it on notice. I know from the daily reporting that the NCM provides to me and others. By that stage it would have been, if not daily, several times daily.
Okay. And how often would you brief the
But I'll take the detail on notice because I don't want to mislead you.
No, and I appreciate that. And how often would you or the NCM be briefing the Minister for Home Affairs? And presumably also the Prime Minister too.
Yes, so it depends on who the PM assigns as being the lead minister. So the NCM is a I'll use a technical term, or rather bureaucratic term, it's a multifunctional instrument. It can be deployed in support of any minister. The Minister for Home Affairs, as my minister, so I report to her, I'm responsible to her to ensure that the NCM is functional, it's fit for purpose, it's got staff, it's got the tools it needs to do its job. But as we discussed before the break
throughout those last 2 months, December and January, how often did you brief her on the NCM's progress?
She would have been, as I was, the recipient of regular reporting, probably daily, I would say, but I'll check that on notice. As the minister, if you like, who hosts the NCM, I just want to be very clear about this. The NCM is a cross-government tool which can be deployed on diesel exhaust fluid or essential workforce issues, grocery supplies. We heard earlier about the train outage in northern South Australia. the PM might well decide to appoint a lead minister and the NCM swings in to support that minister.
Yeah. And just on grocery supplies, what advice or strategies were canvassed to address such supply chain issues?
It was really an extension of, and depending on your level of interest and how much further we're going to go into the detail, Senator, I might seek to have Mr Buffoni rejoin us. But essentially, we continued and extended the relationships that the NCM had built 2 years ago through the supermarket task force component or version of the NCM, which involved direct linkages into the supply officials or officers in the major supermarket chains, as well as the company that supports the miners as well. So Mr Buffone, as assisted by colleagues in our infrastructure team, have got direct links into both at the chief executive level, but into also the supply parts of Woolies, Coles, Metcash, Aldi, etc.
And I ask because I noticed in your opening statement, which you'd circulated to us, you don't mention food security as one of the, I guess, the functions of the NCM, and I just wanted to see if that was the case.
I wasn't seeking to be exhaustive,
okay.
Senator. I was being more illustrative.
But food security would certainly fall under that.
Yes, yes.
On the 12th of January this year...
Sorry, to be clear, I did say such as disruptions too, and then I listed a number of matters, but that wasn't meant to be exhaustive.
And I guess on the 12th of Jan, and I sort of want to just focus here just for a little bit, Minister Andrews, 3 weeks into this crisis regarding the supply chain, admitted that she'd only talked to the supermarket on, I think, the 11th of January. Is that your understanding?
Well, when you say admitted, I'm not sure that I would...
That she'd spoke to the supermarkets
I'm not sure that I would consent to
on the 11th of January regarding the crisis in the supply chain.
Well, whether that was the first engagement or otherwise, I don't know. I'd have to check. But she's at the peak. She would have been at the peak of a whole series of engagements that would have been driven out of the department, other departments, and those working through the auspices of the NCM.
So you don't know that the minister did meet with the supermarket
Whether she had any
the...
personal engagement, I'll take that on notice. And if Mr Buffone gets here in time, he can perhaps address that because he would have supported her directly.
The NCM, would it not be the case that it is or should be used to solve these type of crises as they emerge?
Well, its job is to stabilise a crisis. We're not the policy authority on, rail infrastructure in Central Australia. Our job is to, if you will, be the first responder to coordinate the Commonwealth's first response to stabilise the situation. And as I said earlier in response to Senator Grogan, if we then, in our short-term work, learn or generate long-term insights, we feed those to other departments and to the NRRA.
I guess where I'm going with this, Secretary, is that why has it taken the Minister such a long time to engage with these important stakeholders, given that the crisis we knew would occur for some months? And we've had a number of, prominent industry peak bodies like the BCA, the NFF, who have also said, look, since October we've been warning government, try and fix this issue before it becomes a crisis. Why has it taken the government such a long time to come to the table and start talking to the supermarkets?
I have to respectfully perhaps contest the characterisation that government came late. Whether the minister personally engaged with supermarkets, I've taken on notice, but she and other lead ministers, depending on who the lead minister is, oversees the NCM. They're the subject of, I can assure you, daily, if not more frequent reports, and they give us direction as to what the government's policy is. So the notion that out of the clear blue sky, ministers just started to become engaged on the 11th of January is not accurate, Senator.
And Senator Ciccone, before you go on, I feel like I must put on the record how incorrect the characterisation you have put on the evidence that's been given by the Secretary is. He did not suggest that there was a failure to engage. In fact, he took it on notice. That means we will get that information to you. It doesn't mean the answer is no.
And I guess, Minister, do you then accept that the Minister for Home Affairs was late in her dealings with key stakeholders in the supermarket and supply chain?
I don't accept that proposition, and the reason that I don't is because the matter's been taken on notice, and so it's not based on information that's before the committee.
There is information before the committee saying that she didn't engage by her own words until the 11th of January.
11th of Jan.
So do you have an earlier date, Minister?
If I can assist.
Please do.
I'm interested in the basis of the minister's statement.
Understood. I can assist in when the committee's ready.
Does the minister have knowledge?
Senator Keneally,
Does the
the
minister have
call is
knowledge?
with Senator Ciccone. Are you seeking the call?
Look, I'm happy to address the matter raised by Senator Keneally, since it is in the nature of trying to give Senator Ciccone a hand.
I don't need a hand, by the way.
Minister Andrews has been the lead minister on supply chains for a few weeks, and during that time she has engaged actively and constructively. Prior to that time, the matter was being dealt with by the Treasurer, and the Treasurer had multiple and extensive engagements on that matter. And of course, the actions of the minister are also reflected by their various departments, all of which were active in this space.
What was the decision of government to switch it from the Treasurer?
Done. I think the Secretary was going to take that on notice. The decision of government.
So,
to,
and if I may, Chair, with respect, with Senator Ciccone's permission, ask a follow-up question.
Sure.
When was the decision of government to switch responsibility for supply chains from the Treasurer to the Home Affairs Minister?
Well, I'd have to take that on notice. The supply chain strand of the NCM work has been on foot for 2 years, and then we dial up or dial down different supply chains depending on the nature of the situation at hand.
And who makes that decision to switch ministerial responsibility?
It's a matter for the Prime Minister. He will assign lead ministerial responsibilities.
Right, so do we have a date for when that
I'd have to take
switch?
that specific
Well, I'm
on.
asking the Minister since she provided that information. Do you have a date, Minister, as to when that change happened?
I'll take it on notice.
It hasn't come through on your phone yet?
Senator Keneally.
Classy, Senator Keneally.
Senator Keneally.
I'm just observing you. You got a quick
Senator
answer. I was
Keneally,
hoping you could get another
your
one.
observation, may I suggest, is not appropriate. The Minister has taken this question on notice. Do you have, or Senator Ciccone, you seeking the call again? Do you want to continue your questions?
No, that's right. We might move on.
Senator Van has
you.
just got a couple of questions to follow up on. Senator Van.
Thank you. Secretary, is it right to say that long-standing, both in practice and in corporations law, that the boards of Australian companies are the ones that should be running the risk management on their supply chains and what they do?
Well, boards have got particular responsibilities under the corporations legislation across the governance of, the entirety of the entities that they, as a board, oversee. And then, of course, certain matters are delegated to management. So I think that's well understood. But if you're asking the question, where does the principal burden for risk management sit within a private corporation? It, of course, sits with the company. Where the NCM, I hope I'm not preempting a follow-up question, but where the NCM adds value is, if you will, if the sum total of each company in the sector operating in its own commercial interest and according to its own continuity and risk management arrangements is less than what the nation needs. Yep. So there are very particular arrangements. I'll give you one example that's not in relation to the more recent food supply chain issues, but at the start of the pandemic, each of the companies said to us through the supermarket supply chain arrangements that the NCM set up, we can only go so far, and then we start to get into regulatory hurdles such as, for instance, after-hours noise regulations from councils about the ability of our large trucks to go through streets.
Yep.
A company can only take its engagement with those issues so far before they put their hand up and say, look, if someone could deal with the municipal regulations collectively, all of us could supply food more quickly in terms of restocking through the back of those shops if our trucks could go in through the night. Another very brief example, which I've given, I'm fairly certain I've given on evidence before, is that when even discussions about collaboration in supply starts to give rise to cartel considerations under the law overseen by the ACCC, the value of the NCM is to say, look, we can engage with the ACCC, in fact, with Chairman Sims and his senior officers, what discretion is lawfully available under the relevant legislation. So the NCM's role is not to do the job of the companies, but to address those gaps where aggregated or synchronised effort, on top of all the companies doing their best that they can, gives you more benefit.
Thank you, Secretary. You not only preempted my follow-up question, you improved on it. So thank you.
I do apologise. I didn't mean to.
No. Please, I appreciate the breadth and depth of your answer. Thank you.
Thank you very much, Senator Van. I'll now go back to Labor senators, to Senator Grogan.
Thank you, Chair. I'd like to ask some questions about the Safer Communities program. We know from previous estimates rounds that during round 3 of the Safer Communities Fund, 91% of the funding ended up in government-held, independent or marginal Labor seats. That's correct? Yep.
I don't know, as a matter of fact, but Mr Ablong, who runs our the relevant program, might be able to assist.
And while Mr Ablong's digging that out, of course, you'll be aware, Senator Grogan, that these matters are applied for by people in the community based on need, and quite often they are based on incidents in the community that require a response. For instance, graffiti and vandalism, fires and the like. And so it's important to note that there has usually been something of a lead up and a demonstration of need associated with these
There were
matters.
also a range of others that were not, and the 91% is a little high.
Well,
So I might
91%
just
doesn't
ask-
reflect 91%, a number you've given me, and I'll take it on face value, though I don't have that confirmed for me in front of
Okay,
my
so
papers.
I'm very conscious of time. We've already gone well over. So can I just get straight to the question? If we put that to one side, we may not
I was just
agree.
making the most for your benefit while Mr Ablong was getting to the table. I'm happy to hand it to Mr Ablong, but
Sure.
I thought you might like some extra information.
Does the department still believe that the funding awarded under that program was effective and consistent with the Commonwealth grant guidelines?
Well, our job is to advise the Minister of the Day as the decision maker on consistency with the guidelines. Mr Ablong, would you care to add to that?
Senator Mark Ablong, Deputy Secretary, Strategy and National Resilience. As the Secretary said, the advice that we provide to the decision maker, which is always a Minister or an Assistant Minister of the Commonwealth, is always consistent with the Commonwealth grants, rules and guidelines. Relevant ministers have complied with their obligations under those grant rules and guidelines when awarding all of the Safer Community Fund grants.
So there were no instances that you're aware of where the Commonwealth grant rules and guidelines were not followed across this grant program?
Senator, we're not aware of any where the rules weren't followed. Those rules require the decision maker, the Minister or the Assistant Minister, to receive written advice on the merits of a proposal, and that was certainly given to them, to report to the Finance Minister when approving a grant not recommended by the relevant officials, and those ministers and Assistant Ministers did so, and to advise the Finance Minister when approving a grant within their own electorate, and that occurred. In fact, I'm not sure that we've got an example of a grant within the electorate of a Minister or Assistant Minister.
Has there been any criticisms?
Sorry, Senator Grogan, can I just make, for the abundance of clarity, this program is governed by the Commonwealth Grants Rules and Guidelines,
We're well aware of
and
that.
they have been complied with at all times.
That was my question, and it has been answered.
And
Thank
I
you
wanted to
for
make it
answering
very
the second
clear
time.
that...
Sorry, yes,
make
just
it
if you
very
just
clear
allow the
for you.
Minister to finish her answer. Thanks, Senator Grogan.
So has there been any criticisms or critiques of the department or the decisions made through this program of it being effective?
Senator, we sometimes receive complaints from applicants when they have not received funding, and those are followed up with the relevant grants hub in terms of whether or not they met the requirements. We've not received any complaints about our administration of the Safer Community Grant program.
Okay, so there hasn't been any criticisms or critiques of the department that you're aware of
Well, it's been
in
the
relation...
subject of an audit. Which
Yes, the ANAO is expected to release their audit on the program soon, we welcome opportunities to continue to improve the program, but we're not aware of any complaints.
So I think, Senator, the evidence is that in some cases if I can use this term, failed applicants might come forward seeking either a form of redress or at least a form of explanation. Are you referring to any particular round, or are you asking about...
Round 3.
Round 3. Just so we're clear with the Senator, were there any specific complaints, either seeking redress or further and better explanations received in relation to round 3?
Not that I'm aware of, Senator, no.
So we'll check that completely. And then more generally, in terms of our administration of the program, it's been the subject of recent audit attention, and the Auditor-General, as I understand it, will be tabling a report soon.
And do you have a sense of what the content of that report might hold?
Well, yes, because I'm an authorised officer to receive his report prior to tabling, but I wouldn't wish to speak to it prior to it. And I'm not sure if it's been tabled, but once it's tabled in the Parliament, I'll feel more at liberty to speak to it.
Okay.
But to answer your question, yes, I've read it. I've read the Auditor's report, and I don't believe it. He's an officer of the Parliament. I don't believe it's proper for me to anticipate or speak to his findings before his report is tabled.
But you would make a response to that report?
Yes.
You would have already made that response?
Yes.
Would you be prepared to tell us what that response is?
In broad terms, I'm happy to say that such recommendations as the Auditor-General has made in relation to the administration of the program, both from the point of view of record keeping and the provision of advice and the like, are matters that the department has been offered an opportunity to respond to. Our response, as always, is contained in the Auditor-General's report. You'll see it as part of the department's response. And I can advise, hopefully without breaching any confidences, because I'll just speak to the department's position, is that we've accepted all of the recommendations.
Okay. And is there anything in the administration that you would change following this report?
You're really inviting me to speak to the nature of the findings and to the recommendations made by the Auditor. He's an officer of this Parliament, so I don't really want to take liberties with his reporting responsibilities to this Parliament.
So the guidelines to administer this program, can you tell us when those guidelines were put into place?
For round 3?
Yes.
So the guidelines for round 3 were, I believe, in July of 2018, but I might ask Ms Spencer if she wants to come to the table. She's got more and better particulars on round 3.
So, and you said 2018, would that be, was that the first row of the guidelines put in place at round 1?
Well, Senator, round 1 was managed by the Attorney General's Department because the Safer Community Grants Program was mogged into the department, and round 1 was before. The responsibilities were changed under a machinery government change to the Department of Home Affairs when we were created, which was after round 1. So each of the rounds has a different set of guidelines established for that particular round.
And so we're clear with the Senator, was round 3 the first that we administered?
Round 2 was the first that
we did round 2. Thank you.
And did you change the guidelines between each program? Is that what you're saying?
Well, so the guidelines, each round of the Safer Communities Fund tries to seek a different outcome. So they're not all addressing the same thing every round. Some are early intervention programs that look to deal with community safety around religious establishments. Some are about police and youth associations. Some are about the development of infrastructure, those sorts of things. So each of the set of guidelines, along with the general grants guidelines, which apply to all Commonwealth grants, which are administered from the Department of Finance, for the specific round, there is a set of round guidelines that talk about what is required in order to be considered an eligible grant for the purposes that that particular round has been established to deal with.
So the guidelines are changed each round just by nature of the target for...
That's correct, Senator.
So I would distinguish, Senator, between the criteria that might be applicable to the public policy objective that's been pursued, might be physical infrastructure, better lighting, fences, etc. But the common guidelines, if I can use that term, that derive from the Department of Finance guidelines, they deal with probity, record keeping, the process by which advice is given to ministers. That tends to be, I think those guidelines have been fairly static for some years. They tend to be universal. So what gets added are particular criteria that relate to the objectives that you're trying to achieve with that round of funding.
Okay.
I'll just
And have any other
that
of
with
those
Ms. Spencer.
guidelines...
Sorry, Senator. Ms. Spencer, I just want to be absolutely sure that my answer is accurate.
Kira Spencer, First Assistant Secretary, Law Enforcement Policy Division. That's right. So we use standard Commonwealth grant guideline templates, which are publicly available on the Grant Connect website and through the Business Grants Hub. What we then do on each round is issue new guidelines based on those templates to reflect the selection criteria and eligibility criteria for each round, as the Secretary and Mr Ablong said, to reflect particular focus of each round.
And is there any other element of the guidelines that have been changed between round 2 and round 3? Or just the criteria for the particular target that you're aiming for?
Do you need to check that as a matter of fact, Ms Spencer?
We can check as a matter of fact. The other elements that are changed are things like it includes the application dates and when applications are due, so all the general, but generally we use those common templates, and then it's simply the eligibility criteria and selection criteria that will change from round to round.
So are there any criticisms or complaints about the guidelines that were changed between rounds 2 and 3?
Not as far as I'm aware in relation to round 2 and 3. If I can add to the evidence already given, there was some criticism from some community organisations in relation to round 5, early intervention, and that round was a targeted round to focus on key organisations that we knew were able to deliver in the early intervention space, and it was targeted to those specific organisations. Subsequently with that, with round 6 for early intervention, we've made that an open round in response to some of those criticisms and concerns.
Okay. And then the guidelines that are in place now, all the applicants were assessed under those guidelines?
That's right. So the Business Grants Hub assesses the applicants against those guidelines. And if I can be just a little more detail, so on each grants round, so we talk about round 5, round 6, there can often be different programs. So in round 6, we have an early intervention stream and an infrastructure stream. So the guidelines for each of those streams are different. And from memory, in most of the rounds we've had at least 2 different streams. I know round 5 we had 3 streams. We had one focused particularly on the Northern Territory as well.
Okay. And so all of the funding decisions are appropriately informed and then documented?
That's right. So that assessment process is undertaken by the Business Grants Hub. We get their assessment package with all the assessments and all the documentary evidence. We put those recommendations to the decision maker, in this case for this round the Assistant Minister for Home Affairs, and previously it was the Minister for Home Affairs.
Okay.
And to the extent that the Minister has intervened in circumstances where he might have deviated from the assessment that was given by the department, that was undergone first within power, because of course if ministers can't make decisions, then you might as well not have them. You might as well just subcontract everything out to the department. And the second thing to say is that the overwhelming bulk of those interventions were to assist organisations in labour strongholds. So for all of your bandying around of 90 plus numbers, it is people in, for instance, the seat of Isaacs, which couldn't be called a marginal seat by anyone's definition, who were assisted and served by those interventions. So I think that's an important matter to put on the record to counterbalance some of the, otherwise confusing statistics you might have rolled out earlier on.
I'm not sure they're confusing. I think they're quite straightforward.
Well, it's confusing when you put it in the context. I mean, you would bring it out to try and suggest there's something awry in the decision.
That's right. That's exactly right.
And
that's why we're here.
When I say to you that the facts demonstrate that it is overwhelmingly organisations in our community that are part of the multicultural community and that are in labour strongholds, it shows that the minister is somebody who is making decisions on a factual basis. And when each of those organisations can point to instances of vandalism and harm that presents risks to safety and security of people and property, then those decisions are more than justified.
I will just go back to one of your points, though, Minister, in terms of you referred to if the minister didn't have the ability to make those decisions, why would we bother having them? And just hand everything over. Oh, can I take you to your perspective then on the guidelines? Because if you feel that the guidelines are merely a secondary point, which is what I took from your comment, it may not be what you intended.
It's not what I said.
No, that's why I have made the point of clarity.
I think that's
there.
an important thing to say. Well,
But by
they're
saying that
guidelines.
the minister-
Guidelines guide
Minister,
decision
sorry,
making.
could I just, Senator Grogan, if Senator Grogan, if you could just complete your question, please, and this is your
Certainly.
last
My
Thank you, Chair. I
apologies.
appreciate it. Your point about the minister, obviously ministerial decisions, we all know how that works, but the point that we should override those guidelines when we feel like it, like I say, I appreciate I'm characterising here, but that's certainly how your commentary sounded to me. Can you just explain to us how committed to those guidelines you actually are?
Senator, can I provide some detail on that?
All right, hang on. We might just, sorry, Ms Spencer, we might just allow the minister to...
I'll throw to Ms Spencer in a moment.
Thank you.
But
Thank you, Ms Spencer.
the guidelines are just that. They are a useful and important guide directing the parties who are applying to draw out the right information to help with decision making. When members of the community, through their organisations, apply for these grants, those guidelines help them to get the right information before a decision maker. Now, sometimes an assessment will be made by the department and then there are intervening facts that need to be taken into account in making a decision. But quite frankly, when you look at every single one of the examples where Assistant Minister Wood has intervened, they are overwhelmingly justifiable on their facts. One example I'll take you to, in the federal electorate of Gorton, of course the member there is Mr O'Connor. They had experienced regular racial and religious and verbal vilification. There had been the placement of messages with negative connotations towards Hinduism, statements of disrespect, damage to the front gate, to the letterbox, the dumping of rubbish, and over 90% of that community felt unsafe when they attended the religious site. So even though...
Sorry,
I'm not saying that...
Minister, Senator Grogan, you're making a point of order. What's your point of order, Senator
It was just
Keneally?
a point of order on clarification.
No, that's not a point of order.
Okay, well, point of order then.
That's not a point of order.
Well, my apologies
Your
then. Well,
point of
then may
ro-
I ask a clarifying question of the Minister, Chair? To her answer.
No, because we are well over time. I did say to Senator Grogan that she was on her last question.
Well,
that question, Minister, have you completed your answer?
Look,
happy
I hadn't completed
All
my
right,
answer.
so if you could just fairly
And also, I
quickly-
hadn't finished my question, as I can just put that on the record as
Senator
well.
Grogan, we will come back to you, but we do need to share the call around. Minister, could you quickly complete your answer?
Are you talking about round 3 with Minister Dutton, or are you
Senator-
talking about another round?
Senator Keneally, could I just ask the Minister to complete her question? We will come back to that if
Well,
you wish.
she's answering not. She's
Senator
not answering
Keneally,
the
you
question
don't
that was
have the
asked.
call. Senator Keneally, you don't have the
She's
call.
not answering the question. that
You
was
don't
asked.
have the call, Senator Keneally. Minister.
I am providing details in relation to the Kundrathu Murugan Kumaran Hindu temple.
Which
now,
is not a question
that's an
that was asked.
example.
Can I point
And was
out?
not done
It's-
by Minister Dutton, who gave 91%
Senator
to
Keneally,
marginal
you're-
seats.
Senator Keneally, you're not in order.
I was
just
very
asked-
Well, the
clearly
minister's
told,
not
no,
relevant.
Respectfully, Senator Keneally, I was from
Senator
the
Keneally,
outset.
She's not
Minister,
relevant.
could I ask you to complete your question? We are going to share the call and then we will come back to this.
Thank you. And for Senator Keneally, I was clearly talking about the actions of Assistant Minister Wood. That was plain from the introductory sentence, and so I won't wear that.
Just briefly,
but
if you
Is
could
that the
complete
site
your...
that has a lot of
the-
Liberal
if you
donors
could-
at that site?
Minister,
don't be
and Senator
ridiculous.
Keneally, I would ask
Don't
that
be
you...
ridiculous.
Order.
In the seat of Gorton,
Minister,
Labor stronghold,
could
please.
I just ask you to pause, please?
So you're denying there's
Senator
no Liberal
Keneally,
donors on the management
Senator
committee
Keneally,
of
you
that
don't
site?
have the call. You're not in order. Now, my job as
minister
chair,
denying
excuse me, Senator Keneally, my job is, as chair, is to maintain the order of the committee. I've already indicated we will come back to Labor senators on these matters. Minister, could you please complete your answer very briefly?
Thank you.
And then we'll share the call around and then we will come back to both Senator Keneally and Senator Grogan if they wish. Minister.
Senator Grogan, examples like the one I've just provided to you from the Hindu community indicate that where interventions occur, they aren't prompted by anything nefarious, they are prompted by the activities and concerns of that community. The guidelines and all the information presented in line with them is of course taken into account, but none of that overrides the Minister's ability to act flexibly when that community demonstrates a need.
Minister,
and that
thank
need
you.
was more than demonstrated.
Thank you, Minister.
In those cases of intervention.
And I am going to ask those at the table, respectfully to the those giving evidence, including the Minister, we've got a lot to get through today, so if you can keep your answers fairly succinct, that will help.
Forgive me, Chair. I just get very upset when people slur the Minister when he's been acting so honourably.
Minister, there's no need to debate that particular point. If I could just ask all those giving evidence today to just keep your responses fairly brief so we can get through all of our questions. Look, I just want to move now to the issue of national terrorism. I'm just keen, Mr Pizzolo, to understand the current status of the terrorism threat in Australia from the perspective of the department.
Well, of course, in terms of the overall assessment that's provided to us all by the Director-General of Security, exercising his statutory responsibilities, and of course the terrorism threat level is probable. What that means for the department is that the Counter-Terrorism Coordinator, Mr Kefford, who will come to the table should he wish, then operates his coordination function in an environment where the assessment is that a terrorist attack is thought likely to be the case to the level of being probable. That means that the work that we do with states and territories is affected. That means that our work in relation to our international collaboration is so conditioned. But Mr Kefford, a few brief remarks for the Chair. How do you operate in an environment where the terrorist threat level is probable?
Thank you, Secretary. Andrew Kefford, Deputy Secretary, Social Cohesion and Citizenship. Senator, there's ongoing work particularly through the ANZ Counter-Terrorism Committee, where we work with our state and territory counterparts as well as our friends in New Zealand to progress a range of initiatives. Obviously, that's all conditioned by the advice from the intelligence agencies that are part of that structure. And so at the moment there's a range of exercises in contemplation. There's work going on in relation to the National Counter-Terrorism Strategy, and so the work of those groups continue. And obviously, as I say, is conditioned by the changing advice as to the threat and the likely areas from which that threat's most likely to be seen.
And as we come out of the pandemic, how do you expect that threat will change?
Well, again, I'd refer to the Director-General of Security's comments the other evening, where he was speaking particularly about the impact of people spending time in isolation, accessing potentially radicalising material on the internet, and so we've seen that across the community. Obviously, the broader international issues remain an area of focus, whether that's Afghanistan or being able to improve some of the face-to-face cooperation we've done with our counterparts, particularly Indonesia and the Philippines. Obviously, that's been restricted by the travel restrictions, but in terms of the threat environment broadly, I suspect the biggest single factor from the pandemic has been that sense of increasing isolation and opportunities for individuals to spend time, perhaps unsupervised, accessing radicalising material on the internet.
And so from the department's perspective, what's the big challenge you believe which lies ahead?
Well, it all boils down, Senator, to both maintaining community safety is the ultimate goal, of course, but where that works is continuing the cooperation that we have with our law enforcement partners here and overseas, continuing the partnerships that we have in place with community groups, because one of the things that's been referred to again by the Director-General the other evening was the extent to which the indicators that an individual may be heading down a path towards radicalisation will be most likely recognised by people who are close to them through a change in behaviour and so on. So part of that is continuing the work we do through the programs that we have in place to increase the awareness of those indicators and to increase the supports that are in place to support people in those circumstances. And in that context, of course, the government's announced in the last week or so a significant package in relation to countering violent extremism.
All right, thank you very much. I'll now return to Labor Senators. Senator Keneally, you have the call.
Thank you, Chair. I have some questions in relation to the Australian women and children in northeast Syria. And I understand that Home Affairs and DFAT have been paying careful attention to the situation of these women and children and have been exploring options for their safe repatriation in cooperation with Australian security authorities and considering how community reintegration might occur. Am I correct in understanding, as the Sydney Morning Herald has reported, that Australian officials travelled to the camps and interviewed families in November last year?
I'm not sure, Senator, that report itself was factually based. It might well have been. I'll ask Mr Kefford to speak to that in detail. I should say, by way of a preambular introduction, we in the Department of Foreign Affairs have got the joint leaders. I think I've given evidence to this committee before on establishing a number of conditions, whether the conditions on the ground have changed sufficiently to ensure that the safe extraction, exfiltration or movement of persons to whom we owe consular responsibilities has been met, whether the safety both to the persons themselves as well as our staff have been met, and also to have regard to the threat back in Australia to their that their presence would potentially give rise to. So we are engaged with the Department of Foreign Affairs and Trade.
Yes, I apologise again. The Chair is very keen for us to have concise answers and concise questions. So
and
if
just
we can,
one very brief comment. The strategic environment has not changed since I last said to the committee that we had the situation under review. There's been no policy change in terms of going in and.
I merely asked, is the report correct?
November, so against that context, was there a?
I know all that, Chair, with the Secretary. Excuse me, with the greatest of respect.
You're directing the question to the Secretary.
No, I'm directing to Mr. Kefford.
Senator, I'm not sure I remember the particular details of the article to which you refer. And in relation to visits, we've given evidence here before that there's not been, along the lines the Secretary's outlined, consular visits. And I'm not sure it's for me to comment on the activities of other agencies
So you're
in this hearing.
so are you saying that Australian officials have not travelled into the camps in November last year and interviewed families?
No, Senator, what I said is it's not for me to comment on the activities of other agencies.
So it wouldn't have been a Home Affairs agency, it
No.
might have been?
No.
All right. I do understand that in the last few months, countries such as Norway, the Netherlands, Sweden and Switzerland have conducted safe repatriations. Do you have any evidence to contradict that?
We're aware of those reports, Senator, yes.
Thank you. In mid-January, ISIS attacked a prison in northeast Syria where Australian young males, including including boys, had been detained. It was reported that an Australian boy was injured in the violence, and I have spoken to people who have been in direct contact. Does the department have any information on this boy's welfare?
We're aware of that reporting, Senator, yes.
Do you have any, that wasn't my question. Do you have any information on his welfare?
Nothing further than what's been reported, Senator, no.
This incident surely highlights that allowing Australian children in particular to remain in this environment puts them at grave risk. Australia does have international obligations here in regard to our citizens, and ignoring them surely expands the risk of significant mental and physical trauma or even death of Australian children. What will it take for the government to act to ensure that these children are safe?
Well, Senator, I'm not sure that the evidence that we've given is that we're ignoring the plight of such persons. What I've said, and I did state it before, so I won't repeat it, is that a number of policy conditions have to be met before we return to government with advice that it's safe to put in place a plan to get such people out.
It has been reported that Australian officials have gone into the camps, safely gained access and returned. Are there countries that are similar to ours, Norway, the Netherlands, Sweden and Switzerland, and including previously the United States, have been able to repatriate their citizens? There is a suite of anti-terrorism legislation, control orders, temporary exclusion orders and the like that has bipartisan support in the Parliament. I'm trying to understand what is the condition you cannot satisfy that would ensure that we could see that children in particular, who are in a most dangerous part of the world, and indeed in danger right now, are safe. What is the condition that has not yet been satisfied?
That the safety of our own officers, not for a visit, which may or may not have occurred in the terms that have been described in the press, but that our officers could go to a point where a significant repatriation could occur and that there wouldn't be an increased and unreasonable and unacceptable threat to community safety back here in Australia.
So have you identified, on that last point, I think many people would agree with you. We want to ensure that there is no threat. But children have been repatriated previously. There are children who still need to be repatriated. I understand from organisations like Save the Children that there could be arrangements made for these children to be taken to a border. I understand from Save the Children that there are commitments from family members to enter into control order and other types of arrangements. What is the legislative or policy gap? Where is the safety gap? The risk that these mothers pose that you cannot address?
I'm not suggesting by way of the evidence that I've given that there's any legislative or regulatory gap. It's really a question of risk appetite. I would draw your attention, without speaking to the individual that's in your question, I would give this committee, I'd draw a link to the Director General of Security's reference to his concern and ASIO's concern to radicalisation and violent extremism amongst minors. When you make reference to a child, there are children of a particular age, and then there are teenagers. There are older children, shall we say, and each case turns on its facts. But to address the question of what are the policy or legislative gaps, I'm satisfied that we've got the legislative tools we need. Mr Kefford may wish to add to that. It's really a question of an overall judgment to balance various risks. And that sits with the two departments. I've given evidence before that the Secretary of that department and I attend to this issue periodically, indeed more than periodically, and as far as we're concerned, I won't speak for Ms Campbell, but from my point of view, the conditions have not sufficiently changed on the ground.
How many children are in these camps in Syria? How many children who either, if you have the data, are Australian citizens, if you need to parse it in this way, or have a claim to Australian citizenship?
Mr Kefford?
Senator, I'd have to take the detail on notice. We're aware of 12 family groups that claim some connection to Australia, but as to the number of children, that I need to take that detail on notice. Because, and as you say, some of them will be claimed connection to Australia rather than a demonstrated connection.
And some of them will have been born in Australia, and some of them will have been born overseas, presumably.
And in some cases, citizenship cessation might have cut in at a particular point,
There's a handful of those, I understand.
So that citizenship might not be available by way of
It's
descent.
been previously reported there are roughly 40 children.
We will take on notice the precise number.
And what about adults?
Well, I think
They're all women, as I understand it, in these camps?
in the camps.
Yes, there are.
The number is around 60, Senator, but I don't know I'd have to take the detail on that.
60 in total?
In total.
And so of that, adults and children?
Is that women and children?
That's women and children.
Thank you.
One more minute, Senator.
If we give you a better breakdown on notice, Senator, we will.
I just think it's worthwhile us understanding that on the 20th of January 2022, when ISIS fighters launched this complex attack against a prison, there was an Australian minor caught up in the violence. He expressed fears for his life in an audio message sent to family in Australia, and his messages included seeing notes of bodies of young boys and that he had been shot. He was bleeding and he needed help. He is believed to be alive, but confirming that has been difficult for the people here, for his family here. You talk about the risk of radicalisation. Surely leaving children in a situation where they are vulnerable not only to radicalisation by others, but to extreme violence and death, enhances the risk that they will become radicalised.
In situ,
Yes, leaving them in situ.
that is a risk that has to be balanced amongst all the other risks, yes.
Senator Keneally, we do need to
And you,
move
this
to other
boy,
senators.
you have no other verifiable information about his welfare.
Do we have any further and better particulars beyond what's been reported?
I can check, but I don't think so.
We'll take on notice whether we've achieved any more insight into his well-being since that time.
Thank you.
Thanks, Senator Keneally. Senator Grogan, can I just, for the sake of all senators, indicate that we are running behind. I'm keen to move to outcome 2 by 2 o'clock, so if I could ask senators to try and wrap up the questions by 2 o'clock. Senator Grogan.
I'll try and condense mine.
Thank you.
Now, we learnt that Minister Dutton had rejected the advice from community safety experts in Home Affairs and reduced funding for 19 safety projects, round 3. I'm also aware that 2 of the grants were granted to in the seat of Braddon just before a by-election, and that Minister Dutton then spent $36,000 on a RAF jet to get to Braddon to announce those 2 grants. Can you be really clear with me about any complaints or criticisms of the government and whether the minister is aware of complaints and concerns about this grant program and round 3's allocation?
Especially in relation to those allocations in the seat of Braddon?
Well, the whole shebang, really.
Ms Spencer, you gave some evidence before about a number of community groups expressing some concern. Is there anything more that you wish to add that might be relevant to the senator's question?
Apologies, that evidence related to round 5, not to round 3.
My apologies. And so we're going to see this ANO audit report, is it today? This week?
I haven't seen the business list for the Parliament, for the Houses of Parliament, but I think it's due. I think my understanding is it's due to be tabled soon.
Well, it'll be interesting to see what comes out of that.
Is it on the notice paper, as far as you know?
I believe so for today.
It might well be on the notice paper. Is it, Simon's? It's tabled in both houses, isn't it? So.
I'll hand over to Senator Ciccone.
Well, thank you very much, Senator Grogan. I
quickly.
will now give the call to Senator Ciccone.
Thank you very much, Chair. Thank you, Senator Grogan. Now, I just have a few questions, Secretary, with respect to WeChat. And obviously around the media reports, recent media reports of the Prime Minister's loss of access to his WeChat account. With regards to this specific case, did Home Affairs find any indication that it was an act of targeted political interference by China?
When you say fine, I'm not sure that any.
Was there any indication?
I was going to say,
of foreign
I'm not sure that
interference?
anything that we did would constitute an inquiry and an investigation. But Mr. Kefford, who's got a different hat on now, the CFI coordinator.
CFI.
Sorry, countering foreign interference. Sorry. I always admonish my deputies for using acronyms, and there you go, I did it myself.
Okay.
Senator, what I would say in answer to your question is we have had direct engagement with Tencent, having met with them as we have done with a number of the social media companies through the course of December last year. We had direct contact, both the Electoral Commission and with me personally. With the company, the advice we had at the time was that there did not appear, or there had not been a cyber attack, and that the matter was being dealt with. Thank you. The matter was being dealt with under the platform rules in relation to a change of ownership, and so that's the basis on which we are continuing to engage with the company.
So when did you engage with the company? Sorry.
My last communication with the Director of Public Policy was the 3rd of February, Senator.
And when was the first time you engaged with them in relation to this matter?
Well, I met with the Director and his General Counsel, along with the Deputy Electoral Commissioner and a colleague from the Communications Department on the 23rd of November, and then subsequently Mr Marty, the individual about whom I'm speaking, contacted Mr Pope, the Deputy Electoral Commissioner, on the 24th of January, and then I had an email exchange with him a week or so after that, and the response was on the 3rd.
Just so we're clear, so we're not misleading, the engagement in November did not pertain to the account in the name of the Prime Minister?
Yes. That was a general discussion about preparing for the
So did you
election
find
process.
any indication that there was an act or targeted political interference by the Chinese government?
Well, Senator, as I said, you know, what we've been doing is communicating with the company rather than conducting a investigation per se. But the advice we've had from the company most recently is that it's being dealt with as a transfer of ownership under the platform's rules.
So why wouldn't you have an investigation?
Well, Senator, the reason I'm being precise around that is there are powers that exist in the CFI task force amongst the law enforcement and security agencies that go well beyond what a Department of State's able to do in continuing its discussions with the company concerned.
Okay. So what's your assessment of Tencent then? Since you've had these discussions with the company, what's your assessment?
In general or on this matter
well,
particularly?
About the matter that relates to the Prime Minister's access to his WeChat account.
Mr. Kepler?
Well, Senator, I won't restate their response to me. The other indication that the company has given is that they're dealing directly with, and this has been reported publicly, dealing directly with the Prime Minister's office in relation to the ownership of the account. Generally speaking, we've found Tencent to be keen to assist to the extent it can in ensuring that the election is not compromised by foreign interference, and indeed that's been the reaction of all of the companies to whom we've spoken.
Can I presume that this assessment's been communicated to the Prime Minister's office?
I have had discussions, yes.
There's obviously been media reports circulated around the Prime Minister being kicked off WeChat rather than being hacked because his account breached some of the rules that contain to the use of WeChat. But I also have circulated through the Secretariat an article from the Australian Chinese news platform where the Prime Minister has been reported on that program or on the news network as doubling down on the interference claims, telling ACN that the removal of his WeChat account was, and I quote, and this will eventually make its way to you, Mr. Pizzullo.
I was going to say that the staff have got a very clear protocol.
They do, senators first and everyone else second. But
entirely appropriate.
But just in acknowledging the time.
Senator Ciccone, just in relation to the document you've distributed, could you just identify the source of the document?
ACN, to the Australian Chinese News.
Okay, so this is a reproduction of Australian Chinese News.
Thank you.
It's not.
It's how it prints off on the printer. There's no other way of.
Thank you very much, Senator Ciccone. I appreciate it.
It's from the 6th of February as well too, just for the record. Now the quote that I'm looking at here is the Prime Minister has said, "Act of censorship by the government of China." So that the removal of his WeChat account was an act of censorship by the government of China. End of quote.
Sorry, Senator, you're going to have to help me. Where it's unpaginated, so where are we? I'm sorry.
It is, unfortunately, but on page...
I've got a strict pagination rule as my staff know. This is precisely...
No, you're right.
Is it I think it's the penultimate page.
4, yeah, without the pages number there.
Are these verbatim?
But look,
I
guess...
I'm struggling to just establish veracity here. Do these purport to be
verbatim of the Prime Minister's,
right.
Yes.
Thank you, Senator. Thank you.
My question, though, Mr. Pizzullo, is does the department agree that this was an act of political censorship by the government of China?
Well, it's difficult for me to answer that straight up because we're not an assessment or investigative agency. That the investigative powers that Mr. Kefford alluded to properly reside with other agencies. Our job is to coordinate and liaise with the company in question. What's been stated to us, so we're not an investigative body, is that there seems to be a platform rules issue, it's a terms and conditions issue for an account that's been set up, as I understand it, privately as opposed to being set up through the auspices of the Australian government. I guess just as a matter of precautionary principle, anything involving the Prime Minister of Australia, whether it's set up through the auspices of his office, the Liberal Party, or as an extension of his of his role as head of government, I would take a very sceptical and cautious view until I got to the absolute bottom of who the actor is, who had the I think it's called the transfer, who was behind that transfer, who impelled it, who was interested in it. Until all of those layers are gotten to the bottom of, I wouldn't be drawing any conclusions, admittedly either way, but because he is the PM, whether in his own private capacity as a Member of Parliament, as the head of the Liberal Party or as the head of the government, I would just be always taking a very sceptical view.
And thank you for that. Are you able to shed any further light in terms of what you've just outlined in terms of the other, I guess, characters that are behind these accounts, and if any other information you can provide this committee with respect to the Prime Minister's account, WeChat account being closed?
Well, this account, as I understand, is managed directly either by the office or the Liberal Party or a combination of either, so we'd have to liaise accordingly. What I'm saying is that in our discussions with Tencent, they've made references to the observance of the rules they have for transferring accounts. They're treating it as a term and conditions issue, which in its form appears to be right. In substance, who is the actor behind the transfer? I don't know. I'd like to get to the bottom of that, and I've asked Mr Kefford to have more inquiries made.
Are you satisfied with the answers to date from Tencent?
I'm satisfied that Tencent are engaging, but the extent to which they can disclose or elaborate or give us further and better particulars, and I say that only because of the...
Are you satisfied with the level of engagement?
The level of engagement, you'd have to say, is constructive.
I would, and I'd point out that the first contact from the company in relation to this matter was at the company's instigation. So they contacted the Deputy Electoral Commissioner on the day that the story was published, the 24th.
Yeah, and look, I do know there are a number of politicians, including the Treasurer, for instance, apart from the Prime Minister, who also has and continues to use, I think, WeChat. Does the department have any concerns with the use of WeChat?
In and of itself, it's part of free political communication, to use that constitutional term. It's something that members of Parliament, whether on the government side, the Labor side, any other side, are open and entitled to use. There's no prohibition or ban on it. And then there's a question of the terms and conditions that are applicable and whether those terms and conditions are in any way being, how shall I put this, manipulated or influenced for other purposes.
Do you have concerns, though? Do you have concerns?
Me personally?
So there's no advice to government to say, hey, look, I don't think you should be using this app.
On WeChat, Australians particularly.
But should politicians use WeChat?
I'm not here to give guidance or directions to members of Parliament as to how they wish to communicate. If the Director-General of Security has got a concern about interference, he will make that known, but the department has no view about what channels you as parliamentarians should be using. It's really
Does
up to
Home
you.
Affairs think it's necessary to pursue any regulatory or legislative frameworks for the use of apps like WeChat?
There's a larger question about social media and the intersection with electoral integrity. It is something that we, the Electoral Commission and other agencies, are looking at closely. I don't think it's got a direct bearing here. Mr Kefford will correct me, but I don't think WeChat itself is thought to be a vector of, if you will, foreign interference. It's an established platform. It's got payment apps. It's got communications.
So from your point of view, you don't
facilities.
have concerns to say we should not be using this app?
I don't personally, but it's not the job of the department to give that advice or to provide those assessments. Mr Kefford?
The only thing I was going to add, Secretary, is that with all of the platforms, the basic advice about understanding the nature of the platform, the nature of the terms of service, the way in which that can be used as it relates to individuals' activities, I'll draw that distinction from potentials for coordinated, inauthentic behaviour elsewhere, which is a different set of issues. But in terms of your particular question about individual communication, the key is that all users, not just members of Parliament, understand the terms on which they are participating on any particular platform, and they're all different.
Senator Ciccone, we will need to leave it there. I'm sorry, we are really out of time. Look, just one clarification, Mr Bozzolo. Can you rule out any foreign interference in relation to the Prime Minister's WeChat account?
Based on advice from the company, it appears at least prima facie and on its surface to be a terms and conditions matter that where
That
person.
wasn't my question, though.
Understood.
So if you could just address my question.
I couldn't rule it out completely, but on the surface it appears to be a terms and conditions issue. But sometimes things can be manipulated in a way that are, shall we say, opaque and nefarious.
And
I think it'd be ill-advised to rule it out.
Thanks, Mr. Pizzolo.
You haven't finished that, you haven't done any investigation.
Senator Keneally, you're wanting the...
No.
Thank you,
Okay,
thank you.
question
It's
of
an important
clarification.
point, though, Chair, and I think your question to Mr Pizzillo is accurate as well. But yes, technically the terms and conditions we all meet or we don't meet, but it goes beyond
Senator
that.
Ciccone, this is not a time for comment, so we do need to now move on. And I am going to call officers from the Department of Home Affairs in relation to outcome 2. So if those officers could come to the room, that would be very much appreciated. I'm now going to go to questions from senators, and Senator Keneally is seeking the call. Senator Keneally.
Thank you. I have some questions in relation to the Novak Djokovic matter.
Can I seek, Senator, just very briefly, some guidance and assistance from the Chair? Given that the Djokovic matter, and I'll just use that term, will straddle both the department and the ABF, questions to the department will largely focus on the visa issuance, and then there are other questions that relate to the cancellation, the detention. If it would help the committee, and I'm just going to seek guidance here, and I've spoken with the Commissioner ahead of time, if the Commissioner was able to also commence his appearance before this committee, then we'll be able to mix and match, as it were, our evidence. But he's not planning on being here until outcome 3, so I'm just seeking...
It's very easy, if I can assist the Secretary.
Yes.
I have actually organised my questions in such a way, so they're one's to you and one's to ABF.
Okay.
So
there will be some interplay, I have to say. But
I understand what you were seeking, Mr Pizzolo. Senator Keneally is seeking to ask some questions now in relation to program 2.2, which is visas.
Yep.
Yes.
So on that basis, I would invite Senator Keneally to ask those questions.
Thank you.
Great, thank you. So I will, to you, Mr Pizzolo, and to your department, did the Department of Home Affairs ever meet with Tennis Australia in person, electronically or by phone to discuss visas and the entry requirements for players and officials for the Australian Open?
Electronically, I'm almost certain of, because I've seen correspondence. Whether in person, I don't know. And we immediately hit a slight snag. The major events liaison function, which is both for the department and the ABF, resides in the ABF. So we don't compartmentalise our engagement with major events, whether it's Tennis Australia, F1, Formula One,
Okay.
surfing.
So I will raise that with the ABF.
We
when
do
we're
it
here.
jointly.
Okay.
But my officers are involved, so I don't want to shy away from that, but it's just done jointly through a process we describe internally as major events.
Okay, great. I will ask that I will save those for ABF.
Thank you.
The Australian government granted Mr Djokovic a temporary activity visa on 18th November 2021. This allowed him to come to Australia and participate in the Australian Open. What would have been the process for that application and decision? That is it computer generated or is it done by a human being?
So the subclass 408 visa in question, Ms Moy and potentially Mr Willard can assist. So Ms Moy is head of our immigration group and Mr Willard works for Ms Moy on immigration programs. Ms Moy, do you wish to have Mr Willard here as well?
He's coming.
Mr Willard's coming to your right.
Thank you. So the granting process, I think in part, is it automated? And you might just describe the granting, the processing elements.
So the application is applied for online.
And it's the decision is taken by an online process, a computer process? Is it reviewed by a human being?
It's a visa processing officer.
So a
Human
visa
being.
processing officer.
Human being.
A human being does do it. Because there had been some reporting it was a straightforward computer-generated thing. You applied and a computer ticked off and it was issued. So you're saying an actual human being would have actually reviewed it?
Yes, that's my understanding. And Mr Willard.
That's correct, Mr Willard?
Yes.
Michael Willard, First Assistant Secretary, Immigration Programs Division, yes.
So a human being did review it. Okay, good, thank you. Mr Djokovic's public statements about vaccination upon which the Minister for Immigration relied to cancel his visa on 14 January 2022, were made in April 2020, well before he was granted that visa on the 18th of November. Had Mr. Djokovic ever been on the movement alert list as a result of those statements?
Mr. Wyatt?
No.
Do you know offhand? Not to my knowledge, Senator. He wasn't on the movement alert list at the time he was granted a visa. Whether he was on the list in the preceding period, I don't think so, no.
Okay, thank you. So, the date of the Australian Open was well known, and Mr. Djokovic clearly and publicly stated his intention to come to Australia. So, if I'm correct in understanding, one of the most famous people on the planet wanted to come to one of the most famous tennis events in the world. He had well-known anti-vaccination views that contradicted government policy in Australia, and yet when he applied for that visa, which was approved by a human being, nobody thought to consider whether or not
the grant,
those statements might cause a problem or unrest or a risk to public health and safety in Australia.
So the grant relates to criteria that have to be met for the granting of a 408. There are two steps involved here. One is the gaining of a visa, and then for the fulfilment of the entry requirement.
I'm not asking about the entry requirements. I'm asking about the granting of the visa.
Understood.
I'm trying to answer your question.
A delegate can only have regard to the criteria that's as stated in the Act for a 408 visa. The Minister on cancellation has a wider discretion in the public interest to consider whether the presence of someone would, for instance, in this case, give rise to discord, would give rise to a detriment to Australia's good order, and Minister Hawke took that decision on that basis.
Yep. So how would it have been different if he had been on the movement alert list?
It wouldn't have made any material difference save insofar as this. If it had been a criteria or an element of decision-making that would have prohibited the granting or potentially barred the granting of the visa, then the officer would have given weight to those, if you will, sentiments or those considerations. But Mr Willard can go through the details. It's not germane to the granting of a 408 visa for those matters to be taken into account. It is germane, though, because a month later or 2 months later, you can turn up and say you're vaccinated. In other words, the barring...
I'm not asking about the entry requirements. I'm asking
Senator,
about
I
his statements, which is the reason I'm not entering into the discussion about the vaccination status.
I understand that. So the movement alert would principally relate to entry. We'll get to entry, no doubt, later under outcome 3. But in terms of the criteria that the decision maker has to have regard to for 408, would his statements earlier in the year have been at all material?
There's two considerations, two differences in the two decisions, I guess, Senator, that should be considered. One is the timing of the decision and the events that occurred in the passage of time since the visa grant decision. So different set of circumstances that are being considered.
And we'll come to entry later. So the Senator's asking us about the grant in November.
Yep. And the other element is that the grounds for cancellation that were used are different to the grounds for consideration for the grant of a visa, in terms of the character test that applies to visas.
Sorry, I have to ask a clarifying question there. Are you trying to say that if somebody applies for a visa, because they're a public figure and because they have made either public statements or committed a public act or done something, are you saying that your officers would not pause and say, gee, I wonder if we should let this notorious wife-beater or this terrible misogynist or this perpetrator of ISIS ideology into the country? Maybe I should flag this.
Senator Keneally, just so there's no confusion about the analogy you're drawing, you're just making
yes,
a
I'm just giving
hypothetical.
examples.
We're not referring in any way to any individual.
No, I'm not saying Mr.
thank you.
Djokovic. Mr. Djokovic's views are well known. I'm just trying to understand, are you actually saying whoever applies gets a visa and then we worry about the character later?
No, Senator, that's not what we're saying. In those examples you gave, each of those would be grounds to form a view that someone doesn't meet the character test. In this particular circumstance, in granting the visa, the decision maker formed a view that the character test was met, and the consideration in this ground was...
So just so I'm clear on that, you're now saying that the human being who reviewed the visa does have some capacity to consider whether the character test is met?
Yes, it's a requirement.
It's a
for the visa.
requirement, isn't it?
Public interest criteria.
Well, earlier there seemed to be some confusion. So it is a requirement that the human being has to consider whether or not the character test is met.
Correct.
In this case, they determined it was fine. He met the character test, clearly because they granted a
By
visa.
granting the visa, yes.
And how might that have been a different consideration for the person making that decision if Mr. Djokovic had been on the movement alert list?
So in a circumstance where someone is on the movement alert list, it depends on the reason for which they're on the list, and that will determine a different treatment in terms of that particular visa application.
Just take me through quickly the process for putting someone on the movement alert list. Who makes that call?
It can be made by a number of areas. It's maintained.
1 more minute, Senator Keneally.
It's maintained by the Australian Border Force. There are around, I think it's around 700,000 persons of interest on the movement alert list.
For a wide range of purposes.
Yeah, it goes, you know, to everything from issues around national security to circumstances where someone may have a debt to the Commonwealth, or there may be other concerns.
So, but for clarity, again, just so I'm clear, because there's been a little bit of confusion in the answers, and I do apologise if it's my questioning, but just so we're clear, Mr. Djokovic, one of the most famous people on the planet, has very strong anti-vaccination views. He applies to come to one of the most famous events in the world, our own Australian Open. He tweets that he's coming, he's got permission to come, and at no point, either from the point when he applied for the visa or the point which he tweeted he was coming, or at any point was he on the movement alert list, or did anyone think maybe we should cancel his visa on character grounds?
Well, if you're asking now about entry, which you said earlier you weren't, there was a very different line of engagement with Tennis Australia, where it was made abundantly clear to Tennis Australia that presentation at the board, and I do apologise because
I'm not talking about vaccination status. I am
Well,
talking about his anti-vaccine posture and public statements, which is the basis for the visa cancellation.
I understand, but in terms of entry, which also relates to both vaccination status as well as issues of character, some of the time points that you're referring to are subsequent to the grant, because they have to do with the tweet, the arrival, the processing at the airport. We'll get into that, no doubt, under outcome 3. Indeed, quite. In terms of the grant, so let's limit ourselves to what's in your direct knowledge, Mr. Willard. Had an alert been in place, you would have got to the same place where a delegate would have had to have been satisfied. Because what an alert does is push an issue to the delegate. It says, hey, have a look at this. Mm-hmm. If the delegate had any different material before them, I guess that's pertinent. But if they considered the same material and they still formed a view that the character grounds were not in any way infringed, the grant would have proceeded, correct? All other criteria being met.
Correct, bearing in mind the decision...
So what difference would being on alert have been in that circumstance if no new information was tripped by the alert?
Well, if there was no new information available, it would have been a similar decision. He would not have met the threshold of not meeting the character test.
But he met it when the minister decided to cancel his visa.
Following the passage of 2.5 months and a whole series of events in the interim.
It's a whole series of events. That's a very tactful way of putting an absolute colossal cluster at our border.
But the point is, it's a time
I don't
decision
think Mr. Willard was
consideration.
trying to summarise that in those terms, just to be fair to Mr. Willard, but he talked about the passage of time and events.
And federal court overturning decisions and the like. That's what the events are.
Well, the federal circuit.
I'm just trying to explore if the government had been aware and alert to the fact that a person with anti-vaccination views, a famous person with well-known anti-vaccination views, was intending to come to Australia and thought to put him on the movement alert list, or thought about whether or not he posed a risk to public health and safety, this whole sorry saga could have been avoided.
Well, in the alternative, had Tennis Australia followed up on the directions and guidance given by the government that if he...
Has nothing to do
Senator
with Tennis
Keneally,
Australia,
Senator Keneally,
this
with
line
res-
of
with
questioning.
respect, Senator...
Could I just add half a sentence?
It really doesn't.
Senator,
But except
could I
if
just,
he-
conflating
Mr.
issues.
Pizzullo,
Sorry, Chair.
if I could just ask Senator Keneally just to pause. I do appreciate we want succinct answers from all officials, but Mr. Pizzullo does need to be given an opportunity to answer the question. Mr. Pizzullo, and this is the last question.
If
It
he'd
will be then
presented as being vaccinated in early January, the issue would have been rendered moot.
And respectfully,
Senator
just because you don't want to talk about the...
No, I'm going to ask questions about it.
And that's
it's
fine.
not, but that's not relevant to the
Well,
reason his visa was cancelled, Minister.
Respectfully,
I'm exploring the reason his visa was
Well,
cancelled.
Senator Keneally, just
I've been
because
told I can't ask these other questions until Australian
you also
Border
can't talk
Force
over
are
me,
here.
and you're insisting on doing it.
Look, I would
Well,
ask...
because I'm
I would ask
seeking
both
relevant
Could
answers.
I just ask for some order? What I'm proposing to do is now give the call to Senator McKim, and we will then share the call around after that. Senator McKim.
Thanks, Chair. I've got some questions around the Minister's announcement relating to visas for Afghan nationals. The announcement was made on the 21st of January.
I'll just ask Ms Moy to be joined by Mr Wilden.
Thanks. So firstly, the Minister's release says that Australia will give priority in the humanitarian program to, and then there's 4 dot points in the release. One of those is subclass 449 holders, current and former, and their immediate family members. What does give priority in the humanitarian program actually mean?
Well, to do with the sequencing of how we consider applications. Ms Moy, do you want to answer that, or do you want to go straight to Mr Wilden?
I think you've answered it, Secretary.
Oh.
That's correct. The priorities are the sequence of processing.
So sequencing.
Okay, so that's actually not what it says. It says give priority in the program. Other statements from the Minister have spoken about priority assessments. This one doesn't mention the word assessment. Is that an oversight, or why is the phraseology different in this compared to other statements that the Minister has made? And isn't it fair for a reasonable person to interpret that, giving priority in the humanitarian program, to mean that they will get first dibs on the spots that the Minister's offered?
Well, as a matter of law and policy, I understand what you mean by first dibs, but it's not a term of legal or administrative art. But if in sequencing, as a matter of priority, the applications, each grant still has to be considered on its facts, so the grantee still has to meet all the relevant criteria. So I don't think any reasonable person would think that the Minister's giving a direction that somehow the weighting be changed, so that it's, if you will, easier for a grant to be made. I think your officers, Mr Wilden, would not be operating on that basis. But in terms of prioritising the caseload, if you will, putting the file at the top of their pile, is that perhaps the better way to describe how you're proceeding? If I could just to assist. Yep. In a separate message from the Minister entitled, in a message from the Department to the Afghan Australian community on the same day, so these were, statements made effectively contemporaneously, the department has said processing priority will be given to, and then there's a series of dot points, including subclass 449 visa holders, current and former. Yet the Minister's release of the same day says Australia will give priority in the humanitarian program to. Now, those statements are different because the department says there will be processing priority, and the Minister has said priority in the program. I understand.
Why the difference in language is my question.
Well, I understand the parsing. It's, I think they effectively mean the same thing, because there's no way otherwise to, if you like, re-weight your criteria such that a grant is more easily made to a certain group of people than others. It is about processing priority. Mr Wilden, is that?
Yeah, correct. David Wilden, First Assistant Secretary, Refugee, Humanitarian and Settlement Division. That's correct, Secretary. The language was different, the intent is the same. What we are saying is that the identified groups will be considered as priorities when we are looking at I guess you'd say during the triage process, drawing those to the top of the list, as the Secretary have said, for consideration.
Which effectively means as grants are then given and as places are then taken within the program over time, that processing priority will see, if I can use the term stock, a larger number of people take up places within the program from that group, so they don't get any special they don't get any special consideration because of the group they're from, but simply as a function of processing them as a priority, more visas will be granted to that group.
Because if they're in those groups, they will be processed before, their applications will be processed before people who are not in those groups.
It's a sequencing.
Is that accurate?
Correct. It's about, so we go through, we have applications rolling in all the time. They are receipted and identified as being a lawful application. That's a very important step in the process.
Yes.
Then as we get a large number in, we have triage activities which go to the identified priorities that the Minister has said. Okay. We then draw them out, they go to the processing teams, they then start. Then we move on to the next group of receipts, and it's sort of this rolling program. People who may be applied later, who are in those priorities, will move ahead of other people who are not in the priority groups.
Thanks, Mr Woodden, that's clear. Obviously, given there were a large number of people who, Afghan nationals who were granted 449 visas a while ago and whose visas have expired and who are still in Afghanistan, it's not difficult to presume that there may be some challenges in terms of putting a substantive visa application into the department. So, can I first be clear with you? There's no cut-off date for applications to be made in those circumstances.
Correct. There's no cut-off date.
No cut-off date. So if someone's application landed, today or next week or next month, and they were in one of those groups that the Minister has said and you've confirmed will be given processing priority, then they will, as I think you've just given evidence, they will move up, and their applications, even if they were made significantly later than someone who's not in those, an application made by someone who's not in those groups, they would be assessed as a priority and before an application that was made from someone who's not in those groups, even if that application were made significantly earlier.
Subject to meeting the first threshold of being a lawful application and including everything. Yeah. And then I want to also be clear, every application, the decision is on the merits of each case.
Of course.
So it's only about the processing priority.
Yep. All right, thanks. Now, can I just ask, do you know how many Afghan nationals who formerly held 449 visas are not yet in Australia?
It's a bit of a moving feast because we've obviously been, since the evacuation, new visas are granted, so the stock gets higher and higher. But let me go to my table.
Thanks.
So there were 7,186 invitations were given. That's from the beginning of the program, starting with the evacuation through to now.
Do you mean by invitations?
Invitation for a visa. Of those, 6,043 were granted.
And were they all 449s? Sorry, Mr.
These were only 449s I'm speaking of now, yes.
Yep.
So of those, 6,043 were granted and 4,927 have arrived. So it's about just under 1,100 who had visas granted who haven't arrived, and there's an additional 1,000 that, particularly in the final days of the evacuation, 449s were put out that we haven't subsequently had any contact with, so haven't had a visa granted at any point.
Okay, so that last group, are they caught in the priority processing?
Correct.
A group for priority processing?
If they received an invitation from the Minister, they are accorded the same equal status of someone who was granted a visa.
All right, thanks. So how are we, and by we I mean you, how are you going with the processing of these? How many applications do you have on hand from Afghan nationals? How many have you assessed? How many have you granted? Are you just able to give a general update, please?
So in terms of a general update, we've received and receipted, as in deemed to be lawful applications, it's about 55,000 now, applications, generally for the XB class visa.
For which one, sorry?
The XB, so the refugee humanitarian visa. In terms of how many of those have been processed, obviously one large subset are the 449s. The first ambition was safety, so getting people to Australia, we got through the numbers that I read out earlier. 4927 are here, and they have their temporary visas, which will take them up to November next year. And happy to talk if you want about the process for the rest of the year. So the letters of invitation have started going out to those to put in their permanent applications. Additional funding has been provided to the legal sector to help people put their applications in.
Is that only for the cohort in Australia?
At this stage, I'm talking about the cohort in Australia.
Yep.
So for those 4,900, they will roll out in the hundreds every week. We have to be aware of the sector's capacity to actually put those applications together.
Yes.
They go out. What happens is we send a letter saying you have 30 days to get your application together, at which point we will notify them that the bar will be lifted to put the application in. So we meet regularly with the sector on that process. During the 7-day window, when the bar is lifted, they then put their application in, and then it goes to processing. The processing for those visas, while the people are onshore, they are being processed as offshore visas so that they can continue to get settlement services as if they had come through the offshore program. For those people, once they put their application in, we don't anticipate that the normal period of 6 to 9 months will be required. We've already given them medicals, for example, so we front-loaded a lot of activity in advance of receiving their application. But again, each one will be done on its merit. Some will be very quick, some will take longer based on documentation, identity, those sort of things that we need to verify. So that's that half of the program. In terms of how many of the 5,000 have been already done, it's just over 1,000, and they are a blend of those that were granted in the lead up to the evacuation, so a large number of those, but not totally, were the locally engaged staff and their families. We've also granted, in that subset, several hundred since the evacuation, and they are continuing to roll out. With the 5,000 places in the program available, what we're doing is working through the...
I'm sorry, could I just stop you?
Yeah, sure.
Mr Wooden, sorry. When you say 5,000 places in the program...
So in this year's program, the Minister has announced there are 5,000 places for Afghans.
So that's within our existing humanitarian program?
Correct, yes. So what we are doing is working through, if you like, the different elements of the program with those who are currently offshore, those who are onshore and considered offshore visas, to, if you like, land the 5,000 places by 30th of June. That will be a blend of the 4,900 who are onshore, and some of those will roll into next program year, and the rest will be for people who are currently offshore.
All right. Thanks. So you've got in total about 55,000 applications all up.
Sorry, 55,000 that are applications that are deemed, if you like, have already been through the assessment. It's significantly more applications that have arrived in email, but they haven't actually been through that first step of being certified as a legal application.
Yep, all right.
There's about another 100,000 behind that.
Okay, so you've had 150,000 odd applications. You've deemed about 55,000 to be
received as
lawful applications. You've granted, am I right to say, just over 1,000?
Of the Afghans in the program, yes, we've granted 1,000.
Yes, yep. But it is your intent to land the first year's worth of visas, being 5,000, by the 30th of June?
Correct.
Yeah, all right. Now, can I ask, do any of those figures include the Afghan nationals who were already in Australia on temporary visas at the time of the fall of Kabul?
No.
Okay. So what's happening to those folk, given that the government has given a commitment that no one will be forced back into danger in Afghanistan? What arrangements are being made for those folk in terms of either extending their visas or, preferably, at least from my point of view, putting them on a pathway to permanency?
Sure. The process for the IMO legacy caseload, we have decided, I think it's 29,000 now. There are about 2,000 who have not got a final first decision, Everyone else in the program has had a final first decision. A large number of those are now on TPVs and CHEVs. A smaller number are in various stages of appeal, who may have failed and have appealed, and around about 2,000 who we've received applications from that don't have that final decision. Any of those in Australia on a lawful visa continue as such. Any of those whose visa is ending, as in their 3 years or 5 years are up depending on the visa, that visa is extended if they have put in a subsequent application. We do have the odd occasion where the visas have lapsed and they haven't, and we then work with them to get in contact with the department, and we will go through a subsequent TPV or CHEV process with them.
All right, thanks. And what about people from Afghanistan who are currently either in Papua New Guinea or Nauru, so they'd be part of the offshore cohort, or who are part of the offshore cohort who are currently in Australia? Given the changed circumstances in Afghanistan, is there any change in the approach to those people?
I might have to ask a colleague to come to the table. I don't look after the offshore caseload.
Okay.
I can respond to that.
Yeah, thanks.
Thank you, Senator. So in terms of those who are onshore, who are transitory persons, their situation remains the same in terms of no pathway to permanent residence, and they will either remain in their current arrangement. So some of the medical transfers are some in community detention or residence determination, some in held detention, until such time as their pathway to return to a regional processing centre has been taken, or until their process within the US engagement program has come to fruition. So whether that's a positive or a negative pathway.
All right, thanks.
Senator McKim, we're going to have to move to other senators.
I'll just ask one
just
more.
make this the last question,
Yep.
please.
I do have some other questions in this outcome, Chair, just to flag with you. But can I ask in regards to, and I think this would be one for you, Ms Moy, in regards to people you would describe as transitory persons, people who are from the offshore cohort but are currently in Australia, if they are released from held detention, either in an immigration detention centre or in an alternative place of detention, and if they're released into community detention, does their visa status change?
So if they're released into community detention, their visa status is the same. They remain as a transitory person. The issue is that the arrangements for community detention have different levels of security compared to that for held detention. So in residence determination, there's still arrangements whereby individuals need to stay each day and each night at that house or property unless they receive approval not to. So
and are they conditions of their?
They're conditions.
Are they attached to the visa?
They're attached to the arrangement to be released from held detention. So the visa still remains as a transitory person with the intent to be only here for a temporary purpose, and once that temporary purpose is finalised, then to return to their regional processing country or to somewhere else where they have right of entry.
Oh, thanks.
Thank you very much, Senator McKim. I'm now going to give the call to Senator Scarr.
Thank you, Chair. And I have some further questions following on from Senator McKim in relation to the Afghanistan situation. Mr. Kefford, you said that of the 459 visa holders, or those who were issued 459s, 1,100, I think you said, had not arrived in Australia. Is that correct?
The 499s.
Sorry, the 449s.
Yeah, so that's so yes, that's correct. Around 1,000 have not arrived who were granted visas. We are getting arrivals all the time. In terms of the initial evacuation, there were 2,668 449s during the evacuation phase who have arrived in Australia, and there's 2,259 have arrived since then, and they arrive regularly through charter flights organised by the Department of Foreign Affairs or through commercial means where they, if you like, surface in other countries where they've managed to escape to.
And Senator, if I might, just for the accuracy of the Hansard, it's Mr. Wilden giving evidence. You might have said Mr Kefford. I tell them apart because one's bearded. So Mr Wilden is at the table.
Sorry, Mr Wilden.
That's perfectly right.
Corrected. I'm a long way away, but I can see you on the video, so I've got no excuse.
I just wasn't sure. Sorry, Senator.
No. So do you know how many of that 1,000 who haven't arrived, how many are in the UAE, say, how many are in Pakistan, how many are in Afghanistan? Do you have any granularity with respect to where
So
they are?
look, not until they come to our attention. It's sort of a bit of chicken and egg. We know they haven't arrived here. We know that there are a number of people from Afghanistan regularly crossing borders. It's something that certainly the Department of Foreign Affairs in relation to those 449 holders do not recommend because of the safety issues, not only of the transit but also arriving in countries illegally can have poor consequences. We do know, however, there are 449s currently residing in Pakistan. And some of those we are preparing to uplift to Australia. We know that some have made it into Iran. That's a little bit harder in terms of flights. And again, we just every now and then we find people coming up all over the region and further afield, but in much smaller numbers. But it'd be safe to say a large number would probably still be in Afghanistan, but we just can't affirm that.
Okay. And when you were answering Senator McKim's questions, there was another cohort you mentioned, 1,100, I think, 449 visa holders who were not accounted for, or it wasn't as clear because there was a process going on towards the last few days of the evacuation, and we all know what was happening during that time. It was very, very difficult. Can you just explain who was in that cohort from your perspective?
So that group was a group where the Minister agreed to offer a 449, which is the process, unlike many visas where someone approaches the Australian government to apply for a visa, the 449 is actually offered by the Minister and then they accept the offer. There's a group of 1,000 to 1,100 that were, a letter was sent out by the department on behalf of the Minister with his authorities to say you are being invited. However, they didn't make it into the airport in Kabul during the evacuation. They dropped off the scene in terms of not having any further communications. We didn't automatically grant a visa at that point because we didn't know where they were, we didn't know what their circumstances were. We have had a number of people who got out on other flights done by partners to other countries. We know some of those people were in that group, etc. So what the decision was, given they were only 3-month visas, were if they hadn't been granted the visa at that point, we have a record of all those people who the letters were sent to, and in the event they do come to our attention later, a visa we can go to the Minister at that point and seek a visa be granted.
Okay. Well, look, I want to move on to another related topic, but if I can just really give my compliments to everyone in the department who's been working on this. It's just been a superhuman effort from my perspective. I'm close to the community in Queensland, and it's just been incredible work done by the departmental officers. So if I can convey my deep respects in that regard. I'd like to talk about the services which are being provided to the recently new arrivals in terms of assisting them to transition to life in Australia in terms of settlement.
So for those people who arrived, and they were, the largest group obviously was the 449s, we also had a number of other visa holders. We had people who had applications in 4 other visas, for example, partner visas, and we had some permanent residents and Australian citizens who arrived. For that first period when they were coming in very large numbers, they were going into primarily 75% went into Sydney and Melbourne. Other states took smaller numbers. The decision was made that we would provide that, first of all, quarantine and then immediate set-up services or settlement services to everyone. That was in those initial weeks. Since then, obviously, people who have other visas or Australian citizens have then gone about their lives. For those people who are entering for the first time on 449s and will be applying for other permanent visas, primarily refugee humanitarian visas, They entered the settlement program, and it goes back to my earlier answer to Senator McKim's question around why are they offshore visas. We don't, under the current legislation, we can't provide settlement services to onshore visas. So by doing offshore, they get the traditional settlement services provided to all refugees who come. That goes to, we have 4 settlement providers around Australia, and in essence, they become responsible for settling these people into accommodation. We get them their Medicare cards, we introduce them to job networks, we get the children into school, they have house lots provided for their accommodation. It has been fairly difficult because a large group, for example, arrived in Melbourne when Melbourne was in lockdown. Therefore, when they came out of quarantine, getting them into accommodation was challenging. So a number of them spent a bit longer than usual in what we call temporary accommodation, such as the university houses, etc. We've now got most of them into their permanent settlement houses, and that's a large group down sort of Dandenong Way, others around different parts. We try to keep, obviously, where there's connections with family, we try to keep those in the forefront of our mind. So the majority now of that, other than those who've arrived very recently, so if we go back to anyone who's arrived before Christmas, having done their quarantine, they are by and large settled in their new houses. They have their access to healthcare. We've been through processes to look at, if you like, what we would call the extended services such as NDIS and access to HECS, which comes when someone becomes a permanent resident, and we're talking to the universities and we're talking to agencies around access to services for someone on a temporary visa, given it might be a little while till they get a permanent visa. But it's been a fairly comprehensive effort to get these people in place with the normal services. The only other thing I'd add is we've also... Yes, sorry. Sorry, go on. I
was just going to ask, many have been through trauma that is very difficult for, certainly difficult for me to appreciate the extent of what they've witnessed. They have family and friends still in Afghanistan under living in very difficult circumstances, and certainly some of the families I've spoken to are suffering a great deal of mental pain. What are we doing to provide assistance in that regard in particular?
Sorry, yes, I was just about to go on to those elements. There are additional packages beyond what I described with the standard settlement services that we give to refugees. What the government has also done has announced additional support for this cohort, and the settlement support package for Afghans had several elements. The first I mentioned was the access to legal services, and the government provided it was $6.4 million to legal providers to help with the preparation of applications. We've also provided, to your particular point around torture and trauma, $7.9 million additional funds to providers for counselling services, and that's not just for people who have just arrived. There is an awful lot of, if you like, vicarious trauma or triggered trauma across the Afghan sector for people who've come in previous years who may still have family members in Afghanistan or in difficult circumstance. We've also provided an additional $4.8 million looking at, for these new arrivals, for skills recognition, education pathways and employment. This is a slightly different cohort than many of the refugees that arrive. We have a lot of very highly skilled people, a lot of people with very good English language skills. We want them to be able to leverage off the capabilities they have. So setting up this bespoke service around, a lot of them want to start their own businesses or get straight into employment. We want to accelerate that where we can and not let them take perhaps the slower route for people who've come with lower English, lower education levels. And the last one, just in support of the general settlement services, $8 million is also being distributed to community organisations to help them get involved. They do an awful lot for the sector anyway, off their own bat, but obviously the additional funding will help them do a little bit more to help people in need.
Senator Scarr, I'm sorry, we will need to move to other senators. We have gone over your allocated time. But thank you so much, Senator Scarr. I'm now going to give the call to Senator Keneally.
Thank you. I do want to ask some questions about the digital passenger declaration, but before I do, can I just go back to the issue of the visa and just confirm that it is indeed a human being that makes that decision?
Correct.
Because the Treasurer, Josh Frydenberg, on the 17th of January told David Koch on Sunrise that it was a computer-generated system that granted him the visa. I'm happy to table the transcript if I need to, but I just think it's important not to take perhaps advice from Josh Frydenberg on this matter, but to actually hear from the department. It was not a computer-generated process.
Well, it's an individual. I'm not quite sure what the minister may have been referring to. He may have been referring to the computer-generated letter of advice, but we can go back and check the transcript and
Well,
find
David
out.
Koch asked, well, the average Australian would be thinking, why shouldn't you have to prove that to actually get the visa in the first place? And Josh Frydenberg said, well, again, as you know, we get lots of visas and there's a computer-generated process.
Senator Keneally, would it be possible to table that document?
Sure, I'm happy to. I just think it's, I'm just wanting to confirm that I hadn't misheard you, Ms Moy, that it
Ms
is a
Moy, do you
human
need
being.
to have a copy of that document to answer that question?
I'd be happy to see a copy of the document to see what the actual
Sure,
wording is.
but really my question is, it was in this case a human being.
We know certain positive.
Yeah, that's the only question I really needed answered.
And, yes.
Thank you. On the digital passenger declaration, and can you just remind me again, so you said that this will be operational on Friday? Is that what
Tomorrow.
from tomorrow?
So it goes online tomorrow, it goes live tomorrow.
Yep.
But obviously, because of the way bookings occur, we've decided to program in something of a grace period, so up until the 18th, which is Friday.
Yep.
ATDs will be accepted. What we're stating on our banner and on our website channels otherwise is that if you are intending to arrive from the 18th onward, please use the DPD channel.
Please, or it's a requirement?
It'll be a requirement in the sense that at some point the ATD will be switched off, so you'll only be able to go.
When will that point be?
Unless now you're doing permissions,
Mr.
Mr. Milford. When does the cutover occur? So the cutover from the ATD to the DPD when it's completely closed.
Indeed, Senator. Mike Milford, Group Manager of Technology and Major Capability. So the Secretary is correct in saying his details. As of the 18th, people will be required to fill out a DPD. With the ATDs, past the 23rd, flights will no longer, of February, flights will no longer be available on the ATD for people to select. So basically what happens is that those who have filled out an ATD prior to tomorrow have a week's grace, basically, because you can fill an ATD out 1 week in advance, but people will find if they attempt to that they can't fill out an ATD because they can't select flights past that date.
Thank you.
So effectively there's a week period.
Thank you. The incoming minister brief for Minister Hawke in December 2020 stated that the new digital passenger declaration incorporating COVID-19 declarations would be available from July 2021. Why didn't that happen?
In December 20, I'd have to go back to the coming brief. I think at that point we were assuming that budgetary approval would be given in February, March, from memory.
Indeed, budgetary approval wasn't given at that stage.
I think our budgetary approval, just trying to think, was June? Was it June?
It was
21?
28th of June, 2021. We were given a budgetary approval. We then signed a contract for the DPD on the 6th of September.
So the state of the department.
That's all very helpful, but it doesn't answer the question why. Why didn't it happen by July?
Well, it directly explains it because based on our best state of knowledge to Minister Hawke, did you say December of 20?
December 2022, incoming brief. New digital passenger declaration incorporating COVID-19 declarations will be available from July 2021.
So our advice to Minister Hawke would have been based on our best knowledge at the time. Obviously you have to go through a budgetary process. The timing of budgetary decisions are a matter for government. Obviously subsequently facts changed.
Incoming minister brief from Minister for Home Affairs, Karen Andrews, of March 2021, stated it would be available from November 2021.
And again, based on...
Why didn't that happen?
Based on the best information we had when Minister Andrews took over from Mr Dutton, we were anticipating budget decisions being taken at a particular time. That would have allowed us to enter into contracts at a particular time. That would have...
So you're saying government didn't allocate the money?
Correct. it requires a budgetary decision, and the budgetary decision that's pertinent here was taken in June of 21.
So wait, the budgetary decision was taken in June of 21.
2021. I
Yes,
should say.
28th of June 2021.
Thank you.
Right. Okay.
So when Mr.
So
Hall came
yes,
into
so they
the
didn't take.
portfolio, sorry.
So when you told the minister in March 2021, when were you anticipating the budget? When you told her in March 2021 that the card would be available, or the declaration would be available from November 2021, when did you anticipate the budget decision would be taken?
During the budget,
And it wasn't, it was taken
No.
later. So it was a decision of government
taken after the
that
budget.
delayed the funding getting to you to get the card, the DPD in place in
It
time.
was a decision of government taken after the budget had closed in May of 21.
Then again, in response.
May 2021, I should
Yeah,
say.
in question, so when was the budget, when was the money allocated, in the budget or in June?
It was decided in June, which meant that
Right,
because you're still ahead
okay.
of the financial year, the money became available from the 1st of July, which was only a few days
Yeah.
later. So
In
it would
re-
have been a super heroic effort to go into contract and deploy the technology within 3 days.
Well, it's pretty heroic to be advising incoming ministers that you're going to have something completed
No,
when
it
it's
was a
now
completely
over 6 months overdue.
It was a non-heroic act. It was based on the best information we had from Centrals as to when matters would be considered.
Maybe you should have conditionalised those targets a bit better.
Senator
Again,
Keneally,
in question, in response.
is that a question?
I do have a question, thank you, Chair. In response to question on notice SE 21140, the timeline then moved to December 2021. So we're now going to see it roughly as the borders are opening on the 21st of February. I note that the Minister Andrews in September told the Canberra Times that the DPD will support the safe reopening of Australia's international borders by providing digitally verified COVID-19 vaccination details.
Yes.
And Mr. Pizzullo, in previous budget estimates, you said in regards to the digital passenger declaration, we're going to have to bake in and build in health information into that declaration, and there's no point being told that when you're an hour or two out from landing.
Yes.
How would the Novak Djokovic situation have been different had the DPD been delivered on time, that is, the timeframes you told Minister Hawke or Minister Andrews in their incoming briefs?
When the system is fully built out and fully integrated with all of our other alert systems, it would provide the Border Operations Centre and the officers manning the primary line as well as the check-in point, our officers forward. It would have given them an automated view of what the traveller contended in their declaration, and that includes instant access or near instant access to supporting documentation.
And when would they have had that access to that information? Before a person got on the plane?
When the DPD is fully built out, noting that there are a number of steps to still go to integrate the incoming passenger card and also to create automatic linkages to certain other databases, which are still a few weeks or a few months off. If we had a time machine and travelled back in time, a fully functional DPD with all of the parameters set to interrogate not just the declaration but supporting documents, would have alerted or would have tripped, to use our internal parlance, much more quickly than an ATD would, yes.
Sorry, that with respect, does that mean you would have known before a person boarded a plane to come to Australia?
In terms of real-time support to decision makers, and I'll get Mr. Milford to explain the technical magic by which this occurs. Once the DPD is integrated both with, I'm going to use a few acronyms.
When does a
here.
person fill out the DPD?
So you can fill it out up to 72 hours prior to travel, if not earlier. When we're fully integrated, the incoming passenger card, which is still a technology step still to go, and then also integrated it with our border systems, we can set the rules such that officers are alerted not just to the declarations that are made, but also supporting documents.
So before they get on the plane, because they
Yes.
fill it out 72
Yes.
hours
Yes.
at a minimum
Yes.
before they get on the plane.
And
so when that full integration happens, you would have real-time information and you would be tripped that somebody who does not meet our vaccination status is intending to come to
Correct, and
Australia,
there's some
and then
technical
that
magic.
person can actually be denied what?
Well, there's a separate question there of power. So
Yep.
at the moment, the determination that's made pursuant to section 44...
One more minute, Senator Keneally, and then we'll need to go to afternoon tea.
Senator, the declaration that Mr Hunt's made pursuant to section 44 of the Biosecurity Act requires that you provide evidence of your health status.
Yep.
It's not a bar itself because...
So what happens if someone doesn't provide that evidence? That is the crux of my question.
Understood. So the policy is that you have to be fully vaccinated, and I dealt with that earlier in terms of the ATAGI advice as to the TGA approved or recognised vaccines, or that you have a medical exemption that says that you cannot be vaccinated, you're precluded from vaccination, anaphylactic shock.
Yes, I
VFA
understand.
Or if you're unvaccinated, this is where states and territories kick in, that you've got a place within
Quarantine, yes.
within their very limited, but there are places for unvaccinated persons to come to Australia.
Please,
so the
Mr.
officer,
Pizzullo, the chair has been really strict on time, and I am trying to understand what happens if someone fills out the DPD.
and it trips one of those categories, the officer then still has to make a decision based on, because the bar isn't on
And
prohibiting...
what are their options for decisions?
So if they're fully vaccinated, no issue. They're broadly exempt. If they've got an exemption, the officer has to interrogate the nature of the exemption. Is it one of the permanent conditions?
Yep.
Recent infection, I know we're going to talk about Tennis Australia later. Recent infection is not one of those conditions, so that gets dispensed with. The only remaining category, I'm unvaccinated and I have a commission exemption and I have a place in quarantine.
I'm unvaccinated, I don't have a place in
Senator
quarantine.
Keneally,
What happens?
I know
I'm
you-
sorry, Chair, but this is the fundamental question I've been
Senator
trying to get an
Keneally,
answer to
then
for
the-
the last 4 minutes.
Then the
Please,
airline...
Mr. Pizzullo, just answer my question.
Then the
Okay, I'm
airline-
just going to, just to help Senator Keneally, could you just state again your question, Mr. Pizzullo, if you then could answer it, and then we will need
Thank
to
you, Chair, I really appreciate
move
that.
to
Thank you.
afternoon tea. We're running late.
So unvaccinated?
Unvaccinated, doesn't have a quarantine space, fills that out on the digital passenger card. What happens?
Airline is advised not to uplift.
So in Mr. Djokovic's case, it is possible, had the DPD been in place, the airline would have been advised not to allow him to uplift.
With real-time interrogation, not just of his declaration, but the supporting documents, it's hypothetically possible, yes.
And when is all this integration actually going to happen? Is it going to happen next week?
Mr Milford?
Senator, there are two more releases. There's a release tomorrow, then there's a release in April and a release at the end of June. At the end of June, the DPD will be complete and will be integrated with our back-end systems. The greatest difficulty we have is not in the form, it's actually with the integration with the back-end systems.
So that integration at the end of
Senator
June.
Keneally.
I'm just trying to get clarification. Thank
correct,
you, Mr.
Senator.
Milford. I appreciate your short answer.
Thank you.
Thanks, Senator Keneally. We are now going to suspend for afternoon tea, and we will return in 15 minutes. Thank you.
Thank you.
Now in session, we are continuing with outcome 2. We have no one at the table at this point in time.
It's not a good sign.
So while officials come to the table,
You've intimidated them.
Yeah. I'll just indicate, Chair, when Labor
yes,
gets the
Senator Keneally.
When Labor gets the call again, I would like to see it. Thank you.
Thank you. All right. Well, thanks, Mr. Pizzullo. And I'm very pleased to give the call to Senator Thorpe.
Where's the minister?
I'm sure the minister is just a minute
I don't
or
think.
two
Can we
away.
start with that? Carry on.
Thank you, Chair. And my question's relating to the innocent Aboriginal people that are being locked up, incarcerated and tortured for no good reason. So in the case of McHugh and Minister for Immigration, the federal court found that once a non-citizen held in immigration detention puts in issue their Aboriginal identity, they cannot continue to be detained unless and until the government disproves their Aboriginal identity. How is the department implementing this decision?
In the first instance, I just want to refresh my memory as to what McHugh found. It's very much in accordance with the summary you've given, but the General Counsel will attend, and then I'll ask other officers to speak to how that's been given effect. So the case was McHugh, wasn't it?
Yes. That's correct.
McHugh, yep.
Pip DeVoe, General Counsel, Department of Home Affairs. And Senator, you're exactly right that the case of McHugh, which was, I think, determined some while ago now, was the first case to deal with the state of the reasonable suspicion that the detaining officer must hold and where the onus of the proof as to that suspicion lies in the context of litigation around a declaration as to whether a person is subject to the provisions of the Migration Act. So nothing has changed since that decision, other than to say that in accordance with it, those people who are still in detention, who have raised claims as to their indigeneity, are going through a process whereby, as part of tied work with Australian Government Solicitor, the basis upon which that claim is assessed is given to the Australian Government Solicitor and measured against the tripartite test as set out in Mabo 2. And where a person is either found to meet that test, then they are clearly immediately released from detention. Equally, if they probably meet that test, they are then immediately released from detention. And I say probably because it's a reasonable suspicion as to detention, and so even though it might not be established fully at any given point in time, as soon as it's established with some probability, then it can't be justified that the detaining officer maintains that reasonable suspicion.
Thank you. So why haven't the 25 people still in immigration detention who have asserted their Aboriginal identity, why haven't they been released while the department is considering their claims?
Because having raised it, the evidence does not yet meet the level where that reasonable suspicion is displaced.
So who decides Aboriginality in this country?
Well, the question is Aboriginality for the purposes of the application of the provisions of the Migration Act.
So
which is,
who decides?
Well, I think it's really important to understand that that's a small subset and it's not purporting to be determinations about people's indigeneity more broadly. So the assessment as to...
Senator Thorpe, could I please ask
Yes.
you to pause
Thanks,
while
Chair.
Ms DeVoe answers the question. This is a complex area of law, so please give Ms DeVoe the opportunity to answer the question.
Sure.
So for them to be continue to be detained, there needs to be an officer of the department who holds that reasonable suspicion, and that is assessed as against evidence as required by the Mabo test in conjunction with the Australian Government Solicitor because it's tied constitutional work.
Thank you. So how many people asserting Aboriginal identity have had their visas cancelled?
Ms Moore, do you have that information to hand?
Senator, what I can tell you is as at 31 December, we've got 21 people in immigration detention who are being assessed as to whether they meet or probably meet the tripartite test.
So how many?
21.
21 people asserting their Aboriginal identity, so the department's still holding them until when?
They're being assessed as to whether or not they meet or probably meet the tripartite test.
So since the 31st of December, has that been?
That's the figure as at the 31st of December. There are 21 people.
So how long have you been assessing these Aboriginal people for?
I have to take that on notice in terms of the individual 21 people. We'll all have different timelines.
Sorry, just for clarification here, Ms DeVoe, can I just ask you to explain briefly the tripartite test and why this is relevant in terms of Senator Thorpe's questions? Because we've obviously discussed this before, but I think it's important for the record for everyone to understand precisely what this is.
I'll do that. Point of order just on procedure, Chair. Are you seeking the call now, or is it still Senator Thorpe's?
Senator Keneally, there's no point of order. I'm asking for Ms DeVoe for a clarification.
I'm seeking clarification on your...
There's no point of order. Ms DeVoe, you have the call. Thank you.
Well, I did, excuse me, Chair, but after last estimates, I sought the clerk's advice about the role of the chair and whether it was the role of the chairs to interrupt senators in their questioning, and the clerk's advice was very
Senator
clear.
Keneally,
He referred me to Privilege Resolution 110, So yet I'm seeking to understand, are you aware of Privilege Resolution 110? And are you taking Senator Thorpe's time? Are you interrupting her questioning what is happening here?
Senator Keneally, there is no point of order. If anyone, I have to say, Senator Keneally, you have interrupted other senators and other questions a number of times today. I am simply asking for a clarification and not in any way interrupting Senator Thorpe. Ms DeVoe, if you could just
Can I just,
clarify
sorry,
that
Chair,
question, please.
could I just ask a procedure question as well? Because I am concerned that I always never get to ask all my questions,
Yes,
and I would,
yes, Senator Thorpe.
really be disappointed if this is part of my 10 minutes.
No, that's fine, Senator Thorpe. What's your question?
What's my question?
You are seeking a question of a procedural question?
Oh, just in terms of, this is not being counted in my
I'm happy
time.
to add an extra minute or so to your block, so
Thank
you're
you.
not deprived. Mr Vogt.
Thank you, Chair. So, Senator Thorpe, perhaps before I go to the tripartite test, it's important to recognise that the discussion as it relates to the Aliens Power and the application of the Migration Act only applies to persons who have been born overseas, who are citizens of another country, have not availed themselves of Australian citizenship, and nevertheless claim that indigeneity. So that's the scope of the people who are perhaps relevant. The tripartite test, as stated in Marbo 3 and then applied in the Love and Tom's decision, has three limbs. The first is that the person must be biologically descended from Aboriginal or Torres Strait Islander people. The second limb is the person must self-identify as Aboriginal or Torres Strait Islander person. And the third is that the person must be recognised by elders or other people who hold traditional authority in the same Aboriginal and Torres Strait Islander society from where the person is descended. And traditional authority is understood here to mean authority in an Aboriginal society which has a spiritual connection to country from before British settlement and has since that time continued to follow laws and customs that came from before British settlement.
Thanks, Mr Vogt. Senator Thorpe, I'll add 3 minutes to your block, so that well and truly covers you.
Thank you, Chair.
Thanks, Senator Thorpe.
Thank you. So how many people asserting Aboriginal identity have been deported since the Love decision was handed down?
Ms Moore, do you have?
No, Senator, I'll need to take that on notice.
Thank you. Can you tell me specifically what evidence does the department want from an Aboriginal elder to prove their practice of traditional authority under the third limb of the tripartite test?
And look, that's quite a complex issue, Senator, and indeed it was explored in the case that was recently before Justice Mortimer, which had a number of components to it, and that's in the case of Helmbright, which was completed in June 2021, where the third limb was not established. And perhaps just to give an indication of the grounds in which it was found not to be established will give you an indication of the sort of material that would be required to satisfy the court for a declaration, or indeed the department in order to not go as far as needing the court to so declare. The first, in that case, it was found that there wasn't any evidence from the Circle of Elders who decides who can and cannot be a member of that particular group. So that was that sort of information related to who the group of elders were, what authority they had within the group, and what the rules were in relation to establishing both that group, but also how they made decisions about who was a part of the group.
Sorry, could I just ask, were they traditional owners or were they a circle of elders from random places?
It was described in the judge's reasons as a circle of elders. And so then, even if that had been established, then the second element that there was a concern about in this case was that even if that had been established, it's a fact that the Circle of Elders need to have a role in deciding the membership, and there wasn't any evidence in that case about those who comprise the Circle of Elders or any of them having a role in deciding Mr Helmbright's membership. And then the third matter that didn't get reached, but would have got reached if the first two had been met, was that the Circle of Elders in that case needed to have had a role in deciding the membership and including Mr Helmbright's membership, and there wasn't any evidence about that. So essentially that's a good guide to indicate that you need something about who's making the decisions in the group, whether they've made a decision about the person in question and whether they've got the authority to make the decision about the person in question. And obviously, for a consideration by a court or anybody else, we need evidence of all of those things.
Thank you. So has the department developed guidelines around this?
That I don't know. There's definitely been lots of training in relation to what to do when a person raises the issue of their indigeneity.
Can I just say it's not an issue? Identifying as an Aboriginal in this country is not an issue.
No. And indeed, that identification meets the second limb, but clearly there's an issue in terms of what evidence is available to meet the rest of the tripartite test. And so that training is given to detaining officers who need to make that assessment when it's raised, but also is relevant to what procedures are followed once a person raises it. As I indicated, from a legal point of view, there's generally assessments that are done, and the correspondence that's entered into with the person who's making the claim can go on for some time. They'll provide some information that'll be assessed if it's still wanting. Further information will be asked, because it's not a thing that happens at a particular point in time and that decision is good for all time. As soon as evidence comes to light that tripartite test is probably met, then regardless of whether there's been a decision before that, so new information might come forth, then that at that point in time, then the person would be released from detention. But it's also relevant to any considerations that might be made if the person is claiming in the context of a visa cancellation or revocation of a visa cancellation, that those provisions don't apply to them.
Thank you. So there is no departmental guideline to determine who's Aboriginal in this country or not. You're basing it on the Helmbright case, in which a circle of elders, which we don't know if they're traditional owners or not, that's how this country is making decisions on people's Aboriginality. Is that right, or am I just losing my mind? That sounds really crazy.
No, of course, as I said, it's only for those who are claiming that there's an issue as to whether the Migration Act applies for them. It's not the same as other tests in relation to Aboriginality.
Why aren't they all the same? I'm just confused, as every department in the Commonwealth goes by the three-part test in a particular way, except for Home Affairs, who've come up with their own guideline, which I'm hearing is based on a circle of elders, which is a bit like tokenistic and basically culturally inappropriate.
So the test that's being applied is, I gave Helmbright as an example of where the test wasn't met, so that might assist you in understanding the type of evidence that might be needed in order to establish that it's been met. The guidelines actually don't, in and of themselves, establish what the high watermark or the test is. They're actually saying this is how you apply what the court has said we must apply and have no choice about applying through the Love and Toms decision, because the Love and Toms decision has been what the High Court has said is the application of whether a person has met those tests. Yeah. So it's not Helmbright and it's not the department's guidelines. Those things are reflective of what the test is, and we can't make up a different test. So even though there might be a broader test that's available for someone as to whether they might get...
I'm running out of time, sorry. I need to ask my final questions, and it's based on an answer I received to my question on notice 287 from the supplementary estimates. It was stated that between the 15th of April 2021 and the 31st of October 2021, less than 5 persons were released from immigration detention on the basis they meet or probably meet the tripartite test used by the High Court in the matter of Love and Toms. How many people was that exactly? 1, 2, 3 or 4? And how many people have been released from immigration detention on the same basis since the 31st of October?
Senator, I'll take on notice what the less than 5 was, unless my colleague can assist, but I can indicate that as of the 14th of January, a total of 11 people have been released.
Thank you very much, Senator Thorpe. I'll now give the call to Senator Roberts.
Sorry, there was, Ms Moy was going to respond.
Oh, apologies.
as well.
Ms Moore, did you want to add to that answer?
It's fine, Chair. Senator, Mr Vose answered the question and the first bit will take on notice.
Are you sure you don't have anything further to add?
No, thank you.
All right.
Thank you,
Okay.
Chair.
Thank you very much. Thanks, Senator Thorpe. Senator Roberts.
Thank you, Chair, and thank you all for being here today. My questions are fairly straightforward and they'll be fairly quick. Are staff of your department telling people they must be vaccinated in order to attend citizenship ceremonies in Queensland?
There are state orders that are applicable. I'll ask Mr Kefford, who administers our citizenship program, to come forward.
Thank you.
It'll be a function of what the state public health orders are, but and you're interested in the state of Queensland?
Yes, I am. Yeah.
Particularly? State of Queensland, Mr Kefford.
Thank you, Senator. The conduct of citizenship ceremonies, we rely significantly on local councils around the country, and as the Secretary's indicated, this department doesn't impose conditions relating to public health on the attendance or not at those functions. So, for example, the Australia Day ceremony here, the guests were required to comply with the ACT's rules as being the representative local council for that purpose.
Do we provide advice to that effect? In other words, I think the Senator's question is what the department is advising.
The department's advice is that the ceremony needs to be conducted in accordance with the code, the ceremony's code, but the public health arrangements are a matter for the states and the local council.
Great. Thank you for that, and thank you, Mr Pizzillo. That's exactly what I'm after. I'm told by some constituents in Queensland that this has happened to them. They've been told by your department that they must be vaccinated in order to attend the citizenship ceremonies in Queensland.
Well, Senator, I'd prefer to receive more precise information as to the circumstances.
Well, my understanding is that it's the same as you just said.
So if my departmental officers, as they properly should, are advising attendees to conform with applicable state or state or territory, in this case state, public health orders, then that's appropriate. But as Mr Kefford said, we don't have a separate vaccination policy or vaccination mandate that we apply to ceremonies. It's a function of what the state orders are.
So, Mr Pizzillo, there's an anxiety that's being caused because the federal agency is telling people that the Queensland agency requires double vaccinated when it doesn't. The Queensland COVID requirements for citizenship ceremonies are not a function of vaccination to attend. They basically exclude citizenship ceremonies and any citizenship ceremonies.
Well, we'll take on notice whether we are misinterpreting or misconstruing the Queensland public health orders, but I can assure you there's no such thing as a Department of Home Affairs public health order.
No, I'm not implying that. I'm saying that your staff apparently are telling some of our citizens in Queensland that they must be double vaccinated rather than saying they must comply with the state government's health orders.
Mr Kefford, can you, without any particulars from the Senator, can we shed any further light on this matter?
No, Secretary. My understanding is our approach has been to say you will be required to comply with the local health requirements and nothing further.
Okay. So thank you, Chair. Thank you, Mr Pizzillo.
Oh, thank you very much, Senator Roberts. I'm now, Senator Keneally, you're seeking the call. I'll now give the call to Senator Keneally.
Thank you. I just want to go back, if I can, Secretary Pizzillo. We were speaking earlier about the funding for the digital passenger declaration. So I've got a question on notice on the permissions capability business case approval. It's BE 21256, where I asked when was the business case for authorising funds to deliver the permissions capability approved by Cabinet, and the answer is that 74.9 million was provided in MyEFO in 2021 to support the development of a new digital platform for the efficient and secure collection of incoming passenger information. So I'm clear, you're saying that that money didn't flow to you until June?
So there was a
I'm trying to understand the sequence.
first pass allocation of funds, which was to do with the pursuit of certain trials and the development of certain technical prototypes and the like. Mr. Milford can speak to that. Once the business case was proved up in a second pass sense, so in other words, it's ready to go, subject to the department's choice as to the successful tenderer, those monies were released in June of 21.
So there was no additional money provided on top of the 74.9 million?
No, I believe, there would have been additional funds for the actual contract
Yes, I'm going to come to that,
procurement.
actually.
So Mr. Milford, can you distinguish, it was MyEFO, would have been MyEFO 20?
Yes.
Can I just
MyEFO
clarify,
20.
Senator? Yep. So the allocation that we received in MyEFO 20, as distinct from the final second pass or final business case approval in June of 21.
Secretary, I might pass to
So, Secretary, I've got some
Thank you.
figures that I can provide.
Thank you, Ms Moy.
So the 74.9 million was allocated for permissions capability in MyEFO 2021, including 15.4 million for the permissions task force, 8.1 million for the procurement business process and policy design, 27.8 for ICT, and 23.6 for biometric anchoring at the border. So that work allowed us to do the a lot of the pre-work in terms of putting before government approval for any final contract signing.
Right. And so then the money that flowed to you in June 2021, that
Yes.
is about roughly 6-7 months ago,
Yes.
was that part of the 74 million or was that additional
It
funding?
was additive. So, Ms Moy, we just might want to be very clear about which MyEFO round we're talking about. I think your evidence pertained to financial year 2021 from memory?
2021, that's correct.
So
So there's foundational capability called the permissions platform, and then there is a particular application called the DPD that gets built on top of that. That latter money was approved in June of 2021.
and how much was that?
Ms Moy or Mr Milford?
So I might ask the assistance of the CFO for this, but the MyEFO for 21-22 has not yet been disclosed. So the government statement for MyEFO stated that the government will provide additional funding for the development of the permissions capability to digitise permissions-based government services, including digitising the paper-based incoming passenger card to facilitate the safe reopening of Australia's international borders. The funding for this measure is not for publication due to commercial and confidence sensitivities, as disclosing the overall funding information could undermine ongoing negotiations with vendors. So the MyEFO funding for 21-22 has not been provided publicly by government.
So in short, Senator, that June decision was a post-budget decision, so it'll be accounted for through the forthcoming MyEFO round.
But it doesn't sound as if it will be
It's
publicly disclosed because of
NFP
commercial
at
and
the time.
confidentiality?
It was NFP at the time. I'm not quite sure if it will be. I'll check and take on notice how it will be dealt with in the future.
Right. If I can ask a couple more clarifying questions around the financials then, Ms Moy. From questioner known as SE 21144, the department has stated that at 5 November 2021, 5.7 million, there's a very detailed figure, but for 5.7 million has been paid to Accenture in regard to the permissions capability project. What is this expenditure for? Is it for the digital passenger declaration?
At the moment, the Accenture is working on both the digital passenger declaration and some parts of the base capability of permissions.
So are you able to break down that 5.7 million as to what's going to the DPD and what's going to the permissions capability, base capability?
To break it further down, I'll take on notice, Senator.
You don't have that, or?
No, I don't have it with me.
What is the, sorry, then let me ask this. With regard to a separate ITC contract, Accenture Contract CN 3441145, titled Information Technology Consultation Service, the original contract value was $603,350. Now it's $17 million. to be precise, $17,755,859. Can the department explain what the scope is of that original contract and why the cost has grown to 17 million?
Sorry, Senator, could you give me the contract notice number again?
CN 344 1145, Accenture contract, CN 344 1145. It's titled Information Technology Consultation Services.
Mr. Milford, does that ring a bell as the head of IT?
It doesn't ring a bell. I'll take that on notice. Now,
Wow.
Senator, to explain it, the permissions capability is the broad-based capability of which the DPD is the first example.
Yep.
And
Yeah, I
so
know that.
the reason for taking those last two figures on notice is because in building the base capability, we built some of the DPD, but then there were specific issues in relation to the DPD which are on top of the base capability.
Is the engagement of Accenture that the Senator just raised connected in your mind to the permissions capability, or is it some other technology?
I think it's in relation to the base ICT capability for the permissions capability, because a part of the permissions capability is back-end work, is APIs, is design work, and it's probably related to that.
Can we just check precisely against the contract number?
People will be working on that now.
With respect, if we could today try and do that, I would be utterly grateful, because I think you can appreciate that you're seeing something that's been expanded to 29 times its original value does raise a red flag, and legitimately in what is budget estimates to examine government expenditure, trying to understand.
Senator, I'm sure my team's working on the details at the moment.
Thank you, Mr. Milford. I'll seek to return to that. And I would also be interested in knowing if these contract variations are in accordance with guidelines provided by the Department Finance. I just have a few more questions regarding procurement. And I want to just ask a question about probity. On 2 occasions, the department has not completely answered a question on notice as to whether or not a minister has recused themselves from cabinet considerations. The department has twice responded that conflicts of interest by ministers are governed by procedures set out in the cabinet handbook, and these procedures were followed in this case. What we're actually asking is whether ministers have recused themselves in relations to the permissions capability project, because if we go back to the global digital platform, it was publicly stated that some ministers had recused themselves. So I think it's a legitimate question to ask. Have any ministers had the necessity to recuse themselves in relations to the permissions capability, base capability, or the digital passenger declaration?
I'd be reluctant to answer in relation to ministers outside of the portfolio. We'd want to check with the relevant portfolios, but it's my clear recollection that no Home Affairs ministers have had to do that. Whether others have had to, we'll check.
Thank you. And would you be the department that could answer that question, or do I need to lodge that with Prime Minister and Cabinet?
Well, it's about Cabinet process, so the Cabinet handbook is administered by the Prime Minister's department.
So you can check, but you may not be able to answer me.
Correct. That's right.
Right, thank you.
We can certainly check with our own ministers, and I'm going off my own recollection. I'll check, but I don't believe... Remembering that the GDP, the Global Digital Platform, was a precursor project.
Yes, I do.
Very different.
Yeah, well,
so in relation to
certainly remember it.
in relation to permissions, I don't recall a Home Affairs minister having to recuse themselves. No.
Yep. The department issued a public interest certificate in relation to the permission capability procurement. Has a complaint been made by a supplier under Section 18 of the Government Procurement Act 2018?
I don't know, and I would have to check and come back to your notice.
Do we know, Mr. Milford?
I don't know, as a matter of fact.
I don't know, as a matter of fact. I'm not aware.
No, I'm not aware, Senator. I'll take it on notice.
All right. Thank you. And then lastly, was there my understanding, and correct me if I am wrong, that there was no public interest test for this procurement?
I'm just struggling to understand.
Senator,
in procurement terms, what a public interest test is.
I'll have to take that on notice in terms of whether or not there was a process that dealt with with any public interest test.
So I'm trying to understand, was there any testing as to whether or not the public service would have the capability to deliver this procurement?
Yes, I see.
Okay. Deliver this project.
So we're required, I see. So we're
Not
required,
procurement, this project.
under procurement guidelines where there is private capital being mobilised, and we've had this discussion in the context of the GDP, because that was a private capital project, to ensure that there's a comparator as between private capital delivery as opposed to delivery effectively through public capital. But otherwise, a procurement by the government through its public service of the sort of capabilities that a company like Accenture, other companies potentially, there's no requirement to say, well, could the public service build it? Because if we could, we'd be like Accenture. In other words, we'd have the shape, form of that kind of company. The test you have to be able to satisfy yourself under a public-private partnership is whether public capital could be more efficiently deployed. But even in those cases, you end up procuring services, say from Boeing for an aircraft or from Accenture for an IT company. The government doesn't build those sorts of things, they procure those sorts of things. The difference is whether public capital is more efficiently deployed or private capital is more efficiently deployed.
So just so we're clear, there is no, your advice to the committee is because of the nature of the project, there's no requirement for
because it's going to be publicly funded. It's going to be a public capital project. So
no, if I could finish my question.
I do apologise.
Your advice to the committee is that because of the nature of the project, there's no requirement to do a public service comparator.
Because of the nature of the financing of the project.
Because of the nature of the financing, not the capability.
No.
But you just said that we would need to be like Accenture to be able to deliver this project.
Correct.
In capability or in financing?
Both.
So it is capability.
I need you to wrap up to Senator Keneally.
Yes, so it is capability as
so
well.
So the threshold question is who's financing it, and then you have to run a public interest test to say is it better financed through taxpayers' funds or through private funds, just like a toll road in state governments.
All right.
Senator Keneally, thank you. We'll need to share the call around. We are trying to stay on track and move to outcome 3 at 4:15. I now give the call to Senator McKim.
Thanks, Chair. I just wanted to follow up on a couple of questions from on my previous topic, which I think was Mr. Wilden, and hoping he's around, but maybe he's not around.
I suspect.
Oh, he is around. My apologies.
Be around. He better be around.
Mr. Wilden, thanks. Just on the number of visas out of the 55,000 lawful applications that you've received from Afghan nationals, I think you said a little over 1,000 had been granted. Is that right?
Well, I wouldn't say there's a direct correlation of the 55 and the 1,000 because some of those visas would have been granted prior to the evacuation, and most of those applications have come in after the evacuation. So it's not sort of a binary. They're the same source at the same time, and then the grant is as a result of that. But those numbers are correct: 1,000 grants, 55,000 applications.
All right, and just to be clear, those grants are not just simply extensions of 449s. They're grants of
they're grants of permanent visas.
So they're grants of permanent visas.
Correct.
So those folks that have been successful in those applications are on the pathway to permanent residency and ultimately to citizenship.
Yep.
All right, thank you. Could I also ask about, in that 55,000, you mentioned humanitarian visas, but are some of them in the family visa stream?
No, I'm speaking specifically about people who've applied for the refugee and humanitarian visas.
All right, thanks. What about folks that have applied for family, in what I think you call the family visa stream or the family reunion visa stream? Many of these are older applications that have been with the department for some time. Are you prioritising the assessment of those applications?
I'll have to ask Mr. Willard, who runs the family program, to come and address those questions.
Okay, thanks. Appreciate that. Thanks, Mr. Willard.
Senator, in answer to your question, we've established a team to specifically process this caseload. Based in Melbourne, it started with 19 staff. There's now 28 staff in the team, and their focus is on progressing this caseload. In respect to prioritisation, in a strictly legal sense, they're not prioritised as such under the, there's not a direction prioritising them, but because our on-hand caseload is smaller than the number of places we have in the program, we're focusing this attention on this cohort.
All right, I was going to ask, so there's no change, am I right to say there's no change to Ministerial Direction 80?
That's correct.
So are you prioritising these applications in terms of processing?
Not in the sense of a ministerial direction about prioritisation, but in the sense of directing specialised resources at this caseload, which has a number of challenging issues that need to be resolved. We're focusing that effort with a dedicated team.
All right, is the availability of health checks in Afghanistan still holding up the processing and decision-making on family visa applications?
Yes, that remains an issue. The approach that we're taking is that we're obviously not closing any cases because an applicant is unable to complete any of the checks in Afghanistan. And we've seen circumstances where individuals have indicated they would like their request for health checks to be issued because they have capacity to travel to another country, and where that's the case, we're doing so. Okay. Otherwise, we're communicating that we're not going to close the case. We'll wait until the circumstances change and the individuals may be able to access a health check. I should add that team's got through about 1,700 cases to date in terms of assessments and issuing those letters. Many of these are to people who are not in Afghanistan and subsequently left Afghanistan.
Appreciate that. So how many partner visa applications, so there'd be subclass 300 and 309 for Afghan nationals are currently have been lawfully received but are waiting to be processed?
Outside Australia, there's 7,204.
7,000, did you say?
7,204, and in Australia, 716, and that's as at the 30th of December.
Thanks very much. You may know, but we've got quite a few of these cases on the books in my office, and we've been escalating spreadsheets to the department. But from within our caseload, which is about 270, where it would appear that about 2 or 3 families a month are receiving partner visa grants. Would that extrapolate across reasonably consistently across the entirety of the nearly 8,000 that you've got on your books?
We're seeing an acceleration in grants. There's been 763 grants to, this is 300s and 309s to Afghan nationals since July 21. And as I said, because we've gone through that exercise of reviewing the cases and issuing 1,700 requests for further information to allow us to finalise the application, we're starting to see an acceleration. The latest advice I've got from the team is that for the week ending the 28th of January, there were 54 grants in that week.
54?
54 in that week.
So you'd be looking at a couple of hundred a month on those numbers?
We're certainly trying to finalise as many as possible. There's so many variabilities, Senator, and possibilities of issues coming up that could mean we're not able to finalise a case. It is difficult to estimate exactly how many. I've got some advice from the team that they think there's around 700 cases that could be coming towards finalisation over the course of this financial year.
All right, thanks. And just last question on this, Mr. Willard, and thank you. Has there been any consideration given to, in order to get around the issue of the difficulty of doing some of these health and character and identity checks for folks that are still in Afghanistan, has there been any consideration given to issuing a different class of temporary visa for these people so they can actually come to Australia on a temporary visa and do those checks here?
We've actively been looking at all options for this cohort. We don't necessarily have an answer at this point. We're certainly engaging with Mr Wilden's team and with DFAT about whatever opportunities might come up. The team who's handling the caseload is at a point where they've got a good knowledge of all of the cases on hand. As far as the information that we hold tells us, obviously there's a lot of cases where circumstances may have changed and we might not be aware of that at this stage.
Obviously things are quite difficult in Afghanistan at the moment for a lot of people.
I think to be more, if I may, Mr Wilden, to be more emphatic in responding to the Senator, has consideration been given to bringing people here temporarily and in considering their cases on balance? The matter has been looked at from time to time. On balance, it's the government's position, on advice from the department, I have to say, to wherever possible avoid that circumstance, because you get into this loop of persons found not to be owed protection or persons found otherwise not to be in a position to be granted a visa are then here. We've seen long drawn out cases of temporary arrivals being stuck in a degree of ongoing processes. So I think it's fair to say, Mr Wilden, we can be a bit more emphatic to the Senator that our preference would not be to bring people here temporarily with a view to then granting permanency.
All right, but these are, Mr Pizzolo, these are people who are
am I right in
partners.
terms of both the advice we've given and the attitude of the government?
So, certainly not to the extent of not doing necessary checks, but if mechanisms emerge where that's possible to happen in the course of, for example, evacuation flights, should one be available, that's the sort of
where checks can be
consideration.
done?
Yes.
Right. Thank you.
All right, thanks. And I'll just make the point that we're talking here about partners and, in many cases, young children of Australian citizens and permanent residents of Australia that are in a war zone, which in many areas is descending into a famine. Many of these people have had their applications in with the department for many years. Mr Pizzolo, these are partners and children of Australian nationals, Australian citizens.
And where there's some connection of that nature and some checks can be done, not some checks, where checks can be done, arrangements can be put in place. I was referring to cases where the applicant is largely unknown to us.
All right, well, this line of questioning to Mr Willard was specifically about partner visas.
Thank you.
It's just 300 and 309s. Look, I'll just, because I know the Chair's trying to move us along, I just want to ask about the situation that expired bridging visa B holders find themselves in. So these are, I'm not sure which of your officials can help here, Mr Pizzolo, but these are people who were granted bridging visa Bs. They travelled overseas pre-pandemic. They weren't able to come back during the pandemic because the Australian Border Force continually refused their applications to travel, or they were unable to travel for other reasons, other pandemic-related reasons. Their bridging visa Bs have expired. They can't apply for new ones because they're not in Australia. What is the department going to do for these people? They're stuck overseas at the moment. They're in this kind of bureaucratic black hole.
Well, if they had bridging visas, the assumption is that there's no underlying visa that they can rely upon.
Well, in fact, the bridging visa Bs are when people have got lawful applications in for another visa class, right? And for some particular visa class.
Visa is the point. So, Mr. Wilden, what can be done in those cases?
So if there's no visa in effect, the individual is able to apply for another visa. If they meet the requirements for that visa, they're able to travel to Australia.
Well,
where they can apply offshore.
So people in this cohort of my books have been continually rejected for tourist visas by the department on the grounds that they're not tourists. So what kind of visa can they apply for in order to get back? Because it's not clear to these people what kind of visa they can make a lawful application for, given the situation they find themselves in through no fault of their own, stuck overseas for 2 years now. The department is rejecting them time after time for other visa classes.
So
what kind of visa can they apply for?
In the cases where the prior application related to some form of substantive visa, which entail, for instance, residency, I think a delegate would form a reasonable suspicion that they weren't going to be tourists.
Yes, that could be the case. It's
Apart from the fact that tourists are barred from entry in any event.
It's very difficult.
Not for long.
not
for long, indeed.
In response to your question, Senator, it is very difficult to give generic advice about a very, very wide range of circumstances. There are some visas for which these people may have applied that can be granted either on or offshore. That is, the application that is in progress may be able to be granted on or offshore. Not every case, but there are some
Are you
visas.
prioritising those substantive applications made by bridging visa B holders who are overseas? And I mean, just to be clear, from 21 February, a tourist can come into Australia, but someone who's lived here potentially for 6 or 7 or 8 years, who's built a life here, and who just happen to be overseas because they were overseas on a bridging visa B at the start of the pandemic, they can't come back. So you're saying to tourists, come on in, but people who've built a life in Australia, you're telling them they can't come back.
But prima facie, there must be the absence of an underlying substantive visa, because for them to be on a bridging visa B, it means...
That's right, but many of them have had applications in for years. It's your department's fault that they don't have a substantive visa because you haven't processed their application.
But as Mr Willard was saying, it might turn on character issues, it might turn on other issues that have prevented the issuance of a visa. The fact remains that, yes, they might well be overseas, and yes, they might well have had a period of residency here prior, but they don't have an underlying visa because that's why they're on a bridging visa. But short of knowing each case particularly, I don't think we can offer generic advice, can we?
It's very difficult to give generic advice.
I understand that, but...
Senator McKim, we are over your allocated time. We will need to move to other senators, but we can return to you if required. I just wanted to update everyone on timing. Labor senators have indicated that they are seeking more time on outcome 2, but there will be less time required in outcome 3, so we are hoping we can state a time on the overall program for today. So on that basis, we are now anticipating to extend outcome 2 a little, but we'll have less time allocated to outcome 3. I'll now give the call to Senator Kitching.
All for being here today. I might need Mr Wilden because this will be a continuation of the discussion we had at the Foreign Affairs Committee inquiry.
Well,
Mr Pizzullo.
I'll determine
Lovely, yes,
who
yes,
my
I'm
witnesses
all
are,
happy
but
with that.
I suspect you're probably on the money, but but I note you've made a reference to proceedings in another committee as opposed to evidence that was given earlier, that's all.
Yes, so what I'm really after, so I want to ask you two things. Can you give me a month-by-month number on the 449s? And that way I might be able to calculate if I subtract those that have come, and then that would give me a figure. Is that going to work? Is that going to vaguely...
Month by month in terms of their issuance?
In terms of the issuance, yes, of the 449s.
I'd have to go back and reconstruct the picture of the grants on a month by month. I can give you arrivals roughly,
yes,
but I can't give you the grants because the bulk of the grants, as in probably about 3,500, were done during the evacuation phase, and it has slowly gone down. This could be a long process, or I could take it on notice because I've got it by flight.
You can do it by flight.
I can do it by flight, of which there is 102
flights. I think
that,
we might take
that
that
people have arrived on with 449s. That's the breakdown of information I have.
If you can do that on notice.
Yeah, I'll aggregate it up and give. And going back, we may be able to get the grants by month. I'll just have to take that on notice.
But you understand what I'm trying to do?
Yes.
Okay, so now I hate to sort of ask it. Do you think that you can give that to me as quickly as you possibly can?
Oh, of course.
And then we can, just so that the final report.
Yes, no, I get the link.
Yeah.
Yes. No, I'm sure people are listening, and I'm not sure we can have it today, but we can certainly have it fairly quickly.
Yeah, that would be great. That way.
So, sorry, Senator, just to be clear, you're asking for evidence to be provided to assist in the finalisation of a report by another committee?
Well, I'm happy to have it here and now. But I also, otherwise I can call you back for another hearing.
No, I understand that.
I
just might seek some guidance. I'd like to be flexible and accommodative of the Senator's request, but the time for responses to questions on notice, will that align with the finalisation of a report by another committee?
Reporting at the end of March, which is, so I would like them...
We can do that.
Will that work?
Yes, we can make that work.
Is that all right? Thank you.
Yeah.
It's an unorthodox way of supporting another, but if it helps, then let's be unorthodox.
Flexible.
Flexible. That's a better term. Flexible.
Now, can I also, and I'm happy for this to be on notice.
So we'll respond on notice.
Yes, perfect.
Month by month, and we'll get it in on time to assist the finalisation of the work of another committee.
Yes.
Is that the request?
This is almost like Mr. Wilden and I having a continuation of a discussion that we were
Right, sorry,
having
Senator. I wasn't party to
previously-
that engagement.
I will invite you next time, Secretary.
No, please don't. Thank you.
Now, could I also possibly get an update from the... I know you gave me updated figures and Ms Moy gave me updated figures when we last had that day of hearing, but could I get a breakdown on... and I'm actually reading from 5.68 in the interim report, so you can go back to look at... But the so the 449s, the permanent refugee, the permanent partner and provisional partner, and the permanent resident, as at, I don't know, today's date, or is it easier to do it at the end of February? Whatever suits you.
Sure. I can give you at the 11th of February.
Lovely.
And the numbers have really only shifted in the 449 category because we've had the other categories have remained constant for a few months. But the numbers are, as at 11 February, Class XB, but that is subclasses 200, 202, 203 and 204, is 111. Yep. Class XB subclass 201, which is the in-country, is 336. Other permanent, which is a broad range, 199. Subclass 449, 4,927. Other temporary, 206. And Australian citizen, 417. We've previously reported there are also 167 transit, which were people who came on flights into Australia but have subsequently gone elsewhere, usually nationals of other countries.
Okay. Is there anything... So are more flights being organised now for the next month or so?
So in terms of flights organised, there's two elements. One is just normal commercial travel. So we have, and I'll just to give you a sense, you know, we've had flights heading out almost daily, but they might have one person, 5 people, 3 people coming through Singapore, coming through Doha, etc. So that's sort of a general flow. There's also charter flights, which the Department of Foreign Affairs have organised, and they've been fairly regular out of Islamabad. And we did have the 2 flights, I think I gave an evidence, out of Doha, which are the only... Since those 2 came, there's not another one planned out of Doha because of issues with the Qatari government and their arrangements with the Taliban.
Okay. I think that's all I have, but I am just corrected by someone who was watching that the report is due 4th of March. So it's the beginning of March, not the end. Okay. So I apologise for that.
We'll try our best.
We shall.
Oh, thank you.
If that
I really
saves being
appreciate
recalled,
it.
we'll try our best.
Thank you. Thank you. Thank you, Chair.
Thank you very much, Senator Kitching. Senator Grogan.
Thank you, Chair. I have some questions about respondent EGZ17. This is the recent federal court matter, most recent date of Friday the 11th of February. The respondent is a national of Afghanistan, an ethnic Hazara and a Shia Muslim, applied to the Minister for a protection visa on the 15th of November 2016 and was refused. Can you explain why the government is seeking to deport this individual at this point in time?
Sorry, Senator, I missed just the very first part of your question. Did you refer to a court case?
Yes, the court case, most recent hearing was on Friday.
Right. Ms DeVoe, in the first instance, please. I just want to be very precise. If we're engaged in litigation, I'll obviously put the government's position consistently with the submissions that we've made to the court without litigating the matter here.
Sure.
Are you familiar with the case, Ms DeVoe?
I am, Secretary, and I think the burden of your question, Senator, actually goes to some of my colleagues down the other end of the table. But the case that was reported on Friday is the case you referred to in terms of there having previously been a decision that the person was not found to be owed protection. That was a decision of the Immigration Assessment Authority. And then that decision, which goes back some years now, was the subject of a judicial review application. And in the judicial review application, what the judge at first instance found was that even though it was a judicial review of a decision taken some time ago, and of course judicial review is different to merits review, it's about the process of that decision maker on that decision, but the judge at first instance found that because the circumstances in Afghanistan had so dramatically changed subsequently, that decision several years ago was what's called legally unreasonable. And so what the full federal court found on Friday was that's entirely the wrong approach, and indeed some other judges of recent times have...
Sorry, just to be clear, the Senator's question was premised on a hearing. Are you saying in your evidence that there's a decision to hand?
On Friday.
Thank you.
Which confirmed that the remedy is not found in judicial review in saying that the change of circumstances in relation to Afghanistan as a country is relevant, because it's a review of that decision on the facts of that decision. So the remedy is a different one if the person is not to be returned. So they originally were found not to be owed protection. That hasn't changed. The remedy is not an overturn by way of judicial review of that decision. The remedy lies in other discretionary grants of visa, or alternatively decisions to not return in the current circumstances.
Because in short, judicial review involves assessing, standing in the shoes of the decision maker at the time the decision was made, whether or not they acted in a reasonable way, broadly speaking. And so what had happened in the interim wouldn't ordinarily be taken into account. And while there are practical considerations that the court will consider, no doubt, in the discretionary powers that it has, nevertheless, as a general principle of administrative law, you don't want to change that without some care.
Senator, I can also add that to the end of Ms DeVoe's evidence, the Minister Hawke has confirmed that the government is not looking to remove any Afghan unlawful non-citizen or lawful non-citizen who may be on a final bridging visa while the situation in Afghanistan remains dire. So the situation at the moment is anyone who is in that category of being on a bridging visa for final departure, for example, will be looked at for review of their bridging visa until such time as the situation may allow for them to be removed at a point in time.
So your question, Senator, about why is the department seeking to deport this person is, as stated by Ms Moore, is something that we're not looking to do at the moment.
Okay, that's great, because that was my next point was how is this person going to be treated given the changing situation that we're looking at now. So that's good. So he can guarantee, anyone can guarantee that they're not going to be sent back at this point in time given the current situation, following the Minister's commitment.
The ministerial direction that we have, could you just briefly restate it, Ms Moore?
And the Minister's been public about this. He's made a statement that says that while the situation, and I'm to praise of his comment, but while the situation in Afghanistan remains dire, that we won't be looking to return anybody who is a unlawful non-citizen, be it that they may be on a final departure bridging visa, for example, to Afghanistan.
Thank you very much.
Thank you very much, Senator Grogan. Senator Ciccone.
Thanks a lot, Chair. Secretary, I just wanted to... I've got a few questions here with respect to the Park Hotel and the alternative place of detention. Yeah. Could you confirm how much the department spent on the operation of the two hotels, the Kangaroo Point in Brisbane and the Park Hotel in Melbourne?
The delivery of detention services is a matter for the Australian Border Force, whereas the status resolution and the visa determinations are a matter for Ms Moy and her officers. So to assist the Chair with the management of the time management of the committee, if the questions are now moving to, if you will, the management of detention, the provision of services, the placement of detainees into different hotels as they're called, that's probably a matter that the Commissioner and his staff can attend to. If you want to go back to asking about their visa status, then that's a matter for Mr.
What about
Moy.
the costs of running these facilities?
As I just said, that's for Mr. Outram and his staff.
Outcome 3?
Mm-hmm. So we do visa management and status resolution. The ABF then runs detention services.
All right. And even just confirming some of the quans and answers that we've received, I've had some follow-ups on some quans. Is that something?
If they relate to the management of the contract, the management of detention services, the provision of detention services, the costs of those services, they're properly matters for the ABF.
All right. So, for instance, there was one quan, BE 21445, and it was stated that the cost per person is about $46,490.
Well, that goes to costs.
Per year for community detention. And I just wanted to see if that figure was still correct.
Now community detention starts to move back into a different realm because that's not held detention. Ms Moy, can you assist the Senator at all with... Thank you. So my statement to you was made in relation to alternative places of detention where there's held detention involved. That is delivered by the Australian Border Force. Where a determination is made to put a person into the community under what's known as CD or community detention, we can assist. And Ms Jones, where are you, Ms Jones?
They don't make it easy, do they, Nick?
There you go. It's obvious to me. So Ms Jones, can you assist the Senator with in relation to the management of community detention?
1-5.
As distinct from held detention?
What do you mean?
Good afternoon, Justine Jones, First Assistant Secretary, Status Resolution and Visa Cancellation Division. In 2021 financial year, the average cost of managing a person in residence determination, colloquially known as
Sorry,
community
could I ask
detention.
you to speak up a little bit, just with the bells going off in the background?
Oh, sorry. In 2021 financial year, the average cost of managing a person under residence determination arrangements was $54,798.
So the figure that was provided in that quan was for the previous financial year, is that correct?
Possibly. I don't have the quan in front of me.
Well, I don't know if someone's able to assist you at the back, but BE 21445.
Yes, we'll try to get it.
Yes,
Yep.
we'll, yeah.
Thank you, Secretary. So I understand there's 32, is that right? 32 individuals or 32 of the refugees that are currently in the alternative place of detention have national security concerns?
Sorry, we're going back to held detention now. So there's residency determinations, otherwise known as CD, and then there's held detention.
Well, my question's around there are 32 of these refugees who are currently, in one way or another, in hotel quarantine.
Right, that's
in
held
hotel
detention.
detention.
Yep.
And I just
Yep.
want to see if there's still national concerns about those 32 individuals.
Well, there would be a range of concerns that relate to either character or security. I don't know what you're basing your reference to 32. Is that a
Well,
is
it
that a
follows on
question
from the
notice?
quan.
Okay.
So it might be helpful. Look, I might just move to another matter whilst we get this quan. It was about an individual by the name of Mehdi Ali. You'd be aware of, Secretary, refugee who arrived by boat when he was 15. He's now 24 years of age and currently in Park Hotel. My understanding he's been approved for US resettlement.
Yes.
Is that your understanding?
That is correct. And we might just swap out. It's not in Ms Jones's area, so he is not owed protection by Australia, so he's in what's known as the IMA offshore cohort, transferred here for medical transitory purposes. So Mr Ablong or Ms Sullivan will join.
Just before you do that, my question is, why isn't he in community detention as opposed to being in the Park Hotel?
If that's the question, we're back to Ms Jones. So.
Yes, and I was just to say, don't...
These questions are all valid in outcome too, Mr Pizzullo, from your point of view, are they?
Well,
because I've got a range of questions on these.
It's a very good observation through you, Madam Chair.
Parking them to outcome 3.
So visa decision making, which relates to ultimately a person's right to remain in the Australian community, that's 2.2. Their placement in detention, their management in detention and the provision of detention services are properly a matter for 3.5. The complicating factor here is that Mr Ali, who's self-disclosed quite a bit about himself, so I think it's proportionate and reasonable for me to talk about his case is being dealt with under 2.4. So there's a selection of...
I don't know if that helps you, Nick, but...
That's right.
Yeah.
Well,
Mr Pizzullo, I think that
those
to
are the
best
facts.
to the extent that you can answer the question now, that would be very helpful.
Okay.
Thank you.
But if you go back to my question, why isn't he in community detention?
So, Ms Jones, why don't you just very briefly address the issue of how placement decisions are made as between secure held detention in a facility, an alternative place of detention or a residency determination. You might just briefly describe that process of decision making to the senator.
I understand the process, but why has that decision haven't been made? Why is he not currently in community detention?
So if I can speak just to the cohort he comes from, which is the cohort we call transitory persons who came to Australia for temporary purposes, being medical treatment from the regional processing countries. He is part of that cohort, and they were placed in held detention. For them to be released from a held detention placement, and that includes the APOD. APOD is also held detention. It requires ministerial intervention. Generally, transitory persons don't meet ministerial intervention guidelines for the department to refer the cases, but nonetheless we do work with ministers and their officers about putting MI subs up for this group of people, and we have been doing that in recent years.
MI being ministerial
intervention. So essentially it is the minister's personal non-delegable power that needs to be used. So the department is not able to grant a visa to anyone in this cohort, and nor can we determine whether they could go into a community detention placement or residence determination arrangements, as they're properly called. That is a matter for the minister.
But you can confirm, though, that he has been approved for US resettlement?
Yes,
I
as
understand.
a matter of
Okay.
public record,
Yep.
he's
All right.
self-disclosed that about himself.
I mean, are there any other character or national security concerns about this individual?
I must say I'm reluctant to be too particular about a person's circumstances.
Maybe you could answer the question, Mr. But assist. Could you just describe the nature of the vetting
Senator
US
Keneally,
process?
you're interrupting Senator Ciccone.
Yes, you're right, but I'm not the chair. Senator Ciccone, with your
The
permission.
rules apply equally. Senator
Well, actually,
Ciccone,
they
you have the
don't,
call.
but,
Well, I'm happy
Actually, they
for,
don't.
obviously, my
You
colleagues to have asked a clarifying
You would like
question.
to hand the call over to Senator Keneally?
Well, I'm happy
Senator
for-
Keneally, you have the call.
I would just say, Mr. Pizzula, Secretary Pizzula, it might aid in answering Senator Ciccone's question, rather than speak about Mr. Ali particularly, maybe give the committee and the public some extent of the nature of the vetting process for the US approval.
Thank you, Senator. I'd be more comforted if I could answer in those terms. And we are going to have to swap out Ms Jones, because Ms Jones is responsible for visa determinations under the Australian Migration Act. Mr Ali is not being determined as to be a refugee or otherwise under the Australian Migration Act. So we act in partnership with the US authorities, who go through their own statutory requirements that are set through Congress to the State Department. There is a program that Mr Ablong and his colleagues do with. Rather than speaking about Mr Ali's case particularly, following the very helpful suggestion, why don't we just describe in broad terms? We're not speaking on behalf of the US government, but as we understand the US process, Mr Ablong.
Well, maybe in the interest of time too, because Senator Ciccone will have very limited time.
So very briefly, what do we understand the US process to entail?
Did President Trump call it extreme vetting? Yeah, he did. And then, secondly, would it be reasonable to assume that the Americans' vetting process would pick up any national security or character issues?
I think it's fair to say it's rigorous, but...
It is a rigorous process. Certainly they do look at security concerns as defined under US legislation and code as to what security is, which are different from Australia's parliamentary processes for the definition of security. They also look at character and health matters, are the major requirements.
Thank you, Mr. Ablong. Is there any other questions?
Thanks, Senator Keneally. Senator Ciccone, did you have any additional
Thank you, Chair.
questions?
Just a few others. And look, again, whether it's three or two, I'll get your guidance, Secretary. But the third country resettlement, and it's specifically about New Zealand's offer.
Yep, no, that's under 2.
Okay. So has the department provided government any advice about accepting New Zealand's generous offer to resettle about 150 refugees per year?
I've given advice, evidence to this committee in the affirmative. That is to say that were certain conditions to be met, the advice has been, and government indeed has not only taken that advice but has publicly expressed it in these terms, that subject to a number of conditions that Australia would want to see fulfilled, is an offer that's both welcome and appreciated. But Mr Ablong, I think it's been a while since any public statement has been made, but it's still the case, as I gave evidence earlier, that the New Zealand offer is still being positively considered, subject to the resolution of some issues that pertain to those conditions?
That's correct, Secretary. And Senator, the Minister made a statement that said the matter is being discussed between Australian and New Zealand officials. The New Zealand Minister and the Australian Minister met in December 2020, January 2021, April 2021, May 2021, October 2021 and December 2021 to discuss this. And senior officials have met through the course of 2019, 2020 and 2021 to hammer out the details. The final set of those negotiations are expected in the next few weeks on the New Zealand side as to where their position lies. They have to take the matter to their cabinet, so it'll have to go through a New Zealand cabinet process before they come to us with their final position, which...
So to be clear for the Senator, when you say final, you don't mean next, you mean the final round of officials discussions?
That's correct.
So they are soon, they are going to occur soon, Senator, and then we obviously need to clarify with the Australian Government whether...
So once we receive something from the New Zealand Cabinet, is what you're saying, the Australian Government will then respond to that
Senator,
decision?
the officials on both sides have been in discussions about the terms of any agreement to facilitate the resettlement of 150 per annum. New
it'll
Zealand,
be concurrently agreed, I think.
It is. New Zealand
So
has...
both governments will... Sorry, Mr Avalon, but both governments will consider the matter concurrently, I assume?
Depending upon how you define concurrently, yes.
Roughly at the same time, yeah.
Roughly the same time,
Shall we go with that definition?
We can.
And these are discussions between ministers or between the departments?
Well, variously. In some cases, Mr Avalon said there's been ministerial level engagement, then they delegate to officials to then hammer out, deal with, sort of technical questions that they've raised, and then we both keep.
So, is there agreement in principle?
Yes,
it's fair to say. Okay.
Yes, I think it's fair to say the Australian Government's made it clear, subject to the satisfaction of both parties and the resolution of a number of issues, which I referred to Senator McKim, I think, earlier. There has to be, to satisfy the Australian Government's policy, some kind of ironclad, or if not quite ironclad, firm blocking, and I'll use the term that's been shorthandedly used, of any backdoor, it's not a legal term, but any ability for a person to arrive, particularly after July 2013, to de facto settle in Australia by way of achieving a 444 special purpose visa, which would allow them effectively, it's not permanent residency, but long duration residency in Australia.
Is there any time frame when the Australian Government would see us accepting the New Zealand offer, or saying this is sort of our goal to...
I think ministers have said that they look forward to speedy early resolution.
Early resolution is the way it's been described.
What does that mean in practical terms?
I mean, I can't speak for the New Zealand Government, so...
You can speak for the Australian Government.
We'd be reluctant to say this year, because I think we've said that before, and that was like last year. So,
Senator Ciccone, we are going to have to
I'll leave it there, Chair. Thank you.
Move to other senators. I'll give the call to Senator McKim. Just conscious that obviously we're dealing with some issues that do stray into outcome 3. So I'm just seeking senators' cooperation to principally stick with outcome 2. And then we can quickly move to outcome 3. Thanks, Senator McKim.
Sure, thanks, Chair. Well, I was going to park these till outcome 3, but it seems they're to be dealt with in outcome 2 now. So it's just to follow on the questions I originally started asking in overview this morning, Mr Pezzullo, and that does relate to the Minister's decision-making around releasing people from held detention into community detention.
So I might get Ms Jones back.
All right, thanks. So one of the issues I raised this morning is whether the Minister makes requests for departmental advice on a case-by-case basis, or a review of all people within a particular cohort. I just wonder if there's...
It's typically the latter, and Ms Jones can speak to the detail because she runs the division, but there are directions that are sent to the department in terms of what are known as interventions or ministerial interventions. They set out certain criteria that the Minister of the day says, please advance these matters to me if they meet certain triggers or thresholds. And that can be, in some cases, only 1 or 2 people might fulfil those criteria. In other cases, more people are looked at on a systematic basis. But Ms Jones, How do you apply the directions as related to triggering an MI or ministerial intervention to the minister?
If I can talk specifically about the transitory persons, which I think you're interested in,
Yes.
Senator.
Thank you.
As the Secretary mentioned in the earlier session, it's a combination of both. So we put up at times submissions that are about managing the cohort onshore as a whole, and we also put up submissions on individual cases, and sometimes they are in batches.
Okay. So how many transitory persons are currently in Australia? That is, people who are in what I would call the offshore cohort, so they were at some stage on either Manus Island or Nauru, and they're currently in Australia. So how many are we dealing with at the moment?
As at 31st of December 2021, that number is 1,177.
Okay, thanks. And how many of them were transferred under the provisions of the Medivac legislation?
Under Medivac, 154.
Okay, thanks. You mean 154 who are currently in Australia?
Who are currently in Australia, who were brought here under the repeal of Medivac
As at,
legislation.
what did you say?
As at 31st of December 2021.
Yep. All right, thanks. Now, how many are currently held in the Park Hotel?
Of the total cohort, I believe that is 28.
28. And are they all Medivac transferees?
I don't have that split in front of me, but I know from previous inquiries we've done of this data that when you look at the split, it is both. It's not solely people brought here under Medivac.
All right. So and how many are in other APODs as opposed to immigration detention?
Oh, I don't have that. Certainly there may be a small number, but of the just less than 70 in held detention, it's a combination of APODs and immigration detention facilities.
So, sorry, that's 70 are in held detention who are part of the Medivac cohort?
Yes, I think it's actually 68 is the number as at now.
So there's 68 people. So there are 68 people who were transferred here under the Medivac legislation who are in held detention, is that right?
No, that's total. I haven't got it disaggregated by whether they were Medivac part of that legislation before it was repealed. Sorry.
All right, so are there any other alternative places of detention apart from the Park Hotel that are currently being used for that cohort?
Possibly, but I don't have that detail in front of me. I'm sorry.
All right. So there are some people who were transferred here under the Medivac legislation who are in the Park Hotel. I think you've given that evidence. Is the department working on advice to the minister in relation to those people, or has the advice already been put up to the minister and it's been rejected in terms of transferring them into community detention?
I would describe it as a work in progress, so we are still continuing to work with the Minister's office on this group of people in terms of potential ministerial intervention.
So that's the same evidence that was given last time, that it was a work in progress, but hasn't been any releases recently. Are there briefs up with the minister that are awaiting the minister's attention, or is the hold up at the department's end?
I wouldn't describe it as a hold-up.
I'm sure those people would describe it as a hold-up.
Yes, but we're working through our normal processes which we engage with the Minister's offices, both of them about our prioritisation in terms of resourcing on ministerial intervention cases. And we, as I said, provide advice broadly about the cohort, but also specific cases. So as an example, we currently have a ministerial brief on 13 of that group that's currently with the Minister.
Okay, so
that's not a ministerial intervention submission. It is a brief with the details of those clients.
Okay, so what's the difference between a brief of that kind and a ministerial intervention submission?
So a ministerial intervention is a specific process which, once kick-started, that the minister is being asked to consider intervening in that case. The precursor to that is us often sharing information about the client's details, their immigration history and everything. So there's a sense of whether the minister may be interested in considering that case of ministerial intervention.
So the distinction there would be between an information submission and a decision submission.
Thank you. That's helpful. So the process under normal circumstances will be the information submission would go up first. The minister would then indicate back down to the department whether he or she were interested in intervening, and then if the answer to that was yes, the Minister is interested in intervening based on that information, then the department would prepare a ministerial intervention submission. Is that about how it would normally run?
Correct.
Yeah, all right, thanks. Now, of the folk in the Park Hotel who were transferred here under Medivac, given that there was a security criteria in the Medivac legislation, isn't it correct to say that none of those people are being held because there are concerns around security? Because if there were concerns about security, they could not have been... If ASIO had concerns about security, they could not, under the auspices of Medivac, been transferred to Australia in the first place, could they?
At the time of transfer.
That's right. But they've been locked up ever since, Mr Pizzullo.
So my understanding is none of this group of people have security concerns raised with us by the external agency, no.
Okay, so just to be
But
clear...
what it does do... Sorry, Senator McKim.
No. I just want to clarify. I'm happy for you to have a say, Minister, but I just want to clarify that answer.
Senator McKim, please could you just give the Minister the opportunity to add to the answer? Minister.
I was just going to say, ever so briefly, that what it does indicate, though, is that the matters that were foreshadowed by the government at the time of the Medivac policy arguments, i.e. that these people would immediately seek to stay onshore in Australia, has been borne out by this circumstance.
So I'd just like to make sure I understand the answer you've just given, Ms Jones. So I think the evidence you've just given is that in regards to people in the Park Hotel, the department has not had security issues raised by any of Australia's security agencies in regards to any of those people. Is that right?
For the cohort that is there currently, yes, that's correct.
That's right. So they're not being held because any security agency has a concern about their security or
not
past
security
behaviour.
agencies, but there may be other behavioural or character type issues that the department is aware of.
Are there?
Senator, there may be, yes.
Yeah, but I'm asking, are there? Is that why some of them are still being held? I mean, the situation, Ms Jones, I'll just lay it out for you. People who were on the same boat back in 2012, 2013, they were sitting next to someone. One of those two people ended up on Manus Island. The other one went straight into the community in Australia. This is the most ad hoc of inhumane processes. Two people who are sitting next to each other on a boat. One goes into the Australian community, one goes to Manus Island. I won't take you through all the things that happened on Manus Island. I'm sure you're very across that. I know Mr Pizzullo is because we've discussed them many times. Now, some of them are here in Australia, held in the Park Hotel, and again, some of them have been released into the community and others haven't. And what's making it really difficult for the people in the Park Hotel who remain there today is they just don't understand why it is that they're being singled out like this. So that's what I'm trying to get to the bottom of today, is why are they still held in the Park Hotel? So are you, and I'm not asking about specific cases, I'm trying to keep my questions genuine, are they all still held in the Park Hotel because of behavioural concerns? Is that why they're still held in the Park Hotel?
I can't talk to the details of the cohort that remained there in totality, but I can say, while not trying to get in the mind of the Minister who makes decisions about cases in relation to whether they choose to intervene or not, but I can confirm that there are cases that have been put to ministers where there are some concerns around character and the ministers have declined to intervene.
All right. So, all right, and thank you. And you've said there's a brief or briefs containing information in relation to 13 people who are currently in the Park Hotel. Are there any submissions for ministerial intervention currently with the Minister?
Related to the 13? Or
No. They would presumably be pre any ministerial intervention brief, but I'm just asking...
There's none currently with the Minister, but we have one ministerial submission that is for a small number of people that is being drafted by the department at the moment.
Oh, okay. And do
Senator
you have
McKim, we are going to have to, move
the final
to
question
other
on that?
senators. All right, I'll give you the grace of one final question, please.
Thank you. Do you have an approximate time frame in terms of when you might submit that up?
No, I don't, but we do work on these particular cases as a priority.
All right,
thanks, Senator McKim. Senator Ciccone. Senator Grogan, second
Thanks.
call. Senator Grogan.
Thank you. The Shadow Minister's received a number of complaints and case studies from MPs and senators regarding the Parliamentary Liaison Network response time and support. As you're aware, electorate officers are a critical part in that process and provide a great deal of assistance, and they're often used as a default for immigration and visa inquiries and a contact point for constituents and their families. There seems to have been a significant increase during COVID with border closures, exemption processes, etc. The support that those officers provide is invaluable, as I think you would probably agree. But the timeliness and effectiveness and assistance has become highly problematic, and the response times significantly increased. What are the PLN's current service standards for call and email responses?
I might give the evidence in two parts. On the visa side, Ms Moy can speak to that. The PLN itself, from memory, Ms Sharp, does that come under executive? No, all under immigration, sorry. It's a very big department. Sometimes I've got to get the plumbing reminded to me. The PLN, Ms Moy, PLN standards overall and specifically on visa. I should say, Senator, just while Ms Moy is looking at her notes, you speak about them being invaluable and highly responsive. That cuts both ways, and certainly when I took up the role as Secretary of Immigration, which is coming up to 7.5 years ago now, I thought in some cases some of the local bespoke arrangements that tended to be configured state and territory specific were not in keeping with the national standards, and it struck me that effectively the Migration Act was potentially being the subject of a degree of corrosion, because depending on which PLN officer you're able to sort of advance your case through which Member of Parliament, you're able to use informal networking, which as a matter of good governance I didn't find particularly satisfactory. So in the period 2014, 2015, 2016, which predates the pandemic, so I'm not suggesting a direct response to your question, we did standardise those processes. Not all Members of Parliament were comfortable or pleased with that, and some of them raised their concerns directly with me. But I'm not going to have a situation where informal networks, whereby a PLN officer who knows the relevant processing section down in Hobart or in Adelaide or in Perth says, hey, Senator X, is making some inquiries, can you bump that up the list? I just didn't think that was in keeping with transparent Migration Act processes.
So you've standardised that now?
Yes.
Since 2015?
At least. We did a review.
So can we talk about the current situation?
Yes,
then?
so we did a review of the PLN roughly 2015, 2016. I'd have to refresh myself, and we imposed a much more standardised process. I'm not at all suggesting that the officers themselves were doing anything wrong, but for years, how shall I put this? Local arrangements had come to the fore, which I didn't think were in keeping with universal national standards.
But you've settled that now?
I believe so.
Cool.
And then whether...
So if we could go to the service standards,
so
I'm very
on the
aware
current
that
standards,
I'm trying to
we're
move on.
imposing those strictures, Ms Moy, which has slowed up some of the response times. I'm happy to take the rap for that. Ms Moy.
Thanks, Secretary. So in terms of the Parliamentary Liaison Network, there has been quite an increase in the number of contacts. So in terms of total cases...
No, I guess I'd like to understand the service standards first.
So I'll have to take the actual service standard on notice. I can probably get that quite quickly from my staff who will be watching. I don't have the physical service standards with me.
If we could get that.
We can get that. And there's been a 35.8% increase in the number of cases this financial year. So last year there was 13,471 total cases. We've already dealt with 8,862 as at the 31st of December. And that's individual cases, so that's not individual contacts. And that may be multiple contacts per individual case. And 8,556 of those cases were received by email and 306 received by phone. So there has been an increase in the use of the email channel versus the phone channel. So in terms of services, we have switched more staff to the email channel to deal with the flow that has increased there, a 49.6% increase and a 62% drop in the number of phone call contacts of the first cases. But I'll get the actual service standards for you before we finish today.
That would be great, because it will give rise to understanding some other elements. Have you increased the staffing levels to deal with the identified increase in demand?
I don't have the details of the staffing here with me, but I'll get that for you as well in terms of the numbers. I know that we have had some interruption to some staffing levels, as all employers have, in terms of staff who've been off with COVID over a period of time in the last probably 3 to 4 months. But I'll check what the service standards have been and equally the staffing numbers available.
And you might just, while you're doing that, check for me if there's been any change to the service standards in the last 2 years.
Certainly.
Are there many of those emails and phone calls that go unresponded to or unanswered?
No, Senator.
None?
No.
None at all. So all of the emails get responded to and all of the phone calls get answered?
Yes.
Great.
In what time frame? I'll come back to you on.
Okay, cool. One example in an email from another office regarding the PLN was about an urgent departure request from a constituent's family member, and that email was sent on the 31st of December 2021. It was followed up again by that office on the 14th of January, and a response was received from the PLN on the 23rd of January, stating that they were unable to meet the usual service standards. Obviously, you don't have the service standards in front of you, which may be an indicator of part of the problem. But a 24-day turnaround on an urgent matter is I think, a matter for concern. So I'd be keen to understand if you have any plans in place or you've done anything to try and resolve those issues, given that in your responses it is stating that you're not meeting those service standards, whatever they might be, and hopefully somebody in the department will be able to work them out and provide them.
I'll come back to you on whether we're meeting the service standards.
Okay. I assume you're not, given that your emails state that you're not.
I haven't seen that email or that case, Senator, so perhaps if you can give that to me separately, I might be able to chase that particular instance.
Well, maybe I'll just take an opportunity to read you some of the quotes from that email that I think provide some concern. Due to the volume of nomination and visa applications, the department is not able to respond to individual requests for processing updates on the status of their visa application. It is open to constituent to apply for a travel exemption, which, if approved, would lead to the prioritisation of their visa applications. Travel exemptions for temporary visa holders are only available in limited circumstances, which are set out on the department's webpage. Please assure constituent that their application remains under assessment. However, we are unable to provide a time frame for the finalisation, as the processing of the application will be impacted by the number of applicants received by the department that have a higher priority under current direction. So this is sort of common terminology. You've obviously standardised, which is great. Obviously, we don't want to see variable service standards, so well done. But this kind of information doesn't lead to a great deal of support for those people on the ground who are trying to assist in getting these constituents answers to their questions and getting their matters resolved, particularly when they are, in this situation, quite an urgent matter.
Sorry, I don't know the actual case, Senator, but it does sound like the officer was pointing the person towards, excuse me, the different lines that they had available in terms of applying for exemption. Is this for outwards travel?
These are from a couple of different cases, so it's the kind of
different
emails
cases,
that we're receiving at the moment. Yeah. Okay. So we could potentially provide you some summaries.
One more moment, Senator Grogan.
in trying to assist the department. I think there is with that system working well, there's a huge support to the department. Obviously, if it's standardised and it's working as it should. But we're not feeling that this sort of situation, the kind of responses are particularly helpful. Concerned about the service standards, which obviously we'll come back to once you're able to find someone in the department who knows what they might be.
Well, I'm sure there's someone who knows what they are. I just don't have them
I'm sure
in
there
front
is.
of me.
It's just about finding them. But this is a situation where people are highly stressed, highly concerned about their situation, and these sorts of commentary is not overly helpful. Are you happy with that kind of response?
I don't know what the question was, Senator, and you've
I just read you some quotes of the kind of terms that we're
that was
hearing.
from different cases, so I don't know what the response was, because the Parliamentary Liaison Network can provide information about where people can go. They can assist your officers to provide information about where people should go to or what action people can take in their circumstances. They can't actually prioritise their visa application. They can't prioritise an activity on that visa based on the fact that someone's come through.
They can seriously assist in the flow of information, and I guess what we're seeing is that we're not seeing that it's being particularly assistive at this point in time.
Well, I think it would be really valuable to me if you were able to provide me with the actual circumstances or the actual cases, and then I can actually have a look and see whether or not that meets our service, the outcome that we're looking for in terms of the services we provide through the PLM.
Yeah, well, maybe we could have a look at the service standards and see how that's how it sort of compares.
Senator Grogan, we will need to leave it there and move the call around. I now...
If I could just
give,
one...
We have actually gone over time and we are running well over time.
Indeed. So perhaps we'll just provide your contact details for Labor MPs or just a summary?
I'm happy to take them through the committee.
Thanks very much, Senator Grogan. Senator Ciccone.
Thank you, Chair. Mr Pezzullo, I've got some questions about the agriculture visa. The ag visa.
Oh, yes. Yep.
And I just want to draw to your attention, I've just tabled with the Secretariat just to assist. There was a Quan number 40, and it's portfolio question number SE21040.
I think
you may want to give one to Mr Pezzullo. Yep.
Very strict adherence to etiquette and protocols.
Yes,
well
I know.
done to the officer.
I'm sure you're a stickler for protocols, don't worry.
Thank you.
But my question to you, the last round of estimates, was when you were asked to provide advice to government about the design of the agriculture visa. And look, the response that I got was simply one of when it was announced, which we already knew on the 23rd of August. So I want to put that back to you, my original question. When were you asked to provide government with advice in the design of that ag visa, presumably before it was announced?
Quite. Well, given that we undertook to come back with the precise dates, and it's, as the Chair gave us guidance earlier today, it's within power for the committee to ask about not the content of advice, but its timing. I'm very happy for Mr Willard to give you that advice. I'm not quite sure why the answer has been truncated.
Look,
sorry, I shouldn't put it in those terms. I don't know why the answer is as brief as it is, because you asked about when advice was rendered, and we're obligated to provide advice to this committee. I think I'm right, Madam Chair, you read out the guidance again this morning about we can't go to the content of deliberations, but as to their timing, that's certainly within scope. So, Mr Willard, what's the answer?
Senator, in respect of the ag visa, which is now in existence, it's 22nd of June.
Mr Willard, you can remove
I just can't
your
hear with the mask on.
Oh, beg your pardon.
Thank you.
It's 22nd of June in respect of the ag visa that is now in existence, and there was subsequent advice.
Sorry, just to be clear, what happened in June? Was that the tendering of advice?
That was the provision of advice, initial advice. Subsequent advice was provided between the 22nd of June and going through to August.
Thank you.
Mr Willard, are you able to advise me on how many individuals have entered Australia prior to January 1 of this year as part of the ag visa program?
Senator, the answer is 0.
And I do note, and you may be aware, but Minister Littleproud made some remarks late last year about the program, saying that it would be up and running by Christmas. Is that still not the case?
From the department's point of view, all the legalities are in place. Relevant instruments have been affected, and we just now await the settlement of relevant bilateral agreements, which are the responsibility of the Department of Foreign Affairs and Trade.
So is the only, I guess, operational side of things that's holding up the visa from actually being used is the bilateral agreements?
So the design of the visa requires there to be a bilateral agreement in place.
So the design features complete?
In terms of the regulations?
In terms of
Mr.
the
Willard?
migration regulations, the Australian agriculture visa is in existence, has been since the end of September.
Sure.
And should there be applications made, we're in a position to process the visas in accordance with the regulations.
So now the outstanding component of why it's not being used, or there aren't people on this visa in Australia, is because of the bilateral agreements. Is that correct?
Yes, and obviously employers and individuals taking part in the program.
Are you aware of any employers part of that program? Or can that process not occur until the bilaterals are in place?
We wouldn't be able to grant a visa until the bilaterals are in place.
It's a design feature of the visa.
How many visa holders of this type are you expecting to arrive this year?
Well, it will be a function on the timing of when bilateral agreements are in place, which is a matter that DFAT is pursuing, and then a function of demand from employers for the visa.
So we are ready, Senator. We're ready to receive
I get that. Are you
applications.
expecting any bilaterals to be approved the first half of this year?
It's really a question for DFAT, Senator. I'd note they have released...
Okay, well, let me rephrase it. Have you had advice from DFAT to suggest that there may be bilaterals in place?
I'd note they've released a fact sheet on the 1st of February that does note that discussions with Indonesia are advanced. This is quoting from the fact sheet. And details are expected to be finalised.
It's fair to say that we're in dialogue with our departmental colleagues at DFAT.
Certainly engage with DFAT regularly on this matter.
And what have they, I guess, given you into the latest advice about where the ag visa program's at? Last time I think in estimates I asked you, and you may have come back to me with, there's a phase 1, I think, then a phase 2 design feature of this program. Are we in that phase 2 now, or are we still in phase 1?
The phasing is part of DFAT's program, Senator, so forgive me if I'm not completely up to date on what their phasing arrangements are. From the perspective of my team, who are responsible for visa processing, should an application be lodged, we would process it in accordance with the migration regulations.
Are you aware of which countries DFAT has been negotiated other than Indonesia?
The other advice they note is a small number of countries in Southeast Asia, and again, this is...
which
I think it's best if we don't give evidence on behalf of DFAT.
I'm reluctant to step into the space, Senator, beyond... What I'm quoting from is a fact sheet that they've published. I'm reluctant to give my views, not informed by the proper diplomatic process that DFAT go through, about
in relation to
status
another
of
department for which you're not responsible.
Correct, yes.
Look, and I appreciate that, but I mean, the department still has a role to play, and you're part of you have a significant role to play. I mean, you do issue these visas. I mean, you are
no one's coming here without a visa, I can assure you. But the point being, Mr. Willard and I might well have knowledge from cables and other documents as to the state of proceedings. But if we start giving evidence on behalf of something that another department is leading, you start to corrode accountability to this parliament. We've got a degree of engagement, a deep degree of insight and engagement into where our colleagues are up to, but I prefer that they give evidence about their progress.
Yeah. I mean, when do you expect that these visas will start to be issued?
Once the agreements are in place and once employer sponsors are notified to us and we start getting applications. I can't be any more particular about dates, I'm sorry.
Have you been provided with any advice from DFAT about Minister Littleproud's recent visit to Indonesia and the status of discussions about the ag visa?
Not beyond that broad advice that I gave previously.
So Home Affairs is no longer now the lead agency when it comes to this program, is that correct?
So Home Affairs is responsible for the visa processing in respect of the program. I think we've discussed it previously, but the regulations that in effect set up within the migration regulations for a program administered by DFAT to operate. And the migration regulations provide for the lodgement and assessment of visa applications in the context of that program.
And is there still that intra-departmental committee or body that sort of talks about these issues? I think in previous estimates, I understand that you may have explained to me the process. You've got Home Affairs, you obviously have DFAT. Is the Department of Agriculture in there somewhere?
Department of Agriculture regularly participates in interdepartmental meetings and indeed engagement with the sector.
The other aspect of this visa, will there be pathways to permanency?
The government has announced that there is an intention to create options for permanent residence pathways for participants in the program. However, this will involve further consultation and design work.
So is that a yes, that there will be pathway to permanency?
Yes, government has committed to creating options for permanent residence.
As part of the agriculture visa?
Yes.
Has there been any other discussions with providing these non-citizens who are here illegally now? I forget the phrase you used, but the undocumented workers.
Unlawful non-citizens.
Unlawful non-citizens and amnesty?
No.
Has there been any discussions or advice that you've provided government about giving such individuals other rights through bridging visas?
Yes.
Are you able to, provide any numbers in terms of how many people are in that category that you believe will be able to be entitled to apply for a bridging visa?
Ms Moy, we have something like 300,000 persons on various categories of bridging, as I recall it.
Correct. So, Senator, there's two parts to that. We have approximately 73,000 unlawful non-citizens is the expectation in Australia at the moment.
How many, sorry?
About 73,000. And that's over a long period of time. So they may be people who came very young, who came with parents, even back in the 40s, all the way through to people who may have overstayed their working holiday maker for, a couple of weeks. In terms of people who are unlawful non-citizens, they have the ability to come forward and talk to the department, and we look at regularising their status to ensure that they can apply for a visa if they have entitlement to apply or have eligibility to apply, or we can assist them with removal from Australia if that's the correct pathway. But there has been, given that we have those processes within our immigration program, there is not considered that an amnesty would be suitable.
Would those individuals be able to apply for an ag visa?
The ag visa is, as Mr Willard has said, is related to bilateral agreements with other countries. So they would have to satisfy the arrangements of that process.
Including going home, I assume.
Quite possibly, correct. Yeah.
I'll start to conclude here, but just in terms of this ag visa, can you confirm for me, are there any English requirements or skill testing as part of this visa?
Mr Willard?
So there's two parts to the answer, Senator, and they go to, again, that construction where there is a migration regulations which can only be activated if people are participating in the DFAT program which sits around the ag visa. So all of those settings that go to those questions are within the space of the DFAT program and are properly addressed to DFAT.
Okay, so things to do with even training requirements, employer obligations, that's...
So within the migration regulations, because it is a sponsored visa within
Last
the migration.
question, Senator Ciccone.
Within the migration regulations, there are employer obligations that apply in line with other sponsored visas.
So those
Okay,
items-
Senator Ciccone, we are going to have to
hang on,
move.
I just want to clarify, because those
Senator
things that I
Ciccone,
just run
we've
through,
gone
are they part of
4
that
minutes
requirements or not?
over. Could you make your clarification very quick, please?
Senator, I think your question was the things you were running through in terms of English and training, whether they were employer obligations or not. Strictly speaking, this is again in the sense of migration regulation obligations as opposed to DFAT's program. No, they're not. No, not English language and not training requirements.
Salary requirements.
Okay, thanks, Senator Ciccone. Senator Pratt, you have the call.
Thank you very much, Chair. What's the department's view of skills shortages in Western Australia and Perth currently, and labour shortages?
What's the department's view? Well, we're not the employment department. Our job is to, according to the priority skills list, is to ensure that skilled migration occurs in an orderly fashion.
Yeah.
We work very closely with Treasury in terms of the macroeconomy, and we work very closely with our colleagues in the Department of Employment.
And the states, of course.
And indeed, but in terms of, if you will, hotspots or, if you will, pinch points in the Australian labour market, that's very much a matter for our colleagues in the Employment Department.
How would a state government go about changing CHEV regional areas to include different regions?
That is a question for us because we administer the CHEV program. Who's the CHEV boundary designator or decider? Which division, Ms Moy? Mr Wilden. So CHEV is a humanitarian visa, so I'll ask Mr Wilden to return. CHEV boundaries is the question, Mr Wilden.
Sorry, could you just repeat the question for me in terms of CHEV boundaries?
How do we go about changing a CHEV regional area for, because as I understand it, a CHEV visa holder can work in a region, and if they don't work in a specified region, they've got more limited pathway rights attached to that.
So if a CHEV holder lives in a designated area, which are fairly broad, then they are entitled after their 5 years to apply for a range of other visas if they've met the conditions during that 5 years.
So my question was, how do you change the CHEV regional areas?
Boundaries.
Well, if the boundaries are to change, that would have to be a request to the Minister, and the request would have to be generated from somewhere. For example, Perth have asked for to be included as CHEV, and that's a matter that the Minister will consider and come back when he's had those considerations.
Well, the State Premier has in fact sent 3 letters now, one in January 2019, one in December 2019 and one in September 2021 to the Minister for Immigration, asking for the Perth metropolitan area to be included as a CHEV regional area, and still has not got a response to the government. When will the Premier get an answer?
I can't answer as to when the Minister will respond. The Minister, I'm aware of the request and the Department has given advice, but I can't speak to when the Minister will make that decision.
Have there been any other states and territories who've requested changes to CHEV regional areas? What's the status of their request? Are they also being ignored?
I don't believe there has been another request. I'll check the records to be clear, but I don't recall them being any other requests.
The Department's own information says CHEV postcodes are designated by the Minister for Home Affairs based on recommendations of state and territory governments. Therefore, any request for amendments should be directed to the lead agency in each state or territory. Why has the Minister not yet acted on the advice of the lead agency in Western Australia?
I suspect that's one for me to take on notice.
Thank you.
Areas of designated as regional for CHEV arrangements are different to the list of designated regional areas for migration purposes that I know. Can I ask if there's any timeline at all, or if you are aware of people who have returned to their country of origin, not because it was safe to do so, but because they were working in an area that denied them that pathway. Have you done any data on the number of people that have returned, Chev visa holders that have returned, based on where they lived prior to their departure, in which area it was that they lived, whether it was one with a pathway attached or one that had work rights and no pathway attached? Because I certainly know of people that have left Western Australia and have never been heard of again, and we very much fear for their safety.
Well, people make their own decisions about where they want to be. If people who are here on a TPV and Chev have left the country, we don't know where they go to because they're individuals making their own decisions. If they have sought permission to travel because they intend to return, that comes to the department. If they get on a plane and leave, then they leave and we don't know the reasons why and we don't know where they go to. We don't track people.
So how do you know what the impact of this government's policy, Chev restriction, whether it contributes to adverse humanitarian outcomes for those that return or their families?
As I understood your question, because you asked about pathways to permanency, all persons in the Chev program, so long as they meet the conditions of, 42 months out of 60 months of either regional work or study,
correct,
are able to then apply for effectively a permanent visa. It's the only way in which a temporary protection visa holder can in fact gain permanency if they're otherwise barred. So there's no distinction. I think I heard you say some have left from certain Chev areas because there's no pathway to permanency and some have a pathway to permanency. That's not how the Chev arrangement works. If you are a Chev holder, you have to work or study, because it's study as well, is it not? For 3.5 out of 5 years, as I recall it, under the law. So
yeah, no, I understand all of that.
So all persons have got equal rights.
I was skating over some of the internal complexities and differences in
Well, I just want to assure you, Senator, that
Yeah.
everyone in the Chev program, so subject to them fulfilling the requirements of their visa, have got a pathway to permanency.
Except those that have been working in Perth.
But if they're working in Perth, they're working outside of being in a designated area, yes.
Yes, and they're the ones I'm worried about.
The whole point of being on a Chev is that you work in your designated region, your Chev region.
Yes, but the Premier of Western Australia wanted to make Perth part of that. People thought that that would be acted on by this government in a timely manner, and it hasn't been.
Well, it's important Sorry, Senator.
So when the Premier made that decision back in 2019, people were of the expectation that they would be able to work in Perth.
Well, it's important that people take their advice based on the conditions that are prevailing at the time, and this is a federal government program, it's not a state government program.
Yeah, but your own website says that it's the state
that recommends, by all means.
That recommends to the Commonwealth about what will happen.
But the decision maker is the Commonwealth Minister. And the Minister at the table has taken on notice a question about the Minister's intentions about resolution of that question.
Okay. May I ask, please, there is a labour shortage in Western Australia, and that includes, for example, agricultural workers in Perth, construction workers in Perth. There's certainly no need to punish people based on an arbitrary migration zone as far as the purposes of Western Australia's labour market goes. It seems like an arbitrary attempt to set prescriptive pathways just because of the nature of their arrival.
I don't think it's fair to couch it in those terms for this reason. When the law was changed in December of 2014, it's something that I can speak directly with knowledge of because I was the Secretary of the Department. The arrangement that the government came to, from memory with the crossbenchers, was that the Safe Haven Enterprise visa would be attached to regional areas. Mr Wilden will correct me, I don't think any metropolitan capital city is otherwise captured. Are any major capital cities captured?
Not the major capitals. I think Hobart is not captured.
Right. Are any cities captured as a Chev? that you might describe as non-capital large city?
No.
Right. So the idea, Senator, is to support regional employment and regional study. I don't want to get myself into the mind of the minister, but he might be concerned, I suspect, and Minister Stoke has taken this on notice, that once you create that precedent, that a regional program can be attached to the Perth city, to the urban, to the urban city of Perth, then you're not really running a regional program.
Yeah, I think you'll find there's some variation in that already across the country.
We'll take on notice whether any metropolitan cities...
further to that, I want to ask,
sorry,
as of March...
Sorry, Senator Pratt, just to confirm that Mr Bozzolo, you will take that on notice?
As to whether any large metropolitan capital cities have been so designated, I doubt, but I'm going to check.
Thank you.
Okay, can you please also provide advice to the committee? In a previous answer, we'd been told, as of March last year, there'd been about 6,500 persons from the IMA legacy caseload to have voluntarily departed Australia, and that 390 persons from that caseload have been removed, and that 91 persons in that caseload have died in Australia. So can you please give the current figure, and in the new breakdown of the above figures, may you also advise how many were on TPVs and Chevs when they departed, how many were refugees and what their country of origin was? And does the department gather information about the reasons for return or monitor those who do return, particularly those who have found to be refugees? Because I'm keen to ensure that we're not in breach of our refoulement obligations. And what does the department gather in relation to information about the reasons for return or the outcomes for those who do return? What assistance and advice is given to people who decide to return? And also, if you can take on notice as far as deaths in Australia from that IMA legacy caseload, how many people have died in Australia and on what visa were they when they died, and how many have died by suicide or suspected suicide?
I suspect we'll need to take all of that
We'll
on notice.
need to take all those details on notice. The only ones were that you did mention those who have left. As I'll just repeat my previous evidence, people who choose to leave, it's a matter for them. We don't have any refoulement obligations if someone chooses to leave the country.
I know, but your refoulement obligations do go to the conditions you put on someone when they're here that make it unviable for them to stay.
Last question, Senator Pratt.
No, I'm done. Thank you.
Okay,
Chair.
thank you so much. We'll now move back to Senator Keneally. Just as an indication of time.
Just point of order, Chair. I wanted to clarify that the Home Affairs website does indeed say that Canberra, Adelaide, Darwin and Hobart are all Chev regional areas.
Thank
I
you
want
very
to
much.
know when Perth will be one
Senator
as well.
Pratt,
Thank you.
that wasn't. You didn't need to raise a point of order in relation
Well,
to that.
they had said
that's
that
fine.
they weren't.
You've
There were none in major cities, and they were in danger of misleading the committee. So I just wanted to make sure that
Taken on notice, there was no misleading.
No, Senator Pratt, if I could just ask Stephen to hold. What you raised was not a point of order. You've found some further information, which you've now imparted to Mr. Bozzolo. You can't in any way suggest that there was an attempt by the department to mislead anyone, but thank you, you've now provided that further information. So just for clarity, could you just restate that, Senator Pratt?
For information, the Home Affairs' own website says Canberra, Adelaide, Darwin and Hobart are all Chev regional areas.
If that's on our website, I trust it's accurate. So.
Thank you very much. Thank you very much, Senator Pratt. Just for the benefit of everyone listening, we are endeavouring to move to outcome 3 very shortly. I believe we have one more block of questions from Labor only. And We are really going to need to make this very quick, though.
Yep.
If I could
Great.
ask senators to do so. So I'll
Great,
give the
thank
call to Senator Keneally.
Thank you. Mr Secretary Pizzullo, would I be correct in saying that I'm sorry, I apologise, I will start over. I want to table an email that you sent on the 16th of August 2021, where you specifically told Deputy Commissioner Saunders to hire DPG Advisory to prepare some work and advice regarding quarantine services. In that email, you say, quote, "In the interest of getting more urgent traction on the development of an industry-led and industry-financed quarantine scheme, you are authorized to engage DPG for an urgent advisory task of 2 months' duration. I'm taking this initiative as I have come to the judgment that absent some catalyzing action by the department, there will continue to be discussion within business, the agricultural sector and universities without a first mover appearing."
Mr Pizzullo, before you seek to answer that question, I'm just checking, is that not more appropriately placed in outcome 3?
Yes, it's a border management
Yeah,
question.
it's a border management issue. Senator Keneally, we might need to defer that question or those questions until outcome 3. Do you have any other outcome 2 questions?
It's actually a question about the tender.
It's still a border enforcement, border management issue.
Didn't we do it in outcome 2 last time?
I've got a feeling we came to it quite late in the piece at the end of 3.
No, I think it was.
Can we?
I think it was 3.
Can
No,
we get the Secretariat to check that?
no, I think I'm absolutely certain it was outcome 3 last time because it was very late in the evening. It was one of the last, just because I just happened to remember that.
Oh, it was late.
I mean, we've got no issue. We're keen to go to outcome 3 very shortly.
Well,
so
I
we.
think
So Senator
McKim.
McKim has got some outcome 2 questions. We'll just finalise
All right,
those.
well, I'm happy to.
We can then release
Well, that's
officers
great,
from
Senator.
outcome 2,
Yep.
and we'll
I
move
should
to outcome
advise,
3.
Chair, do you mind if I advise that, given the undertaking given earlier to Senator Keneally, that we would be comprehensive in our response on the Djokovic issue? I intend to hold back Program 2.2 officers to the extent there's an interplay between the visa,
Absolutely.
the cancellation and the detention.
Thank you.
And so that's by agreement with Commissioner Outram, we will hold visa experts back.
Thank you very much, Mr Pizzullo. I'll now give the call to Senator McKim, who has just a couple of minutes of questions.
A short
He
number
assures
of
me.
questions. I would phrase it as Chair. Thank you. I just want to ask some questions around the announcement made by Minister Hawke on the 18th of January around visa extensions for current and former 485 visa holders.
Ms Moy?
Yeah, so the Minister announced that such an extension would take effect on 18 February and that visa holders would be notified directly by the department of the extension of their visa and may arrive after this occurs from 18 February onwards. Obviously, we're only a few days short of the 18th of February as we sit here today. Of the large number of 485 visa holders that I've got on the books in my office, not a single one has been advised yet that they've received an extension. So when will or when are current and former 485 visa holders being advised that they'll receive an extension?
Senator, so the extension will be given effect to by a change to the migration regulations on the 18th of February. So at that point, they will have the extension.
So that's automatic and it's for every current or former 485 visa holder who is overseas, is that right?
There is a start point at the start of the pandemic. The intent is to give every 485 visa holder who was impacted by the travel restrictions due to the pandemic an opportunity to restart their 485 visa. So it's ordinarily that visa is only available once in a lifetime.
Yeah, that's right. That's right. So that's an automatic restart? They don't need to apply for that?
No.
So, sorry, no, they don't need to apply?
No, they don't. If I could just clarify. So the purpose of that change is to allow those visa holders to travel from the 18th of February.
Yes.
From the 1st of July, there's then the opportunity to apply for the second in a lifetime.
Once they are here in Australia.
Yes. So sorry if I wasn't clear before. The 18th of February change is about enabling that group to travel.
Yes.
And then they can apply for the
So,
visa.
so if I could just be clear, Mr Willard, and thank you, your answer's been very helpful. So if there is someone who is currently overseas whose 485 visa expired while they were overseas because they couldn't travel back during the pandemic, they will receive an automatic 485 visa on the 18th of February.
Yes, to allow them to travel to Australia, if they wish to, in order to apply for the second 485 visa.
Thank you. And does that extension, that automatic extension, is that only given to main applicants or is it given to dependents as well?
All 485 visa holders, so it would be anyone who held the 485 visa in the COVID period, whether they're a primary applicant or a dependent.
All right, thank you. Now, on 476 visa holders, so these are visas specifically for recent engineering graduates, and I do note that there's at least 8 engineer categories on the priority migration skilled occupation list. Why wasn't a similar or automatic extension given to 476 visa holders? Because, again, many of them are in the same situation as the 485 visa holders in that they were stuck overseas because of the pandemic and their visas expired.
I'd point out there's a distinction between the two cohorts in that the 485 visa holders prior to the pandemic would have come to Australia and studied in Australia and obtained an Australian qualification, which would then enable them to apply for the 485. The 476 is a different cohort who have, there's no requirement that they've come to Australia. The requirement is simply that they've graduated from an institution identified in the Washington Accord that goes to engineering qualifications. So it's a different set of circumstances to consider. And government has to date has determined not to extend those requirements to the the option of applying for a second visa to the 476 cohort.
All right. Even though there are a number of engineering categories that are on the priority migration skilled occupation list, I mean, is there?
The 476 is recent graduates. Typically, and a recent engineering graduate would be unlikely to be able to meet the standard required to be a skilled engineer. There's typically a period of experience that would be expected before they can reach that level.
All right, thanks, Mr. Bowen. Last question, Chair. Thank you. Thank you. I just wanted to ask about other visa classes where visas expired while people were overseas and stuck overseas because of the pandemic, 457s, 482s, 500s. To the best of your knowledge, Mr. Willard, does the government have any plans for people in those visa classes around automatic extensions or reinstatements of their visas? And has the department put any advice up to the department, up to the minister in regards to those visa classes?
Yes, the department's provided advice around a range of visa classes as to, what's in the mind of ministers or the government. I can't comment on that, but advice has been provided.
So some of that advice has been put up, but you haven't heard back yet, is that right?
Yeah, the other point I'd want to make, Senator, I know you follow the issue closely, but just for general awareness, there are a large number of changes that have been put into effect broadly under the title of COVID concessions.
Yeah.
And there's different concessions for different cohorts. For some cohorts, it's the ability to apply for another visa without having to pay the visa application charge. Other cohorts have had extensions in eligibility periods in light of the COVID impact, which allow them, for example, some of the regional provisional visas can qualify for their permanent visa. Apologies, Chair, it's a long list.
Thank you, Mr. Weller. Perhaps to short circuit it, could I just ask you if you would on notice, please, if there's any further information you can provide around 457s, 482s and 500s in terms of whether advice has been put up to the government, whether the government signed off on that advice or rejected it, and what arrangements are in place for those.
Certainly, if I could just make the final point, there are a number of concessions already in place for 457s, 482s and 500s.
Could you just detail those on notice for us, please? Thanks very much.
Thank you very much, Senator McKim. We are now going to move to outcome 3, but I'm just going to propose a brief 5-minute break. So we will suspend for 5 minutes and return at 5:45. Thanks.
Thank you, Chair.
Chair.
The committee is now in session. We are now moving to outcome 3. I'm very pleased to call officers from the Department of Home Affairs in relation to outcome 3. And I give the call to Senator Keneally.
I think, does the Commissioner want to make an
Commissioner,
opening
I wasn't
statement?
sure whether you were going to make your opening statement now or when a bit later, but my apologies. Would you like to make an opening statement?
If that's possible, Chair, please. Thank you.
Yeah, thank you very much, Commissioner.
Thank you very much. Thank you, Chair and committee members. When I last appeared before this committee, Australia had just begun to reopen its border to international travel under a staged process agreed by National Cabinet for a COVID-safe reopening to the rest of the world. And as with everything associated with the world's response to this once-in-a-century pandemic, reopening any international border is a dynamic and evolving endeavour, not least with the emergence of the Omicron variant late last year. And by necessity, the experience of today's international traveller is significantly different compared to before the Australian border closed in March 2020. Since the 1st of November 2021, fully vaccinated Australian citizens and permanent residents have been able to leave Australia without requiring a travel exemption. The definition of immediate family was also expanded on the 1st of November to enable fully vaccinated parents of Australian citizens and permanent residents to travel to Australia. And on the 15th of December 2021, Australia reopened to fully vaccinated international students, skilled migrants, working holidaymakers and refugee, humanitarian, temporary and provisional family visa holders. In addition, international travel zones have been established with eligible travellers from Singapore, Japan and the Republic of Korea who are able to travel without an exemption and outside arrival caps. And Australia's staged border reopening has helped, in fact, to test and refine our systems and processes before a broader reopening in a way that protects the health and safety of Australians. Since the 1st of November, the ABF has facilitated nearly 580,000 arrivals through airports around the country, and already the daily average for international arrivals in February is almost 11,000 people per day, compared to a daily average of 2,200 passengers in October 2021. And by this time next week, on the 21st of February, Australia will, of course, reopen to all fully vaccinated visa holders, welcoming the return of tourists, business travellers and other visitors. This is a significant milestone, and the ABF is well prepared and postured to once again facilitate high volumes of goods and passengers across our border while protecting the Australian community from those who seek to circumvent our border requirements. We have a multi-layered approach to protecting our border, which starts offshore. The ABF has officers in 18 overseas locations working with airlines to ensure they understand Australia's border entry requirements, as well as the Border Operations Centre in Australia, which supports airlines 24/7. The Border Operations Centre took over 85,000 calls from airlines in the last 6 months that led to airlines denying uplift to over 2,500 people who did not meet our border entry requirements. And while we hear about high-profile cases, these do not always represent the experience of the hundreds of thousands of people who have successfully crossed our border and done the right thing to ensure they meet our entry requirements. Our assurance program that checks vaccination documentation on arrival, since it was established in mid-November 2021, shows that over 99.9% of international arrivals are complying with Australia's vaccination entry requirements. So the system is working and our borders are robust. However, no international border in the world is infallible, even before COVID-19, and we continue to review and strengthen our processes to ensure we remain in an optimal position to support the next stage of reopening. The ABF does not generally comment on specific operational matters or individuals. However, the publicity garnered in the lead up to the Australian Open requires addressing as it generated significant debate and some confusion. While COVID-19 has meant travelling to Australia is more complicated than it used to be, over 1.2 million passengers have successfully entered Australia since the 1st of July 2020 and complied with our border requirements. And since the 15th of December 2021, to enter Australia without applying for an individual travel exemption, a non-citizen must hold one of the eligible visas and be fully vaccinated. A traveller who provides acceptable proof that they cannot be vaccinated for medical reasons can access the same travel arrangements as those who are fully vaccinated. It is an individual traveller's responsibility to ensure they meet all border entry requirements, regardless of who they are or the reason for their travel to Australia. Having a previous COVID-19 infection is not, and nor has it ever been considered, an allowable reason for a medical exemption from COVID-19 vaccination travel to Australia. Minister Hunt and the Department of Health both clearly advised Tennis Australia of this in November 2021. Vaccination status is confirmed at check-in by the airline. Before arrival in Australia, individuals also provide details of their vaccination status through the Australian Traveller Declaration, or the ATD, which is used to refer them to the relevant state and territory officials upon arrival. And as I mentioned earlier, our assurance processes show that 99.9% of passengers have the required evidence of their vaccination status. Visa cancellation delegates exercising powers under the Migration Act 1958 undertake a comprehensive training program covering relevant legislation and the cancellation process relevant to incoming passengers. This is regularly reviewed to maintain consistency and fairness and to ensure matters of case law are appropriately addressed in training. And when a non-citizen's visa is cancelled, of course, they are entitled to challenge the decision through the courts or, where available, merits review in the Administrative Appeal Tribunal. And if and when errors are identified through a merits review or court decision, training and procedures are reviewed and adapted as necessary. The ABF has also continued to enable cross-border trade to support Australia's economic recovery and, since March 2020, has facilitated the arrival of over 27 million doses of COVID-19 vaccines and 36,000 doses of COVID-19 treatments. And the ABF is supporting the Therapeutic Goods Administration to protect the community from unscrupulous suppliers. And since March 2020, the ABF referrals to the TGA have led to the seizure of 12,900 unauthorised COVID-19 test kits, as well as unapproved medicines and substandard protective equipment, including the seizure of over 721,000 units of ivermectin and 186,000 units of hydrochlorine and 51,000 face masks. And in conclusion, as Australia's frontline border law enforcement agency, the ABF will continue to adapt and learn as we support Australia's ongoing pandemic response and, post-COVID, our economic recovery. Our dedicated officers will remain vigilant in protecting the Australian community and its interests at our international border. Thank you, Chair and Committee.
Thank you very much, Commissioner. We are now going to go to questions from senators, and I'm actually going to give the call first to Senator Abetz.
Thank you, Chair, and a change of topic from COVID to vaping. Can I ask, in further response to the question on notice that was provided in SE 21-051, where we were told that 63 consignments containing nicotine vaping products had been detected since the 1st of October 2021, with 11 of those seized. I'm just wondering, do we have an update in relation to detection rates and seizure rates?
Senator, I might ask our Group Manager for Customs, Vanessa Holborn, to step forward and see if she has any more information. I don't have any more precise information on that. If she doesn't, we'll have to take on notice, but we'll see if GM Holden has any information.
We'll see how we go, and if need be, put them on notice. But I would prefer some information if it's available.
You're the Deputy Controller General, aren't you? That's a much fancier title.
That's correct, Secretary.
So the Deputy Controller General.
Vanessa Holborn, Deputy Controller General, Group Manager Customs Group, Australian Border Force. So the question, Senator, is in relation to vaping and detections and seizures of same. Unfortunately, Senator, I'll need to take that on notice. I don't have that information before me tonight.
All right. If you could, I'd be much obliged. And then also I'll notice what was the consignment volume of all detections and the consignment volume of all seizures. Now, in the answer that was provided to question 51, there seems to be a significant lag between the 63 consignments detected and the 11 seized. Can I ask, what's the Therapeutic Good Administration's average referral time to determine whether a consignment is seized?
Again, Senator, I'll need to take that on notice.
All right, if you could, thank you. In answer to the next question, which was 052, taken on notice, I was advised by Border Force that additional enforcement measures for nicotine vaping products imported without a doctor's prescription were to, and I quote, prioritise existing profile and targeting efforts. Can you give us any update as to that? Has there been any additional resourcing allocated to the detection and seizure of nicotine vaping products?
Senator, I can probably answer that. The answer is no. I set priorities for Australian Border Force, and we do devote a lot of effort to tobacco and vaping products, but also narcotics, firearms, childlike sex dolls and other things.
And I would have thought that would be a lot more important than a vaping
so
product, which actually help save lives. But we won't go into that at this estimate.
Thank you for your commentary, Senator Abetz.
So if the answers to that is no, that's very helpful because it deals with a lot of follow-up questions I may have had. Is Border Force able to provide an update on the amount in dollar value and in kilograms of illicit tobacco seizures year to date for the 2021-22 fiscal year?
Yes, Senator, I can provide that detail to you. For financial year 21-22, as at 31 December 2021, the Australian Border Force has seized 145.9 million cigarettes and 19.3 tonnes of loose leaf tobacco. That equates to a potential, this is duty evasion, of $193.7 million. The 2021 financial year figures, 194.4 million cigarettes and 65.5 tonnes of loose leaf tobacco. Duty evasion, approximately $312 million.
And how much of that was through the mail system as opposed to sort of bulk imports via a shipping container or hidden in some other product?
I don't have that breakdown, so I'll take that on notice.
If you could take that on notice, I'd be obliged. Are we able to give any indication of what came in through the mail stream or not?
I'm not able to, no.
No? All right, take that on notice. All right, Chair, as promised, I'd be brief. Thank you very much.
Thank you very much, Senator Abetz. I now give the call to Senator Keneally.
Thank you, Chair. Just before we begin, I have a couple scene-setting questions and then we'll go to some specifics. Is it a case that, quote, every single person who comes into Australia has to prove they're vaccinated or prove they cannot be vaccinated for medical reasons? That's one of the entry requirements.
No, I think the actual wording in the biosecurity determination, I'll need to take this on notice potentially, is that they have to provide information about their health status. And that can be through the Australian Traveller Declaration or if they're unable to complete a traveller declaration through a written form. We do, though, require that airlines at check-in verify the vaccination status of passengers coming to Australia. We've also, as I mentioned, implemented a compliance assurance process where Border Force officers have intervened with over 100,000 passengers since November and directly asked them questions and asked to see the documentation pertaining to their vaccination documentation and status. And as I said earlier on, we've through that process had a 99+% compliance rate.
Yep. And to be clear, those are requirements not for entry into Australia, but entry for quarantine-free entry into Australia. Someone can come to Australia.
It depends.
Can someone come to Australia without being vaccinated?
An Australian, a permanent resident, immediate family, they can come unvaccinated, of course, and
they
people
need
with
to quarantine.
And people with a commissioner's exemption within the caps can come unvaccinated. And people where they seek a commissioner exemption and the state or territory agrees them to come above the caps can come unvaccinated.
And what about tourists?
Tourists can start coming not unvaccinated, vaccinated tourists from next week, the 21st. But any tourist visa, people coming here for tourist reasons have not been able to get it's not been a travel exemption category for people to come here as tourists.
Yes, I understand that. I'm seeking clarification because there is a lot of confusion in the community about who can come here unvaccinated.
Well, Senator, as I said earlier on, if you look at the compliance rates and the number of travellers who've come and navigated the border successfully, there's a lot, in the millions.
I'm not querying that. I think the community is just trying to understand what are the requirements for people who are arriving from overseas now that the border's opening up. And I think it's just useful to have it on the record.
Yeah. There's also, you make a valid point, and the amount of information that's pushed out through Home Affairs website, DFAT website, Department of Health website, and there's a tremendous amount of work between the departments correlating and making sure the consistency and the currency of that information that's pushed out in Australia and of course overseas as well, plus the engagement, daily, weekly with airlines, airports and so on and so forth. So there's a tremendous amount of effort put into communicating, because you're right, there's a lot of changes and the international travel system has become fragmented. And globally, there's a lot of inconsistency, so it's difficult for travellers.
Yes, and I might come to that later, but that's not the main part of this line of questioning. So I also want to establish two things right up front. One, if Novak Djokovic had been fully vaccinated with a approved vaccine for COVID-19, a TGA-approved vaccine, when he arrived in Australia on the 5th of January 2022 with a temporary activity visa, he would have been able to enter Australia.
Indeed, or had he had a travel exemption, or had he had a genuine, contraindication medically and a certificate to back that up with.
And what if he'd entered and quarantined for 14 days?
As he did the year before, indeed.
Yes.
So had Tennis Australia, as the year before, applied, with tennis players for travel exemptions, we would have worked with Victorian Government as we did the previous year, and no doubt unvaccinated players would have had to work with Quarantine Victoria in terms of what their quarantine arrangements would be.
So my point is that Mr. Djokovic, of course, could have chosen to get vaccinated, or he could have chosen to quarantine, and therefore he does bear some responsibility for the circumstances in which he found himself.
Indeed.
Yes. By the way, that quote I read out earlier, and it is from the Minister for Home Affairs, and I think it's from a TV interview she did on the Today Show on 7 January, and I think it goes to some of the confusion that does exist in the community on who's coming and what vaccination status under which they can come.
Well, it was made clear, though, Senator, abundantly clear. So Tennis Australia sought information from ATAGI in November specific to the issue of tennis players who were unvaccinated and the issue of previous COVID. And explicit advice in relation to their explicit question was provided twice, one from the Department of Health, one
That's
from
not
the
what I would
Minister.
have.
So there's no confusion to me in that regard.
Yeah, okay. Well, we'll see. I'd like to now go to the morning of 6 January when Border Force interviewed Novak Djokovic at the Melbourne airport before notifying him of his decision to cancel his visa. And I'm relying on documents provided by the Federal Court, publicly provided by the Federal Court. So if I get any detail wrong, please feel free to correct me. But I specifically want to look at the period between 4:11am and 5:20am on the 6th of January. The documents tendered to the court indicate that Australian Border Force issued Mr Djokovic with a notice at 4:11am and then advised him he had 20 minutes to give any further explanation, and that Mr Djokovic then asked the delegate if he could wait till 8 or 8:30am so he could contact Tennis Australia to try to figure this out, and the delegate says they will speak to the bosses. And at 5:20am, the delegate says, that's absolutely fine, I've spoken to my supervisors, and they're more than happy to allow you to have a rest. My question is, who made the decision to give Mr Djokovic until 8:30am to give him a chance to rest? I'm not asking for names, I'm looking for an indication of the rank or the seniority and whether this decision was taken solely within Australian Border Force at Melbourne Airport, or if there were officers external to the airport or even your office that were involved in that decision to allow him to have till 8 or 8:30.
So the initial agreement with Mr Djokovic to give him till 8 or 8:30 was a decision taken by the delegate. This is an ABF officer, APS 4 level. I may ask Deputy Commissioner Freeman to come forward and assist me here. The reason I say this, Senator, just so you're aware, is that Deputy Commissioner Freeman was the acting commissioner on that date, and so is more familiar with the detail, but
Thank you.
I'll let them.
You might just announce yourself and introduce yourself.
Will do.
Deputy Commissioner.
Thank you, Chair. Dwayne Freeman, Deputy Commissioner, Australian Border Force. Yes, Senator, so the person that made that decision was the delegate.
The delegate who said,
APS.
I'm going to go, I've spoken to my supervisors?
Correct.
So did the delegate spoke to the supervisors. Did the supervisors need to elevate that decision, or they gave him or her, I shouldn't assume?
No.
So did the delegate speak to anyone?
The delegate, under the records I've seen, spoke to his supervisor, which is the APS 6.
Oh, so the delegate spoke to the APS 6 and had an indication that it was okay to give Mr Djokovic until 8 or 8:30 to rest?
From my understanding, correct.
Was there any communication between 4:11am and 5:20am between the Australian Border Force and any minister or minister's office?
You're talking from the ground at the airport, or
Well, I'm talking anywhere.
anywhere?
The Australian Border Force
Yeah.
and a minister or minister's office between 4:11am and 5:20am.
Not to my record, I don't believe so, no. Certainly nothing that's on my record, or no interview record that I've seen to date.
Do you have any information, Commissioner, to add to that?
No, Senator, as I say, I wasn't actually there at the time.
Right.
So the acting commissioner obviously kept the records of any engagements he had with ministers or other people, and also has undertaken a initial review of the process within the ABF, so I think he's the right person to answer that question.
Great.
There was a meeting quite close to that time. It probably was after 6 o'clock, so I'll just have to check my diary notes just to make sure that was close.
Well, I'm going to go through his timeline, so that might be useful. We'll come
Sure.
to that. What about other agencies then between 4:11 and 5:20? Home Affairs, Health, any other?
Not to my knowledge, no.
So it was solely within Border Force. So I want to now look at that period between 5:20am and 7:42am on the 6th of January. Documents also show that two supervisors approached Mr Djokovic outside the interview room at 6:07am as he was waiting for a bed, and asked him if he wanted until 8:30am in order to rest. Is that correct?
That's my understanding, yes.
Okay. At some point, and I can't quite tell from the documentation, the delegate and his supervisors both woke Mr Djokovic, who said again that he wanted to wait until 8:30am, and the documents indicate that one of the supervisors asked him to agree to a decision immediately, saying that Mr Djokovic had already said he had nothing further to add, and that Mr Djokovic said he wanted to wait to speak to his lawyers. At what time did they wake Mr Djokovic?
I don't have that transcript in front of me right now. I'd have to actually get that in front of me.
Senator
Right.
Keneally, we are at 10 minutes. I'm wondering whether we could
Well, okay.
wrap this up, and then obviously if we need to return to you, we will on this issue.
Okay, well, what I might say then, Chair, that might assist Mr Freeman when we come back to my line of questioning is that I do have a series of questions that go through the timeline. If he has documentation that he might want to access to aid in answering those questions, it might be useful.
Sure. Thank you.
Thank you.
Thanks,
Thank you,
Senator
Chair.
Keneally. I'll now give the call to Senator Patrick.
Yeah, thank you, Chair. So I go to an article that was, actually I want to come back to Mr Vizzulo. I've been committee surfing and I went to RRAT, and the department advised me that in relation to the security issue I raised, transport security issue, that the government has made a direction. The Secretary said he didn't want to contradict Home Affairs, but that you were wrong. So,
Oh, did he?
Yeah, he did.
Okay.
So, I just wonder.
I can't engage in committee surfing in the way that you're able to, Senator. I'll have one of my staff do some surfing.
And then gave some detail as to what they're doing up until the expiry of the RASI program that currently funds security.
Yes.
But made it clear there has been a direction from government and that Home Affairs ought to be aware of that. I just wonder if, I don't want to take up too much time, but if you could take that on notice to have a look at.
I will, Senator. I'm assuming that this is a close paraphrase.
Well, yes, close.
Okay, I will make some inquiries.
Thank you.
Committee surfing, I hadn't heard that term. But
well, that's what crossbenchers do.
Okay.
Okay.
Just remain in your suit at all times, please, Senator Patrick.
Okay.
Did he now? I would like to just go to an article that was in one of the papers relating to a man that had come through Border Force and had his phone looked at. It was written by Josh Taylor on the 18th of January. A man who was forced to hand over his phone and passcode to Australian Border Force after returning to Sydney from holidays has labelled the tactic an absolute gross violation of privacy.
Mr Bozzolo, just to interrupt, do you need that article distributed
well,
to you?
I think both the Commissioner and I do recall it, but it might be helpful to have it.
Senator Patrick,
Sure.
it would be helpful if you could distribute that article, please, and table it.
So the relevant legislation in question is the Customs Act, which Mr Outram administers on a day-by-day basis. I'll assist as I can,
sure.
But it would be helpful to have the article.
In some sense, I don't want to go to the details of the individual in this particular instance. I'm just wondering about...
You're speaking of the powers? Is that...
Of the powers, the exercise of them, and what the requirements might be. You might understand the way the article is portrayed would be concerning to a senator in the context of people just coming through customs, having their phone taken off them, being asked to hand over a password and having the contents of the phone examined.
So in short, Senator, there are seizure powers that the Border Force has, which I'll ask the Commissioner to speak to how he operationalises the powers. It does pertain solely to the purposes of the legislation. You can't just, to coin a phrase, surf the phone looking for any matter. It has to be related to matters that are within the jurisdiction of the Border Force. The compulsion to hand over a passcode is not in the Act. It's a request. It will expedite the process by which a seized phone can be examined. But, Commissioner, do you wish to speak to the particulars of how your officers go about that process?
Indeed, and Senator, I can't speak to the individual case, but obviously we have the customs function at the Australian border. So part of that function is examining goods to identify whether there is duty payable or whether, for that matter, there's any prohibited material associated with the goods. Officers obviously have to exercise those powers according to law, according to standard operating procedures, and make records. So it's not a question of just, as the article suggests, officers can just surf for the fun of it. And, you know, I'd have to get behind individual cases, but there's a power there, explicit powers in the Customs Act, obviously as you'd expect. We have a lot of people, unfortunately, who bring into Australia prohibited items within their mobile devices, whether that be, you know, to do with child pornography or things like that. And my officers do search for that kind of material. Not suggesting this person for a minute had that sort of material on their phone, but there are other things they may search for as well. But they won't be going on some surfing exercise just to look for, you know, somebody's phone for the fun of it.
Okay, so is the seizing of the phone or the taking of the phone and then the searching of the phone a function of some intelligence cue? Or is it random?
It could be. So sometimes it depends on, we have a system at the border where other law enforcement partners can provide information to my officers that gives them sufficient grounds to search for a particular thing. And so it could be generated by information provided by another organisation indeed.
Okay, so it just sort of concerns me that in some sense there's a discretion associated with the use of the power. That's not,
the individual officers make that decision.
Yeah, that's not uncommon. Normally, if someone were walking down a street and they wanted to look at the content of my phone or someone else's phone, they might require a warrant, for example. And I'm just trying to...
They would require it.
Okay, so they might require a warrant. So we've got sort of a situation where you could be walking through an airport coming into Australia, and that there's an exception to that general
Indeed,
law.
Senator. So you see the area where people's bags get searched.
Sure.
So if somebody's walking down the street, then you're right. The specific, requirement for the police officers to have reasonable grounds or whatever to suspect. But, the threshold in a customs-controlled area at an international airport, this is a global customs issue, is there's an entitlement for customs services to search passengers' goods and bags for things that are either dutiable or that may contain prohibited imports. So it might be tobacco, and the Department of Agriculture have other powers as well, of course, in relation to plants and seeds and those sorts of things being brought in through the border. So an international airport doesn't operate exactly in law the same as somebody in the street. I accept that.
Sure.
And I think it's fair, Commissioner, to be quite particular. It relates to the prohibited area. It doesn't relate to general preambulation through the food court or the general precinct. It's in that customs-controlled area.
Customs control
and no
area.
different from your bag being requested by the officer to be opened, and for the Commissioner's officers. So it's in that controlled area and solely for the purposes of border enforcement.
There is a difference in the context that if you're looking for something that might be a prohibited item like food, wood, that's slightly different to being able to look through someone's phone, particularly when they're not they're not present when you do so.
Maybe to a degree. There's lots of things you find in bags that you can't act upon that are of interest.
The issue, and Senator, this is going to become an increasing issue, is that intangible goods, of course, are able to be used to convey things of value. So in other words, to circumvent duty being paid and other things. They can be valuable things that can be sold, that can be in digital form. Or in fact, things, as I mentioned earlier on, like, child pornography. So intangible goods are a thing we deal with at the border. And, the laws in relation to intangible goods at the border are quite similar from the purposes of prohibited imports as tangible goods.
Okay, but in the case of child pornography, I've got no issue with you chasing that sort of material. Again, I would have thought there might be some reasonable suspicion threshold required before you just took a phone.
Indeed, there are thresholds. Yeah, as we said earlier on, we can't just go on a fishing expedition, and certainly, the actions we take on behalf of other agencies, there has to be a threshold met in relation to satisfying the officer who's going to exercise the power that they're sufficient to exercise the power.
Okay, so this story, and again, I don't really want to go to the individual, but the story told is a person going through customs has their phone taken off them, is asked for the passcode, and gets his or her phone back, and then they walk out none the wiser as to why someone may have gone through their phone, or even perhaps a little bit disturbed that there might have been text messages that were that.
Senator, maybe I could take on notice the question about the process and procedures we follow through this kind of arrivals process, but there are other laws that relate to what we do with information that's seized. There are issues about how it's destroyed, how it's handled, privacy, those sorts of things. So it's not just open slather, get information from somebody's phone and just share it out. There are strict rules about how that information is used and how it's stored and how it's disposed of.
And indeed, I wonder also about the right of a person to be able to be present when a phone is examined.
I'll include that in the advice we provide on notice.
Could you also then, on notice, provide some details as to the number of times those particular powers have been exercised?
Indeed.
Over the last
year, or
just over the last couple of years, just to see how how often they are used. It might be once or twice, in which case I have no
suspect it's
concern.
more than once or twice.
Yeah, okay. And can you just wrap some context around that, just to give me the numbers of people that do transit, just to give a feel for
Yes, the
percentages?
volumes. Yep.
All right, thank you very much.
Okay, thanks, Senator.
Thank you, Chair.
Thank you very much, Senator Patrick. Senator Molan.
Thank you, Chair. Could I call the head of OSB up to the table, please?
Commissioner, I'm very happy for the Commander of OSB to come forward.
And welcome.
Admiral, I should advise the committee this is the Admiral's first appearance in his role. He's just taken over both as the head of Maritime Border Command and as the commander of the Joint Agency Task Force Operation Sovereign Borders. Admiral Jones.
Thanks, Admiral,
Welcome,
and
Admiral.
my congratulations to you as well. I just wondered, in relation to Operation Sovereign Borders and border security, can you give us some initial impressions of how, in the form of an update, of how Operation Sovereign Borders is responding to the enduring threat of maritime people smuggling, please?
Thanks, Senator. Chair, I have an opening statement to make in relation to Operation Sovereign Borders, which might fit the bill.
Thank you.
Thank you very much.
Good evening, Chair and members of the committee. As has been said, I'm Rear Admiral Justin Jones, the Commander of Joint Agency Task Force Operation Sovereign Borders and the Commander of Maritime Border Command. I thank you for the opportunity to provide you with an opening statement on my 10th day in the job. As the Commander of Operation Sovereign Borders and Maritime Border Command, and like my predecessors, I am committed to preserving safety of life at sea. I'm also committed to ensuring the integrity of Australia's border is maintained against all criminal activity, including the threat of maritime people smuggling. Through collective efforts and capabilities of all sovereign borders agencies, the maritime people smuggling threat to Australia remains suppressed, but it is not defeated. As at 31 December 2021, it has been more than 7 years since the last successful people smuggling venture to Australia. It's been more than 8 years since the last known death at sea from maritime people smuggling ventures en route to Australia. And to contextualise this, we should remember that 1,200 people are believed to have drowned attempting to reach Australia by boat between 2008 and 2013. We remain determined to prevent this from happening again. Australia continues to be an attractive destination for both legal and illegal migration. We are aware that people smugglers continue their attempts to exploit vulnerable people by marketing illegal maritime people smuggling ventures to our country. Combating these criminal syndicates, protecting our borders, and preventing deaths at sea requires constant vigilance and active measures across all three Operation Sovereign Borders lines of effort: disruption and deterrence, response and returns, regional processing and resettlement. The best outcome for Operation Sovereign Borders is to prevent people from boarding illegal maritime ventures in the first place. We continue to focus on upstream efforts to combat maritime people smuggling. This includes deterring people from joining illegal maritime people smuggling ventures and disrupting ventures in source and transit countries before they reach Australian waters. We continue to deliver targeted and persistent deterrence messaging to vulnerable people offshore that may be at greater risk of criminal exploitation by people smugglers. This messaging ensures that they are aware of Australia's strong border protection policies. We also make them aware of the risks of attempting dangerous voyages across open oceans so that they are better prepared to counter the lies of people smugglers. A key element of this messaging is the government's highly effective Zero Chance strategic communications campaign. Since the campaign's launch in May 2019 to 31 December 2021, the digital component has reached approximately 41.3 million people across 11 source and transit countries. Our offshore deterrence approach is supported by ongoing engagement with regional law enforcement and security partners to build capacity and to disrupt people smuggler networks and activities at the source. These engagement efforts have continued despite the challenges associated with COVID-19. Our relationships offshore remain strong, delivering great benefits for Australia's civil maritime security. Additionally, we maintain a strong air and maritime posture through Maritime Border Command assets, which, helpfully, I command. We are ready to rapidly respond to any potential maritime people smuggling ventures and other on-water threats that seek to test the integrity of the Australian border. Since the last Senate estimates hearing, maritime people smuggling activity in the Australian region has remained suppressed. There have been no interceptions of maritime people smuggling ventures targeting Australia. Our strong border protection policies under Operation Sovereign Borders and Maritime Border Command remain an effective deterrent to criminal activity. International movement controls associated with the COVID-19 pandemic have also helped to further suppress maritime people smuggling. Nonetheless, we remain vigilant and are closely monitoring the maritime people smuggling threat environment to ensure we have an early warning of potential unauthorised arrivals. During my tenure as Commander, Operation Sovereign Borders and Maritime Border Command, we will continue to protect the integrity of the Australian border. We will preserve safety of life at sea, maximise collaboration across government, strong international engagement and formidable border response capabilities. Our message remains clear. Anyone that attempts to organise an illegal venture targeting Australia or that attempts to travel to Australia illegally by sea has zero chance of success. I thank the committee for its time and welcome any questions.
Thank you very much, Admiral. Senator Molan, we're about to break for dinner. Would you, from a timing perspective, are you happy to ask your questions now?
Yes.
And keep them reasonably
It will.
brief?
They
All right,
won't be long
fantastic.
at all.
Thank you.
Thank you. Admiral, you spoke about the three lines of effort: disruption and deterrence, response and returns, regional processing and resettlement. How important is the returns part of it, is to return safely, to return those boats safely? And I guess that's what people generally refer to as turn back.
Well, as I said in my opening statement, Senator, the best outcome is to prevent a venture from departing a source country or a transit country in the first place. But the operational modes of return with which I'm sure you are familiar are crucial to the ongoing viability of Operation Sovereign Borders.
So if we ceased to turn boats back, the deterrent effect would be decreased?
I think it's reasonable to say that the deterrent effect of what are currently strong policies might be questioned.
And therefore, if a future government decided to that they couldn't turn boats back, do you think that's a threat to the ongoing success of Operation Sovereign Borders? Because it certainly has been a success so far.
Senator, for me, that's a hypothetical. I will deal with what policies I have at my disposal right now.
Thank you. You mentioned that it's more than 8 years since Australia has had a death at sea. That we know of.
That we know of.
Thank you. And more than 7 years since, I just missed that and I had a quick look through your statement. More than 7 years since what, please?
More than 7 years. More than 7 years since the last successful people smuggling venture to Australia.
Okay.
Senator Molan,
Yes.
2,742 days.
Sorry, so, Minister, say that again, please.
2,742 days.
2,742 days. Thank you. Since the last successful attempt.
Correct.
And 8 years since a death, as far as we know. So it is a robust policy at the moment. Of those of your 3 lines, and there were really 6 factors in those 3 lines. What do you think is the most important one? Is there a more important one, or do they come as a package?
Senator, I think they come as a package. I think the deterrent value is that Operation Sovereign Borders has a layered effect, as the Commissioner has alluded to in his opening statement. The border continuum, as we know it, commences offshore, indeed on somebody else's shore, and runs right through to Australia's sovereign territory itself. So I think the package is itself the most important aspect of Operation Sovereign Borders.
So thank you. And so I think that if you look at the package, and you've stressed the importance of deterrence before, an essential part of our strong stand on deterrence is that illegal entry is not a path to permanent settlement. And if that was changed, would that work against the overall success of the package?
Again, Senator, I think for me that's a hypothetical. So I will continue to pay careful attention to the threat environment as I see it at any given time.
Okay, and that's fair. Is the policy that illegal entry is not a path to resettlement, is that an important part of the overall package?
Well, it's an important and key message, which is part of our messaging, our strategic messaging campaign. We don't seek to advertise the message that you cannot come to Australia. It's that you cannot come to Australia through illegal channels, in particular maritime people smuggling channels.
Thank you. And my last question is, what in essence makes it illegal?
That the Maritime Powers Act is
no, sorry.
Act.
What is the act? What is the act? It's not the act of getting on a boat. It's not the act of sailing across. Is it the act of not coming through a recognised entry point?
What makes it illegal is that it is by law, by legislation, illegal to arrive in Australia unauthorised by boat.
Thank you. Thank you. And Chair, that's all I've got. Thanks.
Thank you very much, Senator Molan. We are now going to suspend for dinner, and we will return in 1 hour. Many thanks. Thank you. Hope you have enjoyed your dinner. We are continuing with the Department of Home Affairs in relation to outcome 3. Look, I've just got a couple of questions in relation to Australia's border security. Commissioner, I'm wanting to ask you about an update on how the ABF is managing travel exemptions and the change after the borders are scheduled to open, of course, on the 21st of February. Just if you could just give the committee an update in relation to those matters.
Certainly, Chair and Senators. So, as I said earlier on in my opening statement, the ABF is postured very well for the reopening of the border. In fact, we've surged a number of officers back out of other areas of operation into our airports. All of those officers are being familiarised with the new digital, passenger declaration process that was described earlier on. We're also working extensively, including with Home Affairs and the Border Measures team, in relation to engagement with airlines, airport operators in Australia and offshore. Our airline liaison officers are actually working with the check-in staff of airlines in other countries to make sure that they're familiar with the new arrangements. That's the first thing. Secondly, in relation to exemptions, the 21st of February will significantly simplify the exemptions arrangement, because provided people are vaccinated, they no longer require an exemption. In a whole lot more visa classes, so it will resemble much more what the border looked like before COVID-19. And so that simplifies things for us, and it allows those decision makers doing exemptions actually to focus on processing more visa applications, which is what most of them were doing beforehand. So that's a real positive. And then finally, our Border Operations Centre, which operates 24/7 and 365, that's the centre at which all the airlines reach in at the uplift point for passengers with any queries they might have about visa status, medical status, so vaccination and rapid antigen tests. So we expect that centre will remain busy whilst we do still have some exemptions, and of course the requirement for passengers to be fully vaccinated. So the other thing I would say is that the quality assurance process I mentioned earlier on, where we're checking the vaccine certification of arriving passengers, that will continue for some time. And we've introduced additional measures where people who do claim a medical contraindication of COVID and provide evidence of that through the ATD or DPD, those documents will continue to be manually checked. So, in other words, Senator, we're ready and looking forward to it.
Commissioner, how do you think that the exemption process applying to the international borders has helped protect Australians from COVID-19?
Well, from my observation would be, considering that we had no similar regime in place beforehand, we had very little time to plan what the regime would look like. It's been incredibly successful. If you look at the number of people who have successfully come to visit Australia in relation to the exemption grounds and those who've managed to go from Australia to other parts of the world, and the balance that we've struck between, facilitation of that travel for compelling, compassionate and economic purposes, and keeping Australia safe from COVID-19 in all its forms, whether it be Delta or Omicron and other things, I think it's been incredibly successful.
Thank you very much. I'm now going to hand the call over to Senator Sheldon.
Thank you very much, Chair. Good evening, everybody. It's good to see you, Minister, and Mr Pezzullo and Mr Outram. I just have some follow-up questions from the previous discussions we've had at the spillover estimates on the 26th of November and the job security hearings 2 weeks ago regarding the ADF raid of Jeff and Jane Smith. As we've discussed previously, the High Commissioner of Vanuatu was listed on the warrant, which of course is highly unusual and potentially illegal. Assistant Commissioner Brezzo said at the job security hearing on the 3rd of February, and I quote, "The ABF has not been able to identify any official material relating to the High Commissioner of Vanuatu." He went on to say, if that material exists, the ABF is not aware of it, as no such material met the conditions of the warrant, and therefore it was not examined as part of our investigation. I just want to be clear, in order for your officers, Mr Outram, to determine whether material meets the conditions of the warrant, the material needs to be seized and read. Isn't that a logical statement?
Not in this day and age, Senator, and AC Bretso is actually online and listed as a witness to this proceeding, so if we need to call AC Bretso, he can come on from Melbourne. But with digital information, of course, it's not possible or feasible during the execution of a search warrant to go through all the digital information. So digital information has to be downloaded and quarantined, if you like, in a secure area. And then it's not manually searched through, because sometimes you're talking about literally terabytes of information. So search parameters are then run across the digital data. So not all of the data is examined. And what HC Bretso said, and this is the process, is that in the case where you do then stumble upon anything that might be subject to diplomatic immunities and privileges, then additional safeguards are in place as well. It wouldn't be just given to the investigators. So in this case, no material, as I understand AC Bretso's evidence, no material was discovered through that electronic search process that came within the scope in relation to diplomatic privileges or immunities.
At the Job Security Inquiry on the 3rd of February, Ms Moy from the Home Affairs Department, in a question asked about the search, the raid, and her response was, as I understand it, Senator, in responding to a question from me, that material can be done electronically, as you've just said, Mr Outram, where the keywords in relations to the conditions of the warrant are inserted, and then that information is looked at to determine whether or not it becomes part of the evidence or not. Can you describe, is that in conflict with what you say the process is?
No, I don't believe so. So I simply gave you a high-level description of the fact there's an electronic search conducted of the information, that people that don't physically pore over every document, every communication, every bit of information. But I might ask AC Bretso actually to come forward and clarify his evidence, and that's probably best because he led that evidence.
Thank you.
Good evening, Phil Bretso, Assistant Commissioner South. Can I just confirm you can hear me?
Yes, we can hear you loud and clear. Thank you. There's a bit of a delay.
Apologies, Senator. Just with regards to the Commissioner's last comment, he's correct. So when, in this instance, a phone is downloaded with information, the information is electronically sorted in terms of search parameters that relate to the 3 conditions of the warrant. It's when that search is completed electronically that the ABF can then filter those bits of valid information that, as I say, relate to all 3 conditions of the warrant.
Thank you. For example, all 3 conditions concurrently, or is it they only have to meet a condition of one of the aspects of the warrant for material to be seized? So I'll explain it a bit further. You might have to turn the mic off, Mr. Bezo, when we're talking his feedback.
Perhaps, Mr. Bezo, when you're hearing the question being asked, if you could just turn your microphone off, because we're hearing all the feedback. Just a bit tricky, there is a bit of a delay. So, Senator Sheldon, could you just ask your question again? And Mr. Bezo, if you could just turn your volume off if that's possible.
Yeah, thank you, Chair. For example, text messages or records of phone conversations between Mr. Smith and the Vanuatu High Commissioner would satisfy the first and second conditions of the warrant, wouldn't they?
Senator, that's true. And just to confirm, I am turning my microphone off. Unfortunately, this is a similar issue we had the other day. Yes, Senator, they may have met the first 2 conditions of the warrant, but the third condition relates to the purpose of the warrant as well. So they have to meet all 3 in order to then be identified as us as something that's relevant to that warrant.
Just want to explore that a bit further. Once your officers determine that the material meets the first and second conditions of the warrant, your officers would actually need to search and read the material to figure out if it meets the third condition of the warrant, wouldn't they?
They may have to, Senator, in terms of once it identifies all 3. So there are parameters on the search that go to the entities that might be covered and also sort of keywords that might go to the purpose of the warrant. So the third condition of the warrant then goes to grounds suspecting that they will forward evidence as to the commission of a work-related offence. So the first example you gave may not necessarily come up in a search, but certainly once those communications have come up and reviewed by investigators, and if they aren't relevant and if they don't go to the purpose outlined in the third condition of the warrant, then they're obviously not considered for the purposes of the investigation.
So just so I'm clear, the first condition of the warrant's there, the second condition of the warrant's there, and then there's a consideration by the officers whether the third condition's met after looking at those 2 aspects of the first and second conditions of the warrant. Is that correct?
That's correct. So the first search goes for all 3, but then yes, investigators consider anything that comes up that relates to the 3 conditions and have a further filter on that. Yes, that's correct.
So the officers check the messages between Mr. Smith and Mr. Farr. Don't relate to the third condition of the warrant without seizing and reading them, is it?
Senator, what I'm advised is that no communications involving Mr. Farre met all 3 conditions of the warrant and therefore have not been considered as part of the investigation.
I appreciate there was just on feedback again. There was a first condition was met, second condition was met of the warrant. There was consideration given and looked, and the documents, the material that was viewed that had Mr. Farr and Mr. Smith's and key words looked at. Is that correct?
No, that's not correct, Senator. My understanding is that nothing from the initial search involved Mr. Farre. So that's not to say that on the phone of Mr. Smith there may have been communications with Mr. Farre. There may well have been, but because they didn't come up with search parameters, they were considered by investigators.
Right. So on the second condition of the warrant, Mr. Farre's name didn't come up. Is that what you're saying to me?
No, Mr. Farre is on the second condition of the warrant, so his name would have come up on that, but not in a search that considers all three conditions of the warrant.
But to consider, I'm just making sure I'm getting this clear because it's not that clear to me. We've confirmed the first condition and the second condition of the warrant applied. Then there was consideration whether the third condition applied for the warrant, whether that would be then exercised. So there was consideration, wasn't there, by officers?
In this instance, Senator, again, the advice provided to me was that Mr Farah didn't come up for consideration by officers.
So that I want to just be really clear here. You're saying that they didn't look at the messages?
I'm certainly saying that there was identification of any messages within those three parameters.
No, I'm asking you very clearly regarding search warrant condition 2 and condition 1. In relationship to those two conditions, did officers look at the messages between Mr Farah and others, including Mr Smith?
Senator, not to my knowledge, because the investigators would then have a sense of what met all three warrants. I understand what you're saying, but no, not to my knowledge.
The way you're managing the feedback is working well. Thank you very much. We can hear you loud and clear.
Thanks, Chair. If you, so just again, can you describe in clear terms just about, again, I Mr Outram had a shot at it before, but if you could have a shot at it as well, just to explain how the material in conditions 2 regarding Mr Farr was considered. So there was nothing that came up about Mr Farr. So whether condition 3 was required to be considered, you'd already discounted it because he wasn't actually, there wasn't an issue with condition 2. Is that what you're saying?
What I'm saying is I certainly, that is the advice I've got in terms of anything that met all three conditions. So at that stage, as we discussed at the Job Security Inquiry, Senator, what happens is any information that hasn't met those three conditions isn't considered, no longer continues, and has to be ultimately disposed of in terms of compliance with the Evidence Act.
How do you make an assessment when, first of all, we know condition 1's been, the warrant was exercised because the material was seized. We also know that the Commissioner, our High Commissioner, was also named on the warrant. We know that condition 2 was looked at electronically and, I understand, viewed by officers. So without them doing that, don't they have to view it to make a decision whether condition 3 applies?
Well, I think, Senator, some of it comes down to the search parameters that are put in as well. And I would have to take on notice precisely what those parameters are, because in some instances, it could have keywords. So what I mean by that is it could link multiple entities or people that are mentioned on the first or second condition that relate to part of search parameters. But I'm not aware of the specifics of the search parameters. So as a result, I'd have to take that on notice and check with those of the search.
Senator Shelton, we have gone over time for your block. I will need to move to other senators. We can come back to you briefly if you need. Senator McKim.
Thanks, Chair. Commissioner Outram, I had some questions for you on the same matter that Senator Patrick was asking you about actually before dinner, which was the confiscation of phones and electronic devices at borders. And I do understand that you took a number of those questions on notice, which is fine. Can I ask you, and again, if you need to take these on notice, I'd completely understand, but do your officers have the power to manipulate data on somebody's phone that they take? Like, can they add data or delete data or change data or copy data from people's phones or computers?
Senator, but no, is my understanding. So, but I'll take it on notice and confirm for you what exact powers they do have in relation to electronic devices for arriving passengers.
All right, thank you, I appreciate that. And if as part of that you could also take on notice, please, whether if there are any powers, I presume there are powers to, for example, copy data. I mean, if you used the example before dinner of child pornography, I presume if you found some, you would have the power to copy that. And
Indeed, it's a download. You either seize the phone or you download data.
Yeah, yeah. And my question is, does the relevant data, if you did, as you say, download data, does that have to be relevant to the belief that the officer had in terms of his or her reason for seizing the phone in the first place? So I'm happy if you answer.
I'll take that on notice, but if I could just give you a sort of context, a bit similar to the questions by Senator Sheldon. In this day and age, when you're searching electronic devices, there could be terabytes of data. And the only way to sift through it is electronically. So you may well download data that isn't of interest in terms of your reasonable grounds to suspect for a particular thing, but you can't and haven't got the time to pore over terabytes of data to find the thing you're after. You've got to run searches.
So you might download a wide range of data for the purpose of searching.
Indeed, and then there are strict rules about, of course, how you handle and manage that data.
Yeah, yeah. Okay, thanks. Yeah, anything more you can provide on notice would be appreciated. And can I just finally ask, and again, if you wish to take this on notice, that's fine, whether you do have the powers to compel someone to provide their passcode to a device? Or
I think the Secretary answered that earlier on, but I'll take it on notice and again, we'll provide you a definitive view of our powers at the border.
Yeah, thanks.
In relation to these devices.
In the story that Senator Patrick was referring to, which has now been tabled, it quotes a spokesperson for the ABF as saying if an individual refuses to comply with a request for an examination of their electronic device, they may be referred for further law enforcement action. And specifically, I'm asking whether a request for the examination of an electronic device would capture not just the handing over of the device, but the provision of a password or passcode.
I'll take it all on notice. Thank you.
All right, thanks. I've got some questions around Operation Sovereign Borders, which I suspect might be for Rear Admiral Jones. Thanks. Rear Admiral, thanks for your opening statement to the committee. I just had a couple of follow-up questions from it. Just firstly, you talk about your commitment to ensuring the integrity of our country's border is maintained against all crime types, including the threat of maritime people smuggling. That's a quote from very early on in your statement. I just want to be clear, or I guess I should ask you, are you suggesting that someone who comes to Australia by boat to seek asylum is committing a crime?
Senator, pardon me, Senator, I'm not suggesting that vulnerable people are criminals. I am suggesting that people smugglers are criminals.
Yeah, so you're not suggesting that someone who comes to Australia by boat, even if that boat is crewed by someone who you would regard as a people smuggler, you're not suggesting that that person who is coming here to claim asylum is committing a crime?
They are, by that act, breaking the law as it is written. But
no, I'm asking specifically. There's a difference between being a breach of the law, which many government departments regularly are, for example, in not answering an FOI request on time, and committing a crime. Rear Admiral, I'm specifically asking about committing a crime. Are you suggesting that a person who comes here by boat to seek asylum, even if they come in a boat that is crewed by people that you would describe as people smugglers, are you suggesting that those people who come here to claim asylum by boat are committing a crime?
The act itself is not a crime. However, arriving in a unauthorised and illegal maritime venture is contrary to Australia's domestic laws.
No, thanks. So they're not committing a crime. Now,
that's probably not quite precisely what the Admiral said, but that's okay.
In fact, it is precisely what the Rear Admiral said. Well, I'm happy to clarify that. Rear Admiral, I understand you're making a caveat in terms of something being in breach of the law, but specifically, is someone arriving here by boat to seek asylum, is that person committing a crime?
I will just restate my original answer, Senator. It is not a crime to travel by sea, but it is in breach of Australia's domestic laws to arrive illegally and unauthorised by boat.
Thank you. So you've agreed twice now that it's not a crime. So I was just clarifying that for the Chair. You've said in your statement, Rear Admiral, that it's been more than 8 years since the last known death at sea from maritime people smuggling ventures en route to Australia. The word known is doing quite a bit of heavy lifting in that sentence. We just can't know whether there have been any deaths at sea from what you describe as maritime people smuggling ventures. We just can't know that, can we?
That's correct.
Yeah.
What we do know is with the enormous reduction in the number of boats that
I'm not
are making
asking
their
about
way
that.
to Australia,
Well, thanks, Minister, but I'm not asking about
then the likelihood thereof is greatly reduced.
Thank you. I'm not asking about that.
Senator McKim, it is open to the Minister to add to the
Sure.
answer. So,
Thanks. And Rear Admiral...
yeah.
Sorry, Chair.
That's okay.
And Rear
Let's go
Admiral, you've accepted quite reasonably, in my view, that we just can't know. And it's possible, isn't it, that some deaths may have occurred on ventures that are en route to Australia, and others may have occurred post turnbacks conducted by Operation Sovereign Borders. That's true, isn't it?
It is possible that there have been deaths at sea unknown to us. On turnbacks, however, those personnel are tracked, so we do know that there have been no deaths, to my knowledge, on turnbacks or
So you track the boats?
Yes, we do.
And you count the number of passengers that are at the boats when they get back, do you?
Yes, we do.
You do?
So that's
Senator,
the
if I-
kind of tracking, I beg your pardon, Commissioner, we have in place would be for all 38 of the boats that have been turned back, and that involves, of course, 873 people and their crew.
Senator, the other thing I might say is that we may know in some circumstances, because we work very closely with Coast Guards in other jurisdictions, and sometimes they will notify us of a venture that they believe is on its way to Australia, and of course if it doesn't arrive. So there are means by which one can get to know if potentially people have died at sea.
Okay, so just to be clear, on every single turnback that's happened under Operation Sovereign Borders, you've had a head count of the people on every single boat when it's arrived back on land. Is that
I'll take that
your
on
evidence?
notice for accuracy, but that is the case to my knowledge.
Thanks for taking that on notice. I wanted to ask about the Zero Chance website, which you've referred to as well, Rear Admiral, in your opening statement.
2 minutes, Senator McKim.
I beg your pardon?
2 minutes.
Oh, well, I'll just give a bit of notice that I probably won't be able to wrap this in 2 minutes, so I'm happy if you want to come back to me, Chair.
All right.
Once I've had my 2 minutes, that is. Could I ask, Admiral, firstly, what is if any, is the financial contribution of the Sri Lankan government to this?
There's no contribution by the Sri Lankan government. It's an Australian government strategic communications campaign funded by the department.
And it's helping to make sure that the 2,742 days that Australia has gone since the last successful maritime people smuggling venture continues on. That communications program is really important to making sure people don't risk their lives in dangerous boats at sea.
Thanks, Minister. Rear Admiral, you've described this campaign, the Zero Chance campaign, as highly effective in your opening statement, and you referred to the number of views, I guess, that it's had across 11 source and transit companies. Is that your only metric for success, the number of views that it's had?
I suspect that is one measure. I would also suggest that a contributing measure of success to the campaign is that we've had no ventures for the last 7 years, and indeed in the time that the Zero Chance campaign has been running.
All right, thanks. I mean, I guess I'm just trying to drill down a little bit, because as you've also acknowledged in your opening statement, There's a range of strategies that go to make up Operation Sovereign Borders, and I'm trying to understand how you would weight various of those strategies in terms of their importance to achieving the overall objective. So that's what I'm trying to achieve here. So you've said that the zero chance digital component has reached $41.3 million. 41.3 million people, but you don't know. I mean, they could have logged on to have a laugh at it, couldn't they? I mean, you don't know that it's been effective just because a number of people have had a look at it, do you?
I can surmise that it has been effective through our tracking of sentiment in our partner countries and our work with regional law enforcement agencies and security partners. I don't have the latest sentiment data at the moment, but we do know that it has an influence. And I think the press reporting this morning, indeed, on the ABC News website, has a witness who thinks it is successful.
All right. Do you accept...
Last question, Senator McKim. Yes, Minister. Did you want to add to that?
As the Rear Admiral said earlier in his evidence, this is one of a number of components of Operation Sovereign Borders, and together those work to achieve the extended period that we've had of no people smuggling ventures coming to Australia. No one part works on its own, but this information program is one of the bricks in the wall that's necessary to make this work.
Do you accept, Minister, that this the Zero Chance campaign actually massively trivialises the lived experience of people who are facing persecution?
Not at all.
You don't? So you think that someone who's facing
excuse me, can I
death
finish my
or
answer,
persecution
please?
is seriously going to look at a website and play a civil game, and then they're going to go, oh, well, look, that'll totally change it. I won't flee because I'm in fear of my life. Are you seriously suggesting that,
Order.
That performance?
Order. Senator McKim and to the Minister, could I just ask Ms Senator McKim if you can please give the Minister the opportunity to answer the first question that you asked. Minister.
The campaign does not have that impact. What the campaign does is allow Australia to be among the most generous and welcoming countries in the world by ensuring that the places we have available in Australia to open our arms and assist those in need who are facing persecution, who are facing some of the most barbaric situations, are saved for them. And that's the important role that Operation Sovereign Borders and the Coalition's firm policy on border protection achieves. It allows us to help the most vulnerable people in the most dangerous places in the world.
Don't pretend you care about them. You've been torturing some of them for 9 years now, Minister.
Senator McKim.
You've been torturing some of them for 9 years.
Please
don't pretend you care about them.
Senator McKim, please come to order. I would ask you that what you've just said is a reflection on a senator in this place. That is a breach of the standing orders. I understand there is a difference of opinion, but can you please express yourself in a way and ask questions which does not reflect on senators in this place? I'm now going to give the call to Senator Keneally.
Thank you very much, Chair. In the interest of time, I have sought to condense some of my questions, and hopefully we can return to the Novak Djokovic, although I will thank Rear Admiral Jones for being here today. But unfortunately, we don't have hours of time at our disposal. So if I could return to the Novak Djokovic and particularly, yes, thank you, questions about Australian Border Force. I have sought to, as the gentleman comes to the desk, I have sought to condense my questions, and I flagged to the Chair that, as discussed, Senator Grogan will have some additional questions on another matter. At any point between 5:20 a.m., when the delegate first told Mr. Djokovic that he could have until 8 or 8:30 a.m., and 7:29 a.m., when the delegate made the decision to cancel Mr. Djokovic's visa, Did the delegate, his supervisors, or any other Australian Border Force officer speak to a minister or a minister's office?
To my knowledge, the only person that spoke to the minister or the office was myself. And as I said earlier, the exact timing of that, I've got to get the exact time, but it was approximately 0700. So it was around 7 o'clock in the morning.
And have you determined the time in which you woke Mr. Djokovic?
According to the record, the discussion where the officers re-entered was at approximately 05:45.
5:45.
Yep.
Who did you speak to at 7 a.m?
Minister Andrews and her
You spoke
chief
directly
staff.
to the Minister for Home Affairs?
Correct.
And what was the nature of your communication with her? Were you seeking her advice, or were you advising her of what was happening?
No, she was merely looking for an operational update as to what was happening on the
Right.
ground, given the situation was obviously quite topical.
So to go back, you said that at 5:45 a.m. Mr. Djokovic was woken. He was told at 5:20 a.m. he could have until 8 or 8:30. What caused the change of position?
Just to clarify, I didn't say he was woken. I said they re-entered. So
Sorry.
yeah,
And he was, and at that point, so we're clear, at 5:45, he was told, he was encouraged to make a decision at that point.
what I've been informed is that the officers re-entered the room to understand whether Mr. Djokovic was happy to continue with the interview, and he expressed that he was.
Well, in fact, that's not what the court documents indicate. In fact, Mr. Djokovic said that he might have something in a few hours after speaking to his lawyers. And it says, over several pages of the transcript, the supervisor pressured Mr. Djokovic to simply continue the interview immediately. Mr. Djokovic, having formed the view they were going to cancel his visa, it's obvious, relents, feeling that he has no choice, and he does the interview.
Yeah, two
Why
things.
why didn't Australian Border Force tell him he had until 8 or 8:30 and then change their mind about half an hour later?
Yeah, so the officer, the delegate, had originally agreed to the 8 to 8:30 timeframe, and that's clear. And unfortunately, as that went through the chain of command, they realised, or they thought, that the break there was for fatigue purposes, or that he needed a rest. They reconsidered that and re-entered the interview.
So when you say chain of command, can you be more specific? Who
So
made the decision to re-enter the room and seek to restart the interview?
So there's 4 people in that chain of command. There's the APS 4, the APS 6, there's an EL 2, and then there's a SES 1. So my understanding is the conversation between the EL 2 and the SES 1 led to the re-entering or re-instigating the interview without their knowledge that the break was given for the purpose that was granted.
So
And that
are
was an
you
error.
saying that the SES 1 and the person below that officer did not know that it had been agreed to give Mr. Djokovic a break?
Correct.
Until 8 or
sorry.
8:30?
Just to clarify that, they were aware that he was granted the break to 8 to 8:30.
Mhm.
They weren't aware for the purpose that the break was agreed.
That it was rest, or that it was...
It was for the purposes of meeting with his lawyer.
They were
at 8 to
unaware that
8:30.
it was for the purposes of meeting his lawyers.
Correct.
And getting advice from Tennis Australia.
Correct.
So that's where the mistake was made.
Correct.
Is that and so the government's decision to withdraw from the first court process regarding the first visa cancellation, that's where the mistake was made.
Correct.
That's the lack of procedural fairness.
That's correct.
Commissioner, have you reviewed this matter, and have you made any changes to processes or policy in the wake of it?
There's a thorough review ongoing between the ABF and the Department, Senator, as you would expect. And I have, though, already issued some directions in relation to at least the recording of these kinds of interviews, because not all of the conversations on the night were tape recorded with Mr. Djokovic, and I wish they had been. So I've issued directions along those lines, but there is a more in-depth review going on now about our training and how to deal with, in particular, high-profile or complicated matters like this. This obviously came late at night, and the officers, were probably junior in experience in that regard. So, of course, there will be changes as a consequence of this.
How junior is an SES1?
No, the officers, I'm talking about the officers doing the interview, and of course there was a miscommunication, of course, on the night. I'd rather that didn't happen, but there's a lot to this that we are working through, and certainly when he was the acting commissioner, he's done an initial review and reported to me in some of his observations and recommendations.
You mean Mr. Freeman?
Mr. Freeman, yes. The Deputy Commissioner.
Just for the sake
So,
of it.
but also bear in mind that we work with the department very closely here in terms of visa cancellations, and so we're going through a joint process with the department in terms of a very thorough review of the circumstances surrounding them, not just the visa cancellation decision.
Well, thank you, and I appreciate that answer. In the interest of time, I want, just to be clear, the only communication that you are aware of, that either of you are aware of, is between yourself, between Australian Border Force and a minister or the minister's office, is that phone conversation you had with, I presume it was phone, with the Minister for Home Affairs,
Correct.
where she was only, you were advising her on the situation.
In that time frame that you've given me, yes, between those
Was there
hours.
communication at any time then between the point at which Mr. Djokovic arrived in Australia and the point at which
yes.
we cancelled his visa?
Yeah, I had a conversation with the Minister's office at about 6 o'clock the day before, on the 5th, so well in advance of his arrival.
And what was the content of that conversation?
A similar conversation is to say, well, what is the current status? Because there was a lot of, at that point in time, a lot of information outstanding in relation to what documents he had with him. We weren't really sure of what was going to present to us at the border.
This is 6 in the evening.
6 p.m. in the evening, that is.
Did they express any view as to what decision Australian Border Force should take?
Absolutely not, no.
Last question. Do we have a cost yet of the legal proceedings to bring this matter to a conclusion? What has the government spent in its legal proceedings to bring this matter to a conclusion?
I'd have to check with Ms DeVoe, noting that there were 2 judicial proceedings.
Where?
But if Ms DeVoe, is she here? Yep. If she's got some early indicative costs, I'd be pleased for her to advise, but otherwise toting up lawyers' bills sometimes can take some time. And when you say bringing the matter to conclusion, there's a federal circuit court, and then there's the subsequent.
Until the man was deported.
Yeah. So in both instances, the circuit court and the federal court matter.
Yes. So the legal costs haven't been paid yet because they haven't been invoiced through February, but we had an estimate of costs that was given before the proceedings, and then in relation to the 2 proceedings, costs were awarded against the department in the first proceedings, costs were awarded for the department in the second, and those 2 will, when they do come in, generally offset themselves. So we'll need to get the invoices and then make the determination in consultation with Mr Djokovic's lawyers as to how those 2 cost orders are sorted out.
You said you had an estimate going in. What was that?
And he was awarded costs on the first, and we were awarded costs on the second?
Correct, yes.
Yes, Ms DeVoe did just say that. I caught that.
Yep. I'll just have to find that figure. It might be that the CFO's got it handy, but
Hopefully they'll net out to 0. But
It contains several pages of
Come back to this.
Sorry?
Do you want to come back to
I think the combined estimate at this stage was in the vicinity of about 360,000 without any awards going either way. So that includes external legal expenses and also legal expenses internally.
Right.
But as I said, it's an estimate.
Thank you.
Senator Keneally, thank you. We've just got a couple of minutes of this block left for Senator Grogan.
I wanted to discuss the detention and deportation of Miss Renata Vorokova. So she was detained on the 6th of January, shortly after Mr Djokovic's arrival. Can you tell us where Miss Vorokova was when she was detained?
That's the matter for the Border Force. It was a cancellation and detention decision taken by the Border Force.
Commissioner Bretzo, who is online, may well have that detail.
I understood you only required another 10 minutes between the two of you. Yeah. Well, we are trying to move to the AFP. We were due to move to the AFP at 8 o'clock. I'm going to ask senators to very briefly ask their questions. Senator Grogan, could I offer you another 5 minutes to complete your questions now?
And then if need be, I'll have to go to another block then.
Well, we might need to move to the AFP and go to a spillover in that case, because we just can't run half an hour late at this time of night. So can I invite you to ask your questions in the next 5 minutes?
So can you tell us where Ms Vorokova was when she was detained?
Good evening, Senator Phil Bledsoe, Assistant Commissioner South. Ms Vorokova was met at her hotel and was asked to come for an interview, and she was subsequently, when held in detention, I believe at the Park Hotel, to confirm that premises.
Cool. And how many officers were present at that point to take her into custody?
Senator, I don't have that number in front of me. I believe it was, but I'll just have to check that number as well.
You believe it was 3, did you say?
I believe it was 3, but I just have to check that number, Senator. I don't have the precise number of officers that were present at the time.
Okay. So I'd just like to quote what Ms Vorokova said. So I understand she legally entered Australia on the basis of a supposedly valid medical visa, medical exemption. She'd been in the community competing in a tennis tournament for about a week. And then she said, no, we'll table this article for anyone who needs it. I'll do it. Thank you. And she said, I didn't expect that in the darkest dream it was just too much. She admitted to bursting into tears during the questioning and after she'd been detained. And she said, I was worried. I didn't feel safe until I was back home. Nothing was certain. It was as if I were watching a film, a long interrogation with instructions such as undress, get dressed. Yuck, I don't even want to think about it, let alone live it again. Was Ms Vorokova strip searched by the ABF during her detention?
No, Senator.
Senator, if I could also clarify and qualify something you said there as well, is that Ms Vorokova arrived into Australia with a letter/certificate produced by Tennis Australia claiming that she had a medical exemption based on the fact she had prior COVID-19. And prior COVID-19 has never been aground in Australia for a contraindication of COVID, as was made clear to Tennis Australia twice in November by the Department of Health and the Minister for Health. So the letter that she entered Australia under, in fact, probably confused the airline that uplifted her because it wasn't a valid medical certificate, or that it purported to be.
Can I just confirm a point there before you go on, just because I know that
I'm just clarifying here.
No, I know, but you've said something that I would then like to clarify further, if you don't mind. Is a letter from Tennis Australia a valid medical exemption?
No, but it seemed it was purported to be.
Okay.
No.
I think it's important that Commissioner Outram finish that answer, though, because I think it goes to the heart of the difference.
She said he was not.
Okay.
So, in chronological order, it's important we get to the detail of this. In early November, Tennis Australia sought clarification from ATAGI about whether prior COVID-19 was a contraindication for the purposes of medical exemption to come to Australia. They received 2 replies, one from the Department of Health and one from the Minister of Health. Both explicitly dealt with their question to say, no, prior COVID-19 is not a medical reason to not have a vaccination. So Tennis Australia, it would appear, knew that information, and yet in December, a doctor from Tennis Australia produced a letter that purported to be a certificate, a medical certificate from a doctor at Tennis Australia saying that because they'd had prior COVID-19, they were medically exempt, and this was a certificate of that. So that letter, either deliberately or inadvertently, was used by tennis players And it confused airline checking people because they thought it was a genuine medical exemption certificate for the purposes of the Australian international border, which it was, of course, not.
Cool. Thank you very much for that. So you're saying that she was not strip searched, but she's saying that she was.
For a strip search to occur of a detainee, it has to be approved by an SES Band 3 officers in very limited circumstances to search for weapons or things of that nature, Senator.
Was she asked to remove any of her clothing?
I'll ask her, I doubt it, but I'll ask AC Bretso to answer that question.
No, Senator. Before she would have gone into detention, as the Commissioner mentioned, she would have had her bag searched, and that's consistent with anyone going into detention, just to make sure that there was nothing prohibited or otherwise in her luggage, but she was not asked to remove clothing.
Okay.
Final question, Senator Grogan.
One more question. All right, I'll leave it there then.
Thanks, Senator Grogan. Senator McKim, I will go to you now, and you have promised me that it's 5 minutes only because we do need to go to the AFP, and I'm going to ask everyone if they can keep their answers quite succinct so we can complete Senator McKim's questions in 5 minutes. Thank you.
Well, thanks, Chair. Look, the last one on Operation Sovereign Borders, happy for it to be taken on notice. Just an update of the table that's been previously supplied to the committee entitled Returned People Smuggling Ventures. And if that could include the number of persons returned, if that's known, and the number of children, if that's known, as well as the country to which the venture was returned. So I'm happy to...
Senator, I'll take it on notice.
Yeah, all right, thanks. Thanks, Commissioner. Could I ask, in regards to people detained currently or up until recently on Christmas Island, how many have previously held a protection visa or a humanitarian visa? If you don't have that breakdown, I'm happy for that to be provided on notice.
I'll take it on notice, but by and large, they are Section 501 cancellations, but some of those people who've had subsequent visas cancelled did previously hold a protection visa, some of them, but I'll give you the exact number on notice.
All right, thanks. And if you could, as part of that, Commissioner, please provide the committee with a breakdown on what section of the Migration Act they were detained under. You've just said you thought most, in general terms, were 501s. That's fine if that's the case. If you've got any more detailed breakdown on that, please.
We'll give you that breakdown.
And what class, if they did hold a protection or a humanitarian or a refugee visa, what class of visa that was?
We'll take that on notice,
All right, thanks. I appreciate that. And again, you may need to take this on notice, Commissioner, but I'm interested how many people in detention are prevented from being removed from detention or from Australia due to the Migration Amendment clarifying international obligations for removals Act 2021. So basically what I'm asking there, Commissioner, just for clarity, is how many people fall within the definitions contained in that Act and are still in immigration detention in Australia?
We'll take that on notice.
All right. Thanks. And Chair, that was well under 5 minutes. I think
You did very well, Senator McKim. Thank you so much. That concludes the committee's examination of the department in relation to outcome 3. Thank you very much, Mr Bozzolo, to you and your officers. We are now going to move to the Australian Federal Police. I call AFP officers to the table. And thank you again for all your time and for your evidence this evening.
Thank you. Thank you.
Oh, sure. Given we are going to take a couple of minutes to bring the AFP to the table, the committee will suspend and resume in a couple of minutes. The committee is now in session. Again, I welcome officers from the Australian Federal Police. Commissioner, good evening. Would you like to make an opening statement?
Yes, thank you, Senator. I'll be as quick as I can. So good evening, Chair and Committee. We begin 2022 where we left off in 2021, seeing an ever-increasing volume of federal crime. The past year underscored that we live in a globalised criminal economy with actions and events thousands of kilometres away in Colombia, Syria or Turkey directly impacting on Australians in Cabramatta, Sale or Taroom. This is why the AFP's international influence and postings in 33 countries has never been more important to Australia's security. The AFP works with international law enforcement agencies in country to help bring to justice those offshore offenders who target Australians, Australian businesses and Australian institutions. In the past financial year, we recorded 266 disruptions internationally, including in Mexico, Malaysia and the Netherlands. Most of our disruptions address the illicit drug trade, but also include terrorism, child exploitation and cybercrime. Next month, I will attend the 40th ASEANAPOL conference in Cambodia, where police commissioners in our region will discuss the need to forge stronger cooperation in the fight against transnational serious organised crime. The AFP's overseas network, including in Southeast Asia and the Pacific, builds trust and makes us a partner of choice. With our policing counterparts, we stay focused on our shared and unwavering commitment to keep our communities safe. We learn and train, we share intelligence and capability, and we assist after natural disaster, tragedy and unrest. More than 60 members of the AFP were deployed under Operation Skyray, which assisted the Royal Solomon Islands Police Force to respond to violent protests in late 2021. Many of our officers were deployed at short notice to provide much-needed operational support, equipment, vehicles, tools, PPE and medications. And when I travelled to the Solomon Islands last month, I met with Prime Minister Sogavare and was deeply honoured to present him with a framed collage of images from a recent medal ceremony with Michael and Christine Dunning. And the Dunnings received several Royal Solomon Island Police Force and AFP posthumous medals on behalf of their son Adam, who at just 26 years old was killed whilst on patrol in Honiara in December 2004. And our partnership with the Royal Solomon Island Police Force goes back 22 years. We will continue to be there for our friends and neighbours in the Solomon Islands, in Tonga, to assist recovery from the recent volcano, and across the Pacific. At home, the AFP is at a heightened alert to protect our community, high office holders, our democratic institutions and democratic values. For the past 2 months, ACT Policing and the AFP have been maintaining public order in the ACT under Operation Hawker in challenging circumstances. And to those officers in ACT Policing and AFP members around the country who answered the call to help to ensure public safety, I do thank you. Your professionalism and dedication cannot be underplayed. Most Australians, though, won't see foreign interference or be targeted by foreign interference. But it has the potential to affect every Australian because it erodes democracy and our institutions. It has never been more important for the AFP to protect Australia and the way Australians live. And that's why the AFP and our partners, particularly ASIO, through the Counter Foreign Interference Task Force, work so closely together to protect Australians from crimes committed in the shadows. Last year, the AFP worked with ASIO and others to bring an individual before the courts on the first foreign interference charges laid since the new offence was introduced in 2018. And that committal hearing is due to start in March in Victoria. And the AFP is aware of increased espionage and foreign interference threats. In the past 18 months, the Counter Foreign Interference Task Force has achieved a number of successful disruptions, most significantly in relation to democratic institutions. And while the Counter Foreign Interference Task Force disruption efforts have been successful in target hardening the physical environment, challenges in the cyber domain are ever present, including hostile foreign actors undertaking cyber-enabled espionage. A priority continues to be the development of national arrangements to identify and respond to interference against diaspora communities in Australia. And this type of interference includes monitoring and harassing sections of the community seen as dissidents by authoritarian states. It may also involve attempts to silence members of the community from criticising the policies of regimes in countries to which they maintain links. Foreign interference is an insidious and resource-intensive crime, and one that I expect will continue to grow and converge with other crime types in Australia. But the AFP, ASIO and our other partners have the technical expertise and legislative frameworks to arrest and bring those offenders to justice. In the lead up to this year's election, I am also concerned about the prevalence of disinformation and the impact this can have on the integrity of our institutions and the election itself. And where disinformation reaches a criminal threshold, particularly where it urges or advocates violence, the AFP will be exercising the full force of its powers. We have already demonstrated we won't hesitate to act. For example, we charge an individual with computer, carriage service and electoral offences for his role in an offensive spam email campaign and sending over 23 million messages during the 2019 Wentworth and 2020 Eden Monaro by-elections. That individual will be sentenced later this year. We're also focusing our effort on crime that directly affects Australians every day. Cybercrime is more than the break and enter 21st century. Its prevalence is increasing year on year. And we are building partnerships across governments and with industry and building bridges to the community to stem the tide of this insidious crime. For example, we recently reached out to a major bank to stop millions of dollars from leaving Australia after we identified the victim of a scam. With these challenges in mind, it's not enough just to keep pace, we must be a step ahead. And I was pleased to travel to the US in late 2021 to witness the signing of the Cloud Act agreement between the US and Australia, which will facilitate our timely access to key electronic data offshore to prevent, detect, investigate and prosecute serious crime. Since my visit to the US, President Biden has signed 2 executive orders to better address transnational serious organised crime, demonstrating the extent of this shared problem around the world. And that's why, in the Global Policing Innovation Exchange, we're partnering with like-minded agencies and the best minds around the world to think innovatively about modern policing challenges. And during the pandemic, the AFP led virtual sessions with senior officers in over a dozen countries dealing with common challenges to showcase practical frontline capabilities, research and development. And as chair of the Five Eyes Law Enforcement Group, which comprises of the Australian Criminal Intelligence Commission, New Zealand Police, Royal Canadian Mounted Police, US Drug Enforcement Administration, US Federal Bureau of Investigation, US Immigration and Customs Enforcement, Homeland Security Investigations, United Kingdom National Crime Agency and the head of UK Counter-Terrorism Policing, I will host my counterparts in Sydney later this year to ensure we can share the intelligence and capability needed to take on known and emerging threats. Our international law enforcement partners look to the AFP to help counter these threats, and in part it is because of our world-leading legislation. And I'm very grateful for new laws passed by the Parliament last year, which are allowing us to target criminality from all angles. We are now using the Identify and Disrupt Act to obtain warrants to target alleged child sex offenders and drug, firearm and money laundering activities. The new extended supervision order scheme will assist to manage the ongoing risk that terrorism offenders pose to the community on release from prison, and amendments in the Economic Disruption Act are helping the AFP remove profit from serious and organised crime, a more than $47 billion scourge in Australia. I would also like to acknowledge that this year is the 20th anniversary of the Bali bombings in Indonesia. It was a tragedy that shocked and devastated Australians, and one that is very close to the heart of the AFP and families of the victims. 20 years ago, we grieved together for the 202 lives lost, including 88 Australians. But just hours after the deadly blast, the AFP deployed to Indonesia to work with the Indonesian National Police to help bring those responsible to justice, and we did. And that partnership between the AFP and the Indonesian National Police has continued and has strengthened over the past 2 decades. I now welcome your questions. Thank you,
Commissioner, thank you so much. We are now going to ask questions amongst us. I'm going to give the call first of all to Senator McGrath.
Thank you, Chair. Commissioner, what proportion of drug trafficking into Australia is done by organised crime compared to the importation by individuals?
I'll just ask Deputy Commissioner McCartney, if I could, Senator, just come to assist with answering that question.
Thank you, Senator. Deputy Commissioner Ian McCartney, I wonder if you could just repeat your question again.
What proportion of drug trafficking into Australia is done by organised crime compared to importation by individuals?
I'd say the vast majority in terms of volume and activities is on behalf of organised crime. It's a sophisticated business, Senator. It's a global business. 70% of major organised crime targets that are actually impacting on Australia are actually based offshore in terms of organising that trade back into Australia. So I haven't got an exact percentage, but it's at a significant level.
Why does organised crime want to traffic into Australia?
The profit, Senator. It's all about the money. I think it's the drug prices, the prices that drug syndicates can obtain in Australia compared with other countries. Unfortunately, and as we've noted before, Australia does have an insatiable appetite, or portions of the population have an insatiable appetite for drugs, and this drives the trade, but predominantly it's a profit issue.
Okay. So these organised crime gangs, they would kill others to protect their particular patches and what they're trying to import?
Yes.
And if I can give you an example, Senator, during Operation Ironside, we identified 29 threats to life. Some of those were involving semi-automatic weapons that were likely to be used in public. One instance in one particular state probably would have resulted in the loss of life of more than one person. So that operation in itself just shows you the threat that organised crime faced, not just to individuals and causing harm to those individuals, but innocent members of our society.
Okay. So looking from the other angle, so someone who's at the end of the chain who purchases these drugs, how does those individual actions impact, I suppose, on national security, the social security system and the economy generally?
Yeah, so I think organised crime only exists for profit and personal gain, personal wealth. What we have seen in up close, in real time, that they're all collaborating together. A lot of these organised crime groups, it's something that we hadn't seen before at scale and offshore. So arch enemies would gather together if it's about making profit and misery off, unfortunately, the users, the end user. So for us, it's about how do we play our role in reducing supply, and then there's also harm minimisation and obviously demand reduction, which sits within health and other departments. So it's a combined effort as to how do we reduce Australia's insatiable appetite for illicit drugs, which unfortunately we have a huge markup. So if you buy a kilo of cocaine in Colombia for say $3,000, you can expect sometimes it might be 300, 400,000 retail down here in Australia.
Crikey. So there have been some countries who have experimented with softer drug laws through decriminalisation. What has that led to in terms of trafficking and the community impact?
It's look, from personal experience, having lived in the Netherlands and seen that Amsterdam experiment, they're now revisiting the whole system there. They had something called narco-tourism, which was a lot of organised crime set up in Amsterdam, headquartered in Amsterdam, because of what was considered over there the soft drug policy. We've also seen it in other cities as well. So now the Netherlands are changing their policy settings on that front. But, we tend to sort of not get involved in policy. It's a matter for Home Affairs and other agencies to decide that. But of course, as police, we've seen that hasn't worked as effectively. It can have unforeseen consequences. A lot of people quote the Portugal example. That's had crime issues attached to it, as well as the Amsterdam example, where now it's only the Dutch citizens are allowed to go into the coffee shops, which are the cannabis houses.
So why do you think parliamentarians such as myself and the broader community should be worried about illicit drugs in Australia?
I think, one is obviously it's against the law. That's the first thing, and it's a scheduled offence and carries serious penalties. I think you're looking at what it can facilitate and enable, which is other crimes, whether that be, and I have to be careful with language here, it's a causal factor of domestic violence. Also, you're talking a lot of traffic accidents where people lose their lives. You'll find that there's a drug involved now more and more in some of the states. Assaults, serious assaults, murder, money laundering, the list goes on as far as all the different criminal activities that are associated with drug crime.
Okay, thank you. One final question, and it's not on the illicit drug trade, but in the UK recently, we saw the murder of a Member of Parliament, the second in recent years. How would you describe the risk to MPs and their staff in Australia of a similar attack happening?
Yeah, we're very concerned in the sense that we have seen that during the COVID times, a lot of people are online now. There is a lot of hate, unfortunately, and racial slur and discrimination and attacks personally on people, and often you don't even know where it's coming from. So for us, we have been working with all the MPs in this building to better, provide a service to yourselves about what numbers to ring, who to contact, what we can offer, and we do a threat risk assessment to work out whether or not you do need protection. That, sadly, will probably be a growth part of our business, and we've already seen that. We've just spent the last 2 weeks with those protesters where we're up to 20 arrests now, and I think climbing even today. And some were wanting to drive a truck, at this place as well. So one had a firearm, illicit firearm with ammunition and plans of this house. So, yeah, we're concerned, and we talk to those individual members of Parliament when we gather that intelligence and make that assessment.
Thank you, Commissioner. I appreciate it. Thank you.
Thank you, Senator McGrath. I'm now going to hand over to Senator Keneally, just reminding all senators that we are operating in 7-minute blocks so we can get through everyone who has questions. Senator Keneally.
Great, thank you. You spoke about charges being laid for spam following the Wentworth by-election and then again the Eden Monaro by-election. Is there any more information you can provide about that?
Yes, Senator, what would you like to know?
What is the nature of the spam?
You
So-
mentioned that it was, I think I'm trying to find your language here. Sorry, I've lost it. Maybe you could just tell us the nature of the spam and why it was a crime.
So most of it was, well, what I might do is ask my colleague just if we can just get the exact words.
Sure, Senator. It was a series of emails that were sent to, it was during the Eden Monaro by-election, the last Eden Monaro by-election, a series of emails questioning the integrity of the Labor member in relation to that matter.
Right, so 23 million messages, that's quite a significant amount.
It was.
Yes, and these were emails, not texts.
Correct.
And so in the 2020, there were email messages, if I understand you correctly, questioning the integrity of the Labor candidate.
Correct.
And what about in the Wentworth by-election?
Questioning my recollection is questioning the Liberal Party member in terms of his integrity in relation to that matter.
And how would you characterise this? Is this a disinformation? Is it foreign interference?
We assessed whether it was foreign interference. We didn't identify any evidence.
Sorry, I apologise, Mr. McCartney. You assessed that it was or it wasn't?
No, we assessed whether it was.
Right.
And our assessment, it wasn't foreign interference.
Was not?
No.
So it's an Australian citizen who's been charged?
Correct.
Right, and it's quite extraordinary. Is there any motivation you can shed on this?
That's a really
Bearing in mind that this
Yes.
is a matter before the court, is that correct?
Yes, Senator, I think it's actually finalised now. I'll get some information. I think he's pled guilty to the offence. I think motivation was obviously a focus of the investigation. We couldn't identify what his motivation was.
Right, and so has he been sentenced yet?
I believe he has. I'll get that information for you, Senator.
Great, thank you. I'm mindful of time, so I appreciate that. I just want to quickly turn to the protests that were here in Canberra this weekend. I was actually in the building and observed some of the work that your officers were doing, and I thank them for that. It was a significant presence of Australian Federal Police, as well as, without going into too much detail of what I witnessed, weaponry and the like. Can you tell us what prompted such a strong police presence here at Parliament House for those protests?
So, as you know, Senator, we base our resource allocation on a number of things, and part of that is our intelligence that we're able to gather, and sometimes that's from the public, as you know, and other means, other agencies. And our assessment was that we were concerned where the numbers started to swell, and then some of the intentions, it was not clear. They were not a coordinated group, which actually presents a different challenge for us in law enforcement.
Yep.
So for us, we were concerned that some of the individuals we identified in there, intelligence supplied by state police identified some troublemakers that we ended up arresting some of those ones. They did turn out to be troublemakers and trying to incite violence. So it's a number of factors, but it was based on intelligence.
Can I just pause you there, because I understand that, and I get that it's a colloquial term, troublemakers, but then you said they tried to incite violence. I mean, troublemakers could be boys and girls acting up in high school.
Oh, okay. So really, these are people who, well, for us would be in the criminal sphere.
Right. And I did note that there was a truck that did breach the barrier,
Yes.
the road barrier. What happened there, and was the individual arrested?
Yeah, the police officers actually had to take some pretty strong action. I think smash a window, open that door, get that individual out, and they successfully did and charged that person who's before the courts.
And did you say, I think in response to Senator McGrath, that there were firearms seized as well from some of the
There
people
was
who
one
attended?
individual that had an illicit firearm with ammunition and some plans of this house, which,
Had
as
plans
you know,
of the Parliament.
yeah, and but as you know, that some of those are publicly available. But it was just of course interest to us about.
It indicates an intent. Of
Well,
some,
we weren't
sorry,
able-
I don't want to put words in your
No,
mouth, but,
but,
it would indicate concern.
We were concerned, yes.
Right. So while it is demonstrably the case that peaceful protest is part of our democracy, I think you might agree with me on this, that violence and threats of violence are not.
a part of a peaceful protest. In your assessment, you talked about individuals. Were there groups that you were concerned about as well?
It was more, Senator, those individuals within those groups, if that makes sense. Overall, they were pretty well behaved. It was just a few who decided to, commit offences. So,
and there were individuals, if I understood you correctly, that you were concerned had a propensity to violence.
Yes, and we had specific information on some of those, not on some of the others, and that was how I would say. Well, we were able to work with the state police intelligence agencies as well, who were able to help us with the numbers that were coming into Canberra.
Just in the interest of time, so I'm happy to take this on notice, but if you do have available the number of officers you needed to deploy for the weekend protest and the cost of the operation.
I'll take that on notice.
Mr. McCartney, do you have any?
But it's in the hundreds.
The hundreds
It's
of
over. It's probably
officers,
around 200. Yeah.
And the cost is in the hundreds of thousands.
It'd be expensive. Yeah, fairly
Be
well
expensive.
for the week or the 2 weeks effort. Yes,
Sorry,
we
Mr.
can get you
McCartney.
those numbers.
He's pled guilty. He'll be sentenced in April of this year, Senator.
Sorry,
Thank you
just
very
not
much.
to confuse, about
That's
whom are you speaking?
This is the Eden Monaro case, Senator, or Chair.
The spammer.
Thank you.
Yeah.
Yes.
Senator Keneally, we have concluded
I will
your
leave
time.
it there at this point. Thank you.
Thanks, Senator Keneally. Senator Roberts, who's just got a couple of minutes of questions.
Thank you. And Mr. Kershaw, is it? Kershaw.
Kershaw, yeah.
Yeah, thank you all for appearing today. And before I ask my questions, I just want to thank you for the work you do and your AFP and work, and also the liaison with the state police in Queensland, the ACT. I was at the protest, very proud of the behaviour of the people, and so pleased that, and I agree with you, those groups were infiltrated by a couple of people, and that's very small, so I appreciate that. Quickly, in relation to the convoy, these questions are coming from a constituent. In relation to the convoy to Canberra protest activity at Parliament House just last weekend, pictures of the day appear to show some types of devices at the front of Parliament House in between the entry to Parliament and Parliament lawns where the protest was in fact occurring. Can you confirm whether the AFP had long-range acoustic devices at Parliament House on Saturday?
That would be something that is our police methodology, which we would have to look at some sort of public interest immunity claim. Senator?
Is there any, surely it's in the public interest to know whether or not they were there without delving too much into
I'd have to, if I could take that on notice, I'd have to get advice.
Okay, I'll be happy. I understand. I'll be happy for that. And also, if you could tell us what type they were, please.
Sure.
And can you confirm whether or not they were used at any point?
Sure.
Thank you very much, and thank you, Chair.
Thank you very much, Senator Roberts. Senator Thorpe.
Thank you, Chair. My first question is to Commissioner Kershaw. You've mentioned in reporting from the ABC on the 22nd of November 2021 that a review of politicians' safety was underway, and I quote, "We will be making sure we do as much as we can to keep our parliamentarians safe," end quote. And I've got that article here for the Secretariat all printed out for you. Commissioner Kershaw, could you tell me what the progress is to date on this issue?
Sure. So I might ask Deputy Commissioner Operations to explain the processes that we looked at, and also the fact that our review focused on enhancing security for parliamentarians, our coordinating and governance frameworks, and also in enhancing intelligence sharing and assessments, and that's based on also our overseas examples. So part of that was an education and awareness program first to make sure that yourself and others knew where to go to if you had specific concerns, and then what the correct procedures are and process. But at the same time, for us to adopt, I would say, a more customer-focused approach, meaning there's not just one size that fits all, if that makes sense. We'd have to tailor perhaps our response or our package. So, for example, we had some MPs, we worked with Home Affairs and others to upgrade security at whether it's your electorate office or your home premises. We also looked at, contacting through our NOSC, which is our National Operations State Service Coordination Centre, as far as any alarms being triggered and different security solutions for members of Parliament, and also respect privacy and other issues and take that into account. Given that, as you know, everyone has different family makeups and so on, so we tried to have a security approach to specific threats, for example, or other concerns that would meet the needs of that member.
Thank you. So are you progressing the safety of all parliamentarians or prioritising some over others?
Brett Pointing, Deputy Commissioner. Thank you, Senator. Just to give a little context to one of the questions that was asked earlier, I think this is quite instructive. It was a question around the security environment for parliamentarians generally. The question was raised is around trends, and Senator, what we're seeing, particularly this year, if you look at 2019 to 2020, we saw around 288 complaints from parliamentarians with respect to harassing, nuisance and offensive complaints. Of course, the internet and etc. has made that much easier to engage. This year, we think that'll be more like 500 complaints. So I think that's very interesting to see their environment changing. That's quite a significant increase in the amount of complaints. As the Commissioner mentioned, certainly I think the genesis for the work we're doing was in response to the death, very sad murder, in fact, of Sir David Ames in the UK, and that's prompted an internal review of the security of parliamentarians around three particular...
So can I just ask, sorry, because I know I've only got 7 minutes, probably not much more now, but
I'll go quicker.
Of that number,
yes.
How many investigations were undertaken?
They're all investigated, Senator. They're all triaged, and unfortunately very few prosecutions are entered into, generally because the evidence, a lot of anonymity, the way people make the complaints, and a lot of complaints don't reach the evidence threshold, sadly. So
just on that, can you tell me what the threshold is then for what is and what is not considered a threat? And when you will take action? In other words, how credible does a threat need to be for you to take it seriously?
Well, we take them all seriously, Senator, but every case is treated on its merits in terms of whether or not we can prove each and every element of the offence to support a prosecution.
So of the 280, you investigated all of those MPs who had threats against them. You investigated all those queries.
Every complaint that's made is
and
investigated.
You're looking at another 500 potentially. And not many prosecutions, but they're all investigated. So just in terms of the threat threshold then, what makes you take action? What's a threat? What's a serious enough threat for you to act?
So, for example, if you have an online threat, they can be challenging for us to resolve. And we've had ones that have lasted for years, where people use those VPNs and you don't know if it's emanating out of Australia, but your intelligence indicates that when you look at it, it's probably likely it is someone in Australia, but you don't know, but they're quite specific. So for us, it's hard with the cyber side of the house to resolve those. But as the Deputy said, is we also have a review process just to make sure whatever we've looked at, if we say no, or we don't think it's got to that threshold, we do re-look at matters regularly based on maybe additional information or other things to be able to try and resolve, well, who is that? Where is that threat emanating from? And we do take it seriously. And if we find out that, we need to take in a wider approach. We do, and that means if we go far and wide. The issue I think we have at the moment is that we've got a double increase in the number of those threats, which means those areas are flat out. And I'm not making excuses, Senator, but I think you probably appreciate we're going through everything because we put threat to life at the highest and then we work our way down.
Thank you very much, Senator Thorpe. I now give the call to Senator Abetz.
Thank you, Chair. And my bracket of questions relates to publicity given in recent times to an AFP agreement or memorandum of understanding with a notorious Chinese National Commission of Supervision. And as somebody who helped derail the proposed extradition treaty with China, I was somewhat perturbed to learn that in the same year the AFP signed a memorandum of understanding with this organisation and is refusing to release that memorandum of understanding on the basis that it's a joint agreement with another law enforcement agency. And I suppose my view is that it's somewhat of a naive view to suggest that this is a law enforcement agency as we know them, as opposed to an arm of government or an arm of a very brutal dictatorship.
So what's the
question? So the question is, why won't you make the memorandum of understanding available, and is it still extant? Is it still operative? Are we still sharing information with this dictatorship?
Did you want to specifically name? You're saying the something commission?
Yeah, what's it called? The Chinese National Commission of Supervision.
Narcotics Control Commission?
Well, we aren't even told that at this stage, so that is where people want to know. And
so our MOU is actually with the Chinese National Narcotic Control Commission, and our other joint agency agreement is with the Chinese Ministry of Public Security.
Yeah, and the agreement on public security, what does that relate to? Because in this brutal dictatorship, we know that public security allows people like Christians, Falun Gong practitioners, Uyghurs, Hong Kongers, for democracy, etc., to be a threat and therefore subject to the law.
Senator, Deputy Commissioner Ian McCartney, just to provide some context, China has a significant impact on Australia from an organised crime perspective. AFP were the first foreign law enforcement office to operate out of Beijing. We identified their strategic importance to China. Notwithstanding those issues, our engagement with China is eyes wide open. It's a very robust agreement. It's governed by internal guidelines on how we operate, both from a death penalty perspective, but also in relation to human rights. Our view, we need to continue to engage with China because of the significant impact on the Australian community from an organised crime perspective, but that we do it with eyes wide open and we apply the relevant guidelines.
Right, so with narcotics there might be a commonality of interest even between a brutal dictatorship and our country, but what about the other agreement?
Well, I think, the Chinese National Narcotics Commission agreement has resulted in 26 tonnes of illicit drugs being seized and 299 arrests.
Yeah, look, 7 minutes, I'm sorry.
Yep. And the Ministry of Public Security agreement, we've resulted in more than 50 million of restrained assets in Australia.
Have we helped repatriate anybody to China under that?
No, we haven't.
We have very strict guidelines on that.
Because there are now reports that people have been taken sort of forcefully or under threat from a host of countries around the world, including from Australia, by operatives of this dictatorship. And I would just hate to think that in any way, shape or form, unwittingly of course, but nevertheless there would be support offered by the Australian Federal Police or indeed any other law enforcement agency in the country.
No, we have not supported that activity and we would act on it if we were provided with information that there was that activity going on.
Are you able to tell us who initiated the MOU discussions in relation to the narcotics one and the other?
It goes back to 2015, so we'd have to go back in our archives. But I think if I can go back to as far as this, Senator, Major General Gray, and we just attended his funeral. He was our commissioner in 1983, was the first commissioner to travel to China. This isn't Australian, no, but it's important in context.
No, 7 minutes, I'm sorry, Commissioner.
Okay.
I don't want to be rude, but this
Sure.
is all very interesting history. But all I asked was who initiated it. Take it on notice.
Well, I
and
think it
come
goes
with
back
the answer,
as far as
please.
then.
And what about the other one in relation to public security?
Yeah. We have a joint agency agreement on economic
Yeah, but
crime.
who initiated that one?
Oh, well, I'll take that on notice.
You'll take that on notice as well?
Yes.
Commissioner,
And-
just wanting to ask a supplementary question. What's the basis on which you're not disclosing the MOU?
That's the first I've heard of it, Senator.
Right.
So are you prepared to disclose the
Well,
MOU?
I don't know. I'd have to see where the request has come
look,
in to the AFP. It hasn't hit my office, which is unusual, but...
All right, Freedom of Information requested on the 7th of October 2021 by Safeguard Defenders. And
Safeguard
then
Defenders.
Safeguard Defenders, and a response by Shelley Miller, Deputy General Counsel, dated 8th of November 2021. Internal review, I refer to your request, dated, and then basically it's been denied because it covers relations between Australian government agencies and agencies of other countries.
So Senator Betts, just for the purpose of these estimates, so you're able to take on notice the basis on which whether you can disclose the document, and if not, the basis on which you're not prepared to do so.
Yes.
Thank you.
For that party, is that right? It's not for yourself, it's for that Safeguard, or is that your...
No,
request?
Safeguard Defenders made the request,
Okay.
and they have provided me the correspondence, and as a result I am seeking to pursue it further.
Sure.
But
No, that's a separate issue. I'm
Yeah.
asking whether you can provide a copy of the MOU, if you want to take that on
I think
notice.
I will take that on notice.
Yeah.
I'd
And
need
then
to
provide
get
a
counsel.
reason,
legal
reasons for your decision.
Yes.
thank you for that helpful intervention, Chair, and I dare say that does my 7.
Yes, it
does.
does indeed.
Thanks a lot for that.
Thank you very much, Senator Abetz. Senator Cox, you have the call.
Thank you very much, Chair. Thank you, Commissioner. I've got a few follow-up questions from the Anti-Child Abuse Task Force. Why is the Child Abuse Task Force up and running only in the NT but not in other jurisdictions?
Well, Senator, as you know, the history of that task force goes back to the intervention going way back in time, and that was the model for the NT. We do have joint task force across the country which are called JACETs. It's our acronym, which stands for Joint Agency Child Exploitation Teams. They do work with each. They are multi-disciplined as far as state police and AFP, and they're in pretty much every jurisdiction, except for probably Tasmania. To an extent, we do that sort of out of Melbourne or out of Victoria, but we do work jointly. I think we have our one member in a team down there. So it's a little bit different to the Child Abuse Task Force in the NT. The state police have primacy, as you know, over sexual assault in the community. Where we have the convergence is that online environment, and as you know, that's getting more and more prevalent, sadly. So we will work with the child sexual assault units when it's what we would call contact offending or offending against children. So NT is unique and funded separately for that purpose, and I think it's within the NT Police. Me being the former NT Commissioner, obviously welcome that, having the AFP embedded into the NT Police. So that's quite unique. And what the JACETs do around the rest of the country is when they have a contact offender, they'll normally refer that to the state police.
Right. How are you evaluating the work, this work of the child abuse exploitation team and AFP's role within that?
So I think I'll give that to the Deputy because we have been reviewing that task force and our joint agency task forces.
Thanks, Senator. You're referring to the Northern Territory?
Yes.
Yep. It's an interesting initiative to the extent that it was strongly driven by our engagement with the Northern Territory Police. We wanted to do something positive in the Northern Territory. We knew that the jacket model that's pretty much in Sydney, Melbourne, Brisbane wouldn't be appropriate given the combined tyrannies of remoteness and distance. So very strongly influenced by the needs of the Territory and stakeholders, including shaping it with elders. So it's just been funded, it's just kicked off. I don't have the evaluation regime with me at the moment, but I'd be more than happy to take that on notice or provide you a private briefing if you...
So is there an independent evaluation?
I'd have to check on that.
Right. Methodology?
Certainly. I don't have that detail, Senator, but I'd be able to provide that.
That's fine for you to provide that on notice.
Yeah.
How is the Anti-Child Abuse Task Force linked with the draft National Plan to End Violence Against Women and Children?
Well, I think all the work we do is informed by it, but it's specifically designed to, implemented to cater for the uniqueness of the Northern Territory. As I said, it was strongly shaped by engagement with the Northern Territory Police and the elders of those three particular communities. But I just don't have the granular detail of the evaluation and methodology with me at the moment.
This specifically was about how you're linking that to the draft national plan, both the standalone one but also the Indigenous specific one. It's for the first time this year we're actually going to have a standalone plan.
Yeah.
And given the population, the Indigenous population of the Northern Territory, I would like to see some linkages.
Yeah.
Is that something you've considered?
Look, I'd have to double check on that. I know that the team at the ACE who run it are heavily involved in the both those pieces of work. So I'd prefer to take it on notice in the interest of accuracy, Senator.
Happy to do that. And have there been any discussions with the Department of Social Services about the work that you're doing with the task force?
I'd have to double check on that and take it on notice. Thank you.
Okay. Thank you very much for that.
Thank you very much, Senator Cox. I think now's an appropriate time to go to tea. We will need to return with you, Commissioner. Hopefully we'll be able to wrap up questions with the AFP by about 10:15.
Sure.
We will suspend and return in 15 minutes. Thank you.
Thank you.
Continuing to provide evidence, I'm going to kick off with a couple of questions, then go to Senator Antic and then back to Senator Keneally, and then we will be moving to ASIO after that. Commissioner, what do you believe is the biggest risk from the decriminalisation of drugs, especially hard drugs such as ice and heroin?
Well, we know that, and I know this personally from meeting with the mothers and aunties of ice addicts, that it can take on average up to 7 years for someone who takes ice to actually not become addicted anymore, and most of the time then it's a tale of destruction, criminality and woe and misery for those individuals. So for us, we know that being it's a very addictive drug that is very destructive to society, and lots of violent crimes are committed by people who take methamphetamine. And what was the other drug, Senator? Sorry.
I was asking about ice and
heroin.
Cocaine and heroin.
And then
that's right.
heroin, as we know, again, is a drug that unfortunately drives people to do incredible things, criminal things, to actually be able to pay for the cost of those drugs, and that drives, unfortunately, an entire marketplace where, again, a lot of criminality occurs, and we know that from the history of going back in the days where there was heroin clinics and all sorts of things where we had a major heroin issue in this country. And one of the things we are concerned about is the rise of heroin and our seizures in Australia. And of course, methamphetamine and cocaine, as well as MDMA, are all very destructive narcotics that lead to, you know, a life of crime often for a lot of these particular individuals. But we target, as you know, Senator, organised crime, who are the ones who are behind the supply and distribution of those drugs.
Commissioner, what impact do you think decriminalising illicit drugs would have on frontline workers, not just on your staff, but paramedics and other frontline health workers?
Well, my view would be it would be a far more dangerous environment to police. The emergency services would certainly have an opinion on dealing with violent individuals, which, as we know, people get into ice rages and all sorts of things. It would become a more dangerous society. It wouldn't be as safe as what we are enjoying today. So for me, it would lead to chaos.
Is there a safe level of illicit drug use?
I don't think there's ever a safe level when it comes to those particular drugs. They are destructive. As I said, I've spoken to ice addicts, I've spoken to the mothers and aunties, and they all agree that that was the worst decision they've made in their lives, those individuals anyway, was to take that particular narcotic.
Is there a safe level of decriminalisation or legalisation of illicit drugs?
I think that's more my own experience, as I said, is that I was able to experience it in different countries and look at the different models. So of course, we're always open to different strategies, but so far the evidence is not stacking up that decriminalisation necessarily leads to less crime.
And is there a risk that it can lead to a lot more crime?
I think the evidence across the globe has demonstrated some of that it certainly can, but it sometimes can take a bit of time for that to occur. And that's why, as I said, some of those examples, we are following those carefully in the overseas environment.
Thanks, Commissioner. I'm now going to hand over to Senator Antic, who's going to share my time with me. Senator Antic.
Thank you, Chair. Thank you, Commissioner. I wanted to ask just a couple of questions about Saturday's protests, if I could. And just in particular, I'd just like to see whether or not you and the AFP can give any indication about the likely crowd size. The media in the country have been talking about crowd sizes in the order of thousands, but it strikes me from photographs that I saw that the crowd stretched all the way from Old Parliament House pretty much to New Parliament House and the sides on the day. Do you have any figures or any estimates that you're comfortable with, that you think are more accurate than perhaps our friends in the media have been telling us?
The estimates that I was supplied range from 6,000 to 7,000 at the low end to 10,000 at the top end.
Seems awfully low to me, given those amount of crowd. But right,
10,000 is pretty large. You know,
it is
but I'm not an
crowd.
expert. I'm not an expert, Senator, in that. But that's what our intel assessed.
Okay.
But you could be right. It could be more than 10,000.
Okay, thank you. And just on that subject, though, you say it's a large crowd. Are you aware of any larger protests that have happened in Canberra in recent time, last few decades in your time?
We were talking about this today. I think going back to the 90s, perhaps, was some large crowds. And then if I've talked personally to Commissioner Palmer, one of the former commissioners, when he talked to me about the loggers, the truck drivers going way back. I think that was the late 80s, somewhere around there. But certainly for a long time, that's the biggest crowd we've had.
Right, thank you. I know Senator Roberts touched on this earlier, but he mentioned the deployment of some equipment, and I think he was referring to an LRAD machine, and I've been provided with this photograph, which I'm happy to table electronically, of course, from a distance. It does appear to show the deployment of an LRAD machine, a long-range acoustic device, I think it's called, which is a device designed to pitch sound at long range and can cause some pretty serious injuries. You can't confirm, even given that photo, that that device was deployed on the day?
Senator Antic, I just want to interrupt here to make it clear that this question has already been taken on notice.
I understand that, but just
Do you have
with
another
benefit
question?
of having had that photograph, which tends to confirm it, we still can't confirm that that device was there on the day?
Yeah, I think to be proper, I'd like to take that on notice.
All right, so we'll ask that one on whether it was used on the day. And just on that subject, you mentioned big crowds. We've had some smaller protests over the years. The Extinction Rebellion one in August of this year, I think, had 30 people and 8 arrests. And we're talking about thousands and thousands of people here. How would you overall describe the behaviour of the crowd?
Yeah, as I said before, overall the crowd were well behaved, and you probably saw there was children and families who were involved, and pretty well behaved. A lot of poor attitudes though, but there's no offence for that. So the police did cop a fair bit of abuse, but again, it didn't cross into the criminal threshold.
Right, so mostly peaceful then.
Mostly peaceful.
Senator Antic, I'm sorry, we are going to have to...
I have one more question, Chair, and it's a very quick one.
Make a very quick one.
Very quick one. My last question is, there were some reports on the day of some interference with the bandwidth, citizen journalists talking about losing footage dropping out. Is that anything you're aware of? Is that anything the AFP was involved with? And do you know anything about that?
No, the only thing I'd heard was that they'd moved to another campsite where there was no internet, and then they moved on, but not that.
Thanks, Senator Antic. Appreciate your brevity. Senator Keneally.
Thank you so much. Thank you. Commissioner, I've got a few short questions regarding media reports about a senior AFP Protective Services officer being sacked following a fraud and corruption investigation by ACLI. It was reported by the Daily Telegraph in early January.
Thank you, Senator. I'll be able
Thank
to
you, Mr. Ponting.
provide some details on that.
Can you start by confirming how many officers were sacked as a result of this investigation?
Yes, Senator, I have the details here. Just bear with me. This relates, Senator, to Operation Nambung, which was a joint ACLI and PRS investigation commenced in July 2019. PRS have confirmed that 2 protective service officers had their employment terminated in July and September 2020, but only one of those terminated was a senior officer. A further 2 PSOs resigned during the investigation in December 2020 and January 21. The investigation is still ongoing, but those dismissals and resignations have occurred during the conduct of the investigation.
Thank you. Have any of the officers been referred to the CDPP for prosecution? I mean, I know you said the investigation is still ongoing.
It's still ongoing, Senator.
So there've been no referrals to the
Not
CDPP?
at this stage. Yeah.
Okay. Will a report into the corruption investigation be made public?
I'd have to take that on notice. It's still ongoing, so I think at the end of the investigation we make that assessment.
And more broadly, are there other AFP employees who've been charged in the past 2 years for any offence?
With respect to that investigation?
No, just more broadly.
It's a good question, Senator. I've been doing some trend analysis of complaints generally in the AFP. Interestingly, if you look at the complaints that have been made against AFP, so in 2018-19 it was 653. There's 4 categories. Category 1 being the least serious, Category 4 being the most serious. So 653 in 2018-19, 586 in 2019-2020.
Sorry, I don't want anyone who's heard my question and now hears the answers to misunderstand. I asked if people had been charged. These are complaints.
Yes, there has been other charges, but I would have to take that on notice to give you the accurate details. But there has been other AFP officers that have been held accountable for unprofessional behaviour.
Right, okay. So you'll take that on notice as to how many in the past
Yep.
2 years?
Absolutely.
Great. As a result of this investigation, what steps has the Australian Federal Police taken to mitigate against corruption?
Thank you very much, Senator. There's a lot of work being done proactively in the AFP. And I link that to the drop in complaints generally. Most of that has been involving education. I'll just go through that. So the PRS has implemented a holistic and proactive approach to promoting, educating and improving adherence to the professional standards of the AFP. This includes Integrity Matters newsletter, where issues of interest are circulated, PRS podcast series dealing with a whole range of issues, a range of other communications, monthly command briefings where issues of professional standards are discussed regularly in order to shape culture, design and delivery of cradle-to-grave training. So all training has, or most training has, ethical issues embedded in it. And of course, PRS has gone from sort of, has changed its stance to doing much more face-to-face, integration with teams, actually talking about ethical dilemmas and trying to shape culture in a positive way.
Thank you. Am I correct that Commissioner Kershaw issued a serious misconduct and corruption declaration against one of the officers who was terminated? And if so, what does that mean?
Look, I'd have to take that on notice.
It was reported in the article, that's why I've asked the question.
Yeah. Look, that could be correct, but in the interest of accuracy, I'd like to...
Are you able to shed any light on that, Commissioner?
I don't remember the particular case.
Of the
Senator.
4 officers that had more than 20 serious corruption and misconduct complaints investigated by ACLI, you don't remember that?
No, I'd have to actually get the facts to that particular matter.
Oh, with respect, and I appreciate you want to get the facts, but I'm just a little confused. 20 serious corruption and misconduct complaints and 2 officers sacked, 2 resigned.
Yeah, what were the allegations? Could you help me, Senator?
I'm happy to table the article. They were accused of being part of, quote, a mafia-style group who've been sacked for abuse of office, accused of fraud by using AFP credit cards to buy white goods, televisions, Xboxes.
I'm aware of that matter.
Yeah, and did you issue a serious misconduct and corruption declaration against one of the officers? And if you did, what does that mean?
Yeah, I'd have to take that on notice. I'd suspect that's going towards the fact that it's a category 4, which means it goes straight to ACLI.
Right.
And that would probably be that declaration.
Okay.
Meaning that we have no, we don't investigate that. That's ACLI.
Yeah. And by asking these questions, I want to be clear, in no way am I seeking to impugn the entire of the Australian Federal Police Force. In no way. I'm just seeking, it was rather extraordinary story.
Yes, and that officer was if that's the same officer we're talking about, was a senior officer, a commissioned officer, and very disappointing for us that that trust had been broken in relation to the use of that credit card. And then through an audit of our credit cards in those areas, we did identify other similar patterns. And since then, we've changed our protocols and controls in relation to the use of credit cards to make sure that doesn't happen again.
Last question, Senator Kim.
Right. Okay. Yes. Thank you. Just in terms of the numbers, Mr. Ponting, I apologise. I asked that because the report, I asked about the number who've been charged with an offence, because the report says the revelations come as it can be revealed. 22 AFP officers have been sacked in the past 2 years and 39 AFP officer members suspended. And the AFP has not revealed if any of those have been charged with any offence. I guess my concern is, people can be sacked for many reasons or suspended for many reasons, and they don't necessarily relate to a criminal charge.
That's correct.
And so that's why I'm trying to understand. I would not want someone to draw a conclusion
that all of those people have been charged with a crime.
Correct.
And so that's why I asked the question, because I think it would be useful to clarify that. So I appreciate you taking it on notice.
Thank you very much, Senator Keneally. This concludes the committee's examination of the Australian Federal Police. There are other senators who have questions that they will place on notice. We are obviously time managing the rest of the program this evening. So, Commissioner, thank you very much for your time and to your officers. We greatly appreciate it. I will now call officers from the Australian Security Intelligence Organisation to the table, please. Director General, good evening. Welcome.
Good day, Chair.
Do you have an opening statement?
I do, thank you, Chair. So it's Mike Burgess, Director General Security, and good evening. Australia's security environment remains complex, challenging and changing. The terrorism threat level remains probable. We know there are violent extremists who possess the intent and capability to kill Australians. As I pointed out last week in my annual threat assessment, COVID-19 has added considerable volatility to the threat environment. We've seen increased radicalisation, particularly of minors, and a growth in specific issue-motivated extremism. Threat to life will always be a priority for ASIO and our partners, but it's important to note that espionage and foreign interference has now supplanted terrorism as our most serious security concern. This is not to downplay the significance of terrorism. In terms of the scale and sophistication, though, espionage and foreign interference threats are outpacing terrorism threats and therefore demand more attention and resources. Parliamentarians such as yourselves often ask me to spell out what political interference looks like in practice so you can identify it more easily. In my threat assessment, I chose to do this with a case study. I deliberately chose not to identify the election, jurisdiction, party, the individuals that were targeted, or the country attempting to conduct the interference. As I stated in the speech, I'm not going to identify the jurisdiction because we're seeing attempts at foreign interference at all levels of government in all states and territories. Attempts at political interference are not confined to one side of politics, and you'd be surprised by the range of countries involved. Predictably, there has been media speculation about who was involved. Unfortunately, some of the speculation missed a key point. We stopped the plan before it was executed, and the targets were not aware they were in fact targets. As I explained last week, while attempts to interfere in our democratic processes are common, successful interference is not. Our democracy remains robust, our parliaments remain sovereign, and our elections remain free, and the overwhelming majority of our politicians remain thoroughly resistant to even the most sophisticated and subtle approaches. My threat assessment addressed several other important matters, but I will not repeat them here. Of course, I'm happy to ask questions about any of those matters or any other matters. Thank you.
Thank you very much, Director General. Senator Keneally.
Thank you, Chair. Thank you, Director General, for being here. Thank you, Ms Bennett. Mr Burgess, given the way in which your speech has been reported and used in question time, I will ask you to be clear on one matter. And please know I would not usually ask an ASIO Director General such a direct question in an open forum, except that this matter has become the subject of political debate in the context of the election. Does ASIO hold any concerns about foreign interference in any of Labor's federal candidates in the upcoming federal election?
Thank you, Senator. I'll take that question in two parts. As I've just said in my opening remarks and as I said in my threat assessment last week, foreign interference is a real threat. We're seeing it at multiple levels, at local, state and federal, across all states and territories. There are multiple attempts. Very few attempts are successful. In terms of your second part of your question, I wouldn't normally talk about the conversations I have with anyone, or you're asking me specifically to comment on the question about Labor candidates in the next federal election. I think what I can say, Senator, Mr Albanese, the Leader of the Opposition, gave an accurate account of the conversation I had with him last week when he asked me that question.
When he was asked that question in a media conference, he gave an accurate answer.
He did.
Thank you. I referred to a report in the Sydney Morning Herald on Friday, the 11th of February, which provides alleged detail about a foreign interference plot in Australia. I note you referenced media reports in your opening statement. I note the article itself has relied on, quote, multiple security sources who are not authorised to speak publicly, end quote, to verify the report. Mr Burgess, do you understand this to mean that those sources who provided information to a journalist were not authorised to do so?
That's how I would take that, yes.
And what might constitute a, quote, security source? Could it be, is it necessarily an ASIO employee, or could it be anyone who had access to security material?
I would take that in the broad.
In the broad, so
Yes.
It does not necessarily mean it's an ASIO employee?
That's correct.
Right, so for example, people you brief, their advisors, people who have access to written briefings on secure servers, and when we talk about broad, is that the type of broad?
By its very definition, broad, there will be many people, not just in my organisation, that will fall into that category.
Thank you. Because members of the public reading that article might see the term security source and assume it is an ASIO officer. What I'm exploring with you is whether that is the only conclusion a member of the public could draw. And it seems to me that your answer indicates, no, that's not necessarily the only conclusion.
It's not how I would take it, but yes, I could see someone might take it that way. It's certainly not how I would take it.
Can you confirm that under the ASIO Act, Section 18, the communication of intelligence on behalf of the organisation shall be made only by the Director General or by a person acting within the limits of authority conferred on the person by the Director General?
That sounds correct to me, yes.
Mr Burgess, did you give authority to anyone to communicate intelligence relating to the attempted and unsuccessful act of foreign interference you referred to in your annual threat assessment?
Senator, I don't think I can answer that question because I'm in that difficult position of I don't comment on matters of media, and if I did, I'm either confirming or denying something, and I don't want to do either of those things. I'm happy to talk in general terms, but I can't talk about that media article because it's a media article that's speculating.
Right. But you can't. I'm not asking you to speculate on the content of the article. I'm asking you if you gave authority to anyone to communicate information about the unsuccessful act of foreign interference.
Well, that would, to answer that question, I'd be commenting on that media article, and I don't want to do that. But to help you out, Senator, when ASIO product is distributed, people have the appropriate level of clearance, and the reporting itself has the appropriate caveats that make it very clear how that information should be handled and what shouldn't, in fact, by that very definition, happen with it, such as public disclosure.
Thank you. What is the penalty for unauthorised disclosure of intelligence material?
It depends on the nature of the intelligence and whose intelligence and which act that particular breach is disclosed from, but I'm not an expert on criminal penalties.
Has the agency made any inquiries internally to determine if any ASIO employee disclosed any information relating to this attempted and unsuccessful act of foreign interference that you referred to in your threat assessment?
Again, Senator, that's difficult because you're talking about as if this was true. So I need to be careful on how I answer that question. But as a matter of principle, can I put this on the record? So ASIO is proudly apolitical. The Director General Security is, I am apolitical. Our Act, in fact, requires us by law to be apolitical. ASIO is here to serve our national interests, not sectional interests or partisan interests or personal interests. So hypothetically, our intelligence is there to be used for national interest purposes only, not interests of individuals. So where it is misused, that's a problem. But I can assure you where it is misused, if it was hypothetically misused, I would look at whether I needed to do an investigation for my own organisation. Of course, we take this matter very seriously. We hold ourselves to the highest level of account.
I'm glad you made the point about whether or not the information is true and that my questions might seem to be assuming it. And I was mindful of that in drafting my questions because I don't know if it's true. And so what I was seeking to understand is what, if we can then go more general, you said that, if I understood you correctly, that you take breaches of security information seriously, and if you feel you need to, you would initiate an inquiry.
Absolutely.
Thank you. Did you discuss your draft speech, including the parameters of this case study that you provided with any minister's offices prior to delivering it?
I gave my minister's office an outline of what the threat assessment would cover.
Thank you.
But did not go into great detail.
Right. Thank you. And that would be the Minister for Home Affairs office?
Correct.
Any other minister's office?
No.
Thank you. You mentioned about ASIO's non-partisan, in the national interest focus. Let me ask you this. You would be familiar, I'm sure, of ASIO's history and what led to the two Hope Royal Commissions in 1974 and 1983. ASIO's credibility with the public before Hope suffered significantly, largely due to an increasing politicised nature of its work and its particular targeting of certain political parties and certain sections of civil society. And those Hope Royal Commissions brought in what's been rightly credited significant reforms in terms of legislation, operations and oversight to bolster public and the Parliament's confidence in ASIO to safeguard the agency and its important operations to keep our country safe. How seriously do you take your responsibility to ensure that ASIO continues to adhere to the principles and practices established by Hope?
Very seriously.
And what would be the risk if ASIO were to be seen by the public as acting in a partisan manner? Because I think it would be fair to say that some people reading those stories last week might have thought that information came from ASIO. Absolutely.
Absolutely, Senator, and that's why we take this matter very seriously. I take it very seriously. I take our reputation very seriously. ASIO is not here to be politicised. It should not be. We're here to protect Australians from threats to their security. We are guided by law, and that law requires us to act in an apolitical fashion and not lend favour to one element of society or another, or one party or another. So we do not do that, but I can see how some people would be concerned by that media speculation.
Would you say it could undermine your credibility and your mission if you were to be seen as a partisan player?
Absolutely. We need the confidence of the people we protect.
And Senator Keneally, you and I have both worked extensively with ASIO as an agency, and it's certainly my experience, and I hope that it would be yours, that they do always act in that impartial and above politics manner.
Thank you, Minister. Director General.
Final question, Senator Keneally.
Well, then I flag I will have some additional questions that I will come back to. Director General, you also said in your speech that using fear of foreign interference, and I might be paraphrasing you here, but you said using fear of foreign interference to stoke division in the community could be as corrosive as foreign interference itself. Could you expand on that? And what challenges does that pose in terms of our social cohesion and ensuring that our democracy remains robust?
So the point I was making, and I'll read it for you just so we can all be clear. I said it is critical we do not let the fear of foreign interference undermine stakeholder engagement or stoke community division. Were this to happen, it would perversely have the same corrosive impact on our democracy as foreign interference itself. There's quite a few aspects to that point. I think it's pretty clear, but one of the concerns, of course, is foreign interference means something's being directed by foreign governments or foreign intelligence services, but the fear of that might actually mean people will not engage with elements of Australian society, and that would be wrong, would it not? Because if they don't go to a certain diaspora community or a certain Chinese Australian or an Indonesian Australian or some other, again, that's perverse and not what's intended here, because a good majority of these people, in fact 99.999999% of them, are doing absolutely nothing wrong, and they shouldn't be targeted or taken in a wrong way, which would actually undermine community engagement, and that's the point I'm trying to make.
Thanks, Senator Keneally. Director General, just a couple of questions from me. Obviously, you're on the record strongly as saying espionage and foreign interference will overtake terrorism as the biggest threat to security. How do elected officials, public servants and political parties remain alert to this most serious threat?
Thank you, Chair. It's simply an awareness of the threat. So that's one of the reasons why I do my threat assessments. It's one of the reasons why my service and myself engage with members of Parliament, state and federal, to raise awareness. The case study I gave last week in my threat assessment is an indication of, or helping people understand what it actually looks like. My key advice to anyone is just be guided by the same instincts and values that guide you in every other forms of your engagement, and be open, transparent and accountable for the actions that you take. That's a winning formula.
Thank you. You also spoke extensively about radicalisation of minors and about the security challenges of spending more time online, particularly during the pandemic. Could you just explain your work in combating these risks with young people to mitigate or combat radicalisation?
Sure. So our work obviously starts identifying other politically motivated violence or people who want to promote communal violence, so terrorism threats from extremists. As I've said recently, it used to be that our counter-terrorism investigative caseload, 2 to 3% of those were minors. Last year that's gone up to 15%. And sadly, on average, over the last 6 months, on our weekly top priority investigations, more than half of them are minors, and that is disturbing. Why is that so? We're not fully formed yet on why that might be so. COVID certainly sent it into overdrive. More time online doesn't help. More time online when you're not out in the community, because lockdowns mean that you're kind of not having those moderating impacts of engagement at school and the community and broader family engagements, may well have driven that increase in radicalisation, and it's disturbing to see that level of increase. Our work is obviously at the wrong end of this, because we get involved when we see an active threat to security. The broader answer to this problem is not ASIO, it's not law enforcement, it's a whole of country, community, all of us have a role to play in actually understanding what's happening here. The final thing I would say, as I said in my threat assessment last week, we know that to de-radicalise adults, it's really hard. But we know with young children, actually there are many more opportunities to take them off that pathway and make sure they end up in a better space. But that's down to every single one of us to notice changes in behaviour and actually look into that and try and understand what's causing that, and hopefully get them off that path.
When you refer to minors, what ages are you referring to?
Below 18. So we typically in our...
I realise they're below 18, but how young are some of these children?
Yes, apologies, Senator.
No,
so
it's okay.
we've seen them down to as young as 13.
13.
So between 13 and 17 is the cohort that we have visibility on.
Thanks very much, Director General. I'll now hand over to Senator Thorpe.
In reporting on SBS News today, 14th of February 2022, it was reported that ASIO recently detected and disrupted a foreign interference plot in the lead up to an election in Australia. ASIO has also previously warned of people being radicalised during the pandemic. Does ASIO feel confident in thwarting the threat posed by the rise of right-wing extremists and neo-Nazis?
Yeah, thank you, Senator. So obviously we refer to them as nationalist, racist, violent extremists, but I understand...
Sorry, what was that?
Nationalist, racist, violent extremists. We try and take the political assignment out of that, but we know what they are, neo-Nazis, and those people have views that none of us share, of course. So that has a ideologically motivated violent extremism, or nationalist racist violent extremism in particular, has grown in our observations over the last couple of years. We've been watching that problem for many years, if not decades, but in the last couple of years it's grown to about reaching parity with our religiously motivated violent extremist cohort. That's another concerning trend. Where we have visibility of it, we work hard to understand the threat. One of the things we've seen in that cohort is there's a lot of talking. The difficult thing for us is to determine whether there is real intent to go to violence behind that, or just vile beliefs and vile statements which won't result in acts of violence. We're working that problem very hard. Of course, when we see active threats to security, that's immediately a handball to our police in the federal government and Australian Federal Police and State and Territory Police to deal with the threats we see, and we do that jointly with them.
Thank you. So have you investigated any infiltration into political parties from right-wing extremists and neo-Nazis?
So we investigate the violent extremist element of that. If our targets are trying to infiltrate political parties in a way that supports their actions, then yes, that would be of interest to us, but I don't talk about specific levels of our investigations and where they go. So we focus on the violent extremists wherever they might pop up.
So are you confident that no right-wing extremists or neo-Nazis have infiltrated any political parties?
I couldn't say with a certainty that they're not in political parties, but I can assure you that we have a good handle on the violent extremists that we know about.
Can you tell me, as best as you are able to, what threat right-wing extremists and neo-Nazis pose to parliamentarians and their staff?
Their threat there would be no different to anyone who is a violent extremist so in terms of across religiously motivated or ideologically motivated. And in fact, in Australia, the most likely terrorist attack will continue to be that of an individual or a couple of individuals that go to violence with little or no warning. Whilst we're watching groups, nationalist and racist groups, such as the National Socialist Network, for example, it's not really the group that's likely to go. They work hard, believe it or not, to actually not do that because they know they do. They hit a legal threshold. But it's the individuals on the extreme of that group or those groups who actually may well switch to violence at little or no notice, which makes it very hard for any of us to do something about it.
And just my final question, Chair. So to the best of your knowledge, have there been any right-wing extremists or neo-Nazis in this building in the last 2 weeks?
Well, I'm not sure I could answer that. We don't vet everyone in this group, and I wouldn't talk about my operational cases in public anyway, and not meaning to be difficult, Senator, but we keep our levels, investigations and who we're monitoring classified, because that's how we continue to able to successfully do our job.
Parliamentarians would be aware or like in terms of safety and process, if there were to be these kinds of individuals in this building, should we know about it? Or?
From my point of view, if we were watching a target that represented a threat to anyone's life or safety, that would be immediately in the joint counter-terrorism teams, and I'd be pretty confident that that threat would be dealt with.
Thank you. No further questions.
Thank you very much, Senator Thorpe. I now give the call to Senator Kitching.
Thank you, Chair. Thank you, Director General. Thank you for your opening statement. I'm reliably informed that the puppeteer mentioned in your case study in your annual threat assessment speech last week is Chow Chak Wing. I believe it to be Chow Chak Wing. Are you able to confirm that it is Chow Chak Wing?
Senator, as I said before, I will not comment on speculation of who is and who isn't targets in general or in specifically as you're asking me there. I think it's unfair that you ask me that question in public.
Thank you. I don't have any further questions.
Thank you very much, Senator Kitching. I know Senator Roberts is seeking the call, but he's not here. Senator Keneally, we'll go back to you.
Thank you very
you.
much. Thank you. Director General, just to continue the line of questioning before my time was expired, do you agree that we've talked about the corrosive impacts of the politicisation of national security information might have on the Australian community and on Australian democracy? Does it also risk damaging relationships with your international counterparts who understandably don't want their information, particularly our allies, broadcast for domestic political purposes?
Again, if I can talk in the general, not
specific,
on speculation of media reporting. Yeah, of course, if part of that politicisation there was release of classified information that was given to us from a trusted foreign partner, that would damage and probably threaten the ability for that line of intelligence to keep coming our way. Because when we're given that, we're entrusted with protecting it appropriately.
And that might be, again, in the general, not the specific, that might be information an ally has about an adversary that they've shared with you.
It could be anything. What's a particular concern for me, other agencies and our foreign partners would be the protection of sources and methods.
Yes.
My organisation, my staff put their lives on the line and they're at great risk, and actually disclosure of information can threaten them or their sources, who are everyday Australians who are also taking risks for their country. And that's why it's totally inappropriate that when something's classified, it's released publicly without the appropriate process. Now, of course, there's no point in having intelligence if the government can't use it, because the government are charged with matters of national security, and but there are appropriate processes by which that information can be used, because you use it in a way that also protects sources and methods, and that's the way it should be.
And by use it, you mean the government uses it in the national interest?
Yeah, correct.
Not uses it in a partisan manner.
National interest.
Yes, thank you. Are there any guidelines, rules, or laws governing ministers who have access to intelligence information and classified material, and how they're meant to handle it?
They would be subject to the same laws of the land that I am.
And their advisors would also be subject to those laws?
Correct.
So would there be risks in a minister referring to not only, quote, open source, but also, quote, other intelligence I see, when answering media questions about the intentions of a foreign government, regardless whether those intentions are malign or benign?
I'd prefer not to answer that question, because, again, I'm being dragged into political space. I know why you're asking the question, and I can't speak for the minister what was in his mind and what processes he went through when saying that.
You obviously heard that interview.
Correct.
Between Minister Dutton and Patricia Karvalis when the minister referred to intelligence he sees. That struck me as an odd phrase for a minister to use.
I'd suggest that's a question you should ask the minister, not me.
I might do that in a minute, but I'd like to stick on this line of questioning. Thank you. Apologise, Director General, my pages have gone out of order. Has your agency made any inquiries to ministers' offices to determine if they have knowledge of how information purporting to relate to the attempted and unsuccessful act of foreign interference you referred to in your annual threat assessment was disclosed publicly?
So again, you're asking me to comment on a particular matter. If I were to do so, I'm either confirming something which I do not want to do. As I've said before, I take these matters very seriously, and when I come across something that would suggest that classified information of my organisation has been disclosed inappropriately, I will investigate that.
But in this,
But I can't comment about this because, again, you're asking me to speculate on media commentary.
But just to be clear, earlier we established it isn't when the public sees references to a security source in the newspapers, they should not necessarily assume that is a National Security Agency employee, or in this case specifically an ASIO employee.
Definitely not an ASIO employee.
Thank you. Director General, I do applaud your efforts to make ASIO more knowable, more visible to the Australian people by delivering your annual threat assessments and putting the agency and yourself on social media. Sharing information about the threats that our country faces and the agency's work can increase the public's understanding, can make our country more resilient, and can instill confidence in our national security framework and in agencies. But I think what we've seen from this example is that sharing this information, particularly in the heightened atmosphere of an approaching election, can lead to its misuse by political actors. I note in the Parliament today, the Speaker of the House of Representatives ruled the comments by Mr. Dutton last week out of order. Have you given any thought as to how you might navigate the risks that your more transparent approach could be weaponized in a political contest or debate?
Yes, Senator. I give those thoughts every time I do a public engagement, including ahead of this threat assessment. I deliberately, as I said in my opening statement, I chose to use that case study to raise awareness, in particular because we have a federal election approaching, and it's important that we all understand what political foreign interference looks like so people can make informed decisions. Of course, I recognise that there may be people who choose to misuse that, officials or members of parliament or ministers. That's a risk. That any misuse is a matter for them to answer to, not myself, other than my actions, of course, but my actions are done for the intent of raising awareness for everyone so we can call out this for what it is, because we do see multiple attempts from multiple countries. Thankfully, not all of them or many of them aren't successful. Some of them are. As I said in my threat assessment also, the case study, the harm did not happen, we prevented it. Of course, we've dealt with other cases where the harm has happened or we come at it at a much later stage, and those cases are far more serious, and therefore it was important to get that case study out there for awareness purposes.
If I could just tease that out a little bit, because your determination to be more transparent with the public does lead, arguably, as we've seen this week, to that information becoming available for its misuse. Have you thought about how, we've talked about how that could potentially undermine or impact the agency that you lead. Have you thought about how you might have to, you've changed your posture as a Director General in terms of being more forthright with the public. Have you thought about how that forthrightness, that frankness, might also require you to become more frank in other contexts, such as when that information is misused? Because not because you want to enter into the political fray, but because you need to safeguard the agency you lead.
Yes, certainly, Senator. But again, you'd be asking me to comment on a specific matter, and I don't want to do that. What I can
This
say.
is a general question.
Well,
about,
generally, then I can be very clear that I'm able and do have very robust conversations with all elements of the political class that I need to, and in the official world, to make it very clear of what I think is appropriate and not inappropriate. And I have the ability to do that as a statutory officer, and I can assure you I will continue to do that when things like this happen.
What about the media? What about your engagement with the media? Because they are part of our democratic process and they played a particularly significant role in this incident.
Sure. I do have engagements with the media, but of course my purpose of engaging with the media is so they can make informed decisions about what they write, not what they choose to write. That's entirely up to them. Of course, not commenting on this specific matter, but I will mention this just because actually it shows you that the media are not perfect. So whether or not, without commenting on Mr. Galloway's article, when he said Chinese spy ring plotted, if he listened to my speech carefully, I had two case studies. One was a spy ring that we disrupted. Another one was the foreign interference plot by the puppeteer and deployer. They're two separate events. I think Mr. Galloway was showing a little poetic licence, but was that misleading, or was that just for the click and collect that drives revenue in the media businesses? But that's not for me to comment on, is it?
No, it's not. Mr. Burgess, I do thank you for your forthright answers. I do have a question on right-wing extremism, and I don't know what my time frame.
You are
on the
actually
far
right on 10 minutes. And I am actually going to give, how long do you need, Senator
It is
Keneally?
literally one question.
All right.
It's not. It's following on from something Senator Thorpe.
All right, you have the call, and
Thank
then
you.
we'll hand over to Senator Roberts.
You spoke there about the National Socialist Network in relation to a question asked by Senator Thorpe, and you mentioned that they are often very careful about about not appearing or making specific threats or incitement to violence in order to not attract attention. Is a use of language one way in which a group like the National Socialist Network might do that? For example, last year they made a post on social media that encouraged their followers to, quote, seduce young women in a certain religious group and to seduce a particular senator, and I'll identify that was me. My name was on that post. Is the use of word like seduce instead of rape the type of tactic groups like this use in order to say, oh, we weren't really making a threat, we were simply making a joke?
I think that's sadly a good example of that.
Thank you. Have you had, and one more question, I apologise, Chair. Are you continuing to consider the facts and grounds that might lead to a listing of the National Socialist Network as a terrorist organisation?
We have these things constantly under review, yes.
I note that the Minister for Home Affairs and other people, such as the chair of the PJCIS, have made comments that they would like to see that listed. I think I'm pretty clear that I would like to see them listed. So it's pleasing to me to hear that you have this under constant review.
We do have it under constant review. I think there's still a need to look at the legislation. It's a high penalty and therefore a high bar to jump. Doesn't meet the threshold, it doesn't get listed, but I'm not the decision maker. There are other factors that the Minister and the Government take into account when they do that based on our advice or advice from others.
Thank you.
Thank you very much, Senator Keneally. Senator Roberts.
Thank you, Chair, and thank you all for appearing today. Recent public statements from you indicate ongoing issues of interference by foreign nationals in Australia, including attempts to influence the electoral process. Is this considered to be an ongoing threat from that identified foreign power?
As I said in my threat assessment, Senator, there are multiple countries, so this threat is real. It happens at all levels of government, local, state and federal, and that threat continues. In fact, espionage and foreign interference has now supplanted terrorism as our country's principal security concern, and that's not to take away from the terrorism threat.
Are the identified risks, well, you just told us they're serious, very serious.
They are.
Right throughout all levels. From your public, changing the topic slightly, from your public statements, why are so many everyday Australians opposed to mandated COVID-19 vaccinations? They're opposed to the mandating, not to the vaccinations necessarily. Why are they being monitored?
Well, that's not my remit. That's nothing to do with me in terms of whether people are opposed to mandates or want to get vaccinated. That's not a violent extremism problem. That doesn't fit within my heads of security, so we don't monitor or follow those people. If those people also happen to be violent extremists promoting communal violence or politically motivated violence, then they would get my full attention. But if they're not in that category, as I said in my speech last week, the vast majority of these protesters we're seeing at the moment are not violent, and they're not violent extremists.
That's very pleasing to hear. That confirms pretty much exactly what the AFP Commissioner said just an hour or so ago. But the press has perhaps taken a slant on that. So thank you for clarifying that. And having been at the protests on Saturday, people are just excellent. Why would you consider... Okay, no, you've eliminated that. You said in your recent security annual threat assessment that you do not have a problem with people holding opinions and would only intervene when these opinions involve promoting violence. You've just confirmed that again. What evidence links everyday Australians exercising their right to peaceful protest are being considered domestic terror extremists. I take it that's a media exaggeration.
No. In terms of protests, it's lawful. Public dissent is totally appropriate and right for people to do. But actually, if people are preparing for or advocating acts of violence, then they do fall into my agency's remit, and we will watch them carefully to understand what they're up to, and with our police partners work to stop them from harming Australians.
Yeah, there is a small element in just about every group who takes advantage of the group.
There certainly is.
Thank you. No, I don't need to ask the seventh question. That everything's covered. Thank you, Chair.
Thank you very much, Senator Roberts. And Director General, that concludes the committee's examination of ASIO. We thank you very much for your time and evidence this evening, along with your officers.
Thank you, Chair.
Thank you. It's now my pleasure to call officers from the Office of the Special Investigator. Director General, good evening and welcome.
Good evening, Senator.
Would you like to make an opening statement before we go to questions?
I have a very short opening statement, if I may.
Thank you.
Since our last appearance at Estimates last year. Thank you, Senator. As the committee may be aware, the office has recently marked its first anniversary. I think we've established some pretty solid foundations, and we start our second year, I think, with some significant momentum in our investigations. And as I've said in the past, we're intent on delivering on our key functions and on our goal, that is conducting a fair, thorough and impartial investigation of the alleged war crimes within our remit. We continue to work closely with the AFP, and we continue to address any complexity that arises with investigating these matters. I must say that the guidance and advice we get from our Special Investigator, Mark Weinberg, as well as the AGS Special Counsel team and the AGS, helps us ensure we carefully manage the novel legal landscape as we advance our investigative work. As always, our primary aim is to protect the integrity of investigations and future prosecutions should any be commenced as a result of our work. Could I say we really appreciate the Senate Foreign Affairs, Defence and Trade References Committee's recent acknowledgement of the importance of the ongoing work of the OSI and their support for our work. War crimes investigations are inherently challenging and confronting, and we're conscious of the important potential impact of our work on many people. Let me just say in conclusion that I think our systems, our staffing, our protocols and governance which underpin our independence are now settled, and relations with key government stakeholders are strong. As I've made clear previously, we can't speak about operational detail or advise exactly how long our work will take, but let me assure you, Senators, that we are committed to conducting these investigations as expeditiously as possible and ensuring that our work is carried out with integrity. Thank you.
Thank you very much, Director General. I will now go to questions and seeking, just if I can indicate who's seeking the call. Oh, Senator McKim.
Thanks, Chair. Good evening, Mr Moratis. Could you just give the committee a breakdown, please, on how many staff you employ?
Yes, I can do that. We're about 84 or 85, consisting of policy, legal, corporate staff, as well as investigators who are, as I've said in the past, a combination of AFP and also State and Territory Police. I can give you the exact figure if you like. If you just give me one second.
Thanks. And just while you're...
About 84, 85 is the figure we've got.
Right, thanks. Is that FTEs or is that actual head count?
In our work, it's pretty much the same thing because everyone's full-time. We don't have part-time.
Right.
We do a few, but not
Thanks.
significantly.
And if you've got it here, I'd appreciate it if not, please take it on notice, just a breakdown in terms of the roles and in particular, specifically, how many have special investigator roles?
We have one special investigator, Mark Weinberg. He's the person who makes the call on investigative strategies and directs our investigators. The actual investigators, the police investigators that is, that's a combination of, as I said, 50 plus investigators who are basically detectives who have had experience in homicides, cold cases, you name it. They've done quite a bit. Our Director of Investigations, Ross Barnett, leads the investigative team, and we have two commanders who work to him, one from the AFP and one from with experience in state policing. So that's how we work it out. And so it's about 50 plus. The figures vary depending on where we're at.
All right, thanks. So those numbers you've just gone through are the total of your investigators, isn't it? Is it fair to say that the rest of your employees are there to support them in administrative terms?
So Mr. Weinberg is a special investigator. He has two support staff, an associate, for want of a better term, a legal assistant. We also have counsel, two barristers working with him, assisting him in his work. And we have staff in the OSI proper support me in my role, whether it's to do with accountability, Senate estimate briefs, things like that, FOI, media, legal and policy work, engaging with agencies that we work with, most importantly with the AFP, because this is a joint investigation with the AFP.
All right, thanks. Could you on notice just provide an org chart?
Yeah, I can do that.
With numbers of...
Yes, I'll do that for you, no problem.
Employees in the relevant roles. Thank you. Are you at full capacity at the moment in terms of employment?
We're able to go higher, but at this stage, I don't want to go into the details, we're comfortable with where we're at. If we need to ramp up investigations, we can do that, I think, with appropriate celerity. However, I think at this stage, our teams are well positioned, and I think we're at what I regard as a good balance of investigators and policy and other dimensions. Things have changed, obviously, over the course of the last year. Things like Afghanistan not being a place we could visit. There hasn't been as much travel as we'd like internationally for some cases, but that could well pick up in the next year or so. So that obviously changes our dynamics and what our staffing needs will be. But at this stage, we're comfortable with what we've got.
All right,
more than comfortable, I'd say.
Thank you. I'll go to Afghanistan shortly, but before I do, can I just ask whether the OSI has referred any matters to date to the DPP?
No.
No. Okay. Has the OSI had contact with the ICC's Office of the Prosecutor, which is carrying out an investigation into war crimes and other crimes committed in Afghanistan since 2002?
Yes, we have, Senator. I wrote to the prosecutor of the ICC explaining the work, the existence, the establishment of the OSI, who's in it, what our roles are, and what our terms of reference are, and that was sent last year. That follows on from correspondence from government to do with the work of the Brereton inquiry, and we're obviously interested in ensuring that the ICC understands what's happening in Australia. We're a party to the Rome Statute, and I'd say we're a party in pretty good standing. The Rome Statute.
Just approximately when last year was that letter? Was it early?
It would have been around, it was after the appointment of the new prosecutor, I think, and I can give you the date.
Thank you.
Again, it's, yes, I wrote to him in June last year.
Okay. Is there any issue with making that letter available to the committee?
I don't think so. I'll take that on notice, but I'll provide it if I can.
Thank you. Have you heard back?
No. We've put it through our embassy, and I think they're well aware of our work, and we obviously follow what's happening in The Hague, but so far there's been no formal response. But
okay,
that's fair enough. They've got many other things to worry about.
Sure. And that's the extent of the contact that you've had?
I think so, yes.
Yeah. All right, thanks. Okay, so just going back to your answer a couple of questions ago, you referred to, I think you said there'd been less travel than you would like. Obviously, conditions inside Afghanistan have changed significantly in the last, probably in the last 6 months, fair to say.
Yes.
Let alone the last 12. What's that meant for the work that you're doing?
I think I've mentioned in the past that obviously it's not ideal in the sense that you can't visit the country and pursue avenues there. It just means that we need to focus on what we can do rather than what we can't do.
And is that, when you say what you can do, is that, I think you've previously said that you were focused on gathering evidence outside of Afghanistan.
Yes.
That remains the case,
Yes.
I presume?
Everywhere but Afghanistan, I guess, is
Everywhere
how to put
but
it.
Afghanistan.
And having said that, there's obviously options short of being physically in the country from things from Afghanistan.
So are you exercising any options to gather evidence from inside Afghanistan?
I won't go into what we're doing in terms
I'm
of...
asking just in general terms,
In general
not
terms,
what
we're
the
looking
options are, but
as broadly as we can, yes.
So you are engaged in gathering evidence from within Afghanistan?
There's a lot of evidence floating around about Afghanistan and the situation there.
Yeah, I was specifically asking about evidence from within Afghanistan that
Yes.
doesn't require you to physically be there.
Correct.
Okay, thanks. Can I ask what steps you're taking to ensure that your staff are adequately trained in working with witnesses who don't speak English as their first language?
We've chosen investigators who I think have, from my experience, pretty good emotional intelligence about how to deal with witnesses. It hasn't transpired to date that we've had to deal with witnesses who don't speak English.
It hasn't?
No, it hasn't been the case.
Okay.
And where we do
what
need-
about witnesses whose English may not be...
As far as I know, I can say in general terms that hasn't been an issue to date. However, we're very conscious of language, and if I may say so, we've actually, with the AFP, taken the initiative of translating parts of the Brereton into Dari and Pashtun, and so it's for the community to understand what happened in the Brereton inquiry. So in that spirit, we're amenable to making sure that accurate, truthful engagement and supportive engagement with witnesses, and we've done a lot of work in that space, generally speaking, broadly speaking, because there are a lot of issues dealing with the variety of witnesses we'll be dealing with and are dealing with.
Yep. All right, thank you. Obviously, there's been a lot of media reporting in recent times around the case in the courts with Mr. Robert Smith.
The defamation case?
Yes, the defamation case. Information about what's going on there has been broadcast, pretty widely across a range of
Yes, I've noticed.
media outlets. How would you describe the impact of that continued publicity on the work that you're doing?
In general terms, it's a private matter. A plaintiff can pursue their interests in a court.
Sure.
To date, we don't think that's impacted adversely on our work.
So just to be clear, I'm not offering any comment or suggesting you should on whether people have got a right to pursue matters in the courts. I'm specifically referring to the fact that evidence has been led in that case.
Senator Kim, if I can just remind you of the important convention in relation to sub judice.
I'm not...
So in relation to that particular matter, if I can ask you just to exercise great care
I'm exercising great care.
any reference to the actual evidence which might be seen to be prejudicial.
I'm referring to evidence that's been widely broadcast, as Mr. Moratis
I
has
realise
just
that, but
agreed.
that's irrelevant because court proceedings are able to be faithfully reported, but in relation to any discussion of the matters currently before the court, I would just ask you to exercise great care in how you reference them.
I'll continue to exercise great care in how I reference this, Mr. Moratis. As I said, I'm not seeking to offer any comment or suggest you should in regards to people's right to take legal action, but there has been evidence led in that case that goes directly to allegations of action on the ground in Afghanistan. Are you saying that you don't believe that the publicity around that evidence has impacted on your work in any way?
We are ensuring their investigations maintain proper distance from any evidence that's adduced in those proceedings, and I'll leave it at that because we want to make sure that anything we do is done with in accordance with all proper procedures, and I don't want to comment further on what evidence may or may not be in those cases, or publicised even in the media.
Just to be clear, I'm not asking you to comment on that evidence. Okay. That's not what I asked you to do. What I asked is whether the publication of that evidence had impacted on the work that you're doing. And I think you've given evidence that it hasn't. Is that correct?
Generally speaking, yes.
And Senator McKim, thank you for asking your question in that manner. I appreciate you exercising great care, given this is currently before the courts.
Thanks, Chair. I've got no further questions.
Thank you, Senator.
Thank you very much. I don't believe any other senators have any questions of the Office of the Special Investigator.
Before we close, I would just like to thank Mr Moraitis and his team for the work that they are doing, and our
Thank you.
lack of questions from senators from various parties tonight across the spectrum means that, one, perhaps we all have confidence in Senator McKim, and
I'm not expressing any lack of confidence in Mr Moraitis or his organisation.
No, I meant that we allowed you to carry the line of questioning for us.
Yeah, no, that's what.
And to thank you for the work that you're doing.
Thank you. We appreciate that, Senator.
Thank you very much, Director General. We greatly appreciate your time and your evidence this evening, and the very hard work of your officers. This concludes today's proceedings. I'd like to thank the Minister and the departmental officers for their attendance, along with Hansard, Broadcasting and our very hard-working secretarial staff. I'd like to move a motion to accept tabled documents that have been tabled during the day. All those in favour, all those against, that is carried. Senators are reminded that written questions on notice should be provided to the Secretariat by 5 p.m. on Friday, the 25th of February 2022. The hearing is adjourned. Good evening. Thank you.